Hello, privacy folks, and welcome back to Privacy Trainer. This time I got a treat for you. This is an explainer video on the GDPR, so Article 1 to Article 99. This was done with AI, and I haven't watched all the videos, but I did do my due diligence, and I think it's good enough for learners to start learning, and even for myself, just to kind of go through it as a reminder. So I hope you enjoy it. Please comment if you see any mistakes for other learners. So that's it. Take care. Enjoy.
Welcome to the most comprehensive GDPR course on YouTube. Whether you're preparing for privacy certifications, exams, or working as a data protection officer, or managing compliance operations, this series provides a detailed breakdown of the legal text governing data in the digital age. Our analysis begins with Chapter 1, General Provisions, and the Regulations Opening Statement, Article 1, Subject Matter and Objectives. This is the official legislative text of Regulation 2016-679, as published in the Official Journal of the European Union. We start here because Article 1 establishes the specific legal goals that the subsequent 98 articles are intended to fulfill. Article 1 sets out the primary objectives that define how this regulatory framework functions. The text identifies two distinct priorities for the Union: the fundamental right to data protection and the free movement of personal data. The regulation structure is designed to address these two priorities simultaneously, linking the protection of the individual to the movement of data. To understand how the law achieves this, we need to examine the precise wording of each paragraph. This textual analysis will show that the GDPR is designed to facilitate digital activity within a set of specific protective boundaries. Paragraph 1 defines the scope of what the GDPR actually does. First, it mandates that the regulation lays down rules relating to the protection of natural persons. This protection is specifically tied to the processing of personal data. The text then uses the coordinating conjunction "and" to introduce a second concurrent requirement. This second mandate requires that the regulation also lay down rules relating to the free movement of that same personal data. By placing these goals in the same paragraph, the law indicates that the protection of individuals and the flow of data across borders are intended to function as a single integrated system. Article 1, Section 1 effectively establishes a dual mandate. The regulation is designed to protect citizens while enabling the digital trade that depends on data mobility. Article 1, Section 2 clarifies the legal status of these protections. It states that the GDPR protects fundamental rights and freedoms, specifically identifying the right to the protection of personal data. However, the articles of the GDPR are supported by recitals, which explain the intent behind the law. This is Recital 4. It explicitly states that the right to the protection of personal data is not an absolute right. The recital clarifies that this right must be considered in relation to its function in society and balanced against other rights, including the freedom to conduct a business. While Article 1.2 establishes the high stakes of privacy as a fundamental right, the recitals demand that it be applied proportionally alongside other societal and economic needs. Paragraph 3 addresses the movement of data directly. It provides that the free movement of personal data within the Union shall be neither restricted nor prohibited. This applies specifically to any restrictions based on the protection of natural persons. The rationale is that because the GDPR creates a uniform level of protection in every member state, no state has a legal justification for blocking data transfers to another on privacy grounds. Article 1.3 ensures that privacy standards cannot be used as a technical barrier to trade, maintaining a single digital market across the EU. To see why this level of uniformity was required, we have to look at the previous legal framework. Before May 2018, EU data protection was governed by the 1995 Data Protection Directive. Because it was a directive rather than a regulation, member states could choose how to implement it, which led to significant differences in national laws. Recital 10 notes that this fragmentation created legal uncertainty and obstructed cross-border economic activity. By enacting a binding regulation, the EU ensured these rules would be applied identically in every country, removing the obstacles created by the 1995 directive. Understanding the text of Article 1 is only the beginning of modern compliance work. The GDPR is a living system that is constantly being refined and clarified. This ecosystem starts with the core text of the 99 articles at the center. Radiating from that center are the recitals, which we've seen provide the necessary context and legislative intent. The next layer consists of guidelines from the European Data Protection Board, or EDPB, providing practical standards for regulatory enforcement. Finally, the outermost layer is defined by the Court of Justice of the European Union, which provides binding legal interpretations. Rulings from this court can change how specific articles are applied by organizations on a daily basis. A professional compliance strategy must account for all these layers. Reading the articles in isolation is insufficient for meeting legal requirements. Article 1 defines the GDPR as a tool for ensuring that data is used lawfully, rather than a simple prohibition on its use. It establishes a framework where protecting the individual is compatible with supporting the European economy, a constant theme throughout this course. Now that we have identified the objectives, we must define the scope of the law's authority. In our next episode, we analyze who and what falls under these rules in Article 2, Material Scope.
All right, let's jump right into this explainer and tackle GDPR Article 2. Think of this article as the ultimate gatekeeper. It literally decides whether the General Data Protection Regulation even applies to what you're doing with data. Now, you might be wondering, why should I care about this? Well, frankly, because misunderstanding Article 2 is one of the most expensive mistakes an organization can possibly make. If you incorrectly assume the GDPR applies to you, you're going to waste massive amounts of time and budget on compliance frameworks you just don't need. But honestly, what's far worse is if you wrongly assume it doesn't apply. Do that, and you leave yourself completely exposed to brutal regulatory action, massive fines, and terrible reputational damage. So, Article 2 solves this whole problem by drawing the absolute hard boundaries of the law.
We've got a great agenda today. First up, the GDPR gatekeeper. Second, we'll cover the 4 exceptions. Then, Section 3, real scenarios. 4, a mini case study. 5, a quick knowledge check. And finally, Section 6, key takeaways.
So let's kick things off with Section 1, the GDPR gatekeeper, diving into Article 2's material scope.
To really understand the GDPR, we first have to establish what we call material scope. You can think of material scope as the what and how of data processing. It's the baseline threshold that determines exactly what kind of activities actually trigger the legal requirements of the GDPR in the first place. And here's where it gets really interesting. The law applies to digital data processed by automated means, absolutely, but it also applies to physical paper records, as long as those physical records are organized in a structured filing system. Now, automated means is pretty much anything digital, right? Servers, laptops, smartphones, cloud databases. But lawmakers, well, they knew they couldn't just leave a massive loophole for paper records. So, if you keep employee health records sorted alphabetically in a locked physical cabinet, that is a structured filing system, and the GDPR is watching you just as closely as if it were a digital spreadsheet.
And that brings us to a really crucial piece of text, Recital 15. Lawmakers intentionally wrote Recital 15 to ensure that whether you're using advanced AI servers, ancient legacy mainframe computers, or just a simple, well-organized filing cabinet, you simply cannot escape the rules just by changing up your technology. The law is fundamentally meant to protect people, not to regulate specific gadgets. This principle, known as technological neutrality, is exactly what keeps the GDPR incredibly relevant, even as modern tech evolves at lightning speed.
Moving right along to Section 2, the 4 exceptions found in Article 2, Paragraph 2.
Okay, so if you pass through the gate of Article 2, Paragraph 1, you are officially in scope. But wait, you also have to look for the secret passages. These are the 4 specific exceptions outlined in Paragraph 2. If your processing falls into one of these 4 buckets, the GDPR actually backs off and does not apply. Basically, the GDPR steps aside for national security, foreign policy, your personal private life, and police activities. Why? Well, because these areas are governed by completely different legal frameworks. For instance, law enforcement activities are covered by the Law Enforcement Directive, not the GDPR. And matters of national security, those are generally left up to the individual member states. Let's zoom in on the household exemption for a second, because this is a massive area of confusion. This exemption protects ordinary people doing ordinary things. So if you have an address book on your phone with your friends' numbers, that's a household activity. You're good. But famously, the Bodo Lindquist case, which was a huge landmark ruling, proved that the second you publish personal data to an indefinite number of people on the internet, you immediately destroy this exemption. Poof, gone. Furthermore, Recital 18 clarifies something really important. While you might be exempt when using social media for personal reasons, the massive tech platform providing you the service is absolutely not. They are still considered a controller under the law. All right, let's see how this plays out in the wild in Section 3, Real Scenarios and Mistakes.
Let's look at real-world applications and pinpoint exactly where things go terribly wrong in compliance. Say a tech company transfers data for commercial purposes. That remains completely in scope under the GDPR. In the famous Schrems II case, case C311/18, the court ruled that even if a foreign government might access that commercial data for their own national security purposes later on, the initial transfer by the business is a commercial act, so the GDPR applies. For a small business keeping a physical customer Rolodex, the GDPR applies because it's a structured filing system. And for an individual posting a colleague's medical data on a public blog, the GDPR definitely applies. Broadcasting to the world entirely fails the household exemption test.
And trust me, regulators will strictly evaluate these boundaries. A super common compliance failure is assuming that just because an activity involves some level of public security, you're magically exempt. For example, in case C439/19 regarding Latvian penalty points for traffic violations, a public body tried to argue that disclosing driver penalty points was exempt. But no, the court firmly established that these exceptions must be interpreted extremely strictly. You absolutely cannot stretch the national security or law enforcement exceptions to cover general administrative tasks.
Let's put this all together in Section 4, a mini case study.
Imagine a local non-profit sports club run by a tight-knit group of close friends. They decide they want to create an online public member directory on their website so everyone can easily find each other. So, let's break this challenge down step by step. First, member names and contact details are certainly personal data. Second, they are processing it via automated means on a web server. So, step 3, can they claim the household exception because they are just a small club of friends? Step 4, absolutely not. Publishing that directory online to an indefinite audience entirely removes their household shield. Doing this brings this small, friendly club squarely under the material scope of the GDPR.
Now for my favorite part, Section 5, Knowledge Check. Let's test your understanding.
It is time to test your knowledge with a professional certification-style check based on the scenarios we've just covered. This is exactly the kind of critical thinking required for exams like the CIPP/E. Okay, question 1. Which of the following falls under the material scope of the GDPR? Is it A, police investigating a local burglary? B, a handwritten, completely unstructured personal diary? C, employee records kept in an alphabetically sorted physical cabinet? Or D, national security agencies protecting state borders? Take a quick moment to think about the boundaries of Article 2. Remember the difference between automated means, structured files, and those strict exemptions we talked about.
And the correct answer is C, because it forms part of a structured filing system. Even though it's physical paper, being alphabetically sorted makes it a structured filing system under Article 2. Options A and D, police and national security, are explicitly exempt. And option B, an unstructured personal diary, is both unstructured manual data and a purely personal activity, keeping it out of scope.
Moving right along to question 2. According to Recital 18, if an individual uses a social media platform for purely personal purposes, does the GDPR apply to the platform provider? A, yes, they provide the means for processing. B, no, the household exemption covers the platform. C, only if the user pays for a premium account. Or D, only if the platform is based in the EU. This question is really testing your grasp of the nuance between a user's personal activity and the massive commercial infrastructure supporting it. The answer is A. Controllers providing the means for personal activities are still subject to the GDPR. While you might just be organizing a fun family reunion online, the social network providing the platform is a commercial entity providing the means for processing. That makes them fully subject to the rules.
All right, question 3. Based on the Schrems second case, case C311/18, if a commercial operator transfers data to a third country where it might be processed for state security, does the GDPR still apply to the transfer? A, no, it falls under the national security exception. B, yes, because the transfer is for commercial purposes. C, only if the data is highly sensitive. Or D, no, because the data leaves the EU. Think back to what we discussed about who is actually doing the processing at the exact time of the transfer.
The correct answer here is B. The transfer is for commercial purposes by an economic operator. The initial transfer by the business is a commercial activity. That means they simply cannot use a foreign government's potential national security activities as some magical excuse to ignore their own GDPR obligations.
Final question. Let's bring it home. What key principle did case C439/19, the Latvian penalty points case, reinforce regarding the Article 2, Paragraph 2 exceptions? A, they should be interpreted broadly to help businesses. B, they only apply to digital data. C, they must be interpreted strictly. Or D, they are completely optional for member states. This tests a super fundamental legal principle about how the Court of Justice views loopholes to fundamental rights.
And the answer is C. Exceptions to the material scope must be interpreted strictly. To protect individuals, the courts have consistently ruled that you absolutely cannot stretch these exceptions. They are narrow, strictly guarded gates, and they don't budge easily.
Let's summarize everything in Section 6. Key takeaways. Let's wrap up by crystallizing the absolute most critical lessons from our journey through Article 2. First, remember that Article 2 is your starting line. It's the gateway to the GDPR. Second, thanks to the idea of technological neutrality, it applies to both automated data and structured manual files. Third, if you are trying to claim an exception, like national security, be hyper-aware that they are interpreted incredibly strictly. Fourth, you cannot rely on the household exemption if you make data public to the internet. And finally, tech platforms that provide the means for household activities are never exempt themselves.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Before we go, ask yourself this: is there a dusty, alphabetized filing cabinet sitting in your office right now that just secretly brought your entire operation under the GDPR? Keep learning, stay compliant, and I'll see you in the next explainer.
Okay, let's just dive right into this explainer and uncover the true global reach of the GDPR by digging into Article 3. You see, when the General Data Protection Regulation was first being drafted, lawmakers faced a pretty massive problem. Think about it. In a totally borderless digital world, how on earth do you protect European individuals from companies operating half a world away? It's a real puzzle. And if organizations misunderstand this article, they risk absolutely devastating fines and regulatory action, usually because they mistakenly think they're safe just because their headquarters happen to sit outside of Europe. So today, we are breaking down the exact territorial scope of this framework. Here is how we're going to break down the long arm of the law today. We'll start with why Article 3 actually matters, unpack the territorial scope rules, look at it in practice, run through a mini case study, do a quick knowledge check, and wrap up with some key takeaways. All right, Section 1, why Article 3 matters, the ultimate GDPR gatekeeper. Let's see how this builds the foundation of understanding who exactly must comply. Now, what's really interesting about this is it addresses the absolute biggest misconception out there. I hear it all the time. Hey, I'm not located in Europe, so the GDPR doesn't apply to my company. Right? Wrong. The reality is that your physical location does not act as a magic shield. The GDPR applies based on your digital reach and your actual business activities, not just the physical mailing address on your website. Listen, if you're just accidentally getting some European web traffic, you might be totally fine. But if you are actively courting European customers, the rules absolutely apply to you, period. Let's move to Section 2, the Territorial Scope Rules. Time to actually unpack the legal text of Article 3. So, Article 3, Paragraph 1 is all about this concept of establishment. In plain English, if your company is established in the EU and you process data in the context of that establishment, you're covered by the GDPR. But what does establishment really mean? Well, Recital 22 tells us it implies the effective and real exercise of activity through stable arrangements. Notice how broad that is? It doesn't matter if you don't have a registered fancy subsidiary. As reinforced by landmark case law like Google Spain, KC 131/12, and Weltimo, KC 230/14, even a super minimal presence counts. Literally, a single remote sales employee working out of their living room in Spain can constitute a stable arrangement if they're conducting real business activities. Okay, but what if you don't have an establishment? Well, then we look at Article 3, Paragraph 2, which focuses heavily on targeting and monitoring. If you intentionally offer goods or services to people in the EU, or you monitor their behavior, you are caught right in the net. The crucial point here, and this echoes Recital 23 and the Verein for Consument Information case, C191/15, is intentionality. Regulators are looking for evidence of intent. Are you accepting euros? Are you offering your website in French or German? Are you running targeted ads specifically to people living in Paris? And under the monitoring prong, Recital 24 clarifies that this really means tracking people online to create profiles or predict their preferences. Oh, and we also can't forget Article 3.3. It's this fascinating little clause that applies the GDPR to places like member state embassies or even registered cruise ships operating in international waters under public international law. Section 3. Article 3 in practice. Let's translate this legal theory into some real-world scenarios you might actually encounter. Regulators look for very specific triggers here, so let's walk through these. Look at the US tech company creating an app specifically meant for tourists in Paris. They're explicitly targeting services and monitoring location. Does the GDPR apply? Yes, absolutely. Next, take a Canadian small business with just one single agent in the EU. Because of that stable arrangement, Article 3.1 triggers compliance. Yep, it applies. But now, look at the compliance failure at the bottom, because this is a super common mistake. A local US bakery happens to get some web traffic from a user browsing in Germany. Does the GDPR apply? No way. The mere accessibility of a website just isn't enough. Regulators look for intentional targeting, not purely accidental random web traffic. So, to protect yourself, you've got to maintain crystal clear records of your target markets and ensure your marketing teams actually understand the difference between general global reach and intentional EU targeting. Moving to Section 4, let's put on our privacy professional hats and walk through a realistic, step-by-step mini case study involving Wi-Fi tracking. All right, picture this. You've got a US retail consultancy advising a massive shopping center in France. They decide, hey, let's track customers' smartphones via Wi-Fi to analyze foot traffic and optimize store layouts. The privacy issue here is pretty obvious. Does a US company with 0 European offices have to follow EU law just for collecting localized physical data? Well, going step by step through the analysis, the answer is a resounding yes. The data subjects are physically located in the EU, and tracking their movement through a mall, that is a textbook classic example of monitoring behavior under Article 3.2b. By analyzing the who and the where, it becomes super clear that monitoring physical behavior firmly triggers compliance, even for a US firm. And as a result, they're actually going to need to appoint a local EU representative under Article 27 too. Section 5, Knowledge Check. Now it's your turn. Let's test your understanding with 4 certification-style scenario questions. Okay, here's the first one. An Australian news app is used by an Australian tourist who happens to be visiting Germany on holiday. Does the GDPR apply? Think about your options. Could it be yes, via targeting or monitoring? Or perhaps yes, via establishment? Or is the answer no, because there's no intentional targeting? What do you think? If you guessed C, you hit the nail on the head. The correct answer is C. It does not apply. The service is intentionally targeting Australians, not individuals in the EU. The app deals in Australian currency, it focuses on local Aussie news, so the mere physical presence of the tourist taking a vacation in Germany doesn't magically trigger Article 3. The fundamental intent of the business hasn't changed, just because their customer caught a flight. Question 2. A US startup offers a city mapping app specifically designed for tourists visiting Paris, and they process user locations for targeted ads. Does the GDPR apply here? Consider the angles. Does it not apply because they're a US company? Or maybe because tourists aren't technically EU citizens? Or does it apply via establishment, targeting, or monitoring? The answer is B, because the app specifically intends to offer services to people located in Paris and actively tracks their location for ads. Both Article 3.2a and 3.2b absolutely apply. And remember this crucial point. The GDPR protects individuals located in the EU, regardless of their actual citizenship. So the fact that they are just visiting tourists doesn't exempt the company whatsoever. Let's try question 3. The Dutch consulate, which is physically located in Jamaica, opens an online application process to recruit local Jamaican staff. Does the GDPR apply to this? Evaluate these choices. Is it exempt because Jamaica is outside the EU? Or because employment data is exempt? Or does it trigger compliance via targeting? Or maybe public international law? The correct answer here is C. It applies via public international law under Article 3.3 and Recital 25. Places like embassies, consulates, and even registered cruise ships essentially carry the GDPR with them across the globe. It's a really unique carve-out. Last question. A Canadian web developer with no physical offices anywhere in the world hires exactly one remote marketing employee who happens to live in Spain. Does the GDPR apply? Select the best analysis. Do remote workers not count? Does being a Canadian company grant some sort of exemption? Or does this trigger compliance via establishment or targeting? The answer is A. It applies via establishment. Just as the Well-to-Mo case taught us, even one single employee conducting real, effective activity constitutes a stable arrangement under Article 3.1. It simply doesn't matter that the company is Canadian or that they don't have a formal brick-and-mortar office building. All right, Section 6, Takeaways and Next Steps. Let's summarize the really key lessons we've uncovered today. So the absolute most crucial point here is that understanding your specific data flows and intentions is literally the only way to accurately determine your territorial scope. To quickly recap, your physical location outside the EU is not a free pass. Establishment is interpreted extremely broadly by regulators. Targeting requires actual provable intent to serve the EU market. Monitoring covers a huge array of modern tracking techniques, profiling, and location data. And importantly, if your organization acts as a data processor for a controller who is caught by these rules, you are directly bound by them too. If you enjoy these GDPR explainers and would like to support the channel, Consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Finally, disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes, but I want to leave you with this final, provocative thought as you evaluate your own daily operations. Do you know exactly where your organization's digital footprint lands today? And could it be unintentionally pulling you right into the scope of the GDPR? Hey everyone, and welcome back to Privacy Trainer. I'm so thrilled you're joining us today. We're going to be unlocking the absolute foundation of the GDPR, and that's Article 4. You really need to think of this as the master dictionary that literally makes or breaks your GDPR compliance. I mean, without a rock-solid grasp of these definitions, navigating the rest of this regulation is pretty much impossible. Now, you might be wondering, why do these definitions actually matter so much? Well, here's the high-stakes reality. Misunderstanding Article 4 is the root cause of some incredibly catastrophic compliance failures and massive regulatory fines. Honestly, if you don't accurately know what processing or personal data actually means in the eyes of the law, you literally can't even begin to protect it, properly contract for it, or comply with data subject rights. So here is our roadmap for today's explainer. We'll start with data and processing, move right into the actors, tackle some advanced concepts, run through a real-world case study, test you with a knowledge check, and finish up with our key takeaways. All right, let's dive right into Section 1. Data and processing, the material and the action. Let's look at Article 4, Paragraph 1, which defines personal data. It's defined as any information relating to an identified or identifiable natural person. Notice how broad the word identifiable actually is here. We're not just talking about a name or an ID number. Let's say you run a small local bakery and you store customer names, email addresses, or even just loyalty card numbers. That is personal data. If that information can be linked back to a living person, whether directly or indirectly, the GDPR absolutely applies to it. Next up is Article 4, Paragraph 2, which covers processing. This means literally any operation performed on personal data. Collection, organization, storage, alteration, erasure, you name it, it's processing. And this brilliantly illustrates a really common trap. Organizations so often think, well, we just store the data on our servers. We don't actually do anything with it. Guys, that doesn't matter. Take a tech company that automatically collects and stores user IP addresses in a server log. Even if they literally never look at those logs, that mere storage is explicitly defined as processing under the law. Okay, moving on to Section 2, the actors. Who is responsible? The absolutely crucial distinction here is understanding the difference between a controller and a processor, which are defined in paragraphs 7 and 8. So a controller determines the purposes and means of the processing. A processor, on the other hand, acts purely on behalf of the controller. It helps to think of this like a film set. The controller is the director. They call the shots, decide the script, and hold the ultimate responsibility for the whole production. The processor is the film crew. They're just executing the instructions and working strictly on behalf of the director. Now, if the crew goes rogue and starts filming their own movie outside of the director's instructions, they become a controller themselves and take on some huge legal liability. And we really can't talk about controllers without looking at how regulators and the European courts interpret this out in the real world. Landmark cases like Google Spain and the Virtus Academia ruling on joint controllership, along with EDPB guidelines, show us that courts look right past what is simply written in your contracts. They look at the actual reality on the ground, who exercises real-world influence and actual control over the data, because regulators are absolutely going to evaluate your actual factual practices during an investigation, not just your paperwork. Next up is Section 3, Advanced Concepts, Complexities, and Common Mistakes. Okay. Pay super close attention here because this is a massive misconception. Pseudonymization, which is on the left, is when you separate identifying data, like, say, replacing a name with a unique code, but you keep the key somewhere else securely. Pseudonymized data is still personal data and it is fully subject to the GDPR. Now, on the right, anonymization, which is outlined in Recital 26, means the data is irreversibly stripped of identifiers. You can literally never figure out who the person is again. Anonymized data is not regulated by the GDPR. So treating pseudonymized data as if it were anonymous is a major and usually very costly compliance failure. Let's bring this to life in Section 4, Case Study, Real-World Application. Imagine a SaaS company analyzing user behavior inside their app to build targeted marketing campaigns. Let's just walk through the analysis together. Step 1. We identify the data subject's footprint. The user's clicks, navigation paths, and device IDs are all considered personal data because they relate to an identifiable person. Step 2. Determine the action. Taking this data, structuring it, and analyzing it to build profiles is clearly processing. And step 3. Assign liability. Because the SaaS company decided why they are doing this for their marketing and how to do it using their algorithms, they are acting as the controller.
Time for Section 5, Knowledge Check. Test your privacy knowledge.
Question 1. A cloud provider stores encrypted employee data for a client but has absolutely no access to the decryption keys. What is their role? Are they A, a joint controller, B, a processor, C, a third party, or D, not subject to GDPR? I'll give you a second. Think about that purposes and means this we just talked about. The correct answer is B, processor. By referencing Article 4, Paragraph 8, we know a processor acts on behalf of the controller. Remember how we said mere storage is explicitly defined as processing? Well, even without the decryption keys, they are processing the data by storing it, but they're doing so strictly on behalf of their client. Let's try question 2. A hospital replaces patient names with unique ID numbers for research, keeping the master list locked in a separate secure server. What is this called? A, anonymization, B, encryption, C, pseudonymization, or D, erasure? And the answer is C, pseudonymization, under Article 4, Paragraph 5. Because the hospital separated the direct identifiers, but still holds that master list, which is the additional information, the data can be relinked. I really want to emphasize this again. This data still requires full GDPR compliance. Moving right along to question 3, an AI algorithm evaluates an employee's daily keystrokes to predict their future reliability and risk of quitting. This is an example of A, a data breach, B, profiling, C, joint control, or D, anonymization. Let's see your grasp of Article 4, Paragraph 4. The correct answer is B, profiling. The regulation specifically defines profiling as any form of automated processing that uses personal data to evaluate personal aspects, particularly to analyze or predict someone's performance at work or their reliability. Evaluating an employee's keystrokes to predict if they'll quit, that is a textbook case of profiling. Okay, let's hit our final test. Question 4. A hacker accidentally deletes a database containing non-sensitive user emails. Is this considered a personal data breach under Article 4, Paragraph 12? A, no, because it wasn't sensitive. B, no, because it was an accident. C, yes, because it is the accidental destruction of personal data. Or D, yes, but only if financial loss occurs. The correct answer is C, yes. This highlights a huge common misconception. So many people think a breach requires malicious intent or highly sensitive data. It absolutely doesn't. Article 4, Paragraph 12 clearly states that a breach includes a security failure leading to the accidental destruction or loss of any personal data. Let's wrap things up with Section 6, Key Takeaways. Here's your practical framework to take away today. Number 1, Article 4 is the dictionary of the GDPR. Everything else relies on these definitions. Number 2, personal data and processing cover almost everything you do. If it touches identifiable human data, it counts. Number 3, remember our film set. Controllers direct, processors execute, and regulators are definitely going to look at actual control, not just your contracts. Finally, number 4, pseudonymization is absolutely not anonymization. Keep your keys separate, but remember, you are still handling regulated data. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Before we go, I'll leave you with this. As you review your own data practices today, ask yourself, are you truly the director of your data, or have you accidentally become the crew? Have you ever wondered what makes up the absolute core of any successful privacy program? Think about human DNA for a second. It contains the fundamental instructions for how everything in our bodies operates, grows, and survives, right? Well, in the world of European privacy law, Article 5 of the General Data Protection Regulation is exactly that. It is literally the fundamental DNA of data protection.
It's not just some preliminary checklist you glance at. It's the ultimate foundation that every single data processing activity has to be built upon. If you understand Article 5, you essentially hold the blueprint for the entire GDPR. But what happens when that DNA gets corrupted? Like, what happens when a business misunderstands or just flat out ignores this single article? Well, the consequences are pretty severe. A corrupted foundation inevitably leads to massive regulatory fines, intense scrutiny from supervisory authorities, and honestly, perhaps most devastatingly, a complete loss of trust from your users. You can have the absolute best privacy policies and the most secure servers in the world, but if you violate the core principles of Article 5, your entire compliance structure just completely collapses. All right, let's dive right into this explainer. Our roadmap for today covers Part 1, the blueprint, Part 2, real-world examples, Part 3, common mistakes, Part 4, enforcement focus, Part 5, a knowledge check, and finally, Part 6, key takeaways. Part 1, the blueprint, GDPR Article 5 principles. So to really operationalize the GDPR, we need to see exactly where Article 5 fits in. It outlines 7 fundamental principles, and I want to be clear here. These aren't just high-minded legal concepts, they are strict, everyday operational mandates. First, we have lawfulness, fairness, and transparency. This means you must have a valid legal basis, process data fairly, and be totally open about what you're doing. Second is purpose limitation. You have to collect data for specific, explicit reasons, and you can't secretly use it for something completely different later. Third is data minimization. Simply put, only collect what you strictly need, nothing more. Fourth is accuracy. You need to keep the data correct and up to date. Fifth is storage limitation, which means don't keep data forever, delete it when its purpose is fulfilled. Sixth is integrity and confidentiality, meaning you've got to keep the data secure. And finally, accountability. This means the controller is responsible for and must be able to actually prove compliance with all of these principles. Now, to really grasp how these principles work, we have to look at the GDPR's recitals. These basically help us interpret the dense legal text. Let's look at 2 really critical connections. Recital 39 connects directly to transparency. It explains that individuals must be made fully aware of the risks, rules, and rights concerning the processing of their data. It's really about taking the individual out of the dark. Then we have Recital 50, which connects to purpose limitation. This dictates that processing data for a new purpose is only allowed if that new purpose is compatible with the exact reason you originally collected the data. For example, you absolutely cannot collect an email address just to send someone a digital receipt and then suddenly decide to sell that email to a third-party marketing firm. That's a huge red flag. Part 2, real-world examples, practical applications. Okay, let's move out of the theoretical legal text and into practical, everyday business applications. Let's look closely at the principle of accuracy. What does accurate actually mean in the real world? Well, it depends heavily on the context. Consider a medical record from a surgery. If a doctor later realizes a finding in the original operation notes was actually incorrect, they shouldn't just go in and erase or overwrite the original text. The principle of accuracy here means appending a clear note about the later discovery, effectively preserving the historical truth of what was observed at that exact time. On the flip side, look at a bank checking a credit database. If that database holds outdated or wrong credit history, an individual could be unfairly denied a life-changing loan. Because the real-world impact is so high here, controllers of those databases have to make exceptional, continuous efforts to verify and update the accuracy of their data. Now let's look at storage limitation, but through the lens of modern tech, specifically virtual voice assistants. According to the European Data Protection Board guidelines, if a smart speaker accidentally records background conversations, like say, it mistakenly thought it heard its wake word, that data must be deleted immediately, unless a valid legal basis exists to keep it. A very common, non-compliant practice is a tech company storing all that voice data indefinitely, basically just waiting around until the user proactively logs in and hits delete. That doesn't fly. The storage limitation principle requires you to delete data the second it's no longer necessary for the original purpose. You can't put the burden on the user. Part 3. Common mistakes, where organizations fail. Despite how straightforward these principles might seem, organizations stumble over them all the time. One of the most common mistakes relates to purpose limitation. The EDPB explicitly points out that simply writing a generic, broad purpose in your privacy policy, like casually stating you collect data for combating fraud or improving user experience, is a direct violation. Why? Because it's nowhere near specific enough. A valid compliant purpose has to detail the exact parameters of the processing. It must be spelled out so clearly that anyone reading it knows exactly what kind of processing is happening, and maybe more importantly, what is not happening. You have to be explicitly specific. Part 4, Enforcement Focus, CJEU Rulings. So how do supervisory authorities and courts actually evaluate Article 5 during an investigation? Well, the Court of Justice of the European Union takes a remarkably strict view of these principles. Take the Digi case, for example. That's case C77/21. The court closely examines storage limitation. In this scenario, an internet service provider had copied a massive database of customer data into a secondary test database to troubleshoot some system errors. And honestly, that's fine for the test itself. But after the errors were fixed, they just left that test database sitting there for over a year. The court ruled this was a clear violation. The moment the test concluded and the errors were corrected, the purpose was achieved. The data had to be deleted right then. It's a very similar story in the Meta case, case C252/21, where the court heavily emphasized the principle of data minimization. Regulators are going to actively check if the data you're collecting is strictly necessary for your stated goal. You absolutely cannot collect vast amounts of user data just in case it might be useful down the road. If your objective can be achieved using less data, then you are legally obligated to process less data. It's as simple as that. Let's map out a mini case study based on that Digi decision to see how easily a totally standard IT practice turns into a massive compliance failure. Step 1. Customer data is legally collected to provide an ISP service. Step 2. The IT department encounters a bug and copies the data to a test database to troubleshoot. So far, we're doing great. Step 3. The test concludes, the bug is successfully squashed, but the IT team gets busy, forgets about the test database, and the data just sits there indefinitely. Step 4, a breach happens, the test database is discovered by regulators, and boom, you've got a massive violation of Article 51E storage limitation. The takeaway here is that even routine IT troubleshooting has to have automated, built-in data deletion protocols if you want to stay compliant. Part 5, Knowledge Check. Let's test your understanding. Let's see how you'd handle a real-world scenario that you might actually see on a certification exam. A virtual voice assistant on a smart speaker accidentally records background conversations in a user's home without the wake word being spoken. What is the required action for the tech company under Article 5? Is it A, keep it until the user proactively asks to delete it? Is it B, go ahead and use it to improve the AI language model? Is it C, delete it immediately unless a specific, valid legal basis exists? Or D, encrypt the data and store it indefinitely for security purposes? Take a second to think about what those EDPB guidelines dictate regarding purpose and storage limitation. All right, the correct answer is C. Accidentally collected data must be deleted immediately unless you have a specific, valid legal basis for keeping it. You definitely cannot use it to train your AI, because that violates purpose limitation. The user never provided that audio for training purposes. And you certainly can't hold on to it indefinitely, waiting for the user to figure it out and delete it themselves, because that's a direct violation of the storage limitation principle. Part 6, Key Takeaways for GDPR Article 5. Understanding the theory behind this is only half the battle. Applying it is where compliance actually happens. So here are the absolute key things you need to remember from this explainer. First, Article 5 is the foundation of the GDPR. Literally everything else builds on it. Second, when defining why you need someone's data, your purposes must be highly specific. Never use generic terms like improving services. Third, fully embrace data minimization. Only process what is strictly and absolutely necessary. Fourth, respect storage limitation. The exact moment your purpose is achieved, you need to delete or anonymize that data. And finally, accountability. It is not enough to just follow the rules behind the scenes. You have to proactively document and be able to prove to regulators that you are following them. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Thank you so much for joining me today to decode the DNA of data protection. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Keep mastering these core principles, and your entire privacy program will stand on an unbreakable foundation. I want to leave you with one final thought. If regulators audited your databases today, would your program's DNA pass the test, or would it show signs of corruption? Think about that, and I'll see you in the next explainer. Welcome back to Privacy Trainer. Okay, let's dive right into this explainer and unlock the absolute foundation of lawful data processing, which is GDPR Article 6. Whether you're a privacy professional, a business leader, or, just someone completely new to the GDPR, this is the one article you absolutely must master. It's literally the gatekeeper to everything else in data protection. So here is our game plan for today. We'll start with 1, the foundation, move into 2, practice and enforcement, run through 3, a mini case study, and wrap up with 4, a knowledge check. We're going to take you from the core theory all the way through a practical certification-style exam. But first, I want to pose a question to you. What happens if you build a massive digital empire on a completely illegal foundation? Well, the answer is catastrophic regulatory fines and, honestly, the forced deletion of your data. Without Article 6, you literally cannot process data. It means your entire business operation could be built on an unlawful, highly punishable foundation. If you get this wrong, all your downstream compliance, like top-tier security or perfectly written transparency notices, absolutely will not save you. All right, let's move right into Section 1, the foundation. Let's look at how the GDPR frames the very concept of lawful data processing. Article 6, along with Recital 40, makes it crystal clear. You cannot touch personal data unless you have a legally valid reason to do so. It essentially translates incredibly complex legal text into a very simple, hard and fast rule. No basis, no processing. And why? Because it exists to shift the power dynamic back to the individual. You don't just get a default right to process someone's data simply because it's helpful for your business. You actually have to earn that right through a specific legal justification. Now picture a highly secure, impenetrable vault. These 6 lawful bases are the only 6 keys that can possibly unlock it. Let's walk through them in plain English. First up, consent. This is when the user says a clear, totally reversible yes. Second is contract, meaning you literally cannot provide the agreed-upon service without this data. Third, legal obligation. The law forces you to process it. Think keeping tax records. Fourth is vital interests. We're talking a life or death emergency. Fifth, public task. This is for government or official functions. And finally, the 6th, legitimate interests. You have a valid business reason, but you have to prove it doesn't harm the user's rights. Let's look a bit closer at that last one because legitimate interest is for sure the most frequently misunderstood. EDPB Guidelines 2024-01 show us that legitimate interest isn't just a free pass for whatever you want to do. Actually, scratch that. It's the exact opposite of a free pass. It requires a strict step-by-step test. Step 1, you need a lawful, clearly articulated interest. Step 2, the processing must be genuinely necessary, meaning you can't achieve your goal in a less intrusive way. And step 3 is the balancing test. This is where you have to prove your business needs don't crush the user's fundamental rights and freedoms. If the user's rights weigh heavier, you simply cannot use this key. So moving on to Section 2, practice and enforcement. Let's see how all this theory actually plays out in the real world. Let's contrast 2 very practical examples. On one hand, a local shop correctly relies on legal obligation to process employee payroll data. They have to do it to comply with national tax laws, right? Perfect. But on the other side, we see a massive compliance failure. A tech company tries to use the contract basis to collect behavioral data for targeted advertising, claiming it's just part of their terms of service. Well, the Court of Justice of the European Union, specifically in case C252/21, explicitly struck this down. They ruled that just because something is useful or casually mentioned in a contract doesn't mean it is objectively indispensable to providing the core service. And here's the thing. If regulators knock on your door, they don't just ask what basis you chose and take your word for it. They demand cold, hard evidence. If you claim consent, they are going to want to see consent logs proving it wasn't forced and that it can be easily withdrawn. If you claim legitimate interest, they want to see your documented legitimate interest assessment proving you actually did that balancing test before you even started processing. In the GDPR world, accountability means showing your homework. All right, Section 3, our mini case study. Let's see how this builds into a very realistic business challenge. Okay, so here's the scenario. An e-commerce platform decides they want to force users to create a permanent account just to buy a single pair of shoes. Naturally, the marketing team loves this for customer retention, but the privacy team needs to determine the legal basis. The business claims performance of a contract is the basis, arguing, hey, to sell the shoes, we need the account. But we really have to ask ourselves, is forcing this account creation genuinely necessary just to sell a pair of shoes? Let's break it down step by step. First, identify the core service. It's a one-off purchase of shoes. Second, we assess necessity. Is a permanent account objectively indispensable to put a box of shoes in the mail? Absolutely not. Following EDPB Recommendation 2025-02 and the solid reasoning in case C1722, we see that because a less intrusive alternative exists, namely a simple guest checkout, mandatory account creation entirely fails the contract necessity test. You would have to rely on consent instead, and that consent absolutely must be optional. Which brings us to Section 4, knowledge check. Let's really lock in this knowledge with 4 certification-style questions. Question 1. A SaaS company processes user data it claims is needed for a contract, but the service works totally fine without it. Which standard are they violating? Is it A, the data must be merely useful? B, the data must be objectively indispensable? C, the data must be explicitly consented to? Or D, the data must be in the public interest? Take a second and think about that strict definition of necessity from recent case law we just talked about. And the correct answer is B. Case C-252/21 firmly established that processing must be absolutely essential for the proper performance of the contract. It must be objectively indispensable, meaning there are zero workable, less intrusive alternatives. Just being useful to the company's bottom line is nowhere near enough. Moving right along to question 2. According to Recital 46, when should vital interests be used as a lawful basis? Is it A, for routine marketing emails, B, whenever a contract is breached, C, only when processing cannot be manifestly based on another legal basis, or D, to comply with standard tax laws? Think about the really extreme nature of vital interests here. The answer is C. Vital interests are essentially your absolute last resort. They are meant for literal life or death situations, like humanitarian emergencies, disaster relief, or tracking major epidemics. It is absolutely not a loophole you can use for routine business operations. Okay, question 3. If a controller relies on consent for processing, what happens if the user suddenly withdraws it? Do they A, switch to legitimate interests, B, stop that part of the processing, C, charge a fee to stop processing, or D, ignore the withdrawal if the service is free? Consider the power dynamic of consent we discussed and the core principle of fairness. The answer here is B. Look, if you choose consent, you have to respect it. Swapping over to another basis like legitimate interests right after a user withdraws their consent is fundamentally unfair, it's deceptive, and it is highly unlawful. You must stop that specific processing activity immediately. No bait and switch allowed. Final question, question 4. When performing the legitimate interests balancing test, whose rights must not be overwritten? Is it A, the data protection officer, B, third-party advertisers, C, the data subject, or D, the competitors? Try to recall that third step of the legitimate interests test we covered earlier. And the correct answer is C, the data subject. The entire core of Article 6 is ensuring that your business goals never, ever crush the fundamental rights, freedoms, and privacy of the actual living person behind the data. If their rights outweigh your business interests, the processing simply cannot happen. So, to synthesize all our main lessons for today, I want you to treat lawful bases as strict logical tools rather than just abstract regulatory hurdles. Article 6 is your absolute foundation. Remember that contract means objectively indispensable, not just helpful. Legitimate interests require that heavily documented 3-part test. Consent has to be real and totally reversible. And above all else, regulators demand actual evidence, not just a nicely written privacy policy on your website. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale that education globally. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and full exam and certification prep, you can absolutely explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while Privacy Uni is designed for learners who prefer a more structured, intensive learning experience. Disclaimer. This content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. Thank you so much for watching. As you go back to your day, I want you to ask yourself this one final thing. If regulators audited your databases tomorrow, would every single row of data have a legal key to exist? Keep training, and I'll see you in the next explainer. Welcome to Privacy Trainer. Okay, let's just dive right in. Today, we're tackling an absolutely foundational piece of European privacy law, and that's GDPR Article 7, which lays out the strict conditions for consent. In this explainer, we're going to discover exactly why so many organizations out there get user consent completely wrong, and how, by doing that, they're putting themselves at massive risk. You see, consent isn't just about slapping a pop-up on a screen and calling it a day. It is a highly regulated mechanism, so let's find out how it actually works. And this brings us to a really serious question that you need to ask about your own organization right now. Is your user consent actually legal, or is it just an illusion? A lot of companies, they think they're perfectly compliant just because they have a button that says, I agree. But if you misunderstand the strict conditions for consent laid out under Article 7, you are risking creating this mere illusion of compliance. And let me tell you, that illusion absolutely will not hold up to regulatory scrutiny, and it can quickly result in some massive, massive fines. So what exactly does Article 7 do? Well, while Article 4 defines what consent actually is, Article 7 is there to provide the practical, operational rulebook for how you actually get it. It defines the strict mechanics of valid consent. It explicitly shifts the burden of proof directly onto the data controller, which means you have to prove you got it right. It's specifically designed to prevent forced, bundled, or disguised data collection, and this ensures users genuinely have free choice and real control over their personal data. Let's translate that formal legal text into practical reality. Paragraph 1 simply means, well, you must prove they agreed. Paragraph 2 demands that you keep the consent request totally separate from your general terms and use plain, clear language. Paragraph 3 dictates that withdrawal must be completely effortless, literally as easy as giving it in the first place. And paragraph 4 establishes that you absolutely cannot hold a service hostage in exchange for unnecessary data. Now, these rules are heavily guided by the GDPR recitals. For instance, Recital 42 reinforces that burden of proof, mandating that you maintain a minimal, crystal clear record of exactly how and when consent was given. Meanwhile, Recitals 32 and 43 emphasize that you absolutely cannot hide a consent request inside some massive, unreadable terms of service document, nor can you bundle it to force a user's hand. Consent has to stand alone. It must be freely given without any negative consequences for the user if they decide to say no. Okay, let's look at how this plays out in the real world with a couple of examples. First, imagine a tech company doing it right. They use separate, completely unticked checkboxes for marketing communications versus their general platform terms. Second, a small business doing it right. They record an oral consent over the phone, and then they immediately follow up with a confirmation email logging the time and date just to meet that burden of proof. But then we have the compliance failure. This is a company relying on pre-ticked opt-in boxes and bundling data sharing with access to their service. That's a huge red flag. The crucial point here is avoiding the trap of common misconceptions. Honestly, a lot of companies still think pre-ticked boxes count as consent, or that saying, by using this site, you consent, is somehow legally valid. It's really not. The enforcement reality, which is backed by major court decisions like the Planet 49 case, proves pre-tick boxes are entirely illegal. Regulators strictly enforce that silence or inactivity is never an active choice. And if giving consent took just one click, well, withdrawing it cannot require the user to navigate a maze or call customer service. It must take exactly one click to opt out. So if a regulatory authority actually decides to investigate your organization, here is exactly what they are going to look for based on Article 7. First up, they will immediately ask for your evidence trail to verify your burden of proof. Second, they're going to review your user interface and overall experience to ensure the language was clear and distinguishable. Third, they will literally test your withdrawal mechanism themselves to see if it's as easy as opting in. And finally, they'll investigate to see if you are illegally holding your service conditional on unnecessary data processing. Let's put all of this into perspective with a realistic mini case study. Imagine a dominant social media network updates its mobile app. Following this update, they suddenly require all of their users to consent to third-party behavioral advertising. If the user doesn't hit agree, they are locked out and cannot continue using the basic messaging functionality of the app at all. So let's analyze this scenario. Step by step, we can break this down. Step 1, we identify the processing. In this case, it's sharing data for third-party behavioral ads. Step 2, we check necessity. Are behavioral ads genuinely necessary to perform the core service of basic messaging? No, absolutely not. Step 3, we apply Article 7, Paragraph 4. The company has made the messaging service conditional on unnecessary data processing. Therefore, Step 4, our conclusion has to be that the consent is forced. It is not freely given, and therefore it is entirely 100% legally invalid. All right, time for a quick knowledge check to test your understanding. Question 1. A user agrees to an email newsletter, but later decides they want to opt out. How must the company handle this withdrawal under Article 7? A, require a written letter to be mailed. B, make it as easy to withdraw as it was to subscribe. C, charge a small administrative fee. Or D, wait 30 days before processing the request. What do you think? The correct answer is B. You must make it as easy to withdraw as it was to subscribe. This is because Article 7, Paragraph 3 of the GDPR explicitly, strictly demands that withdrawing consent must be completely effortless. If they subscribed by clicking a link in an email, well, they have to be able to unsubscribe by simply clicking a link in an email. Moving right along to question 2, which looks at conditionality. To download a free ebook, a website requires you to consent to them selling your personal data to data brokers. Is this consent legally valid? A, yes, because it's a free service. B, yes, if it's clearly stated in the privacy policy. C, no, it violates Article 7.4 regarding conditionality. Or D, no, because ebooks do not fall under the GDPR. And the answer is C. No, it is not valid because it directly violates Article 7, Paragraph 4 regarding conditionality. Selling a user's data to third-party brokers is absolutely undeniably not necessary for the performance of simply letting them download a PDF ebook. Because those two things are tied together, the consent is forced, meaning it's not freely given under the law. Okay, question 3 explores accountability. When a regulator comes knocking at your door, who actually bears the burden of proof to demonstrate that valid consent was obtained? Is it A, the data subject, B, the supervisory authority, C, the data controller, or D, the data processor? The answer here is C, the data controller. Article 7, Paragraph 1 clearly states that where processing is based on consent, the controller shall be able to demonstrate it. This means your organization must proactively design systems that maintain sufficient, clear records to definitively prove the user actually opted in. It's on you. Final question. A company updates its massive Terms of Service document. Buried way down in paragraph 42, it says, "By using this service, you consent to all marketing." Why exactly does the GDPR reject this as invalid? A. It uses a pre-ticked box. B. It's not clearly distinguishable from other matters. C. It requires a physical signature. Or D. Marketing is illegal under GDPR. The correct answer is B. It's invalid because the consent is not clearly distinguishable from other matters. Article 7, paragraph 2, requires that any request for consent must stand completely alone. It just cannot be buried in general terms and conditions. It has to be in an intelligible, easily accessible form using plain language so the user knows exactly what on earth they are agreeing to. So, when you really boil Article 7 down to its core, the key takeaways are actually remarkably simple. Number 1, you bear the burden of proof, so keep your records. Number 2, keep consent physically and visually separated from your general terms. Number 3, speak to your users clearly without the legal jargon. Number 4, make withdrawal incredibly easy. And number 5, never ever force consent for a service if the processing isn't strictly necessary. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam, and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. So I'll leave you with this final thought. Check your own website today. If a regulator clicked your accept button right now, could you legally prove they had a genuine choice? Really think about that. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thank you so much for learning with us, and I'll catch you in the next explainer. Let's jump right into this explainer. Why exactly are the digital rights of children one of the most heavily scrutinized areas in all of privacy law? Well, honestly, it's because a single misstep can expose highly vulnerable users and, frankly, cost businesses millions. Today, we're unpacking Article 8 of the GDPR. This entire article is completely dedicated to the conditions around a child's consent in the digital world. So if you're out there designing, building, or managing any online service that could be accessed by minors, this is a topic you absolutely cannot afford to misunderstand. Let's start with a really crucial question about the immense responsibility organizations take on when their digital services reach young audiences. What actually happens when a company collects personal data from children without putting the proper legal safeguards in place? You know, it's not just a matter of getting some bad PR. Regulators view unauthorized profiling, tracking, or marketing to children as a massive, severe violation of their fundamental rights. And what's really wild here is the financial penalty. Failing to get this right triggers the absolute highest tier of GDPR fines. We're talking up to 20 million euros or 4% of global turnover. We've actually seen this play out in the real world with sweeping regulatory actions, like the Irish Data Protection Commission's massive €345 million fine against TikTok, which heavily cited violations around children's data. So yeah, the stakes are incredibly high. Here is our quick roadmap for today. We'll cover the basics of Article 8, look at some real-world scenarios, discuss enforcement and common mistakes, test your privacy knowledge, and then wrap up with key takeaways. Okay, let's dive right into Section 1, the basics of Article 8, where we'll translate the law into plain English. Take a look at this quote from Recital 38. It brilliantly illustrates the why behind the law. Lawmakers fully recognized that kids are uniquely vulnerable to online marketing, profiling, and data collection. Because children just don't fully grasp the long-term consequences of handing over their personal information, the GDPR essentially demands that organizations step up and implement specific, enhanced protections whenever their services are aimed directly at that younger demographic. Now, a super crucial point to understand is that Article 8 specifically applies to what the law calls Information Society Services, or ISS. I know, it sounds like heavy legal jargon, but it basically just covers most commercial websites, mobile apps, online gaming platforms, search engines, and social media networks. Bottom line, if you're providing a service at a distance, electronically, and there's an economic component to it, you're almost certainly an information society service. This breakdown highlights the core rule of Article 8. If your service relies on consent and is offered directly to a child, the standard age of digital consent is 16. If the user is 16 or older, they can legally consent for themselves. Easy enough, right? But if they're under 16, you absolutely must get consent authorized by someone holding parental responsibility. Here's the tricky part, though. The GDPR allows individual member states to lower this age limit. They can never drop it below 13, but this means organizations have to navigate a really complex web of varying national laws. Moving on to Section 2, real-world scenarios and examples, let's see how to actually put this into practice. According to the European Data Protection Board, an online gaming platform should really follow a simple, proportionate approach like this 4-step process. First, just ask the user their age. Second, if they're underage, let them know a parent needs to authorize the account and ask for the parent's email. Third, contact that parent directly via email to get consent. And fourth, if any complaints or red flags pop up later, well, then you take additional steps to verify. Keep it simple and logical. In this comparison perfectly illustrates a key concept, proportionality. The law says you have to make reasonable efforts based on available technology. So for a low-risk service, like maybe a simple educational app, just getting an email confirmation from a parent might be perfectly reasonable. But for a high-risk service that handles sensitive data or tracks users, the EDPB suggests you might require something like a nominal 1-cent bank transaction to definitively prove parental responsibility. Why? Because the bank has already done the heavy lifting of verifying that adult's identity. Let's jump to Section 3, Enforcement and Common Mistakes, to see what regulators are actively looking out for. You know, a massive compliance failure happens when companies completely ignore the principle of data minimization. Imagine a company demanding a copy of a parent's actual passport just to let their kid play a basic mobile game. That's creating a brand new excessive privacy risk. Other super common mistakes include applying the age of 16 across the board without realizing a specific country lowered it to 13, or honestly just failing to retain the actual proof that the parent gave consent in the first place. If you don't have the proof, it never happened. All right, Section 4, test your privacy knowledge. Let's do some quick certification prep. For our first scenario, let's look at a business challenge involving a counseling service. A youth counseling app is offered directly to a 14-year-old. Does it need parental consent under Article 8? Option A, yes, always. Option B, no, preventive and counseling services are exempt. Option C, only if they pay. Or option D, yes, if the national age is 16. Think about it for a second. The correct answer is B. This is such a vital exception. Lawmakers wisely ensured that vulnerable kids seeking preventative counseling or psychological help aren't blocked by a parental notification requirement. If a teenager is reaching out for help, they absolutely shouldn't be forced to ask their parents for permission just to download a support app. Question 2 tackles a common tech scenario about age verification mechanisms. An app requires a 1-cent bank transaction to verify parental consent. Is this allowed? A, no, it's illegal. B, yes, it's a recommended high-risk verification method. C, only for children under 13. Or D, yes, but only in the EU. And the answer is B. This is absolutely allowed. It really highlights that data controllers must scale their verification efforts to match the actual risks inherent in their processing. A tiny bank transaction acts as a brief confirmation, allowing the platform to rely on the bank's strict identity checks instead of hoarding massive amounts of the parent's personal data themselves. Okay, question 3. Let's test your memory on the jurisdictional flexibility built into the GDPR framework. Under GDPR Article 8, what is the absolute minimum age a member state can set for digital consent? A, 12, B, 13, C, 14, or D, 16? You probably got this one. It's B. They cannot drop it below 13. What this means in practice is that cross-border services must carefully map out varying age limits across different European countries. If you have users in France, Germany, and Spain, you just can't apply a one-size-fits-all age gate if you want to perfectly align with their respective national laws. For our final question, let's address a massive regulatory red flag that authorities constantly look out for. A platform collects parent passports to verify consent for a low-risk mobile game. What principle does this violate? A, purpose limitation, B, data minimization, C, storage limitation, or D, accuracy? The answer is B, data minimization. The European Data Protection Board is crystal clear here. Your solution for proving compliance should never create a brand new, excessive privacy risk. You've got to always ensure the data you collect is adequate, relevant, and strictly limited to what is absolutely necessary for the purpose. All right, let's bring it all home with Section 5, Key Takeaways and Next Steps. These 5 points perfectly summarize the absolute core of Article 8, helping you balance child protection with practical business operations. First, the baseline age of digital consent is 16, subject to national variation down to 13. Second, parental authorization is an absolute must for minors using standard digital services. Third, Always scale your verification efforts to match your actual risk level. Fourth, fiercely protect the principle of data minimization. Never overcollect data just to verify an age. And finally, remember that counseling and preventive services are totally exempt to protect the child's well-being. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam or certification prep resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer time. This content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. Now, I'll leave you with this final thought. If a 12-year-old can bypass your multi-million-dollar compliance system just by clicking "I was born in 1990, are you truly protecting children, or are you just protecting your liability? Thanks so much for watching. Welcome to This Explainer. Today, we are tackling one of the absolute most critical, heavily enforced, and frankly dangerous sections of the entire General Data Protection Regulation, Article 9. If you or your organization process data, you absolutely need to know about this. Why? Well, because Article 9 deals with special categories of personal data. I want you to think of this data like it's radioactive material. It is so inherently sensitive that mishandling it doesn't just mean you're going to have a bad day at the office. It can lead to catastrophic fundamental rights violations for real people and massive business-crippling fines for the organization. So today, we're going to learn exactly how to handle this radioactive data safely. Here's a quick look at our roadmap. We'll start with a core rule, move on to real-world applications, cover some common regulatory mistakes, walk through a realistic scenario, test your knowledge, and wrap up with the big takeaways. All right, let's dive right into Section 1, the rule and the risks. We really need to establish the baseline for Article 9 because it completely sets itself apart from the rest of the GDPR framework. So, Article 9 defines what we call special categories of personal data. This includes information revealing racial or ethnic origin, political opinions, religious beliefs, trade union membership, and it also covers genetic data, biometric data used for ID purposes, health data, and data concerning a person's sex life or sexual orientation. As I mentioned just a second ago, think of this specific data as radioactive. Because the risks to an individual's fundamental freedoms are just so insanely high, the baseline rule here is incredibly strict. Processing this data is fundamentally prohibited. You literally cannot touch it, period. Well, unless you have the right clearance. To get that clearance, you need what we call the double key concept. It's kind of like a nuclear launch sequence. On the left side, for standard, everyday personal data under Article 6, you just need a single legal basis, like legitimate interest or performance of a contract. Boom, you're in. But on the right side, for our radioactive Article 9 data, that first key is simply not enough. To actually unlock processing, you need your standard Article 6 key plus a specialized radiation suit. That suit is a specific exception found in Article 9, Paragraph 2. Without both of those keys, your processing is completely illegal. Moving right along to Section 2, recitals and real-world applications. Let's look at these specific Article 9 exceptions and see what these radiation suits actually look like in practice. These are your specialized radiation suits. They're these strictly interpreted exceptions that actually allow you to bypass that general prohibition we just talked about. The most common one you'll see is explicit consent. And notice it says explicit, not just regular implied consent. Other exceptions include processing necessary for employment law, protecting someone's vital interests if they are physically incapable of consenting, establishing legal claims, or providing medical health care. But here's the catch. The European Data Protection Board is super clear that these exceptions are exhaustive. They must be interpreted strictly. You can't just make one up that kind of fits. Okay, this brings us to a massive trap that so many organizations fall into, and it was perfectly highlighted by a landmark ruling from the Court of Justice of the European Union, specifically case C252/21 involving Meta. The court basically said, hey, Article 9 applies not just to direct, obvious records like a medical file or a political party membership card. It also applies to seemingly normal, everyday data if it indirectly reveals or deduces sensitive information. If your algorithm pieces together normal data points to figure out someone's sexual orientation or health status, congratulations, you are now processing radioactive Article 9 data, and you absolutely need that double key. That's a perfect segue into Section 3, mistakes and regulatory focus. Let's examine the common compliance errors where organizations routinely get totally burned. Regulators do not mess around here. They penalize these mistakes aggressively. A huge failure we see all the time is a company scraping data from a private online group and claiming, oh, the user manifestly made it public. Yeah, no, that doesn't fly. Another one is video surveillance. Cameras capturing a political strike, you're processing political opinions now. What about financial data? A simple bank transaction paying trade union dues reveals union membership. Smart speakers capturing medical conversations in the background of someone's living room? That's health data. And the absolute biggest, most common mistake, trying to use performance of a contract as your Article 9 exception. It simply does not exist in the list. Let's put this into Section 4, Scenario Analysis. We're going to apply all this Article 9 theory into practice with a realistic, step-by-step mini case study. Okay, picture this. Step 1. A tech startup builds this really cool AI therapy chatbot to help users manage their anxiety. Step 2. To process the text inputs, they just write in their privacy policy that they're processing the data based on the performance of a contract to provide the chatbot service. Step 3. Let's do the GDPR analysis. As we just learned, this startup is heavily handling health data, so they just need an Article 6 basis, right? Actually, scratch that. That's the whole point. They remembered their first key, the contract basis, but they completely forgot their second key. Article 9 literally does not recognize contract as an exception, so they are currently processing radioactive data illegally. To fix this, they absolutely must gather explicit affirmative consent. All right, Section 5. Test your privacy knowledge. It's time to run through a rapid-fire interactive quiz with some certification-style scenarios to see if this is all making sense. Here is our first scenario. A company installs video surveillance outside a church. Does this automatically constitute processing of Article 9 data? Is it A, yes, always? B, no, but careful assessment is needed? C, yes, if capturing more than 10 people? Or D, no, religious data is not Article 9? Take a second to read this carefully. Does simply capturing an image of a building automatically process sensitive data? The correct answer here is B. According to EDPB Guideline 2019-03, while the building itself doesn't automatically trigger Article 9, the context and the potential to deduce religious beliefs require a highly careful risk assessment. If the camera's actual purpose is to track who attends services to infer their religion, then yes, you've crossed into Article 9 territory. Let's move to the next one. An online payment provider processes a user's annual trade union membership fee. How must they justify this processing? A, Article 6 legitimate interest only. B, Article 9 exception only. C, the double key, Article 6 basis, and Article 9 exception. Or D, trade union data is not special category. Think back to our earlier analogy for handling that radioactive data. Yep, the answer is C, beautifully demonstrating that double key principle. According to the EDPB guidelines on payment services, because a simple payment transaction directly reveals union membership, which is definitely a special category, you absolutely need both legal keys to unlock the processing. Just having an Article 6 basis is never enough here. Let's try question 3. A user posts about their personal health in a private online group. A data broker scrapes this data, claiming it is manifestly made public under Article 9(2)(e). Is this compliant? A, yes, it's on the internet. B, no, requires clear affirmative action. C, yes, if anonymized later. Or D, no, health data can never be public. Consider the exact wording and strict interpretation we talked about. The answer is B. Case C252/21 strikes again. The Court of Justice stresses that manifestly public is an incredibly high bar. It requires a clear, affirmative action by the user demonstrating their explicit intention to make that sensitive information accessible to the general public. Posting in a private group, even on the internet, definitely does not cross that threshold. Finally, let's look at the worst-case scenario, the financial consequences. Under Article 83, what is the maximum administrative fine for violating Article 9? Is it A, 10 million euros or 2% turnover? B, 20 million euros or 4% turnover? C, a mandatory ban on processing? Or D, 50,000 euro? It's B. And this just highlights that regulators treat the unauthorized handling of special category data with the absolute highest tier of financial penalties. A breach of Article 9 can cost an organization up to 20 million euros, or 4% of their total worldwide annual turnover, whichever is higher. They do not mess around. All right, Section 6, takeaways and next steps. Let's wrap up this explainer by locking in our most critical lessons. Here's what you need to remember. First, assume prohibition. Treat this information as radioactive data from the get-go. Second, always find your double key. You need your Article 6 basis and your Article 9 exception. Third, deduction counts. Indirect revelation of sensitive traits is treated the same as direct data. Fourth, literally never rely on a standard contract to process sensitive information. And finally, claiming data was manifestly made public requires meeting an incredibly strict, very high threshold of user intent. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks so much for joining me on this deep dive into Article 9. I'm going to leave you with this final thought to chew on. Look really closely at your systems today. Are you absolutely confident your organization's data flows aren't secretly radioactive? Think about it. I'll see you in the next explainer. Welcome back to Privacy Trainer, the series where we decode the General Data Protection Regulation, one article at a time. Okay, let's dive right into this explainer and tackle one of the most heavily guarded and honestly frequently misunderstood sections of the entire GDPR, Article 10. If you process data, you absolutely need to understand this, because getting it wrong, it doesn't just mean standard penalties, it means stepping into a literal regulatory minefield. Now, you might be wondering, why is this specific type of data treated with such extreme caution? Well, the answer is actually pretty simple, but it's profound. Mishandling criminal background data doesn't just result in administrative fines, it can literally destroy lives. When an organization improperly accesses, stores, or shares someone's criminal history, they risk causing irreversible reputational damage and severe social stigma. And that right there is exactly the problem Article 10 was built to solve. So here is our roadmap for today's masterclass. 1. Decoding Article 10. 2. Real world and regulators. And 3. Knowledge check and takeaways. Let's jump into Section 1, Decoding Article 10. Let's break down the core text of Article 10 and its supporting recitals into, plain English. The absolute crucial point here is that you cannot just process criminal background data on a whim. Even if you think you have a totally legitimate business interest, or even if you ask for consent, that's not enough. You absolutely must be acting under the control of an official authority, or you've got to have a very specific legal mandate from EU or member state law that provides appropriate safeguards. Oh, and the text adds one more massive restriction. Any comprehensive register of criminal convictions shall be kept only under the control of official authority, meaning private companies, you simply cannot build your own complete criminal databases. No exceptions. Now, here's a really fascinating distinction. Lawmakers actually debated including administrative sanctions in this highly protected category during the drafting of the GDPR, but they explicitly rejected it. So Article 10 strictly applies only to the criminal field. If a penalty is purely administrative, like say a parking ticket or a minor regulatory fine, it just doesn't trigger that intense fortress of protection that Article 10 demands. And we see this exact principle in action in the landmark ruling of CJEU Case C439/19. This case was all about the disclosure of Latvian road traffic penalty points. The court came out and clearly confirmed that because these road traffic offenses are classified as administrative under national law, they do not fall under Article 10. The word offenses in this article, it means criminal offenses exclusively. Moving right along to Section 2, Real World and Regulators. Let's compare 3 practical, everyday scenarios so you can see how this works in practice. First, imagine a tech company that wants to run criminal background checks on its platform users. Under Article 10, they can't just go ahead and do this because they want a safe platform. No, they must find a specific member state law that legally authorizes them to process this data. Second scenario, think of a small business trying to keep a private, comprehensive list of clients with criminal pasts to avoid bad deals. This is entirely illegal. Private, comprehensive registers are outright banned. Finally, any compliance failure here, meaning processing this data without that official authority, is going to lead to severe fines. Regulators view this as a totally unacceptable, high-risk violation of fundamental rights. So what are regulators actually looking for? Well, they commonly penalize organizations for a few specific misunderstandings. They are actively looking for companies blending administrative data with criminal data, or businesses trying to sneakily build private criminal registers. And they come down really hard on organizations that ignore the severe social stigma involved here. Actually, as highlighted in another major ruling, Case C136/17, unauthorized processing of criminal data constitutes a particularly serious interference with a person's private and professional life. Society judges criminal history really harshly, right? And regulators will protect data subjects fiercely because of it. Let's step through a quick mini case study to really cement this. Imagine a gig economy app where users hire each other for odd jobs. Step 1, the business challenge. The app wants to run criminal background checks to ensure user safety. Sounds reasonable, doesn't it? But step 2, the privacy issue is massive. Handling this data carries a huge risk of social stigma and discrimination. Which brings us to step 3, the GDPR compliance question they must answer. It isn't whether this is a good idea, but rather, is there an official authority or specific local law that explicitly authorizes us, a private company, to process this criminal data? If the answer is no, the project must stop immediately. End of story. All right, Section 3, Knowledge Check and Takeaways. Time to put you in the hot seat. Question 1. Think about this scenario-based question carefully. What exact scope of data triggers the strict protections of Article 10? Is it A, all legal data, B, administrative sanctions, C, exclusively criminal offenses, or D, civil lawsuits? And the correct answer is C, exclusively criminal offenses. As we explored earlier, the courts have repeatedly held that the legislative intent was to limit this enhanced protection strictly to the criminal field. Lawmakers deliberately kept administrative sanctions out during the drafting process. Moving on to question 2. Think about the immense power of holding a complete database of criminal histories. Who is actually allowed to hold this power? A, tech companies, B, data brokers, C, any employer, or D, official authorities? The answer is D. Private companies, I don't care how large or well-intentioned they are, cannot build comprehensive criminal registers. The GDPR reserves this immense power exclusively for official authorities, and that's to prevent mass profiling and discrimination by the private sector. Okay, let's look at question 3, which tests your understanding of the real-world harm this law prevents, based on case C136/17. Why is this enhanced protection necessary? Is it A, it takes up too much storage? B, it is liable to stigmatize the data subject? C, it is public record anyway? Or D, it is easy to hack? The answer is B. The court emphasized that society judges criminal history incredibly harshly. Unauthorized processing or public disclosure of this data can completely destroy a person's livelihood. It is a serious interference with their private and professional life. Finally, question 4. This applies our earlier case study directly to a practical scenario. If a company processes Latvian road traffic penalty points, do they need to comply with the heavy restrictions of Article 10? A. Yes, all traffic points are criminal. B. No, they are classified as administrative. C. Yes, if the driver is a commercial driver. Or D. No, because driving is a privilege. And the answer is B. Case C439/19 definitively separated administrative penalty points from criminal offenses. Because the traffic points in Latvia are administrative, Article 10 simply does not apply to processing them. To summarize our masterclass today, here are the core takeaways you really need to remember about navigating Article 10. First, you absolutely need official authority or a highly specific member state legal mandate to process this data. Second, it strictly applies to criminal offenses, not administrative signs. Third, its entire purpose is to prevent life-ruining social stigma. And fourth, comprehensive criminal databases are strictly 100% out of bounds for the private sector. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to really scale education to everyone. Now, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification prep resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available here, while privacyuni.com is designed for learners who prefer more structured learning experience. Disclaimer time. This content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes, so always consult your legal counsel for your specific compliance needs. I'll leave you with this final kind of provocative thought. As administrative data, like social scoring or complex penalty points, becomes more invasive and capable of causing deep social stigma, will the courts eventually be forced to expand what they consider criminal under Article 10 just to protect our fundamental privacy? Think about it. Thank you so much for joining me, and I'll see you in the next explainer. Welcome to Privacy Trainer. Today, we're jumping right into this explainer to tackle one of the absolute most misunderstood pieces of the GDPR, Article 11. If you're a privacy pro, a developer, or a business leader, you've probably felt the massive real-world headache this section of the law was actually built to solve. So I want you to think about this paradox for a second. Let's say you hold some data, like a random analytics identifier or a browser cookie, but you don't actually know the person's name or their real-world identity. Should you collect their government ID just so you can grant them their privacy rights? I mean, it sounds completely backwards, right? Why on earth would you demand a highly sensitive passport just to delete an anonymous cookie? And that brings us to Section 1, the Article 11 paradox, and how we balance privacy with data subject rights. We call this the minimization paradox. It's this super frustrating situation where trying to comply with the GDPR's rules on granting user rights could accidentally force you to violate its core rule of collecting as little data as possible. But here's the good news. Article 11 was built exactly to solve this balancing act. Specifically, paragraph 1 acts as a legal shield. Basically, if your processing doesn't actually require identifying the user, you are absolutely not obliged to acquire additional information just to comply with the GDPR. In plain English, it legally protects you from having to hoard unnecessary identification data just to prove you're compliant. You don't have to become some massive identity verification machine if your underlying business model doesn't actually need to know who people are. And this beautifully flows right into paragraph 2. So, if you receive a data access or deletion request, but you truly can't identify someone in your systems because, they're just a string of numbers to you, you actually don't have to fulfill the request. You just have to inform the user that you can't identify them. Those data subject rights simply don't apply unless the user steps up and provides the missing link, that additional information needed to securely find and verify their data. Lawmakers included this provision because, data minimization is a foundational core principle of the GDPR. You really shouldn't gather more privacy-invasive data like a real name or physical address just to process a privacy request for an anonymous user. That literally defeats the whole purpose of privacy. And the European Data Protection Board, or EDPB, views this as a vital safeguard. Article 11 is there to ensure that protecting rights doesn't accidentally mandate mass surveillance. Moving on to Section 2, let's look at some real-world practical scenarios involving tech, small business, and compliance failures. Applying Article 11 correctly makes a world of difference. For a big compliance success, imagine a clinic that minimizes data beautifully. They process purely pseudonymized health research data using unique participant codes. If a patient wants to opt out, the clinic just uses technical identifiers. They don't force anyone to provide a real name. But on the flip side, here's a massive compliance failure. An e-commerce site illegally forcing users to create a full account and give a birth date just to buy a guest item, all under the guise of managing user data for compliance. Completely backwards. The EDPB guidelines explicitly warn against this. Forcing users into accounts using deceptive designs doesn't protect them at all. Actually, it increases the risk of hackers taking over their identity, and it totally violates the data minimization principle that Article 11 explicitly protects. Creating an unnecessary honeypot of personal data is the exact opposite of what the GDPR intends. Next up is Section 3, Regulatory Focus and Traps, or in other words, what investigators actually look for. This table highlights what investigators scrutinize when they audit an organization. A massive, massive trap is demanding government ID to process a request for data that's tied only to a pseudonymous cookie. Regulators will absolutely penalize this kind of excessive data collection. The correct approach? Just use technical identifiers to fulfill the request. Another huge mistake is claiming pseudonymous data is fully anonymous. It's not. You still have to protect it as personal data. And finally, never ever collect names just in case you receive a GDPR request later. Collect only what is strictly necessary. And make no mistake, regulators will rely on case law to remind you of your limits. A great example is the landmark CJU case C604/22 involving IAB Europe. This case evaluates what actually constitutes identifiable data. It reminds us that if you have all the means reasonably likely to be used to single someone out, then that pseudonymous data is still personal data. Article 11 doesn't just give you a free pass to ignore data subjects if you actually have the reasonable means to identify them. You can't just play dumb. All right, on to Section 4, Case Study and Quiz. Let's test your Article 11 knowledge. Let's put you in the hot seat with a mini case study to see how well you can apply these legal concepts to a real-world business challenge. So imagine a scenario where a user browses a website entirely anonymously. Later on, they submit a data deletion request for their browsing history. The company totally panics, and the support team demands a passport copy to officially verify their identity before deleting the data. As we know now, they've completely failed the Article 11 analysis. This is a severe GDPR violation because they demanded highly sensitive data for absolutely no valid reason. Now, here is your certification-style question. Based on what we've learned, how should the site legally respond? A user asks a site to delete their analytics profile, and the site only has an IP address. Do you, A, ignore the request completely, B, demand the user provide their full name and email, C, inform the user they cannot be identified without additional information, or D, delete the entire analytics database immediately? Take a second to lock in your answer. Okay, the correct answer is C. Under Article 11, Paragraph 2, you simply inform the user you cannot identify them. You definitely don't ignore them, but you absolutely don't demand a passport either. This legally puts the ball right back in their court to provide the missing link if they truly want the request fulfilled. Finally, Section 5, Takeaways and Next Steps for Mastering Article 11. Excellent job on the quiz. Let's lock in your key takeaways from today's explainer. First, remember that Article 11 enforces genuine data minimization. Second, you should never collect additional personal data solely to comply with the GDPR. Third, if you genuinely can't identify a user, you must inform them of that fact. Fourth, you are not required to fulfill data subject rates without that additional identifying info. And lastly, pseudonymous data requires careful analysis, like we saw with KC 604/22. Ultimately, Article 11 is a super practical tool to reduce your risk footprint. Use it to champion data minimization, not as a sketchy excuse to avoid compliance. If you're enjoying these GDPR explainers and want to support the channel, consider becoming a member of Privacy Trainer. Your memberships genuinely help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our core mission is to make high-quality privacy knowledge accessible to everyone and to use AI to scale that education. Also, if you're looking for more structured privacy, security, or AI training, which includes guided learning paths, workshops, practice questions, and certification prep, you can explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available right here, while privacyuni.com is designed for learners who prefer a more structured, deep dive learning experience. Disclaimer time. This content is provided for educational purposes only and does not constitute legal advice, and the content might include mistakes. Thanks so much for joining me today. I'll leave you with this final thought. How will you apply the minimization paradox to your own organization today? See you in the next explainer. So picture this for a second. You're trying to figure out exactly what a company is doing with your personal data. You click on their privacy policy, and instantly you are just slammed with a 50-page wall of dense, completely unreadable legal jargon. It's incredibly frustrating, it's confusing, and honestly, it kind of feels like it's designed to make you just give up and hit accept. Well, here is the secret. Under the General Data Protection Regulation, or GDPR, that kind of intentional confusion is actually a massive compliance failure. Welcome to Privacy Trainer. In today's explainer, we are breaking down Article 12 of the GDPR, which is literally the ultimate antidote to privacy legalese. Let's dive in. Here's a quick look at our roadmap for today. We'll start with the transparency bridge, move into translating Article 12, check out some real-world applications, look at enforcement in cases, do a quick certification quiz, and wrap up with our key takeaways.
All right, Section 1, the transparency bridge.
Think of Article 12 as a bridge. See, everyday people have these incredibly powerful rights under the GDPR. You know, the right to access their data, delete it, correct it. But what happens if that bridge collapses? Well, without transparency, data subjects are left completely in the dark, and all those robust user rights are basically trapped on an island, totally nullified by confusing legalese. And for an organization, this isn't just bad customer service. It's a fundamental compliance failure that opens the door to massive risks and severe regulatory enforcement. So getting transparency right is truly the absolute bedrock of your GDPR compliance. Moving on to Section 2, translating Article 12. Let's go ahead and convert that dense legal text into plain English. The actual wording of Article 12, Paragraph 1, says the controller must provide information in a concise, transparent, intelligible, and easily accessible form using clear and plain language. Okay, so what does that actually mean in the real world? Well, it aligns perfectly with Recital 58. Write like a human being, not a lawyer. If a user literally needs a law degree to understand your privacy notice, you are actively violating Article 12. Simple as that. Now, transparency isn't just about how you speak to people, it is very much about how fast you react. Paragraph 3 establishes a strict ticking clock. When you receive a data subject request, say someone asking for a copy of their data, you have exactly 1 month to respond. That's the absolute standard rule. You can extend this by 2 further months, but only if the request is highly complex or if you're dealing with a massive volume of requests. And here's the kicker. You still have to inform the user about that delay within that very first month. No exceptions. But what happens if you get an access request from an email address you just don't recognize at all? Paragraph 6 gives us a really simple 3-step solution. First, you receive the request. Second, you figure out if you have what the law calls reasonable doubts concerning their identity. And third, you request additional information to verify them. But remember, the core principle of data minimization here, folks, you only ask for the absolute minimum necessary information to prove who they are. All right, Section 3, real-world application. How does all this theory actually play out on the ground? Well, let's look at 3 scenarios. A modern tech company might use these fully automated self-service portals where users can instantly download their data. That's highly efficient and totally compliant. A small business, on the other hand, might not have fancy automation, but they manually reply within that 1-month deadline using a friendly plain text email. You know what? That is also perfectly compliant. But our third scenario is a compliance failure. This is an organization that straight up ignores requests or hides its contact info behind layers of deceptive design and dense legalese. Building on that failure, let's rapid fire some of the most common and dangerous mistakes organizations make. Number 1, charging fees just because a user asked a question. That's a huge no. Information must generally be provided for free. Number 2, missing that strict 1-month deadline. That is just an easy way to get fined. Number 3, using confusing legal jargon, which we know violates the very core of Article 12. And my personal favorite, asking for excessive ID. Seriously, if someone just signed up for your digital newsletter with an email address, you absolutely cannot demand a copy of their government passport just to let them unsubscribe. It's totally disproportionate. Let's move to Section 4, Enforcement and Cases. So how do the highest courts actually evaluate this? Well, in case C487/21, the Court of Justice of the European Union ruled that the whole purpose of Article 12 is to ensure the data subject fully understands the information sent to them. The regulators demand true comprehension. They aren't looking for just technical, box-ticking compliance where you bury the truth in paragraph 40 of a legal document. They want the user to actually get it. And what about charging money for all this work? In another landmark ruling, case C307/22, the CJEU clarified paragraph 5. The general rule is crystal clear. All communications and actions regarding data rights must be completely free of charge. The only exception allows a reasonable fee if the request is manifestly unfounded or excessive, like if someone is making the exact same request every single day. But here is the massive catch. The burden of proof always falls squarely on the controller. You have to prove they are abusing the system. Time for Section 5. Let's do a quick certification quiz to test what we've covered. Here is your first scenario. A user requests their data. The company relies on an automated system, but due to a massive backlog, it takes 35 days to send the reply. Is this compliant? A, yes, because automation allows for technical delays. B, yes, 35 days is well within the 2-month extension limit. C, no, the standard absolute deadline is 1 month. Or D, no, because requests must be processed via paper forms. Take a second to think about it. If you guessed C, you are absolutely right. Under Article 12, Paragraph 3, the controller must provide information on action taken without undue delay, and in any event within 1 month. 35 days misses that strict ticking clock, regardless of any internal system issues you might be having. Okay, let's try another one. A controller receives a 5th identical access request in just 2 weeks from the exact same user. What can the organization do here? A, just ignore it completely. B, call the data protection authorities to report them. C, charge a reasonable fee bearing the burden of proof that it's excessive. Or D, delete the user's data permanently to stop the requests. And the correct answer is C, under Article 12, Paragraph 5. This is a textbook example of a repetitive excessive request. The controller is absolutely allowed to charge a reasonable administrative fee or even refuse to act, but they firmly bear the burden of proving that the request was indeed excessive. You definitely cannot just hit delete out of frustration. All right, final question. A company publishes a privacy notice that is 50 pages long, filled with dense traditional legal jargon. Does this comply with Article 12? A, yes, as long as it contains all the legally required facts. B, no, because it must be concise and use clear, plain language. C, yes, because corporate lawyers mandate this style. Or D, no, because the GDPR states notices must be exactly 1-page maximum. The answer is B. Article 12, Paragraph 1 explicitly mandates that information must be concise, transparent, intelligible, and in clear and plain language. As the CJU has confirmed, simply hiding the facts in a maze of legalese directly violates the core principle of transparency. Let's wrap things up with Section 6, Key Takeaways. Here's what you absolutely need to remember from this explainer. First, be truly transparent. Write for humans in clear, plain language. Second, always respect that ticking 1-month response clock. Third, never charge fees as a default. This information is free unless you can explicitly prove a request is manifestly excessive. And finally, always verify identity if you have reasonable doubts, but only ever ask for what you actually need. So I'll leave you with this provocative thought. If a regular, everyday customer looked at your organization's privacy notice today, would it pass the plain English test? Or would they need to call their lawyer just to understand it? If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale that education. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and certification prep resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available right here, while privacyuni.com is really designed for learners who prefer a more structured, comprehensive learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. Thank you so much for joining me on this explainer, and keep practicing good privacy.
Okay, let's jump right into this explainer. Today, we're breaking down why Article 13 is absolutely the ultimate transparency requirement under the GDPR. Look, whether you're a privacy professional, a business leader, or you're just dipping your toes into compliance, you already know that trust is literally everything. But what actually happens when organizations fail to tell users exactly how their data is being used? Well, that is exactly what Article 13 addresses. You can think of it as the absolute front door to privacy. If you get it right, you're building a compliant, trustworthy relationship from day one. Get it wrong, and well, you're staring down the barrel of regulatory fines and a complete breakdown in user trust. So let's decode this whole thing together.
Here is our roadmap for today. We'll start with 1, Article Overview, then move into 2, the Walkthrough, 3, Real-World Rules, 4, Mini Case Study, 5, Knowledge Check, and wrap up with 6, Takeaways.
Section 1, Article Overview, the right to be informed.
So the absolutely crucial point here is that this article acts as that front door we just talked about. It requires you to be completely 100% transparent the very moment a user hands over their data. And that applies whether they're filling out a form, signing a contract, or just clicking a submit button on your website. It's really the embodiment of the principle of fairness. Lawmakers specifically included this because, let's be honest, for a very long time, data collection happened completely in the dark. Users had absolutely no idea who was taking their information and what on earth they planned to do with it. Article 13 forces that conversation out into the open, right at the starting line.
Section 2, the Walkthrough, Unpacking the Requirements.
Now, what's really interesting here is this exact checklist. This is the information you must provide to users, and you have to do it in plain English so they are never left guessing who holds their data or why. You have to clearly state your identity, the specific purpose of the processing, and your exact legal basis, things like consent or legitimate interest. You also need to explain who else gets to see this data, how long you're actually going to keep it, and you must remind the user of their rights, like the right to access or delete their data. This is absolutely not just a suggestion, it's a strict legal recipe you have to follow.
Section 3, Real-World Rules and Examples.
To see how this plays out, we can look at the Barra case, which brilliantly illustrates a massive compliance failure. In this situation, Romanian tax data was being shared with health insurance funds without telling the citizens at all. The European Court stepped in and ruled that this completely violated the fundamental right to be informed. It really proved a massive point. Even governments and public bodies cannot skip their Article 13 duties. It's simple. If you're going to process and share someone's data, you must tell them first. You absolutely cannot rely on behind-the-scenes administrative protocols.
Now, to avoid some really common enforcement mistakes, we have to clearly distinguish Article 13 from Article 14. This is a huge stumbling block for so many organizations. Article 13 is all about direct collection. So you ask me for my email and I give it to you. Article 14, on the other hand, is indirect collection, like if you go out and buy a list of emails from a data broker. The rules, the timing, and the exemptions change entirely depending on which of these two articles applies to your situation.
We can actually see how this plays out in a fascinating recent example, the body camera ruling in case C422/24. Basically, a transport company tried to argue that filming a passenger with a body camera might not be direct collection, since the passenger isn't actively handing over any data to them. But the court wasn't having it. They confirmed that filming someone on public transport is absolutely a direct collection of data from them, meaning Article 13 applies immediately. The degree of activity by the user really doesn't matter. If you are pulling data straight from their person or their behavior, it is direct collection.
Section 4, Mini Case Study, Step-by-Step Analysis.
Okay, let's put this into practice. Imagine a retail app wants to collect background location data to send users nearby store offers. That's our challenge. The privacy issue here is that background location is highly sensitive, and obviously it's being collected directly from the user's device. So the big compliance question is, when exactly do we show the privacy notice? Well, the proper legal analysis dictates that they must present the Article 13 information at the exact moment the data is first obtained. You simply cannot bury this in some massive privacy policy tucked away in a settings menu. You need a just-in-time notice popping up right as the app requests those location permissions.
Section 5, Knowledge Check. Test your privacy skills.
Let's see how well you've got this down. Question 1 focuses on the source of the data, which, as we discussed, is a really common point of confusion for privacy professionals trying to draft compliant notices. Take a quick second to think about the difference between direct and indirect collection we just went over.
And the correct answer is B, Article 14. Because the company didn't get the emails directly from the individuals themselves, Article 14 applies. It perfectly demonstrates the critical difference in the data's origin. Listen, if you bought it, if you scraped it, or if it was gifted to you by a third party, you are operating under Article 14, which brings its own specific timeline for when you must notify the user.
Moving on to question 2. This one tests the exact timing required by the regulation. It's a metric that regulators fiercely evaluate during enforcement actions. So, are you allowed to wait? Do you get a grace period?
The answer is C. The law is incredibly, unapologetically clear here. The exact moment you collect the data from the user, that transparency obligation triggers immediately. not tomorrow, not within a month, at the exact time of collection.
All right, question 3 looks at exemptions. These are so often misunderstood and frankly wrongly applied by businesses trying to cut corners on their compliance. Which of these allows you to skip showing an Article 13 notice? And the correct answer is B. Unlike Article 14, which actually has a few exceptions like disproportionate effort, Article 13 is incredibly strict. It only gives you a pass if the person already possesses the exact information about your processing. For instance, if an existing customer just updates their address in their portal, you don't need to force them to read the entire privacy policy all over again, assuming nothing else about the processing has changed.
Okay, our final question ties the article text back to the crucial recitals in CJEU case law regarding how we actually communicate with users, because it's not just about what you say, it's about how you say it.
The correct answer is C. You simply can't hide behind a massive wall of legal jargon. As the courts confirmed in case C-75722, the principle of fairness absolutely demands clear and accessible communication. If your privacy notice requires a law degree to decipher, it is fundamentally failing its core purpose under Article 13.
Section 6, Takeaways and Next Steps.
Let's quickly wrap this up with your main takeaways. Number 1, direct collection triggers immediate transparency. Number 2, you must present the checklist of information right at the time of collection. Number 3, you absolutely must translate legalese into plain, accessible English. And finally, number 4, remember that the law leaves virtually no room for exemptions. The only way out is if the user already has the information.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience.
Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. But I do want to leave you with this final thought to ponder today. When a user visits your website or opens your app for the very first time, is your privacy notice actually informing them, or is it just confusing them? Thanks for learning with me today, and stay compliant out there.
Ever wonder how a company got your details when you know for a fact you never gave them out? Well, welcome to this explainer on GDPR Article 14. Today, we're going to follow the invisible data trail to understand exactly what happens when organizations collect your personal information from somewhere other than you. This article is all about dragging the invisible processing of data right out into the light. And getting it wrong, well, that can lead to massive compliance failures and a complete loss of consumer trust. We've got a really packed agenda today. We'll be covering 1. Uncovering indirect data collection. 2. Decoding the Article 14 rules. 3. Real-world scenarios and exceptions. 4. Regulators and case studies. And finally, 5. Our privacy trainer knowledge check. Let's get right into it. Section 1. Uncovering indirect data collection. To start things off, we really need to understand the fundamental difference between data you hand over willingly and data that's being gathered behind the scenes. Seriously, how did this company get my information? If you've ever asked yourself that exact question, you've experienced the precise problem that Article 14 of the GDPR was designed to solve. When data is collected directly from you, Article 13 applies. But what about indirect collection? Imagine a local gym buying a list of fitness enthusiasts in the area just to send out promotional mail. The gym didn't get that data from the individuals, right? They bought it from a data broker. That is exactly where Article 14 steps in. It exists to guarantee that you aren't kept in the dark just because a company didn't talk to you face-to-face. And this brilliantly illustrates the distinction. As confirmed in the recent CJEU case C422/24, the only relevant criterion separating Article 13 and Article 14 is the source of the data. The courts are basically looking at whether it was obtained directly from you or indirectly from a third party. That simple dichotomy shapes absolutely everything we're about to discuss. Moving on to Section 2, Decoding Article 14 Rules. What's genuinely fascinating about this next section is how the law forces controllers to take this hidden processing and expose it. When an organization gets your data in directly, they absolutely cannot keep it a secret. They must proactively tell you who they are, what categories of data they have, why they have it, and who they're sharing it with. But crucially, and this is completely unique to Article 14, they have to tell you exactly where they got it from, even if it's from a publicly accessible source. A super common mistake compliance teams make here is being vague. You can't just wave your hands and say, oh, we got this from public sources. No way. You must name the specific source. You have a fundamental right to know who is handing out your information. So the crucial point here is the strict timeline. Controllers must provide this information within a reasonable period, but absolutely no later than 1 month. Why? Because lawmakers included this strict maximum deadline so companies can't just hoard your data in secret indefinitely. However, there's a catch. If they plan to use that data to communicate with you, they must provide the notice at the time of the very first communication. Or if they plan to disclose the data to another recipient, they have to provide notice before that first disclosure. You literally cannot just sit on the data for 29 days if you're already actively emailing the subject or selling their data off to a third party. Section 3. Real-world scenarios and exceptions. Of course, there are times when tracking down every single person to tell them you have their data just isn't feasible, which brings us to the exemptions. Under Article 14, Paragraph 5, exceptions apply if you actually already have the information. Companies are also exempt if a specific law mandates the collection or if it's protected by professional secrecy. But the absolute most debated exception is when providing notice is truly impossible or requires a disproportionate effort. If we look at Recital 62 of the GDPR, it clarifies that this disproportionate effort exception often applies to historical, statistical, or scientific research. But regulators are strict here, You can't just throw your hands up and claim it's too hard. You have to prove it, document it, and provide alternative safeguards. Section 4, Regulators and Case Studies. Let's see how all this plays out in the real world by looking at how the highest courts in Europe interpret these rules and where organizations commonly fail. Okay, this is a massive regulatory perspective to keep in mind. In the landmark ruling CJEU case C16923, also widely known as the Mosty case, the court clarified a major misconception. If a tech company or a bank uses your existing data to generate brand new profiling data about you, think like a new behavioral score or a risk profile, that newly generated data is actually considered indirectly obtained. It triggers Article 14. You must inform the data subject about the new data you created behind closed doors. This is a huge area where enforcement agencies evaluate compliance during their investigations. Let's walk through a mini case study involving a real business challenge. A scientific research firm scrapes public data to study societal trends. They have names, sure, but absolutely no email addresses or contact info for millions of people. Attempting to track down millions of individual contacts, that is a classic disproportionate effort. As European Data Protection Board guidelines point out, they can use the exemption, but they must still implement safeguards. So what's the solution? Well, they are required to publish the privacy notice publicly on their website so that transparency isn't entirely lost. Section 5. Privacy Trainer Knowledge Check. Okay, it is time to put all this theory to the test with 4 certification-style questions designed to check your practical understanding. Question 1. A transit authority equips ticket inspectors with body cameras that record passengers. Which GDPR transparency obligation applies? Is it A, Article 14, because the camera is a third-party device? B, Article 13, because data is collected directly from the subject? C, neither, as public spaces are exempt? Or D, Article 14, because the passengers didn't give consent? Take a second and think back to our discussion about the source of the data and how the courts view physical recording. The correct answer is B. According to the recent CJEU case, C422/24, body camera footage is obtained directly from the data subject through observation. Even though a physical device is used, the source is the person themselves, so it falls squarely under Article 13, not Article 14. Question 2. A bank generates a new internal credit risk score for a customer based on data provided by a third-party credit agency. Which article governs the new score? A, Article 13, B, Article 14, C, Article 15, or D, no notification is required. Consider the regulatory perspective we just discussed regarding data that a controller generates themselves. The answer is B. As established in the Mosty case, case C169/23, data generated by the controller itself in the performance of its tasks is legally treated as not obtained from the data subject. This internally created profile triggers Article 14 notification requirements. All right, question 3. A marketing company buys an email list from a data broker. When must they provide the Article 14 privacy notice to those individuals? A, within 6 months. B, only if the individual requests it. C, within a reasonable period, max 1 month, or at the first communication. Or D, before they purchase the list. Remember that strict timeline we mapped out earlier for indirect data collection? The correct answer is C. Article 14, Paragraph 3 is very, very clear. You have a maximum of 1 month to notify them. But if you email those people tomorrow, the notice must be included in that very first email. And finally, question 4. An anti-money laundering law explicitly requires financial institutions to collect specific indirect data and prohibits them from tipping off the subject. What happens to Article 14? A, the institution must notify the subject anyway.
B. The institution can ignore the GDPR entirely. C. The exemption in Article 14, Paragraph 5C applies. Or D. The institution must ask the data broker to notify them. Think about how the GDPR handles conflicts with other binding member state laws.
The answer is C, because the obtaining of the data is expressly laid down by a law which provides appropriate measures to protect legitimate interests. The controller is exempt from the notification obligation under Article 14.
To sum up our explainer today, here are your absolute key takeaways. Whenever you process the invisible data trail, you must prioritize transparency, including explicitly revealing the data's exact source. You absolutely must honor the strict 1-month timeline, and please remember that internally generated insights count as indirect data. Finally, while exemptions like disproportionate effort do exist, regulators require them to be interpreted restrictively and backed by incredibly strong documentation. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam or certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is really designed for learners who prefer a more structured learning experience. Finally, a quick disclaimer. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thank you so much for joining me today. I'm going to leave you with this final, slightly provocative thought. As AI continues to generate more and more invisible data about all of us, will Article 14 actually become the most important privacy right we have? See you in the next explainer. Welcome to the Explainer. Today, we're diving deep into one of the most consequential and honestly one of the absolute most misunderstood pieces of the General Data Protection Regulation, Article 15, the right of access. Now, you might be wondering, why should you even care about this? Well, whether you're a privacy professional, a business leader, or just someone trying to wrap your head around your own digital rights, Article 15 is literally the beating heart of data transparency. It's designed to solve a very fundamental problem. We're talking about the massive power imbalance between giant organizations holding mountains of personal data and the everyday individuals that data actually belongs to. And let me tell you, when organizations misunderstand this article, things go south really quickly. We're talking massive operational bottlenecks, a complete loss of consumer trust, and of course, those significant regulatory fines. So today, we are going to unpack exactly what the GDPR's right of access actually means. We'll use clear, structured insights, and we're going to break down all that dense legal jargon into plain, everyday English. Let's get into it. Okay, so here's our blueprint for today. We'll cover the right to know, unpacking Article 15, real-world scenarios, common traps and enforcement, a quick knowledge check, and finally, how to continue your privacy journey. Let's start with Section 1, the right to know, focusing on data transparency. Imagine this. It's 4:55 p.m. on a Friday afternoon, and your organization gets an email from a user. But they don't just want to know what their basic account settings are. No, they demand to see absolutely everything you know about them. Every single click, every inferred preference, every third-party vendor you've ever shared their data with, pure panic sets in, right? It's like a giant puzzle. This scenario brilliantly illustrates the massive operational headache that organizations face every day. But here's the good news. Understanding Article 15 is the exact solution you need to navigate this challenge smoothly. It gives you the legal boundaries and the step-by-step operational requirements for answering that exact Friday afternoon email without losing your mind. Moving right along to Section 2, unpacking Article 15, taking it from legal text to plain English. So at its core, Article 15 gives individuals a multi-layered right. First off, you actually have to confirm whether or not you're processing their personal data at all. If you are, then you must provide access to that data. But you can't just hand over a file and call it a day. You also have to provide the context. What's the purpose of you processing it? How long you're going to keep it? And what are the user's rights? Now, to really understand why lawmakers included this whole shebang, we have to look at Recital 63 of the GDPR. You can think of recitals as basically the director's commentary for the law. Recital 63 clearly states that the overarching goal here is to empower data subjects to be aware of and essentially verify the lawfulness of the processing. It is not just about getting a document, it's about giving the user the actual tools to audit whether you're treating them fairly. For the longest time, a lot of companies thought that when a user asked who their data was shared with, they could just vaguely say something like, "Oh, our marketing partners," or "our IT vendors." But actually, scratch that. The Court of Justice of the European Union in case C-154/21, which involved the Austrian Post, totally changed the game. The court ruled that users don't just have to settle for vague categories anymore. They generally have the right to know the specific names of the actual companies receiving their data. You have to be as precise as possible, unless it's genuinely impossible to identify the specific recipients.
And that leads us to another absolutely crucial point. What does a copy of data actually mean? Well, in case C487/21, the CJEU clarified that providing a copy means delivering a faithful and intelligible reproduction of the data. You literally cannot just give a summarized general description. The court ruled that fulfilling this requirement might even mean providing full document extracts or even entire database exports, if that context is essential for the user to genuinely understand what's happening with their data.
All right, Section 3, Real-World Scenarios, looking at practical application.
Let's look at 3 quick, real-world examples. First up, imagine a tech company that provides a virtual voice assistant. Under EDPB guidelines, fulfilling an Article 15 request electronically with a standard PDF export of the user's voice logs is perfectly fine for access. Though, just as a quick side note, that wouldn't meet the stricter requirements for data portability under Article 20. Second scenario, let's say it's a local small business. If a customer walks into the shop asking for their loyalty card data, simply handing them a printed paper copy of their profile meets the standard completely. But look at the third scenario. This is a classic compliance failure. Ignoring a request just because your database is super disorganized or because your legacy systems are a nightmare to query is a guaranteed way to attract the attention of regulators. Operational messiness is for sure not a legal defense. Let's dive into a mini case study involving automated decision-making because this comes up all the time. Imagine a bank uses a sophisticated algorithm to deny a user a loan, and that user submits an access request. Step 1, you identify they are asking for profiling data under Article 15. Step 2, the bank understandably wants to protect its algorithm as a trade secret. So how do we balance this? Well, case C203/22 gives us the exact answer for Step 3. You don't have to hand over your proprietary source code, but you absolutely must provide meaningful information about the logic involved, like what parameters weighed heaviest in the rejection. And finally, Step 4, you always have to ensure that providing this copy doesn't adversely affect the rights and freedoms of others. You can't accidentally expose another customer's data in the process of answering this one.
Let's hit Section 4, Common Traps and Enforcement. Basically, where companies tend to stumble.
I'd say the most common misconception in the entire privacy world is thinking that if an access request takes 100 hours to compile, the company can just reject it as excessive. Nope. Regulators and courts have made it crystal clear in case C526/24 that operational difficulty does not strip a data subject of their fundamental rights. A request isn't legally excessive just because it's hard work for you. To legally refuse a request on these grounds, the controller bears the incredibly heavy burden of actually proving the request was made with an abusive intent. For example, proving the user is artificially trying to paralyze the company's operations, rather than genuinely wanting to verify their data's lawfulness.
Okay, Section 5. Time for a quick knowledge check to test your skills.
Let's see how much you've picked up. I'll read the scenario, give you a second to think, and then we'll review. Here's question 1. A user asks an online retailer who exactly their data was sold to. The retailer only lists marketing partners. Is this compliant? Option A, yes, categories are always enough. Option B, no, the user can demand specific recipients. Option C, yes, if the list is too long. Or option D, no, data cannot be sold. Think back to those recent court rulings regarding transparency that we just covered.
And the correct answer is B. As established by the CJEU in case C154/21, the courts require maximum precision. This means you must name the actual specific marketing partners if requested, unless you can definitively prove it's genuinely impossible to identify them. Vague categories just don't cut it anymore.
Moving on to question 2. A virtual voice assistant user requests their data electronically. The provider sends a standard PDF. Does this satisfy Article 15? Option A, yes, it's a commonly used electronic form. Option B, no, it must be machine readable like a CSV. Option C, no, they must send paper copies. Option D, yes, but only if they charge a fee. For this one, consider the subtle distinction between the right of access and the right to data portability.
The correct answer here is A. According to the EDPB guidelines on virtual voice assistants, a PDF is perfectly fine for simply showing the user their data under Article 15 because it is considered a commonly used electronic form. However, if the user had specifically requested data portability under Article 20, well, then you'd need a much more structured, machine-readable format like a CSV.
All right, let's try question 3. A bank uses automated profiling to deny a loan and claims their algorithm is a trade secret. What must they provide under Article 15? Option A, the full source code. Option B, nothing. Trade secrets block access. Option C, meaningful information about the logic involved. Option D, only the final credit score. Think about how we have to balance intellectual property with user privacy.
If you guessed C, you hit the nail on the head. Case C23/22 provides a really clear standard here.
You absolutely do not have to surrender your proprietary source code. But on the flip side, you can't just hide behind trade secrets to provide nothing. You have to explain the key parameters and the logic that led to the user's specific rejection so they can actually understand and potentially challenge the decision. Let's look at our final question. A user submits a complex first-time access request that's going to take a company 100 hours to compile. Can the company declare it excessive and refuse? Option A, yes, 100 hours is an undue burden. Option B, no, unless they can prove abusive intent. Option C, yes, but they must charge a fee. Option D, no, but they can extend the deadline by a year. Think carefully about what truly defines an excessive request under the law. And the answer is B. Remember case C526/24. Operational difficulty, even if it takes 100 hours to do, does not make a request legally excessive. The controller bears the full burden of proving the request was made with a specific abusive intent. And let me tell you, that is a very high bar to clear. Okay, let's bring this all together. What are the main things you should take away from this? First, the whole point of access is to enable users to verify lawfulness. Second, a copy means a faithful, complete reproduction of the data, definitely not just a high-level summary. Third, users have the power to demand specific recipient names, not just broad categories. Fourth, you cannot reject a request as excessive just because it's hard. You need hard proof of abusive intent. And finally, always balance the access request against the rights and freedoms of others. Section 6. Continue your privacy journey and your next steps. If you enjoyed these GDPR explainers and would like to support the channel, please consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone. Now, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, and certification prep, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. As a quick reminder, disclaimer, this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. Thank you so much for learning with me today. Understanding these rules isn't just about compliance. It's about respecting the very real individuals behind the data. Which leaves us with one final thought to ponder. Does true data ownership even exist if we don't know who holds our digital reflection? I'll see you in the next explainer. Welcome back to another Privacy Trainer Explainer. We're breaking down the GDPR article by article. Today, we're diving straight into Article 16, which is all about demystifying your fundamental human right to digital accuracy. Honestly, if you've ever had a company, or worse, a government agency, get your personal details completely wrong, and you felt that total frustration of trying to fix it, well, you already know exactly why this specific piece of legislation matters so much. It's a real game changer. Here's our quick roadmap for today. First, we'll unpack the right to rectification itself. Then we'll look at enforcement and a real-world case study. After that, we'll test your knowledge, and finally wrap things up with some key takeaways. So ask yourself this, what actually happens when the algorithm gets you wrong? Just imagine the real-world consequences of, say, a facial recognition system or some automated algorithm flagging you incorrectly. What problem does this article actually solve when your digital identity, floating around in a database somewhere, simply doesn't match your physical reality? I mean, we're talking about consequences ranging from a minor, annoying billing error all the way to being wrongfully detained by law enforcement. That massive gap between digital fiction and real-world fact is exactly the problem Article 16 was written to solve. Section 1. The right to rectification. Let's get right into it. Let's look closely at what the law actually requires from organizations. The text literally states that the data subject, that's you, has the right to obtain from the controller the rectification of inaccurate personal data without undue delay. The absolutely crucial point here is that this isn't just about fixing a typo. It is a strict, active obligation. And, backed up by Recital 59, organizations have to make this process incredibly easy and totally free of charge. You absolutely cannot put someone's right to digital accuracy behind a paywall or some endless administrative maze. No way. This brings us to the two completely distinct operational realities of Article 16. You're basically dealing with two different scenarios here. First, we have inaccurate data, which means there's a flat-out factual error. Your job as a controller is to erase that falsehood and replace it with the actual truth. Then, on the flip side, we have incomplete data. This is slightly different, right? Because sometimes a fact is technically true, but it's missing vital context. In that case, Article 16 gives individuals the right to require completion. You're basically adding a supplementary statement to flesh out an incomplete truth. It's kind of like finding the missing piece of a puzzle. So how does this actually look in the wild? Well, take facial recognition technology, for example.
A huge misconception is that algorithms somehow don't need manual correction. But the reality, straight from the European Data Protection Board, is that you must aggressively correct stored FRT data and system outputs if someone is wrongly categorized. Now, what about a local small business? The trap there is thinking you can just batch update customer records whenever it's convenient for you. Nope. The reality is it must be done without undue delay, period. And when it comes to compliance failures, if a company decides to tweak data just to meet business targets, like, say, artificially adjusting hospital waiting times to look better for an audit, that is considered a massive, severe violation of the accuracy principle. Moving on to Section 2, enforcement, and a really interesting case study. You know, when regulators come knocking, they're looking way past just simple, honest mistakes. They're hunting for negligence. They're going to ask, did you fail to apply technical updates in a timely manner? Did you trade personal data for marketing as opted in without actually checking if those permissions were accurate in the first place? And they come down incredibly hard on deliberate deception, like we just talked about, amending data to give a misleadingly positive impression. Ultimately, what regulators really want to know is this: are your data accuracy routines actually being used by management, or are they just gathering dust in some forgotten policy folder? Okay, let's walk through this fascinating mini case study. It's the European Court of Justice, case C247/23, and it perfectly balances the need for public register accuracy right up against administrative overreach. Here is how it played out. Step 1, an individual requests to rectify their gender identity on a public register. Step 2, the controller pushes back and actually demands proof of gender reassignment surgery to make the change. Step 3 is the big legal question. Does this extreme evidentiary demand violate GDPR Article 16? Well, Step 4 brings us the answer. The court ruled that while controllers can definitely ask for relevant, reasonable evidence to maintain a reliable register, mandating proof of surgery as a standard administrative practice is completely unlawful. It literally violates the very essence of the fundamental right. All right, Section 3, let's test your knowledge. Time to see what we've learned. Let's see how you'd handle this real-world scenario. A customer's profile is factually correct, but it completely lacks their new secondary email address. Under Article 16, what is the appropriate action here? Is it A, delete the profile entirely? B, provide a supplementary statement to complete the data? C, demand legal proof of the email? Or D, refuse the request because the primary data is technically accurate? And the correct answer is B. Taking into account the purposes of the processing, Article 16 explicitly grants the right to have incomplete personal data completed, using supplementary statements. You don't go and delete what's already true. You just add the missing pieces to complete the whole picture. Next question. Thinking back to case C247/23 about that public register, what can a controller lawfully require when a data subject requests rectification of their gender identity? Is it A, absolutely no evidence can be requested? B, proof of gender reassignment surgery? C, relevant and sufficient evidence reasonably required to establish the inaccuracy? Or D, a sworn affidavit from a medical board? If you guessed C, you hit the nail on the head. The court ruled that while you can, of course, ask for reasonable evidence to ensure the register is reliable, because let's face it, public records do need to be accurate, making it conditional on a highly invasive procedure like surgery is a strict, absolute violation of the GDPR. Okay, let's look at this from an enforcement angle now. According to EDPB penalty guidelines, which of the following is treated as a severe compliance failure when it comes to data accuracy? A, amending data to give a misleading positive impression. B, a minor technical glitch that delays an update by one single day. C, asking a user to verify their identity before making a change. Or D, allowing users to self-service their profile updates. The correct answer is A. Regulators heavily penalize the intentional manipulation of data. It so blatantly violates both Article 16 and the core Article 5 principle of accuracy. I mean, look, simple mistakes happen, but deliberate deception, that is a massive glowing red flag for supervisory authorities. All right. Last question for you. If a law enforcement agency's facial recognition technology system wrongfully categorizes a person as a suspect, what must the controller actually do under the right to rectification? A, wait for an annual database review. B, correct the stored data and FRT systems accordingly without undue delay. C, only correct the paper file but leave the algorithm alone. Or D, just notify the vendor to handle the request. And the answer is B, because FRT systems pose such severe, literally life-altering risks to individuals, controllers have got to be hyper-vigilant. You absolutely cannot just pass the buck to some vendor or wait around for a yearly review. You must correct both the specific stored data and the system outputs immediately. No excuses, no undue delay. Which brings us to Section 4, our key takeaways and wrap-up. So here are the absolutely essential things to remember from today. First, you've got to act without undue delay. Second, really know that operational difference between fixing what is factually wrong and completing what is just unfinished.
Third, make sure you facilitate these requests easily and entirely free of charge. Fourth, yes, you can definitely ask for reasonable evidence, but please do not overreach into people's private lives. And finally, remember that accuracy isn't a one-and-done deal. It's a continuous, ongoing obligation deeply tied to Article 5. You have to actively keep that data up to date.
Hey, if you're enjoying these GDPR explainers and want to support the channel, definitely consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the globe. Our mission is simple: make high-quality privacy knowledge accessible to absolutely everyone, and use AI to scale that education far and wide. Also, if you happen to be looking for more structured privacy, security, or AI training, we're talking guided learning paths, workshops, practice questions, and great exam prep resources, you can explore privacyuni.com. Basically, Privacy Trainer focuses on making this knowledge freely available right here on YouTube, while privacyuni.com is perfectly designed for learners who prefer a deeper, more structured learning experience. Just one final thought before you go. Ask yourself, if a regulator walked in and audited your systems today, would they find an active, ongoing commitment to the truth or just a messy database full of assumptions? Really think about that. Quick disclaimer, this content is provided for educational purposes only. It does not constitute legal advice, and the content might include mistakes. Thanks so much for following along, and I will see you in the next explainer. All right, let's dive right into this explainer on GDPR Articles 17. You probably know it as the right to be forgotten. Today, we're going to explore exactly what happens under the hood when someone clicks delete on their personal data. I mean, it sounds super simple, right? But legally and technically, it is genuinely one of the most fascinating mechanisms in modern privacy law. So, why should we care about this article? What problem is it actually solving in a world where tech is gobbling up our data on a completely unprecedented scale? Well, think about it. We constantly hand over our personal info globally, and our digital footprints feel virtually permanent. Article 17 gives you and me the power to reclaim control. It effectively lets us tell an organization, hey, you no longer have the right to hold my story. But, as you'll see, that power is definitely not absolute.
If organizations mess this up, things go south fast. I mean, if a company just ignores a valid request, they're staring down severe administrative fines and a massive, massive loss of user trust. On the flip side, if they panic and just delete everything automatically without thinking, they might unlawfully destroy data they were legally required to keep, like tax records, or they might fail to balance the public's right to information. Getting these boundaries right is absolutely crucial.
Okay, here's our flight path for today's explainer. 1. The right to erasure. 2. Scope and legal recitals. 3. Real-world application. 4. Enforcement and case study. 5. A quick privacy knowledge check. And finally, 6. Takeaways and next steps.
Let's kick things off with Section 1, the right to erasure, power and limits. Notice the tension here. On one side, Article 17, Paragraph 1 lists out exactly when a controller absolutely must delete data without undue delay. This kicks in if the data is no longer necessary, if it was unlawfully processed, or if a user simply withdraws their consent. But look over at the other side. Article 17, Paragraph 3 gives us exceptions where you can, or sometimes even must, keep the data. This covers situations where retaining data is necessary for freedom of expression, complying with a legal obligation, or establishing legal claims. So it's a constant balancing act. Moving right along to Section 2, Scope and Legal Recitals, Interpreting the Law. So, translated into plain English, Recital 65 basically tells us that privacy isn't absolute. It explicitly states that the right to be forgotten is there to stop unlawful retention, but it puts that right squarely next to freedom of expression. We actually saw this play out perfectly in CJEU case C136/17, where a search engine had to weigh an individual's right to erasure, especially regarding sensitive data, against the public's legitimate right to access information. The law doesn't exist in a vacuum, it exists in a shared society. And to put that into perspective, search engines process millions of these delisting requests every single year. Next up, Section 3, Real-World Application, Article 17 in Practice. Let's make this concrete with 3 real-world scenarios. First, imagine a user withdraws consent from a tech app. The outcome? The app has to delete the profile data immediately. Simple as that, because there's no other legal basis to keep it. Second scenario. A former customer tells a small business to delete their purchase history, but national tax law says the business has to keep financial records for 7 years. In this case, the business is going to reject the request for that specific data, relying on the legal obligation exception. And finally, a classic compliance failure. An organization ignores a valid objection to marketing. Because ignoring that objection makes any ongoing processing completely unlawful, Article 17 kicks in hard, demanding immediate erasure. Let's talk about where people trip up. A massive misconception is that organizations can just ignore or reject requests without doing their homework. No way.
According to the EDPB guidelines, the burden of accountability always falls on the data controller to prove an exception applies. Another huge mistake is causing what we call click fatigue. The EDPB warns that if you bombard users with these overly complex consent pop-ups, it completely diminishes the warning effect and leads to invalid consent. And here's the kicker. If the initial consent was invalid, keeping that data becomes unlawful, which triggers an automatic obligation to erase the whole shebang. That brings us to Section 4, Enforcement and Case Study, the Regulatory Perspective. Okay, imagine a software developer contacts a major research institute. The developer recently changed their first name and asks the institute to delete their old name from a historical software development log, saying it violates their private life. How do we handle this? Well, step 1, verify the identity. Step 2, check the grounds for the request. Step 3, assess exceptions. In this case, the institute might rely on the Article 17, Paragraph 3 exception for historical and scientific research, but they have to prove it. They must determine if deleting the name would seriously impair their research objectives. If retaining that exact historical record is strictly necessary to show who built what at a given time, then they can formally notify the developer that the request is rejected under that very specific exception. All right, Section 5, it's time for our privacy knowledge check to test your understanding. Question 1. A user objects to processing under Article 21. What happens to their data under Article 17, Paragraph 1c? Is it A, kept indefinitely? B, erasure is granted unless the controller proves overriding legitimate grounds? C, only deleted if the user pays a fee? Or D, transferred to a third party? Think carefully about the relationship between a user's right to object and their right to erasure. Also, keep the recent Schufa case, C2622, in mind. Got your answer? If you guessed B, you hit the nail on the head. This brilliantly illustrates a core GDPR mechanic. The EDPB explicitly states that if an objection is valid under Article 21, a related erasure request under Article 17 has to be granted by default. The burden of proof to keep the data rests entirely on the controller's shoulders. Question 2. An organization receives an erasure request but claims they need the data for scientific research under Article 17, Paragraph 3d. How must they apply this exception? A, broadly, B, restrictively, showing it's strictly necessary, C, only with consent, or D, they can't use it. How easy is it for a company to just use this exception to get out of deleting data? The correct answer here is B. The absolutely crucial point is that exceptions are not free passes. Regulators demand that exceptions, like scientific or historical research, be interpreted very restrictively. Controllers bear the heavy burden to prove that erasure would render impossible or seriously impair their specific research objectives. Moving to question 3, based on the famous Google Spain case C131/12, do search engines process personal data and fall under erasure rules? A, no, they just index. B, yes, they are controllers. C, only if they create the content. Or D, no, they're exempt. How does the law apply to the vast aggregation of internet data when the search engine didn't even write the web page? The answer is B. The Google Spain case established that even though search engines merely index third-party sites, organizing and aggregating that data significantly affects a person's fundamental right to privacy. That makes them data controllers, placing them firmly under the obligations of Article 17 to assess dereferencing requests. Last question. If an organization accidentally retains unlawfully processed data, what's their obligation under Article 17, Paragraph 1d? A, anonymize it eventually. B, erase it without undue delay. C, keep it for archiving. Or D, ask for retrospective consent. What is the absolute bottom line for data that shouldn't have been processed in the first place? And the correct answer is B. As confirmed in recent case law, there are 0 shortcuts here. If the initial processing lacked a valid legal basis, meaning it was unlawful from the jump, the data must be purged as soon as possible without undue delay. You simply cannot retroactively fix it by asking for consent after the fact. Finally, Section 6, Takeaways and Next Steps. Final review. Let's wrap this up. Always remember, while individuals hold immense power to request the erasure of their digital footprint, controllers must carefully and systematically balance those requests against strict legal and public interest exceptions. If you take away anything from today, let it be this. The right to be forgotten is not just a magic automatic delete button for the internet. It is a legally rigorous framework where the burden of proof always falls on the organization holding the data. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer.
Memberships help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale that education globally. Also, if you're looking for more structured privacy, security, or AI training, stuff like guided learning paths, workshops, practice questions, and certification prep, you can explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available, while privacyuni.com is really designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. Now, I'm going to leave you with one final thought. When you look at the data you manage every single day, what parts of your digital footprint are you leaving entirely up to chance?
So picture this. You've got a furious customer demanding that you delete all of their data immediately because they claim it was collected unlawfully. Your absolute first instinct is probably to just hit the delete button and be done with it, right? But wait. What if they actually need that data preserved to sue someone? Or what if you need time to investigate their claim before just wiping the records? If you just delete it right away, or worse, if you keep processing it as normal, you could face some massive regulatory fines. Welcome to this explainer on GDPR Article 18. We're going to look at the exact solution to this very specific and very common problem.
We have a seriously packed playbook for today's explainer. We're going to cover the basics of Article 18, the specific legal triggers, some practical real-world examples, enforcement pitfalls to avoid, and then we'll wrap up with a quick certification-style knowledge check.
All right, let's jump right into Section 1, Understanding Article 18 Basics. I like to call this the data limbo state. Let's see where this unique concept actually fits into the broader GDPR framework.
This right here is the core problem Article 18 solves. What do you do when a user disputes their data, but you literally cannot just delete it? Think of Article 18 as acting as a crucial, legally mandated pause button. It sits right between normal everyday data processing and outright data deletion. Under the GDPR, data subjects absolutely have the right to erasure, we know that. But they also have this highly specific right to simply freeze things in place while a conflict is being resolved.
By definition, the right to restriction of processing allows data subjects to temporarily halt active processing. It limits the data strictly to storage. Now, the biggest takeaway here is that restriction is fundamentally different from erasure. You do not destroy the data. You keep it, but you completely lock it down. Once this restriction is applied, with the exception of mere storage, you can only process that data with the user's explicit consent, or for legal claims, or maybe for the protection of another person's rights, or for reasons of important public interest. Otherwise, active processing effectively comes to a dead stop.
Moving on to Section 2, the legal triggers and recitals. When exactly are you forced to hit that pause button?
Well, the GDPR doesn't leave this up to guesswork. There are 4 highly specific triggers that dictate exactly when a user can demand this data freeze. First, if they say their data is inaccurate, you freeze it while you verify the truth. Second, if the processing is unlawful, but the user actually opposes erasure. The Court of Justice of the European Union really highlighted this in case C60/22. Sometimes a user wants unlawful data kept as evidence rather than destroyed. Third, if you don't need the data anymore, but the user needs you to keep it for their own legal claims. And finally, if they formally objected to your processing, you have to pause everything while verifying if your legitimate grounds override theirs.
Now, you might be wondering, how does a legal pause actually work inside a complex IT department? That's exactly where Recital 67 comes in. It tells us that restriction shouldn't just be an administrative promise, like telling your team, hey, don't touch this file. It actually has to be baked into your systems by technical means.
In plain English, this means you need an operational mechanism. Think of it like an automated digital quarantine zone. You need this to ensure nobody on your team accidentally uses that disputed data in a marketing campaign or sales outreach. If you have an automated filing system, the restriction must be enforced technically, so the data cannot be changed or subject to further operations. It needs a massive, clear indicator in your system saying this data is entirely off limits.
Let's get into Section 3, real-world practical examples, and how we apply these rules at scale without breaking our operational workflows.
I love this comparison because it brilliantly illustrates that whether you're running massive server farms or just have a single filing cabinet in the back room, the core principle of isolation remains exactly the same. A large tech company might build a literal automated toggle in their database that routes restricted data to a separate secure server tier where marketing simply has zero access. A small business, on the flip side, might literally take a physical paper file out of the active drawer and lock it in a cabinet, or maybe just temporarily hide and password protect a specific row in an Excel spreadsheet. Both approaches perfectly achieve the goal.
But here is where organizations really stumble. It's a classic compliance failure. Imagine a marketing firm properly restricts a user's data while they investigate a dispute. Awesome. They figure out the issue, they resolve it internally, and then they just quietly flip the switch back on and start emailing the user again. This is a massive failure. Article 18 explicitly requires controllers to inform the data subject before lifting the restriction. You simply cannot unpause without giving them a heads up first. On to Section 4. Enforcement, mistakes, and a mini case study. Let's see where things go wrong in the eyes of the regulators.
When regulators come knocking, they will absolutely demand evidence of your technical measures. A major misunderstanding we see is treating restriction exactly like erasure. They are entirely different workflows. Regulators look heavily for data protection by design under Article 25. Your systems must be built from the ground up to handle this specific pause state. They also frequently penalize companies that fail to notify their downstream recipients. Under Article 19, if you restrict data, you have to tell the third-party vendors you shared that data with to restrict it too. And finally, processing restricted data for any active reason outside of the very tight exceptions is just a direct, immediate violation.
Let's bring this to life with a quick step-by-step case study. A customer submits a fiery support ticket claiming their billing address in your system is completely, wildly wrong. The immediate privacy challenge here is that you cannot keep using that potentially false data while you investigate. The correct analysis is to apply Article 18 because the accuracy is contested. So you trigger your technical restriction, isolating that billing record. Once your team finally verifies the correct address and updates it, you must notify the user first, and only then can you lift the restriction.
All right, we've reached Section 5. It is time to test your privacy knowledge with 4 certification-style, scenario-based questions. Let's see how you do. Question 1. A user disputes the accuracy of their address in your system. While you verify it, you apply Article 18. What is the only normal processing activity you can do with that data without their explicit consent? Is it A, marketing, B, storage, C, profiling, or D, sharing with third parties? Think about what the pause button actually means. And the answer is B, storage. Under Article 18, Paragraph 2, mere storage is the baseline allowance. Everything else active, like marketing or profiling, is strictly off-limits unless you have their consent or a legal defense requirement. Question 2. An individual discovers a company collected their data unlawfully, but instead of deletion, they need it preserved for a pending lawsuit. Which specific GDPR provision gives them this exact right? A, right to erasure, B, Article 18.11b, C, right to portability, or D, Article 18.11a. Remember that CJU case we mentioned earlier? The correct answer is B, Article 18.1b. The user is totally in the driver's seat here. They are actively choosing to preserve evidence of the unlawful processing rather than letting the company just destroy it to hide their tracks.
Question 3. A cloud service restricts a user's data. According to Recital 67, what is a valid method for them to enforce this in their automated database? A, asking staff verbally to ignore it. B, temporarily making it unavailable via technical means. C, deleting it completely. Or D, printing it out and deleting the digital copy. The answer is B, temporarily making it unavailable via technical means. Regulators want to see systems design, not just good intentions. Verbal instructions or sticky notes simply don't cut it. You have to prove technical isolation.
Final question. You've successfully finished verifying the accuracy of a user's disputed data, and you've updated it. What must you legally do right before you resume normal processing? A, delete the original. B, pay a processing fee. C, inform the data subject that the restriction is lifting. Or D, notify the local data protection authority. This is that trap we talked about.
And the answer is C, inform the data subject. Transparency has to be maintained at the end of the process too. You cannot just quietly flip the processing switch back on without giving them a heads up.
All right, let's wrap this up with some key takeaways. Article 18 is your mandatory pause button for disputed data. It requires verifiable technical isolation, and you always have to notify the user before lifting that restriction. Now, if you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education globally. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, practice questions, and certification prep resources, definitely explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available here, while privacyuni.com is designed for learners who prefer a much more structured experience. Quick disclaimer, this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. I'll leave you with this one final thought to chew on. If a user can test their data tomorrow morning, exactly how will your organization technically prove to a regulator that it successfully hit the pause button? See you in the next explainer. Hey everyone, welcome back to another explainer. So today, we're tackling what I like to call a massive blind spot in privacy compliance. You know, most organizations think that when a user asks to have their data deleted, simply hitting that delete button in their own database means the job is entirely done. But under the General Data Protection Regulation, well, that is really only half the story.
Today, we are unpacking GDPR Article 19, which introduces the hidden and honestly fascinating complexities of what happens after you delete or change user data. So get ready because we're looking closely at the downstream flow of data.
All right, here's our roadmap for today. We'll be looking at the right to notification, some real-world scenarios, exceptions and enforcement, a mini case study, a quick knowledge check, and finally, key takeaways and support. Let's jump right in.
Section 1. The right to notification, or as it's often known, the ripple effect.
Okay, let's dive into this. I really want you to think of this whole legal concept like a ripple effect. Imagine you drop a heavy stone into a pond. The impact doesn't just stay in that one place, right? It flows outward. Well, data works the exact same way. Imagine a user submits a valid request to have their account deleted. Your IT team wipes their profile from your primary servers and boom, everyone breathes a huge sigh of relief. You're compliant, right? Actually, wrong. If you share that data with marketing agencies, cloud analytics providers, or payment gateways, you have a massive compliance blind spot if you stop at your own servers.
Let's look at the exact text of GDPR Article 19. It states, the controller shall communicate any rectification or erasure to each recipient to whom the personal data have been disclosed. So what does this actually mean? It means your legal obligation absolutely doesn't end at the edge of your own internal network. Lawmakers included this specifically to ensure user rights are fully respected across the entire data ecosystem. The law literally forces you to track down every single downstream partner who received that data and tell them to update or delete it too.
So here's the chronological life cycle of that data ripple. Step 1, the user actually exercises their right. Step 2, you, the controller, execute that deletion or correction locally. But Step 3 is where Article 19 really kicks in. You've got to accurately identify all third-party recipients of that specific data. And then Step 4, you must proactively notify those recipients of the change. It's basically a physical process of legal ripples spreading outward through your entire vendor ecosystem.
Moving right along to Section 2, real-world scenarios and scaling compliance.
Now, the GDPR applies to everyone, but how you handle this ripple effect scales very differently depending on the size and tech of your organization. Here we're contrasting two totally different worlds. For a tech giant, Article 19 compliance is usually handled straight through code. When a user deletes their profile, their central system sends automated API triggers to all connected downstream vendors, like marketing platforms or data brokers, telling them to instantly purge the record. But look at the local business on the right. If a small shop owner corrects a customer's billing address, Article 19 might literally just mean manually sending an email to their external accountant to make sure the invoice goes to the right place. The law is exactly the same for both, it's just the execution that scales with the business.
Section 3. Exceptions in enforcement. Let's talk about the boundary conditions.
Now, what's really interesting about this slide is a vital ruling from the European Court of Justice, case C154/21. You see, regulators aren't totally disconnected from reality, but there are some incredibly strict boundaries here. Article 19 has a second sentence that gives users a very powerful tool. If they ask, you must tell them exactly who those recipients are. The court reinforced that the data subject absolutely has the right to be informed of the specific identities of those downstream vendors. So, you can't just wave your hands and say, oh, we told our marketing partners. Nope. You have to name names if the user demands it.
So the crucial point is how regulators actually view exceptions to this rule. Article 19 says you must notify recipients unless this proves impossible or involves disproportionate effort. But what does that really mean from an enforcement perspective? Well, according to European Data Protection Board guidelines, a totally valid exception might be if your paper archives were literally destroyed in a flood. It's physically impossible to know who is in them. But claiming, hey, we have a messy IT system, or we just have too many vendors to keep track of, yeah, that is a classic compliance failure. Regulators absolutely do not accept bad infrastructure as an excuse for disproportionate effort. All right, Section 4, mini case study. Let's explore the downstream dilemma.
Let's move to this scenario and see how this builds. Put yourself in the shoes of a privacy professional advising an e-commerce company that uses a cloud-based CRM. A customer realizes their email address is misspelled in your system. Under Article 16, they request rectification. So, Step 1, you fix it in your CRM. Step 2, the system logs the change. Now, Step 3, because your CRM automatically syncs with an external marketing vendor to send out newsletters, Article 19 requires that your system pushes that newly corrected email address directly to the vendor. See, Article 19 isn't just about deletion. It applies equally to fixing inaccurate data so that mistakes don't just keep echoing around the internet forever.
Section 5, Knowledge Check. Let's test your privacy knowledge.
Okay, put on your privacy professional hats for a minute. Let's see how well you can apply these rules. Question 1. You successfully delete a user's account from your main database, but you completely fail to notify your downstream analytics provider to do the same. Which GDPR article is directly breached by this failure to notify? Is it A, Article 15, B. Article 17, C. Article 19, or D. Article 20?
And the answer is C, Article 19. Remember, deleting your own copy satisfies Article 17, which is the right to erasure. But actually communicating that erasure down the chain, that is the explicit duty created by Article 19.
Awesome, let's try question 2. Under what strict boundary conditions can a controller legally skip notifying downstream recipients under Article 19? Is it A, always, B, if it proves impossible or involves disproportionate effort, C, if it has a high cost, or D, if the user remains silent and doesn't ask?
The correct answer is B. You can only skip this if it literally proves impossible or involves a disproportionate effort, just like that EDPB example of the flooded paper archives we talked about. Simply having a high cost or a super messy tech stack doesn't let you off the hook for sure.
Ready for question 3? A user writes to a controller and asks exactly which specific vendors were notified of their data deletion. Must the controller provide those specific names? A, no. B, only if a data protection authority asks. C, yes, or D, only for marketing vendors?
The answer here is C, yes. As we just saw with case C154/21, the law explicitly guarantees the data subject's right to know the specific identities of the recipients. Total transparency is mandatory if the user demands it. All right, final question, checking how this whole shebang interconnects. Article 19's notification obligation is triggered by which other specific GDPR rights? A, access, B, portability, C, rectification, erasure, and restriction, or D, automated decision-making?
And the answer is C. Article 19 is a really targeted mechanism. It specifically isolates and connects to Article 16 for rectification, Article 17 for erasure, and Article 18 for restriction of processing. It ensures that when those specific rights are exercised, the results echo properly throughout the entire network.
Which brings us to Section 6, Key Takeaways and Concluding Article 19.
Let's rapidly distill all of these complex rules into some actionable advice you can literally take back to your organization today. Number 1, deletion or rectification always triggers that ripple effect. 2, notifying your downstream vendors isn't just a nice-to-have, it is a mandatory legal obligation. 3, users absolutely hold the power to demand the specific names of the recipients you shared their data with. And 4, bad IT infrastructure is never, ever a valid excuse for claiming disproportionate effort. You've got to know where your data flows.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Now, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Before we wrap up, I want to leave you with this provocative thought. If you don't know exactly who you are handing your users' data to today, how can you possibly take it back tomorrow? Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks so much for joining me, and keep learning.
All right, let's jump right into it. Today, we're mastering one of the most empowering, yet honestly, most frequently misunderstood tools in the entire GDPR. We're talking about Article 20, the right to data portability. Listen, if you get this wrong, you're not just dealing with an annoyed user. You are literally looking at massive regulatory fines and a completely failed compliance audit. So in this explainer, we're going to dig into what this rule actually means, how it plays out in the real world, and exactly how you can ensure your organization stays compliant without completely tearing your IT infrastructure apart.
Think about it for a second. Have you ever felt completely trapped by a digital service? You know the feeling. Maybe it's a music app, a cloud storage provider, or even a fitness platform. You really want to switch to a competitor, but the thought of manually rebuilding your entire profile, your history, your playlists is just exhausting, right? We've all been there. You're stuck in what the tech industry calls vendor lock-in. And that exact frustration, that invisible fence keeping consumers trapped, is the exact problem Article 20 was built to destroy. It's all about empowering users with genuine control over their own digital lives. So here's our game plan for this explainer. First, we'll break down the legal text, which is the anatomy of Article 20. Next, we'll look at real-world applications. And finally, we will wrap up with a professional-grade certification check.
Okay, Section 1, the anatomy of Article 20. Let's see how this law builds a bridge between consumer rights and data mobility.
So the absolutely crucial point to understand here is that this right doesn't apply to everything under the sun. The GDPR states that a few specific conditions have to be met. First up, the processing has to be based on either the user's consent or a contract you have with them.
You might be wondering, why are legal obligation and public interest left out? Well, lawmakers didn't exactly want citizens porting their police records or their tax files over to private tech startups. It's designed for commercial mobility, not government records. Second, the processing has to be automated, so no, you cannot demand that a competitor's physical paper filing cabinets be shipped across town. And third, it applies specifically to personal data that the data subject actively provided. You're empowering users to take the digital data they handed over to you and securely bring it somewhere else.
Now, a whole lot of privacy professionals and developers completely mix this up with Article 15, the right of access. But the distinction is absolutely vital. Article 15 is all about transparency. It's your right to look at what a company knows about you. And honestly, they can hand that over in a flat PDF or a printed letter and be fine. Article 20, though, that is about reuse and mobility. The data has to be given to you in a format that you can effortlessly plug right into a competitor's software. So think of it like this. Access is about looking at your data. Portability is about packing your data up and moving it to a new home. Honestly, so many well-meaning companies get fined because they think a PDF satisfies Article 20. It definitely doesn't.
Now, what's really fascinating is how the lawmakers had to balance these rules. If we look at Recital 68 of the GDPR, it gives us some vital context. It says companies should be encouraged to develop interoperable formats. See, lawmakers really wanted to foster competition, but they also knew that forcing every single startup out there to build identically coded databases would completely crush innovation. So crucially, the recital explicitly states that this doesn't create an obligation for companies to maintain processing systems that are perfectly compatible with each other. The law desperately wants systems to talk to each other, but it's not going to force every company on Earth to build identically mirrored software just for the sake of data transfers.
To actually make that transfer happen, the law strictly requires data to be in a structured, commonly used, and machine-readable format. What does that actually mean in plain English? It means you need to use file types like CSV, JSON, or XML. If you try to hand a user a scanned JPEG image of their account history, sure, a human being might be able to read it, but a competitor's computer system, it cannot easily identify and extract that data at all. If you provide a flat, uneditable image file, you've completely failed your Article 20 obligations.
All right, Section 2. Let's take all these abstract legal concepts and drop them straight into the real world to see how they function inside actual organizations.
Let's bring this to life with a few scenarios. So you're a big tech company, like a music streaming app. You absolutely must allow users to export their saved playlists and listening history, usually in something like JSON format, so they can import it right into a rival app. But hey, it's not just for big tech. A small business, like your local coffee shop using a digital loyalty app, also has to let customers download their points history. And check out our compliance failure here. A fitness tracker company gives users their workout data as an uneditable PDF and then, get this, tries to charge them a €5 export fee. No way. That is a massive direct violation. In fact, European DPAs, like the Italian and Spanish authorities, have issued huge fines to telecom and fitness companies for doing exactly this. Providing locked PDFs or demanding admin fees. You simply must let users walk away with their data securely, in the right format, and completely for free.
So, where do companies mess this up? Here are the 3 traps organizations fall into most often. Trap number 1, withholding data because of an unpaid bill. The European Data Protection Board makes it crystal clear. You cannot block a portability request just because a user owes you money. Trap number 2, confusing raw data with inferred data. The Article 29 Working Party, in their WP 242 guidelines, explains that portability covers data the user provided, plus observed data, like their physical location or heart rate. But it does not cover the highly valuable proprietary inferences or algorithmic scores your company generated about them. And trap number 3, just claiming it's too hard. You are required to transmit data directly to competitors where technically feasible. You can't just throw your hands up and create artificial hurdles to slow the user down.
Now, when regulators come knocking, what exactly are they hunting for? They're actively looking for invisible walls built just to keep users trapped. They will aggressively check for deliberate delays or administrative fees meant to deter users. They'll verify your file formats. They're definitely going to audit your security because, transmitting personal data out of your secure environment directly over to a competitor carries real risk, and you've got to use proper end-to-end encryption. And lastly, they want to see that you're actually explaining this right to the users before they hit that delete account button. Let's walk through a mini case study so you can see exactly how this is done properly. Imagine a user wants to switch streaming platforms. Step 1, verify their identity. You absolutely do not want to hand a user's entire digital history over to an imposter. Step 2, scope the data. You collect their provided profile info and their observed listening history, but you intentionally leave out the proprietary algorithms that recommended specific songs to them. Step 3, secure transmission. You transmit that data directly to the competitor's API using strong end-to-end encryption. This step-by-step process is exactly how a privacy pro should analyze and execute a request.
Section 3, Certification Check and Wrap Up. Let's see how much you've absorbed. It is time to put your knowledge to the test. I've got 4 scenario-based questions to see if you can apply what we just covered like a true professional.
Okay,
Question 1. Read this scenario carefully and think back to the core conditions we discussed. A tax agency processing under a legal obligation gets an Article 20 request. Must they comply? Pause the explainer if you need a quick second to think.
And the answer is B. Because the tax agency is operating under a legal obligation, the right to data portability simply does not apply here. Remember, Article 20 is strictly tied to consent and contract. Financial data isn't inherently exempt. It's all about that legal basis. Awesome job if you caught that.
Moving right along to question 2. A smartwatch user requests their data. Think about the massive difference between the data the user actively provides or generates versus the data the company creates through its own intelligence. Which data must the manufacturer provide? Pause here if you need to.
The answer is B. The EDPB guidelines state that portability covers the data actively provided, like the email, and observed data, like the raw heart rate generated by the user's run. The raw data belongs to the user, for sure, but the company gets to keep the proprietary health predictions it algorithmically calculated.
Here is question 3. A user wants direct transmission, but the two companies use incompatible IT systems. Remember what we said about Recital 68 and technical compatibility? What is the controller required to do here? It's CSMCA. The law is strict, but it's grounded in reality, right? It's not going to force you to completely rebuild your IT infrastructure to match a competitor's. If it is just not technically feasible to build a secure bridge, you provide the data directly to the user in a machine-readable format and let them safely hand it over to the competitor themselves.
All right, let's tackle our final question. A user requests their portable data, but they owe the company €50 in unpaid fees. Does a business conflict override a fundamental data protection right? How should the company respond? Take a second.
The correct answer is A. An unpaid bill is purely a contract issue. It's not a privacy issue. You absolutely cannot hold a user's personal data hostage to settle a financial dispute. You've got to fulfill the portability request without hindrance and just chase down that €50 through your normal billing channels.
Great job on those scenarios. Okay, let's bring it all home. Consider this your ultimate cheat sheet for Article 20. Here are your key takeaways. First, Article 20 is all about empowerment and stopping vendor lock-in. Remember the specific triggers? It requires consent or a contract, and it has to be automated processing. Format is incredibly critical. Think CSV or JSON, definitely not flat PDFs. It covers the data the user provided and observed activity logs, but totally protects your company's inferred algorithmic data. And above all else, you must not build artificial fences to stop a user from leaving. Article 20 literally gives the user the freedom to securely pack up their digital bags and move on whenever they want to.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience.
Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks so much for joining me on this deep dive into Article 20. I want to leave you with a thought. As you build out your digital products and services, will you be the kind of organization that tries to trap its users or the kind that boldly empowers them? Keep protecting that data, and I'll catch you in the next explainer.
Welcome back to Privacy Trainer. Today, we're unpacking GDPR Article 21. You probably know it as the right to object. Now, in the massive world of data protection, we've got a whole suite of data subject rights, right? But honestly, very few are as universally relevant or as consistently misunderstood by organizations as this one. We are literally going to uncover the immense legal power behind the word no.
So think about this for a second. What actually happens when a citizen or a consumer demands an organization just stop processing their data? Does a simple, everyday request carry actual legal weight? And, maybe more importantly for us, what's going to happen if a business just decides to ignore them? Listen, if an organization misinterprets Article 21, they aren't just creating a terrible customer experience, they are putting themselves right in the crosshairs of massive regulatory fines and total compliance failures. Let's find out exactly why your no has some serious legal teeth.
All right, here is our roadmap for today's explainer. We'll start with the right to object itself, peek behind the legal text, look at some real-world applications, run through a quick case study, do a knowledge check, and finish up with our key takeaways.
Section 1. The right to object. Let's just kick things off with a high-level look at what Article 21 really is and where it sits inside the massive GDPR framework.
Okay, so the absolute most crucial point here is that this article acts as a vital safety valve. Just think about it. If a company is processing your data based on your explicit consent, well, you can just withdraw that consent, right? Easy. But what if they never asked you in the first place? What if they're relying on their own legitimate interests or maybe some public interest task to process your info? That's where Article 21 steps in. It gives individuals this incredibly powerful mechanism to challenge and potentially halt that processing whenever their own personal privacy outweighs whatever the organization is trying to achieve. Moving on to Section 2, behind the legal text. Let's actually walk through the wording and translate all this dense legalese into plain, everyday English. Now, this perfectly illustrates what I like to call the Great Divide in Article 21, because you see there are two completely different flavors of the right to object. On the one hand, we've got the qualified right. This is for general processing. If you object here, the organization actually has a chance to fight back. They can run a balancing test to see if their operational needs somehow override your privacy. But look at the flip side. That is the absolute kryptonite of direct marketing. If somebody objects to their data being used to market to them, the processing has to stop immediately. Period. No arguments, no balancing tests, literally zero exceptions. And to really grasp how to apply this in the real world, we've got to check out the GDPR recitals. These are kind of like the director's commentary that helps us interpret the law. Recital 69 makes it crystal clear. The burden of proof falls entirely on the organization, the data controller, not the individual. So if a user says, hey, stop processing my data because of my specific situation, that user does not have to go out and hire a lawyer to prove their case. The controller has to do all the heavy lifting to prove they have a truly compelling reason to keep going.
All right, Section 3, Real-World Applications. Let's see how all this theory actually plays out in reality, especially when regulators get involved and where companies just keep tripping up.
You know, regulators look at these rules very, very strictly. A super common mistake? Tech companies treating a marketing opt-out like it's some polite 30-day customer service request instead of an absolute legal mandate. Not good. Plus, the European Data Protection Board in Guideline 2024-01 made it known that a company's excuse to reject an objection has to be genuinely compelling, not just, convenient for their bottom line. And get this, in a recent Court of Justice ruling, case C654/23, the court decided that even a highly educational newsletter absolutely counts as direct marketing if it slips in links to paid subscriptions. The takeaway? Your no has to be honored.
Section 4. Case study time. Let's put this knowledge to the test with a totally realistic scenario pulled right from the EDPB's Guideline 2019-03, which is all about video devices.
This step-by-step breakdown is awesome because it shows the balancing test in action. Imagine a local convenience store puts up some security cameras to stop vandalism. They're basing this on their legitimate interest to protect their property. Now, a citizen walks by, decides they don't want to be recorded, and formally objects. Who wins that fight? Well, the citizen's objection isn't an instant victory. Since this falls under general processing, the store has a window to legally document why their security needs, like maybe they've had a severe history of break-ins, override that one person's privacy. If they can successfully prove those compelling legitimate grounds, they get to keep the cameras rolling. If not, they have to stop processing that individual's data.
Section 5, Knowledge Check. Okay, it's time to see how well you've absorbed all this with 4 quick certification-style questions.
Here's question 1. A tech company receives an objection to targeted advertising, but they genuinely believe they have a strong legitimate interest to just keep doing it. What must they do? A. Conduct a balancing test. B. Stop processing immediately. C. Ask the user for more details. Or D. Charge a fee to process the opt-out. Take a second to think about it.
And the correct answer is B. Stop processing immediately. Remember, because targeted advertising falls squarely under direct marketing, Article 21(2) kicks in as an absolute right. That balancing test we just talked about, it completely vanishes. The company has to stop processing that user's data for marketing purposes right then and there, unconditionally and absolutely free of charge.
Moving on to question 2. When a data subject objects to general data processing under Article 21, who exactly bears the burden of proof? Is it A, the data subject, B, the supervisory authority, C, the controller, or D, the processor?
The correct answer is C, the controller. We covered this with the recitals, right? It is always up to the controller to prove they've got a compelling reason to keep processing. The individual just has to object based on their particular situation. They absolutely do not have to write a thesis proving that their privacy outweighs the company's entire business model.
All right, question 3. This is a big one for compliance. According to Article 21(4), when must the controller explicitly notify the user about their right to object? A. Within 30 days. B. At the latest at the time of first communication. C. During the annual privacy audit. Or D. When the data is erased.
The answer is B. You absolutely cannot bury this right down in paragraph 42 of some massive unreadable privacy policy. Article 21 specifically states that the right to object has to be brought to the user's attention clearly, completely separately from everything else, and at the very latest, at the exact time of your first communication with them. And our final question, question 4. Under that recent CJEU case C654/23 is an informative daily newsletter that happens to have commercial links considered direct marketing. A. Yes. B. No, because it is primarily informative. C. Only if sent to a purchased list. Or D. Only if the user complains.
The correct answer is A. Yes, the court ruled that even if the main content is super educational or informative, the second you embed a commercial purpose, like slapping in links to promote a paid subscription, it magically transforms into direct marketing. And remember the golden rule? The exact moment it becomes direct marketing, the user is granted that absolute right to just say no.
Finally, Section 6, Key Takeaways. Let's wrap up this explainer with the absolute most critical points that you need to remember and apply to your own compliance programs.
Look, if you take literally nothing else away from today, please remember the Great Divide. Article 21 demands that you know exactly when you're allowed to perform a balancing test for general processing and when you are dealing with direct marketing and just have to stop processing instantly. Always keep in mind that the burden of proof is sitting squarely on your shoulders as the controller, and you've got to make this right incredibly clear at your very first interaction with the user.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And, hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience.
Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Keep learning, stay curious, and we'll see you in the next explainer.
Imagine applying for a loan or a job, and within milliseconds of hitting submit, you get an email. You're rejected. No human ever looked at your application. A purely automated system, relying entirely on hidden data points, determined your eligibility in the blink of an eye. For companies deploying these systems, the temptation to automate everything is huge, but the risks are concrete. Blindly trusting an algorithm to make high-stakes choices without oversight invites regulatory intervention and compromises the relationship with every person in that dataset. Looking at the official title page of the General Data Protection Regulation, we find the legal framework built to stop that exact scenario. Article 22. It explicitly prevents purely automated systems from making significant decisions about people without a safety net. Article 22 acts as the structural balance between two forces, the push for algorithmic speed and the requirement for human accountability. It ensures that as the data economy accelerates, the person at the other end of the screen isn't lost in the math. If a solely automated decision produces a significant legal effect, the GDPR puts up a hard stop. You can only bypass this via contract, law, or explicit consent, but you must always guarantee the user's right to human intervention and to contest the decision. And if the system uses special categories of personal data, like health information, political opinions, or genetics, the rules are even stricter. You generally cannot base automated decisions on this sensitive data at all without explicit consent or a substantial public interest. This legal structure means you cannot treat human review as an afterthought. Organizations must design human oversight directly into their technological architecture from day one. What exactly counts as a significant effect? Looking at Recital 71 of the GDPR, the text gives us concrete examples: an automatic refusal of an online credit application or e-recruiting practices. If it affects your money, your livelihood, or your legal status, it qualifies. When someone is rejected, simply telling them the algorithm said no is a compliance failure. The law grants users the right to an explanation. They need meaningful information about the logic involved and why the machine made that choice. Compare an AI resume scanner that automatically trashes applications to an automated system that schedules delivery shifts. The resume scanner triggers Article 22 because it denies employment. The scheduling app usually doesn't cross that significant effect threshold. A common trap companies fall into is the token human defense.
They assign an employee to blindly rubber stamp algorithmic recommendations without reviewing them. If the human has no real authority or time to change the outcome, the decision is still legally considered solely automated. This brings us to a major piece of case law. Looking at this court document analyzing the Schufa ruling, we see a German credit agency that used automated processing to generate credit scores. They argued they were just providing a probability value, not making the final decision to deny a loan. The Court of Justice of the European Union fundamentally disagreed with that defense. They ruled that if a bank relies heavily on that third-party score to make its lending choice, the generation of the score itself qualifies as an automated decision. This ruling proves data protection authorities will look past the technical handoffs. Organizations cannot dodge their legal responsibilities by offshoring the math to third-party algorithms. Regulators will always demand proof of actual human authority over the final outcome. Let's test this with a case study. Imagine a fintech app that instantly denies car loans based on a user's late-night online spending habits with zero human involvement. First, denying a car loan is a legal or significant effect. Second, the instant nature confirms it is solely automated. Third, the company might claim the contract exception to process the loan application. But fourth, they have entirely missed the mandatory safeguards. To fix this, the app must implement a clear way for the user to request a human review and provide an accessible explanation of why those late-night purchases trigger the denial. Now for a quick knowledge check. Question 1. Does an algorithm automatically applying a 10% marketing discount trigger Article 22? No. Getting a small discount on a sweater does not meet the threshold of a significant effect on your life. Question 2. An AI flags a job applicant for rejection, and a junior intern clicks confirm on 100 profiles a minute. Is this compliant? No. That fails the meaningful human involvement test. The intern is just a token human. Question 3. Based on the Schufa case, is generating a credit score an automated decision if a separate bank actually denies the loan? Yes. Creating a score that strongly dictates a third party's action falls squarely under the rule. Question 4. If a user gives explicit consent for automated decision-making, do you still need safeguards? Yes. Even with consent, you must provide the right to human intervention and the right to contest the decision. Compliance with Article 22 requires bridging the gap between how data flows technically and who holds the actual authority to override the system. To navigate this regulation, remember these 4 pillars. First, the solely standard bans decisions without meaningful human input. Second, the rule only triggers when there is a significant legal impact. Third, you must be able to explain the logic of the system. And fourth, as the Schufa case proves, you can't delegate your legal liability to third-party scores. If this breakdown helped you navigate the GDPR, consider supporting the Privacy Trainer channel by becoming a member. Your support directly funds this free education. For structured learning paths, deep dive workshops, and certification preparation, head over to privacyuni.com. Finally, remember that this video is for educational purposes only and does not constitute formal legal advice. Thanks for watching, and keep your data safe. Imagine investigators are finally closing in on a massive financial fraud ring, but just hours before they seize the servers, the lead suspect submits a GDPR right to erasure request to the tech company hosting their data, demanding they delete their entire profile immediately. Does the hosting company have to comply with the deletion, or can a privacy right be weaponized to destroy evidence? This puts the company in a brutal bind. If they guess wrong, they either illegally obstruct a high-stakes criminal investigation, or they unlawfully violate a user's fundamental data rights. Both carry severe regulatory penalties. To solve this exact paradox, the architects of the General Data Protection Regulation built in a specific release valve, Article 23. Think of the GDPR as a heavily fortified house. Articles 12 through 22 build the solid protective walls. These are the individual rights like access, rectification, and erasure. That house needs a way to let authorities in during a crisis. Article 23 is the heavily guarded emergency exit. The core philosophy here is that the right to data protection is not absolute. It has to be weighed against other fundamental rights and the safety of society at large. This article gives the European Union and individual member states the power to legally restrict those individual privacy rights, but only under extremely strict, well-defined conditions. It is never a convenient loophole for corporations to avoid compliance. It is a precise balancing act between an individual's autonomy and the collective public interest. For any organization to lawfully deny a GDPR request using this mechanism, 3 rigid legal hurdles must be cleared. Article 23 states restrictions must be established by way of a legislative measure, backed by actual law. Second, the measure must respect the essence of the fundamental rights and freedoms, meaning no blanket suspensions of privacy. It must be a targeted, surgical strike. Third, the restriction must safeguard a specific public interest. The regulation explicitly lists these: national security, defense, the prevention and prosecution of criminal offenses, and important economic or financial interests of a member state, including taxation matters. Looking further down at paragraph 2, we see strict transparency requirements. The legislative measure itself has to explicitly detail the purposes of the processing, the categories of personal data affected, the storage periods, and the specific safeguards put in place to prevent abuse. Taken together, these rules reflect a guiding principle found throughout the GDPR's recitals. Any restriction of privacy must be strictly necessary and proportionate in a democratic society. Let's look at how this plays out in practice. Imagine a social media platform receives an access request from a user. Normally, they must provide the data. However, if they are under a confidential police warrant protecting an active criminal investigation, national law forces them to restrict that access. That is a lawful restriction. Or consider an accounting firm. A former client demands the deletion of all their files. The firm lawfully denies the erasure request because national tax laws explicitly require them to retain financial records for 7 years. Now, picture a retail manager who refuses a customer's data request, claiming that company policy protects our proprietary business metrics. They fail to cite any actual legislative measure. This is entirely unlawful. The European Court of Justice enforces these boundaries aggressively. In cases like C-175/20, the court upheld restrictions tied to national tax authorities precisely because they were based on clear, proportionate legislation safeguarding a public economic interest. The dividing line is clear. The tech company and the accounting firm succeed because they rely on external law. The retail manager fails entirely because a corporate preference is never a valid substitute for a legislative measure. Let's clear up 2 massive misconceptions. Private companies cannot invoke Article 23 to protect their own commercial interests, and restrictions aren't permanent. They expire the moment the active investigation concludes. Let's walk through a conflict resolution. An employee named Sarah is fired for suspected corporate espionage. On her way out the door, she submits a GDPR access request for her inbox to see what evidence the company has collected against her. The conflict? The company has already handed these emails over to the police under a specific national criminal procedure law, and tipping her off would ruin the investigation. The company can legally deny her request, but to do so, their legal and privacy teams must formally rely on that specific national criminal procedure law. They cannot just say, "We're investigating you." If an authority audits this decision later, they won't just take the company's word for it. They will demand documentation proving the specific law invoked and verifying the restriction was surgically narrow. The company can restrict access to the espionage evidence, but they still have to hand over her standard HR data, like her payroll records. Invoking Article 23 without precise legal documentation and a strictly narrow scope will result in immediate regulatory penalties. Let's lock in these core concepts with a rapid-fire knowledge check. Question 1. Under Article 23, what is strictly required to lawfully restrict a data subject's right? The answer is a specific legislative measure. Internal policies do not count. Question 2. A restriction must be a necessary and proportionate measure in a what? The regulation specifically states, in a democratic society. Question 3. If police order a dating app to preserve a suspect's profile, how do they handle a deletion request? They must restrict the deletion based on the specific national law governing criminal investigations. Question 4. What must a legislative measure contain under Article 23, Paragraph 2? It must include specific provisions detailing the restriction scope and the safeguards to prevent abuse. Here are your 4 core takeaways for Article 23. Individual privacy rights are not absolute. Restrictions require actual external laws. Those laws must be proportionate. And private companies can only use these restrictions when compelled by national compliance or law enforcement. If this breakdown helped you clarify the GDPR, consider becoming a member of Privacy Trainer here on YouTube. Your support allows us to keep producing free, globally accessible privacy and AI education. And if you are a professional seeking structured learning paths, interactive workshops, and exam prep to accelerate your career, visit us over at privacyuni.com. Finally, please remember that the content in this video is for educational purposes only and does not constitute legal advice. Thanks for watching, and we'll see you in the next one.
Welcome back to Privacy Trainer, where we are breaking down every single article of the GDPR step by step. Today, we're tackling a big one, Article 24, the responsibility of the controller. Look, this is the absolute bedrock of how organizations must prove they are actually protecting personal data. It answers a fundamental question. Why isn't it enough to just mean well? Let me tell you, if you misunderstand this article, you're not just risking a data breach, you are practically guaranteeing massive regulatory fines. So let's figure out exactly why this matters so much. Here's our roadmap for today. We're going to cover understanding the article itself, look at some real-world scenarios and common mistakes, dive into the regulatory perspective, walk through a practical mini case study, test ourselves with a knowledge check, and wrap up with some key takeaways. Section 1. Understanding GDPR Article 24. Let's get right into the legal text and see why it holds such a vital place in the GDPR framework. Imagine this scenario for a second. A company suffers a massive data breach. They scramble and tell the regulators, hey, we promise we tried our best. We honestly had good intentions. But when the regulators ask for proof, security logs, risk assessments, internal policies, the company has absolutely nothing to show. Well, under Article 24, that lack of proof is a violation all by itself. Legally speaking, the absence of documentation actually flips the presumption of compliance, meaning it's not enough to just act responsibly in the background. You have to affirmatively be able to prove you acted responsibly. This brings us to the crucial concept of accountability. I like to call this the captain of the ship principle. As the data controller, you are the captain. You are entirely responsible for steering the ship safely, setting the rules for your crew, and most importantly, keeping a detailed, up-to-date logbook to prove to the authorities that you follow the rules at all times. You really can't just react to problems as they happen. You have a proactive obligation. Privacy has to be built into the very DNA of your operation right from day one, not bolted on as some panicked afterthought when things inevitably go wrong. Let's translate some of this dense legal text into practical business actions. Article 24, Paragraph 1 requires taking into account the nature, scope, context, and purposes of processing, as well as the risks. In plain English, assess your specific risks before you act. Next, you must implement appropriate technical and organizational measures. Basically, use the right tech tools, like firewalls and encryption, and the right company rules like employee training. It also demands that you ensure and be able to demonstrate compliance. Basically, do the right thing and absolutely keep the receipts to prove it. And finally, the text says these measures must be reviewed and updated, which is just a fancy way of saying compliance is continuous. It is never a one-and-done project. Lawmakers didn't write this in a vacuum, and Recital 74 perfectly acts as an interpretive bridge here. It shows that regulators don't just want a 50-page privacy policy sitting in a drawer gathering dust. They want to evaluate the effectiveness of your measures. Think of it like a security alarm on a building. If you install a state-of-the-art alarm but never actually turn it on, or never bother to test the batteries, well, it's not an effective measure, is it? Regulators want hard proof that your privacy safeguards actually work in the real world to protect real people. Section 2, Real-World Scenarios and Mistakes. Let's see how this all applies to actual organizations out in the wild. One of the most brilliant things about Article 24 is that it naturally scales. Consider a massive global tech company. They process millions of users' data, run complex AI algorithms, handle sensitive information. Their risk profile is sky high, so they need an enterprise-grade fortress. We're talking advanced end-to-end encryption, strict access logs, dedicated data protection officers. Now contrast that with a local bakery that just sends out a simple monthly email newsletter with a few coupon codes. Their risk profile is incredibly low. They don't need a digital fortress. They just need a sturdy lock on the front door, secure passwords, basic access controls, and a straightforward privacy policy. The security measures always have to dynamically match the specific risk. Even with that built-in scalability, companies still make critical errors all the time. The biggest one? The set it and forget it mentality. They spend a fortune building a secure system on day one, and then completely neglect to update it for 5 years. Or they mistakenly believe that just buying expensive security software equals GDPR compliance, completely ignoring the human element, the organizational measures. They'll have these beautiful policies on paper, but zero employee training. Also, if you don't document exactly why you made a specific privacy decision, like why you chose a specific vendor, you'll have zero defense when a regulator comes knocking. Treating the GDPR like a static, one-time checklist completely misses the point of Article 24. Section 3, the regulatory and enforcement perspective. So, what exactly happens when a regulator does come knocking? Regulators operate strictly on the principle of show, don't tell. And the highest courts completely back them up on this. Look at the Court of Justice of the European Union ruling, specifically case C-340/21. An organization suffered a cyber attack and essentially tried to play the victim card, saying, hey, it was a hacker's fault. The court firmly rejected that defense. They confirmed that under the accountability principle, the burden of proof rests entirely on the controller. You can't just point fingers at a malicious third party. You have to proactively prove your defenses were robust before the attack even happened. To prove this, regulators will demand system logs, evidence of management awareness, and under paragraph 3 of Article 24, they really value adherence to approved codes of conduct or official certifications as tangible proof you're taking this seriously. Section 4, Practical Mini Case Study. Let's put on our privacy professional hats and walk through a scenario. Let's say a company called HealthApp Pro is launching a brand new biometric login using facial recognition. That's the business challenge.
The privacy issue here is that biometric data is incredibly sensitive under the GDPR. It poses high risks to the users if it ever gets breached. So what's the compliance action? The data protection officer starts with technical measures, mandating state-of-the-art encryption. Then, organizational measures. The DPO asks, who actually needs to see this raw data? They decide to strictly limit server access to just 3 vetted engineers. Crucially, the DPO meticulously documents this entire thought process. Why 3 engineers? Why that specific encryption? It is exactly this extensive documentation step that explicitly satisfies the Article 24 requirement to demonstrate compliance.
Section 5, Knowledge Check. Time to see how much you've picked up with some professional certification-style scenario questions.
All right, question 1. A small local retailer and a multinational data broker both process personal data. According to Article 24, how should they approach their technical and organizational measures? Is it A, both must implement the exact same level of security? B, measures should be proportional based on the nature, scope, context, and risks of their specific processing? C, only the multinational data broker is required to implement measures? Or D, small retailers are entirely exempt from Article 24? Think back to that core principle of scalability.
And the answer is B. Measures must be proportional to the risk. Because Article 24 is inherently risk-based, what is appropriate for a global data broker is completely different from what is required for a small shop. This is exactly why options like D are just flat out wrong. The GDPR doesn't hand out total exemptions based purely on your company's size, it simply scales the requirements to match the reality of your risk.
Let's move to question 2. In the event of a data breach, and according to CJEU jurisprudence, who bears the burden of proving that the implemented security measures were appropriate? A, the data subject whose data was breached. B, the supervisory authority investigating the breach. C, the processor handling the data. Or D, the controller. Remember our captain of the ship analogy and that specific ruling in case C340/21. The correct answer is D, the controller. Regulators are absolutely not going to presume you did the right thing, and it is certainly not the victim's job to prove that your security was weak. As the controller, the burden of proof rests squarely on your shoulders to demonstrate that proactive compliance. Doing great. Here's question 3. Under Article 24, paragraph 3, which of the following can a controller use as an element to help demonstrate compliance with their obligations? A, a verbal assurance to the data subjects. B, adherence to an approved code of conduct or certification mechanism. C, a unilateral declaration published on their website. Or D, deleting all personal data immediately after collection.
And the answer is B. Using approved codes of conduct or official certification mechanisms is a fantastic, regulator-recognized way to visibly prove your commitment to data protection. Options A and C, verbal assurances or unilateral declarations, completely fail the test because they lack any kind of independent verification or structured accountability.
All right, last one, question 4. A company builds a highly secure database system on launch day. 2 years later, they suffer a breach because they never updated the software. Which part of Article 24 did they violate? A, they failed to draft a privacy policy. B, they failed to designate a representative. C, they failed to review and update their measures where necessary. Or D, they failed to adhere to a code of conduct.
The answer is C. The law explicitly states measures shall be reviewed and updated. Compliance is never truly done. If you aren't regularly reviewing and updating your security measures to match new threats and evolving risks, you are in direct violation of Article 24.
To wrap up, let's review the key takeaways. First, you are accountable. Be the captain of the ship, do the right thing, and keep the evidence. Second, risk dictates your action. Your technical and organizational security absolutely must scale based on the specific data you process. Third, compliance is a continuous loop of reviewing and updating. And lastly, documentation is your ultimate defense. So ask yourself right now, if a regulator walked into your office today and asked you to prove your compliance, would you hand them a dusty binder or a living, breathing record of accountability? If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thank you so much for joining me to master Article 24, and I will see you in the next explainer.
Welcome to this explainer on GDPR Article 25, where we're going to unpack exactly how to build privacy right into the architecture of your products and services. Have you ever wondered why privacy sometimes feels like a completely broken promise in the digital world, or why massive data breaches seem to happen almost every week? Well, it usually comes down to a structural failure. So today, we are going to fix that. We're looking at Article 25 of the General Data Protection Regulation, which is literally the ultimate mandate for data protection by design and by default. Let's jump right in and see how we can transform privacy from a last-minute legal afterthought into a core engineering requirement. Here's our blueprint for today. We'll start with the privacy architecture problem, then demystify Article 25, look at it in practice, cover enforcement and common mistakes, walk through a real-world case study, and wrap up with a knowledge check. Section 1. The privacy architecture problem. Let's look at the core issue lawmakers were trying to solve here. We have absolutely all been there. You download a brand new app, open it up, and instantly you're bombarded with requests for your location, your contacts, your microphone, data it clearly does not need to function. Think about downloading a simple calculator app, and suddenly it wants your GPS coordinates. Why does that even happen? Well, historically, developers built a tech first, and then the legal team tried to slap a privacy policy on top of it right before launch. Privacy was treated as a band-aid, not a blueprint. And when organizations ignore those foundational rules of privacy and treat it like a late addition, the results are pretty catastrophic for everyone involved. We end up with invasive overcollection of data. We see severe data breaches simply because security wasn't baked into the foundation from day one. Ultimately, this leads to a massive loss of consumer trust. And, as we've seen from European regulators time and time again, massive regulatory fines. Look, you wouldn't build a house and then try to figure out where the plumbing goes after the walls are painted, right? Section 2. Demystifying Article 25. Enter the GDPR's mandatory building code. Article 25 is really split into two distinct but complementary halves. Think back to that house analogy. By design, which is paragraph 1, means engineering strong walls and secure windows from the very beginning. You actually have to consider the state-of-the-art technology and the risks to users before you even start building. By default, in paragraph 2, is all about the factory settings. It basically means the doors lock automatically when you leave without you having to even think about it. By default, the system should only process the absolute bare minimum amount of data necessary, and it should never broadcast your information to the world unless you actively, intentionally choose to do so. And if we look at Recital 78, it makes it incredibly clear that lawmakers wanted privacy woven into the very fabric of technological development. Recitals in the GDPR act as the why behind the law. This recital is speaking directly to product managers, developers, and engineers, telling them, hey, you are responsible for privacy. It's just as much an engineering challenge as it is a legal one. Section 3. Article 25 in practice. So what do these architectural blueprints actually look like in the real world? Let's contrast a few scenarios. Take a tech company with a rideshare app that only tracks your location while you are physically in the car. That is a perfect example of data minimization by design. Or consider a local bakery that automatically deletes customer order histories after 30 days. That's storage limitation built right into the system defaults. But then, imagine a health app that makes a user's weight and heart rate public the second they create an account. That is a massive, unlawful failure of data protection by default. Section 4. Enforcement and common mistakes. Building inspectors, meaning the regulatory authorities, are actively hunting for structural failures. And believe me, they know exactly where to look. The most common mistakes usually stem from treating privacy as a legal checkbox rather than a true engineering requirement. One super dangerous misconception is that legacy systems built before the GDPR don't need continuous updates. Wrong. Regulators also frequently penalize companies for hoarding data just in case they might need it someday. Another huge trap? Putting out a highly invasive product with terrible default settings and just hoping a confusing pop-up banner asking for consent will save you. It absolutely won't. Bad defaults are illegal defaults. This was really reinforced in case C687/21. The burden of proof is on the controller to demonstrate that their technical and organizational measures are appropriate and effectively implemented. In this specific case, involving MediaMarkt Saturn, a human error led to data being handed over to an unauthorized third party. The European Court of Justice highlighted a crucial point. Simply having a written policy isn't enough. Your design, your organizational measures, and your default safeguards must actually be appropriate to the risk, and they have to function properly. You have to be able to prove your architecture actually works. Section 5. Real-world case study. Let's put on our privacy professional hats for a moment and walk through a realistic scenario. Okay, let's say a fitness app wants to become a social network, and the dev team wants to automatically share your daily running route to a public community board. They cannot do that by default. Article 25 mandates that the factory setting must protect your privacy until you intervene. The developer's desire for rapid user engagement cannot override the user's fundamental right to privacy.
The correct architectural decision here is to build the social board, sure, but ensure the user's profile and routes are strictly private straight out of the box. The user literally has to manually toggle a switch to share their run. Section 6, Knowledge Check and Takeaways. Let's test your understanding with 4 professional-level certification scenarios. Question 1. A tech company launches a messaging app. Which setting satisfies Article 25, Paragraph 2, data protection by default? Is it A, public user profiles, B, end-to-end encryption disabled, C, profile visibility set to contacts only, or D, infinite message retention? Take a second to think about what the factory setting should be to protect the user without them lifting a finger. The answer is C. By restricting visibility to contacts only straight out of the box, the app prevents the user's data from being exposed to the entire internet by default. Options A, B, and D all expose the user to completely unnecessary risk or retain data way beyond what is strictly necessary. Question 2. Under Article 25, Paragraph 1, an online retailer is determining technical measures to secure payment data. What must they legally take into account? A, only the cost of implementation. B, the state-of-the-art, implementation cost, and risks to data subjects. C, the marketing team's preferences. Or D, the physical location of their servers exclusively. Think about the specific formula the law gives us here. And the correct answer is B. You absolutely cannot just choose the cheapest option available. You have to weigh the current technological advancements, the state-of-the-art, against the actual risks to your users. The law is actually quite pragmatic. It acknowledges cost, but it demands you align your budget with the reality of the risk and the modern landscape of secure technology. Moving to question 3. A bank uses a legacy customer database built in 2015, which was before the GDPR. Do they need to apply Article 25? A, no, it's grandfathered in. B, only if they suffer a data breach. C, yes, pre-existing systems must be consistently updated. Or D, no, Article 25 only applies to cloud-based apps. This is a very common trap for organizations. The answer is C. There is zero grandfather clause in the GDPR. The European Data Protection Board guidelines confirm that you must continually review and update your older systems to meet modern privacy standards. Remember, state-of-the-art is a moving target, which means your architecture literally has to continuously evolve. Final question. A smart home thermostat collects temperature data every second. To comply with the data minimization dimension of Article 25, Paragraph 2, the manufacturer should A, write a longer privacy policy. B, limit the collection frequency to only what is strictly necessary. C, send all collected data to third-party marketers. Or D, charge users a fee for privacy mode. If you guessed B, you hit the nail on the head. If the thermostat only needs a reading every 5 minutes to actually function properly, collecting data every single second violates the default data minimization rule. You must engineer the device to only take what it absolutely needs. Writing a longer policy doesn't fix bad engineering. So to wrap everything up today, remember that privacy has to be built right into the foundation. It's a structural blueprint, not a legal band-aid. Your default settings must aggressively protect the user from day one, your systems must continuously evolve with this state-of-the-art, and data minimization has to be hard-coded into your engineering. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I'll leave you with this final thought. If you were forced to make your own personal data public by default on the platforms you use every single day, would you still use them? Think about that before you build your next product. See you next time. Welcome back to another Privacy Trainer Explainer. Today, we're diving straight into Article 26 of the GDPR. We're going to demystify the whole concept of joint controllership and really figure out how this stuff actually plays out in the real world. Let's get right to it. So, picture this, okay? 2 companies get together and launch this amazing new app. But then, disaster strikes. A massive data breach happens. And what do? They immediately start pointing fingers at each other. Who pays the fine? Who has to tell the users? Well, this exact chaotic nightmare is the exact problem Article 26 is designed to solve. Because trust me, when organizations misunderstand shared liability, the financial and reputational fallout is absolutely disastrous. It's a total mess. All right, here's our roadmap for this explainer. 1. Rules and walkthrough. 2. Real scenarios and case law. 3. A mini case study. 4. A knowledge check. And 5. Key takeaways.
Kicking things off with Section 1, the rules and walkthrough. Okay, so Article 26, Paragraph 1. It says, where two or more controllers jointly determine the purposes and means of processing, they shall be joint controllers. Now let's translate that legal jargon into plain English, right? It basically means that if multiple entities are getting together to decide the why and the how, they share the ultimate responsibility to protect the person whose data is being used. And this lines up perfectly with Recital 79, which demands a crystal clear allocation of liability. The law basically wants to make absolutely sure that no company can just hide in the shadows and dodge the blame when things go sideways. Now, the real trick here is understanding the difference between these two things. The EDPB, the European Data Protection Board, makes it super clear. Joint participation means you have to be deciding both the big picture goal, which is the why, and the essential methods of processing, the how. You don't literally have to micromanage every tiny technical detail. Stuff like exactly what brand of server you're using. That can totally be delegated. But if you're teaming up to shape those core objectives and essential privacy decisions, boom, you're joint controllers. And it doesn't just stop at definitions. Paragraph 2 of Article 26 says you have to clearly document who is doing what and make the essence of that arrangement public. Plus, Paragraph 3 is a real game changer because it gives individuals the right to enforce their privacy rights against any single one of the joint controllers. The EDPB actually gives us this brilliant decision tree for figuring this out. Basically, ask yourself this. Would the processing even be possible without both parties pitching in? If the processing by each party is totally inseparable, like inextricably linked, then yep, you've hit joint controllership. For example, think of a small local business sharing their customer database with a marketing agency so they can run targeted ads based on a shared strategy. Neither of them could pull that off without the other's input, right? So they're joint controllers for sure.
All right, let's move right along to Section 2, Real Scenarios and Case Law. Let's look at how this plays out in real life with case C683/21, the famous Lithuanian COVID app decision. This was a major compliance failure. Basically, two entities tried to argue, hey, we can't be joint controllers because we never signed a formal written contract. But the court was having none of it. They ruled that you do not need a formal written contract about purposes and means to be on the hook as joint controllers. All you need are converging decisions that actually have a tangible impact. If your actions are complementing each other to build a tool, the law says, sorry, you share the responsibility.
Because this is so tricky, organizations make mistakes here all the time. Let's bust a couple of myths. Myth number 1, you've got to have equal access to the data. People always assume that if they can't see the data, they aren't joint controllers. But the EDPB says you can absolutely be a joint controller without ever laying eyes on a single personal record. Myth number 2, mutual commercial benefit equals joint control. Nope. Just because you're both making money doesn't make you joint controllers. The facts are that regulators are really just looking for transparent arrangements and clear contact points. Oh, and by the way, as we saw in the recent case C492/23, joint controllers absolutely cannot remain anonymous to each other. No way.
Let's put this into practice with Section 3. A mini case study. Okay, imagine a university faculty and a huge music streaming platform team up to launch a research survey. Step 1, they share the overarching research goal. Step 2, they make converging decisions together on exactly what user data they're going to collect. Step 3, they rely on inseparable processing. The university needs the tech company's massive reach, and the tech company is implementing the university's parameters. They need each other. So, Step 4, under Article 26, Paragraph 2, they absolutely must draft an arrangement defining who handles the rights requests and who puts out the privacy notices. Time to test what we've learned. Welcome to Section 4, Knowledge Check.
Let's look at question 1. Company A and B launch a shared database. What establishes them as joint controllers? Is it A, mutual commercial benefit? B, jointly determining purposes and means? C, using the same servers? Or D, signing a standard processor contract? Have a think about what fundamentally changes a company from just being a service provider to an actual shared rulemaker.
The correct answer is B. Just sharing a server or making a quick buck together just doesn't cut it. The ultimate test is whether they jointly participated in determining the why and the how of the processing. Moving on to question 2. Based on that CJEU case C683/21 we talked about, what is required for two entities to be classified as joint controllers? A, equal access to the personal data. B, a formal written arrangement. C, converging decisions with tangible impact. Or D, a single designated contact point. Think back to the Lithuanian COVID app scenario where the paperwork was missing.
And the answer is C, converging decisions that complement each other and have a tangible impact. The court made it super clear. The classification itself totally does not require a formal contract. As long as the processing by each party is inseparable, you are on the hook. Question 3. Under Article 26, Paragraph 3, how can a data subject exercise their privacy rights? A, only via the designated contact point. B, in respect of and against each controller independently. C, only against the primary data collector. Or D, exclusively through a supervisory authority. Put yourself in the shoes of a consumer trying to get their data deleted here. The answer is B. The data subject may exercise their rights against each of the controllers. It literally does not matter what secret internal contract the company signed behind closed doors. The law empowers the user to hold any of the joint controllers accountable. All right, final question, Q4. What transparency obligation do joint controllers owe to the data subject under Article 26, Paragraph 2? Is it A, publishing the entire processing record, B, making the essence of the arrangement available, C, releasing the source code of the processing, or D, disclosing all sub-processor contracts? Transparency is absolutely crucial in the GDPR, but what exactly needs to be public?
And the correct answer is B. The essence of the arrangement must be made available. This is so the individual knows exactly who they need to talk to for their privacy information and their rights requests.
Let's wrap things up with Section 5, Key Takeaways and Support.
So let's distill all this down into the most crucial lessons. Number 1, jointly determining the why and how is what triggers Article 26. Number 2, you absolutely do not need a formal contract for this to apply. Your converging decisions are enough. Number 3, you must document your respective responsibilities. Number 4, the essence of that arrangement must be public. And number 5, data subjects can enforce their rights against any joint controller. The big takeaway here, if you're shaping data processing with someone else, you can't just hide behind them. You have to map out your shared duties. Now, if you enjoy these GDPR explainers and you want to support our mission, consider becoming a Privacy Trainer member. Memberships help us keep creating free privacy, security, AI, and compliance education for folks all over the world. Our whole mission is to make this knowledge accessible and use AI to scale it out to everyone. And hey, if you're looking for something a bit more structured, like guided learning paths, workshops, practice questions, or certification prep, definitely go explore privacyuniversity.com. Privacy Trainer is all about keeping knowledge free here, while Privacy University is tailored for a more structured, deep dive learning experience.
And finally, here's our standard disclaimer. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks so much for hanging out and learning with us, and I will see you in the next explainer.
All right, let's jump right into this explainer. Imagine your company is based entirely outside of Europe, say in Australia, Brazil, or the US, but you're processing the data of EU citizens. The GDPR has a massive global reach, right? But here's the giant practical puzzle. If a foreign company violates the privacy rights of someone in Paris or Berlin, how does the law actually reach them? What's the mechanism forcing them to answer to European regulators? Well, that's exactly the problem Article 27 of the GDPR is designed to solve. So, what does happen when a company outside Europe breaks EU privacy law? This question gets right to the heart of the challenge. How do European regulators, or just everyday citizens, communicate with or enforce the rules against a company that literally has zero physical footprint in the EU? If there's no office to visit and no local director to call up, accountability could just vanish into the digital ether. Without a concrete legal mechanism, foreign companies could basically ignore European privacy rights with no consequences whatsoever, which would put local EU companies at a massive competitive disadvantage. We definitely can't have that. Here's our quick agenda for today. We'll start with an overview, do a full legal walkthrough, look at some real-world examples and common mistakes, tackle a mini case study, test you with the quiz, and wrap up with the key takeaways. Part 1. Overview, the local bridge. So, what exactly is an Article 27 representative? Well, according to the legal text and the European Data Protection Board, it's a natural or legal person established in the Union, explicitly designated in writing, who represents a non-EU controller or processor regarding their GDPR obligations. The EDPB makes it super clear. This representative acts as your local anchor. They're the ones ensuring comprehensive protection for data subjects and keeping the playing field level for companies worldwide. Basically, they're the ones answering the door when a regulator comes knocking or when a user wants to exercise their data rights. Moving right along to Part 2, our full article and recital walkthrough. Let's look at the actual law. It states, where Article 3.2 applies, the controller or processor shall designate in writing a representative in the Union. In plain English, if your processing falls under the territorial scope of targeting EU data subjects, meaning you're actively offering goods or services to people in the EU or you're monitoring their behavior online, you must legally designate someone physically located in the EU to represent you. It's not a polite suggestion, folks. The word shall, in legal terms, means it is an absolute, strict mandate.
But, there are always exceptions in a law. Article 27, Paragraph 2 outlines exactly who doesn't need a representative. You only get this exemption if your processing is incredibly limited, purely occasional, very low risk, and absolutely does not involve sensitive data, like health records or political opinions. Oh, and public authorities or bodies outside the EU are exempt too. But what does this mean for you? Well, if you're an active tech startup, a SaaS provider, or a busy e-commerce company outside the EU, you almost certainly do not qualify for this exemption. You are going to need that representative.
And let's pull in Recital 80 here, because it brilliantly clarifies how this relationship works. It states, the representative must be explicitly designated by a written mandate to act on your behalf, including cooperating with the competent supervisory authorities. This means it can't just be a casual handshake agreement or a quick email saying, hey, can you cover for us? It has to be a formal, documented designation of authority. Part 3, Practical Examples and Common Mistakes. Let's see how this actually plays out. Check out Scenario 1. A Canadian app developer creates a fitness tracking app that specifically monitors the location and health behaviors of users in the EU. Because they're monitoring EU residents and doing it continuously with sensitive health data, there's no question they absolutely must designate a representative. Now compare that to Scenario 2. A U.S. government agency processes the data of EU citizens as part of an international customs agreement. Because they're a foreign public authority, international law and specific GDPR exemptions kick in, meaning they do not need an Article 27 representative. Now here's a massive compliance trap you need to avoid. A lot of companies try to cut corners and save some money by having their external data protection officer, their DPO, also act as their Article 27 representative. You absolutely cannot do this. The EDPB explicitly flags this as a huge conflict of interest. Why? Well, think about it. A DPO's legal mandate is to be completely independent. They cannot take instructions from the company. An Article 27 representative is the exact opposite. They operate strictly on a written mandate and take direct instructions from the non-EU company. You literally cannot be independent and instruction-taking at the exact same time.
Part 4, the regulatory and enforcement perspective. How do the authorities actually look at this?
When regulators investigate a non-EU company, they zero in on 4 key things. First, they'll immediately check your website's privacy notice. If your representative's contact details aren't publicly listed right there, you're already failing the transparency rules. Second, location. The representative must be established in one of the member states where your targeted users actually live. Third, and this is a big one, regulators expect that local representative to immediately hand over your Article 30 record of processing activities if asked. And finally, remember this. While the representative is the local point of contact, the ultimate legal liability and those massive GDPR fines, they remain squarely with you, the non-EU company. The representative is your messenger, not your human shield.
Let's tie this all together with a quick mini case study. Imagine a thriving US-based e-commerce site that actively targets shoppers in France and Germany. They translate their site into French and German, and they accept euros. Boom, that triggers Article 3.2. So what's the privacy issue? They have no EU office and haven't designated a representative. If a French citizen complains to the French regulator, the CNL, this company is in hot water. The compliance action is straightforward. They legally must appoint a representative physically located in either France or Germany, give them a written mandate, and immediately update their online privacy policy with that rep's contact info.
Part 5. It's time to test your privacy knowledge. Let's see how much you've absorbed.
All right, question 1. A SaaS company in Japan monitors the behavior of users in Italy and Spain. Where must their Article 27 representative be established? Is it A, in Brussels, Belgium, B, in any EU member state, C, in either Italy or Spain, or D, they do not need a representative? Think back to the specific location requirements dictated by the GDPR we just talked about. And the correct answer is C, in either Italy or Spain. Article 27 requires the representative to be established in one of the member states where the targeted data subjects actually are. Since the monitored users are in Italy and Spain, the rep has to be in one of those 2 countries. Just putting an office in Belgium or Ireland wouldn't fly if you don't actually have data subjects there. Moving on to question 2. To save costs, a Brazilian marketing agency designates their external data protection officer as their Article 27 representative. Is this compliant? A, yes, if documented in writing. B, yes, because both roles deal with privacy. C, no, because a DPO must be an employee. Or D, no, this is a conflict of interest. Consider the very different mandates for these 2 privacy roles. The answer is D, no, this is a conflict of interest. As the European Data Protection Board explicitly states, the complete independence required of a DPO is totally incompatible with a mandate-driven, instruction-taking nature of an Article 27 representative. Combining them is an automatic, undeniable conflict of interest. Last one, question 3. If a non-EU company appoints an Article 27 representative, who is ultimately liable for GDPR violation? A, the representative only, B, the non-EU company only, C, both are held equally liable by default, or D, the local supervisory authority. Think carefully about whether appointing a local contact actually shifts your legal and financial responsibility.
And the correct answer is B, the non-EU company only.
Article 27 specifically states that designating a representative is without prejudice to legal actions that could be initiated against the controller or processor themselves. So the representative is a conduit for communication, sure, but the fines and the massive liability for the data processing remain entirely with a non-EU company.
Finally, Part 6, Key Takeaways and Next Steps. Let's wrap this up. If you're outside the EU but actively operating in its digital market, the Article 27 representative is your mandatory, legally binding bridge to compliance. Remember, they act as that vital local bridge for regulators and citizens. They absolutely must be explicitly named in your privacy notice so people can actually find them. They need to physically hold your Article 30 processing records ready for an audit. And above all, do not try to cut corners by making your DPO serve as your representative.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. But I'll leave you with this final thought as you evaluate your own data processing. If a European regulator knocked on your digital door tomorrow, exactly who would answer it for you? Keep analyzing, keep learning, and I'll see you in the next explainer.
So picture this. You wake up, grab your coffee, and find out that a third-party vendor you use, maybe it's your cloud storage provider or your customer support software, has been totally hacked. Customer data is exposed everywhere. Now, your very first thought might honestly be, well, that's their problem. They're the ones who got breached. But under the GDPR, that assumption could literally be a €1 million nightmare. Welcome to Privacy Trainer. Today's explainer completely demystifies Article 28 of the GDPR, which is all about processors. We're going to dive right in and establish exactly why you simply cannot outsource your privacy compliance and what happens when those vendor relationships go terribly wrong. Let's get into it.
Here is our agenda for this explainer. We'll hit 1. The outsourcing risk. 2. Unpacking Article 28. 3. Real-world examples. 4. Mistakes and enforcement. 5. A quick case study and quiz. And finally, 6. Key takeaways.
Section 1. The outsourcing risk. You can't outsource responsibility.
For a really long time, businesses kind of thought that handing data over to a third party basically meant handing off their legal liability. Well, Article 28 completely closes that loophole. If we strip away all the dense legal jargon, a processor is simply any entity that processes personal data on behalf of the controller. That little phrase, on behalf of, is absolutely the key here. They don't own the data at all. They're essentially just a hired help carrying out your specific instructions. Think of the controller as the boss. They're the ones determining the why and the how, the purposes and means of the processing. The processor, on the other hand, acts strictly on documented instructions from the controller. If the controller says, hey, store this data, they store it. They are there to execute the strategy. They definitely do not create it.
Moving on to Section 2, Unpacking Article 28, Rules and Recitals.
Okay, so Article 28, Paragraph 1 clearly states that the controller shall use only processors providing sufficient guarantees. Lawmakers intentionally included this heavy burden. You can't just go out and hire the absolute cheapest vendor you can find on the internet. No way. You actually have a proactive legal duty to vet their capabilities and ensure that they can implement appropriate technical and organizational measures to really protect the data you're trusting them with.
But what actually makes a guarantee sufficient? Well, Recital 81 is basically your practical decoder ring for this. When you are vetting a vendor, you really need to assess their expert knowledge, their reliability, and their resources. Regulators also look really favorably upon processors that adhere to approved codes of conduct or hold recognized certification mechanisms. It shows they actually know what they're doing.
Now here is exactly where so many organizations get it wrong. Complying with Article 28 is a life cycle. It is absolutely not a one-time event. You start with a pre-contract risk assessment, then you sign a highly detailed data processing agreement, and then, this is crucial, you conduct continuous audits. And finally, you have to have a clear process to securely return or completely delete that data when the contract actually ends.
Let's look at Section 3, Real-World Examples. Processors in action.
First up, a classic tech example. Let's say an employer needs some secure data storage, so they hire a cloud hosting service. Now, the hosting service turns around and says, hey, listen, we only store encrypted data. We don't even have the decryption keys. We literally can't see the data, so we aren't a processor, right?
According to the EDPB, that is entirely false. Even if a host just stores encrypted data and does absolutely nothing else with it, storage itself is still a processing activity under the GDPR. Therefore, that hosting service is for sure a processor, and you need a full Article 28 contract.
Okay, now let's look at a smaller business example. A company outsources its customer service to an external call center. That call center uses its own IT infrastructure and its own software to manage those calls. So, does using their own tools suddenly make them a controller? Nope, because the call center is only processing the personal data based on the really strict instructions of the hiring company, like exactly who to call and exactly what to say. They definitely remain a processor. Determining the non-essential means, like which specific brand of IT software to use, doesn't change their fundamental processor status at all.
All right, Section 4, Mistakes and Enforcement. What regulators look for. You have to beware of the phantom controller. This is a massive compliance failure perfectly outlined in Article 28, Paragraph 10. If a processor goes completely rogue and steps outside your documented instructions to use data for their own independent purposes, they legally transform into a controller. Bam. Just like that. They are suddenly on the hook for direct liability and some really massive regulatory fines. For instance, just look at the enforcement action taken by the French regulator CNL against the software processor Daedalus Biology. That processor extracted way more data than the controller actually instructed, basically acting totally beyond their mandate. And that kind of overreach changes the legal dynamic entirely.
So when regulators actually come knocking, they are looking for very specific evidence. The absolute biggest red flags are having no signed data processing agreement at all, relying on super generic contracts, failing to check those vendor guarantees up front, and a complete lack of ongoing audits. The EDPB explicitly states that lacking ongoing oversight is literally considered negligence. In that Daedalus Biology case we just talked about, CNL issued a massive €1.5 million fine. They really emphasized that while processors have their own direct obligations to secure data, controllers are also going to be heavily scrutinized for failing to adequately audit those vendor guarantees.
Moving on to Section 5, Case Study and Quiz. Let's test your knowledge.
Okay, let's put you in the hot seat. Here's the scenario. A marketing firm hires a third-party email campaign tool. A solid Article 28 contract is signed. Everything looks amazing on paper. But behind the scenes, the email tool secretly decides to use the marketing firm's massive customer email list to train its own proprietary AI models to improve its algorithms. So, based on everything we just learned about the GDPR today, what exactly is the legal status of the email tool in this specific situation?
Which statement is correct? Is it A, they remain a processor because a valid contract was signed? B, they automatically become a joint controller? C, they are considered a controller for that specific processing under Article 28, Paragraph 10? Or D, they're exempt because it's just a technical improvement? Take a quick second to think about how these legal dynamics actually play out.
And the correct answer is C. The exact moment the vendor decided to use the data for a brand new purpose, training their own AI, they completely exceeded the controller's instructions. They breached the contract. And under Article 28, Paragraph 10, that specific action transforms them into a controller for that new processing, bringing down the full weight of GDPR obligations directly onto their shoulders.
Finally, Section 6, Key Takeaways.
Let's bring it all together with 4 absolutely critical takeaways summarizing Article 28. First, always remember that outsourcing data does not mean outsourcing responsibility. You are still accountable at the end of the day. Second, verifying those sufficient guarantees is not just a one-time check. It is a continuous, ongoing duty. Third, you must always have a highly detailed, specific Article 28 contract in place before a single byte of data flows. And fourth, if a processor exceeds your instructions and uses data for their own purposes, they legally become a controller and assume all the immense liabilities that come with it. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone.
Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is really designed for learners who prefer a more structured learning experience.
Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Now, I'll leave you with this one final thought. You might have the greatest contracts in the world locked away in a drawer somewhere, but do you truly know what your vendors are doing with your data right now? Thanks for joining me on this explainer, and keep asking the hard questions. All right,
Let's jump straight into this explainer and demystify one of the most critical, yet honestly frequently overlooked sentences in the entire General Data Protection Regulation. I'm talking about Article 29. When we talk about data protection, we almost always focus on external threats, right? Hackers, ransomware, complex international data transfers, the usual suspects. But what about the people sitting right inside your own office? Today, we're going to explore the incredibly strict rules governing how your own employees and anyone else acting under your authority are legally allowed to interact with personal data.
We've got a packed module today. We're going to cover the hook and the problem, breaking down the actual law, some real-world examples, a quick Privacy Pro knowledge check, and finally, your key takeaways and next steps.
Section 1. The hook and the problem.
So ask yourself, what happens when the threat isn't a shadowy hacker in a basement somewhere, but literally someone inside your own house? Picture a glowing digital lock, but it's being picked from the inside. What actually happens when a customer service rep just gets curious and decides to look up the home address of a celebrity? Or what if a manager decides to download your entire client list to start their own competing side hustle? Obviously, they have the technical access to do it, but do they have the legal right? Absolutely not.
And that is exactly why Article 29 matters so much. If organizations misunderstand this, the consequences are genuinely severe. It's not just about preventing internal data breaches. It's about establishing an absolutely ironclad chain of command. The law basically says that access does not equal authorization. Period. Just because an employee has a login doesn't mean they can just poke around and do whatever they want. It holds the controller, so your organization, strictly accountable for ensuring that every single action taken by an employee is backed by a specific instruction. If you fail here, you're looking at rogue processing, massive compliance failures, and basically a total breakdown of your data control.
Section 2. Breaking down the law. Okay, let's look at the exact text of Article 29. It reads, "The processor and any person acting under the authority of the controller or of the processor who has access to personal data shall not process those data except on instructions from the controller." Think of your organization's database like a massive bank vault. Sure, only authorized people have the combination to get inside, but crucially, even when they open that vault, they can only take out exactly what you explicitly told them to take out. Any processing outside of those strict instructions, that's a direct violation.
Now, the key here is understanding who these persons actually are. If we look at the European Data Protection Board's guideline 2020-07, your everyday employees are generally not considered controllers or processors in their own right. Instead, the law classifies them as persons acting under your authority. Think of it this way. They are the hands doing the work, but the controller is the brain. Their access and every single action they take has to be strictly governed by the brain's explicit instructions.
Section 3. Real-world examples and case studies. This graphic brilliantly shows the difference between compliance and total failure. On the left, we've got a tech company doing it right. They use role-based access control. So an engineer only sees code, a marketer only sees marketing lists, and everyone has signed strict acceptable use policies. They are processing data strictly on instructions. But on the right, we have a small business doing it completely wrong. All 10 staff members are just sharing one single admin login with absolutely zero written instructions. Anyone can see everything. In that scenario, the chain of command is completely broken and Article 29 is literally being violated every single day.
And look, this isn't just abstract theory. It's been tested in the highest courts. Get this. In a really fascinating European Court of Justice case, Case C-57921, involving a bank called Ponky Sess, an employee who was also a customer of the bank suspected his former colleagues had snooped on his personal data. The court hammered home that under Article 29, any person acting under the controller's authority can process data only on instructions. And crucially, they ruled that log data, the technical records of who looked at what, are absolutely essential. You need those logs to verify if the processing was actually motivated by your instructions, or if employees were just in there snooping around.
Let's walk through a quick mini case study to really cement this. Step 1. The business challenge. A hospital needs its medical staff to access patient records to actually provide care, right? Makes perfect sense. Step 2. The privacy issue. A nurse decides to view the medical file of a newly admitted celebrity, even though that nurse is not treating them. Step 3. The GDPR analysis. Even though the nurse had the technical login credentials to view that file, they had no medical reason to do so, meaning they had no legal instruction from the controller to process that specific data. That right there is a clear-cut violation of Article 29.
Section 4. Privacy Pro Knowledge Check. Let's see what you've learned.
Question 1. A marketing manager exports a client list to their personal email to start a side hustle. Which GDPR article directly prohibits this unauthorized processing? Is it A, Article 17, B, Article 29, C, Article 30, or D, Article 12? Take a second and think carefully about who is determining the purpose of this processing and whether they were actually told to do it by their employee.
The correct answer is B, Article 29. Our marketing manager basically went rogue here.
By taking that data for their own personal side hustle, they process data entirely without the controller's instruction. It's a textbook Article 29 violation because they completely broke that critical chain of command.
Moving on to question 2. According to EDPB Guidelines 2020-07, how are standard employees classified under the GDPR? A. Joint controllers. B. Independent processors. C. Persons acting under the authority of the controller. Or D. Third parties. Try to recall that definition slide we looked at earlier about the relationship between the organization and its staff.
The answer is C. Employees are persons acting under the authority of the controller. They aren't independent actors. Like we said, they are simply the hands of the organization processing data strictly under the brains, the controller's authority and direction.
All right, let's tackle question 3. Under Article 29, what is the one and only exception that allows someone under the controller's authority to process data without the controller's instruction? Is it A, legitimate interest, B, required by union or member state law, C, data subject consent, or D, public domain data? Look closely at your memory of the exact legal wording we broke down at the beginning of this explainer. And the answer is B. The actual text of Article 29 explicitly states that data shall not be processed except on instructions from the controller unless required to do so by union or member state law. So a legal obligation straight from the state, like a court order or a specific statutory duty, is literally the only thing that can override your explicit instructions to your staff.
Finally, question 4. Based on CGEU Case C 57921, that's the Punky S case, what mechanism should organizations maintain to prove employees actually acted under instructions? A. Employee NDAs, B. Annual surveys, C. Log files of consultation operations, or D. Marketing consent forms. Think about how a regulator or a judge actually verifies what happened in the digital sandbox.
The answer is C, log files. As the European Court of Justice established, log files are absolutely critical evidence. You need them to demonstrate that when an employee opened a file, those processing operations were genuinely motivated by your instructions as the controller, and not just personal curiosity or malice.
Section 5. Takeaways and next steps.
Okay, let's wrap this up with the absolute essentials you need to take back to your team. First, say it with me. Access does not equal authorization. Just because staff can technically click on a file doesn't mean they are legally permitted to. Second, employees must only process data based on explicit, documented instructions. Third, as a controller, you've got to actively manage this through role-based access controls and maintain those log files to prove your compliance. And finally, remember that union or member state law is the one and only exception that lets an employee bypass your instructions. The ultimate takeaway here? You have to document your instructions and enforce them technically, or you risk losing your chain of command entirely.
If you enjoy these GDPR explainers and want to help support the channel, please consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale that education. And hey, if you're looking for more structured privacy, security, or AI training, stuff like guided learning paths, workshops, practice questions, and full certification prep resources, you can also check out privacyuni.com. Basically, Privacy Trainer focuses on making this knowledge freely available, while privacyuni.com is designed for folks who prefer a more structured, step-by-step learning experience.
Quick disclaimer before we go. This content is provided for educational purposes only and does not constitute legal advice. Also, content might include mistakes. Thank you so much for joining this explainer. I'll leave you with this one final thought. If you had to audit your own company's access logs right this second, could you legally justify every single file your employees open today? Keep learning and always keep your data processing strictly under instruction.
Welcome to the Explainer. Today, we're tackling GDPR Article 30. It's essentially the ultimate blueprint for data compliance. You know, if you've ever found yourself wondering how organizations actually prove they're following privacy rules behind closed doors, well, this is exactly how they do it. Okay, let's dive right into this. Just imagine the absolute chaos for an organization trying to protect information when they don't even know what data they hold, why they have it, or where it's going. I mean, it's kind of like trying to secure a massive, sprawling warehouse without an inventory list. If a data breach happens, absolute panic sets in, simply because you don't even know what was stolen. And honestly, that's the exact problem Article 30 was designed to solve. So to solve this chaos, Article 30 requires what we call a Record of Processing Activities, or a ROPA for short. And as Recital 82 of the GDPR explains, this is exactly how you demonstrate your compliance to the regulators. It's a mandatory written document, which, yeah, can totally be in an electronic format, that details the fundamental who, what, where, and why of your data processing. It is literally the absolute core of the accountability principle in action.
Now, it's important to remember that the law treats organizations differently based on their specific role. Controllers, for instance, dictate the why and how of data processing, right? So their record requirement under paragraph 1 is pretty extensive. Processors, on the other hand, only document the specific categories of processing they perform on the controller's behalf under paragraph 2. So we're talking about two very different compliance checklists here.
For a controller, mapping this out means translating dense legal text into a plain English map of your entire data ecosystem. What are the actual purposes of your processing? Who are the categories of data subjects? Are they employees, customers? And who are you sharing this data with? Are you transferring it outside the EU? When exactly will you delete it? And what security measures are protecting it? It really is a comprehensive map of the whole shebang.
All right, now we need to talk about the infamous 250 employee threshold. Guys, this is absolutely the biggest myth and trap in the entire GDPR. So many businesses read Article 30, Paragraph 5, see that enterprises with fewer than 250 employees are exempt from record keeping, and they just stop reading. But you absolutely cannot stop there, because the law has built-in exceptions that change everything.
See, Recital 13 tried to cut small businesses a break with that derogation, but the Article 29 Working Party made it crystal clear. The exemption is completely erased if you meet any of 3 alternative conditions. You must keep a record if your processing poses a risk to rights and freedoms, involves special, sensitive, or criminal data, or, and here's the massive trap, if your processing is not occasional. Think about it. If you process employee payroll every single month, that's regular, right? Which means it is not occasional. So even a tiny 5-person company has to keep a record for those specific HR activities.
So let's look at how this actually plays out in the real world. A massive tech giant, they're mapping absolutely everything in a highly complex ROPA. A small bakery with 10 employees, they map their regular employee payroll data, sure, but they can safely skip logging a one-off promotional raffle. And then, well, we have our failing company. They get hit with a massive fine because they assumed the 250 employee myth protected them entirely, and they just completely ignored their regular HR data.
And let me tell you, regulators absolutely love Article 30. Just look at enforcement actions across Europe, like the Spanish AEPD's case PS/0059/2020 or the Italian Garante's case 9751362, where Article 30 documentation failures were directly penalized. It's almost always the very first thing they ask for during an investigation to monitor your operations. Paragraph 4 explicitly states you must make the record available to the supervisory authority on request. If they knock on your door and you don't have it, they immediately know you aren't accountable and your investigation is off to a really terrible start.
Let's apply this with a quick mini case study. Imagine a retailer launches a brand new cloud-based loyalty app. Suddenly, all this new data flows to a new cloud processor. So what happens to the paperwork? Well, the retailer, acting as the controller, has to immediately update their blueprint with the new processing purposes and the new processor recipient. At the exact same time, the cloud provider, as the processor, must log their new processing duties on behalf of the retailer. This perfectly proves that the ROPA is a living, breathing document. It is definitely not a one-and-done task.
Okay, let's test your practical understanding with a rapid-fire knowledge check. This is going to simulate a privacy certification exam. Scenario question 1. A business with 50 employees processes monthly payroll. Must they keep an Article 30 record? Is it A, no, because they have under 250 employees? B, yes, it's not occasional? C, only if high risk? Or D, yes, but only for processors? What do you think? Take a quick second to lock in your answer.
And the answer is B. Because payroll happens every single month, it's regular. That means the not occasional exception applies, and the small business absolutely must document it. Now, they don't need a comprehensive record for everything they do, but they must document that specific, regular activity. Moving on, question 2 focuses on the specific legal duties of a processor acting on behalf of someone else. Scenario question 2. What is a data processor explicitly required to include in their Article 30 record? Is it A, purposes of data collection, B, categories of processing carried out, C, data subject consent logs, or D, time limits for erasure? Have your answer ready? The correct answer is B. Under Article 30, Paragraph 2, processors don't dictate the purpose. They simply record the categories of activities they're instructed to execute. They don't have to justify the why, they just have to document the what. All right, question 3 looks at why lawmakers actually created this administrative requirement in the very first place. Scenario question 3. Under Recital 82, what is the primary regulatory purpose of the ROPA? A, tax compliance. B, to serve for monitoring by the supervisory authority. C, to share with data subjects. Or D, marketing analytics. If you guessed B, you hit the nail on the head. It is your ultimate accountability tool, designed specifically to be handed over to regulators so they can monitor your compliance.
It's essentially an internal document built for external proof. Okay, final question. Let's see if you can navigate the nuances of the small business derogation for a unique isolated event. Scenario question 4, a 10-person shop runs a one-off, low-risk promotional contest. Must this specific activity be in their ROPA? A, yes, all activities must be. B, no, it is occasional and low risk. C, yes, because they have employees. Or D, only if they use a processor.
The answer here is B. The Working Party 29 explicitly notes that a truly occasional, low-risk activity without sensitive data does not need to be recorded by a small enterprise. So they gotta log their regular payroll for sure, but they can legally skip this one-off contest. So to wrap things up today, here are your key takeaways. Number 1, Article 30 is your master blueprint for compliance. Number 2, both controllers and processors have specific but very distinct duties. Number 3, beware the 250 employee myth. Regular processing, like HR data, completely negates the exemption. And lastly, regulators use this as their primary baseline to assess your accountability. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I'll leave you with this final, crucial thought. If a supervisory authority requested your Article 30 records today, right now, would you hand them a master blueprint or a tangled mess? Start mapping your data, and we'll see you in the next explainer.
Hey everyone, welcome back to Privacy Trainer. So imagine opening your inbox on a random Tuesday morning to an urgent, formal inquiry from a data protection watchdog. Maybe it's an email, or maybe it's a certified letter. But whatever it is, the clock is now ticking. What's your very next move? Do you forward it to legal? Do you just ignore it because, it went to the wrong department? Or do you totally panic? Well, today let's dive into this explainer of GDPR Article 31. This is an absolutely critical rule that dictates exactly what your organization has to do when the regulators come knocking. And honestly, whether you're a massive tech conglomerate or just a small local business, knowing how to handle these regulatory requests isn't just good PR, it is a strict, undeniable legal requirement.
All right, here's our roadmap for today's explainer. We're going to cover why Article 31 matters, breaking down the law, real-world examples and mistakes, regulator views in a case study, then we'll test your GDPR knowledge, and finally wrap up with takeaways and next steps. We've got a lot of fascinating ground to cover, going straight from the raw legal text all the way to practical scenarios.
Let's jump into Section 1, why Article 31 matters, the front line of compliance.
So, what actually happens when the regulator sends you a formal request? You see, if an organization misunderstands Article 31, a completely simple, routine inquiry can escalate into a massive compliance failure in the blink of an eye. Panicking, burying your head in the sand, or defensively refusing to hand over documentation, all of that transforms a standard checkup into the obstruction of an investigation. Regulators are there to protect fundamental rights, and trust me, they do not take kindly to being ignored or stonewalled. When you fail to cooperate, you're essentially telling the regulator that you either have something to hide or your privacy program is just completely disorganized.
Moving on to Section 2, breaking down the law, the mandate to cooperate. Let's translate this into plain English.
Now, you know what's really wild about the official text of Article 31? It's just incredibly brief. It literally just states that the controller and the processor shall cooperate on request with the supervisory authority in the performance of its tasks. That's the whole shebang. It's short, it's broad, and it is absolute. There are no sneaky legal loopholes here saying you only have to cooperate when it's convenient for you. The legal mandate is simply cooperate, period. And just so we're all perfectly on the same page, when we say supervisory authority, we're talking about the independent public privacy regulators in each country. Think of the CNIL in France or the ICO over in the UK. These agencies are set up to be completely independent so nobody can interfere with their work. In plain English, these are the heavy-hitting data protection watchdogs of Europe. And Article 31 is the rule forcing your organization to answer their calls, open your doors, and assist them.
But here's the thing. Article 31 doesn't just exist in a vacuum. Lawmakers backed it up with other rules so regulators don't have to play a frustrating game of phone tag with a busy CEO who might not know the first thing about data privacy. For instance, Recital 82 explicitly says you've got to make your processing records available on request. And then, under Article 39, your Data Protection Officer, or DPO, is legally designated as the primary point of contact. This means regulators can totally bypass the executive suite and go straight to your DPO, expecting immediate, knowledgeable help.
Let's look at Section 3, Real-World Examples and Mistakes. Theory meets practice.
Okay, so a really huge misconception we see all the time across the industry is this idea that Article 31 only kicks in during a full-blown crisis, like a massive data breach or some headline-making investigation. But honestly, that is fundamentally false. Actual compliance means you have to cooperate for any routine inquiry, a standard audit, or even a basic request stemming from a single, everyday customer complaint. Regulators spend a ton of their time just gathering facts, and you are obligated to help them do exactly that.
And that brings us to another major slip-up. As the European Data Protection Board highlights right here in this guideline, processors, not just controllers, are legally bound to cooperate upon request. Before the GDPR, processors had very few direct legal obligations, but the GDPR changed all of that. Yet lots of vendors and cloud providers still mistakenly believe the regulator can't touch them. You cannot legally hide behind your clients when the watchdog comes knocking.
Let's look at 3 quick scenarios. First, imagine a tech company acting as a cloud provider. As a processor, they absolutely must hand over back-end security logs directly to the regulator if the regulator is investigating one of their clients. Second, a local bakery. If they get an email from the regulator about a customer's deleted account, they have to answer promptly. Being small doesn't grant you immunity. And third, the classic compliance failure. Ignoring regulatory emails because they went to some unmonitored privacy inbox. Saying, oh, it went to spam is definitely not a valid legal defense.
Moving right along to Section 4, Regulator Views and Case Study. Inside the investigation.
When regulators evaluate your cooperation, they look at 3 main things: promptness, documentation, and transparency. And get this, according to official fining guidelines, your degree of cooperation directly impacts the size of your financial penalty. They expect timely replies, comprehensive documentation like your Article 30 records, and honest, open communication. If you drag your feet, your penalty goes up. If you lack basic records, it shows systemic negligence. And if you outright obstruct them, you're looking at maximum fines. Play nice, be prepared, and it could literally save you millions.
Let's do a quick mini case study to highlight this. We'll call it the silent vendor. So a regulator asks an HR software provider for their back-end data flow records. The vendor just actively ignores the request, claiming internally that their enterprise clients are solely responsible for answering. The analysis here is crystal clear. Under Article 31, processors have a direct, independent statutory obligation to cooperate. By staying silent and trying to pass the buck, this vendor didn't protect themselves. They just bought themselves a massive compliance failure and a hefty fine for obstruction.
All right, Section 5, test your GDPR knowledge, certification prep. Let's see how you do with a couple of scenario-based questions.
Question 1. Read the scenario carefully. A supervisory authority contacts your company regarding a consumer complaint. Who is legally tasked under the GDPR to act as the primary contact point and cooperate with this authority? Is it A, the Chief Executive Officer, B, the lead software engineer, C, the Data Protection Officer, or D, outside legal counsel? Take a second and think about who the GDPR explicitly names for this structural role.
And the correct answer is C, the Data Protection Officer. Now, it's a common trap to pick outside legal counsel here, and sure, they'll definitely help you strategize your response. But under Article 39, the GDPR specifically assigns the statutory task of cooperating and acting as the official point of contact to your DPO.
Let's try one more. True or false scenario. Your company is strictly a data processor for a large multinational bank. The local supervisory authority requests your internal processing logs. You can legally refuse by telling them to contact the bank instead. So is that A, true, B, false, C, only if the bank approves, or D, only if there is a data breach? Think back to our silent vendor.
The correct answer is B, false. Like we talked about at length, Article 31 explicitly states that both the controller and the processor shall cooperate. You absolutely cannot hide behind your controller. Processors have an independent, direct duty to cooperate under the GDPR, and catching this misconception now saves you massive headaches later.
And finally, Section 6, Takeaways and Next Steps, Securing Your Compliance. Okay, here is your foundational checklist to take away from this. First, always remember that Article 31 applies to both controllers and processors alike. Nobody gets a free pass. Second, make sure your team knows cooperation is required for all routine requests, not just during huge data breaches. Third, empower your DPO as the designated legal point of contact. Fourth, and this is super practical, keep your Article 30 processing records continuously updated and ready to go.
Ultimately, remember that treating the regulator as a professional partner instead of a hostile adversary isn't just good business practice, it's the law, and it can seriously reduce your fines.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification prep resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available right here on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience.
Please note that this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. Thank you so much for joining me for this explainer. I'm going to leave you with this one final provocative thought to take back to your team. If a regulator sent a formal inquiry to your company's general inbox right this second, how prepared is your organization to answer the door?
All right, let's dive straight into one of the absolute most critical pieces of the GDPR, Article 32. Welcome to this Privacy Trainer explainer. Whether you're a compliance pro, a lawyer, a business leader, or totally new to the GDPR, figuring out how to actually secure data legally is, well, it's pretty much essential. We're going to decode the legal text, ditch the textbook jargon, and show you exactly what this looks like in the real world.
But before we get bogged down in the legal text, we really need to ask, what actually happens when organizations get this wrong, when security fails? I mean, we've all seen the headlines, right? Massive data breaches, ransomware, locking up hospitals, massive regulatory fines, and basically a total loss of customer trust. Article 32 is designed to prevent exactly that, or at the very least, make sure you've got the proper shields up when an attack inevitably happens.
So, here is our roadmap for today's explainer. We'll start by decoding Article 32, look at some real-world scenarios, discuss failures and enforcement, walk through a mini case study, tackle a quick knowledge check, and wrap up with takeaways and next steps.
Let's kick things off with Section 1, Decoding Article 32, Translating the Law into Practice. Let's look at the actual rule in plain English. It essentially says that controllers and processors must implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk. The really crucial takeaway here? Article 32 does not give you a rigid checklist. It's not going to tell you to go buy a specific brand of firewall. Instead, it demands that your security scales dynamically based on the specific risks of what you're actually doing with the data.
And honestly, this brilliantly shows the balancing act lawmakers were going for. Like, how do you even know what appropriate means? Well, the GDPR says you have to weigh a few things. You look at the state of the art, what tech is out there right now. You also have to consider the costs. Then you weigh the nature, scope, context, and purpose of your processing against the likelihood and severity of risks to people's freedoms. It's like a calculated risk-based puzzle. And it even explicitly calls out measures like pseudonymization and encryption as good ideas.
Moving right along to Section 2, Real-World Security Scenarios, Scaling Security to Fit the Risk.
To see how this plays out in real life, let's look at two totally different businesses. If a local small insurance business gets a call from someone claiming to be a client, an appropriate organizational measure might just be hanging up and calling the client back on the phone number they already have on file. Boom! Confidentiality protected, no million-dollar software needed. But contrast that with a massive tech company processing huge volumes of highly sensitive data. The risk there is astronomical, right? So the law expects them to use state-of-the-art encryption, ongoing pseudonymization, and highly resilient servers. So the bottom line is security scales to the risk.
All right, Section 3, Failures and Enforcement, and the Burden of Proof.
So, what happens when regulators come knocking after a breach? Well, look at this super interesting ruling from the Court of Justice of the European Union, specifically case C340/21. This case firmly anchors the principle of accountability. It basically means if you get hacked, you can't just throw your hands up and say, wow, those hackers were just too sophisticated. Nope. You, as the controller, bear the burden of actually proving you had appropriate measures in place before the attack. You literally have to show your homework.
Let's put this into practice with Section 4, a mini case study and a step-by-step security analysis.
Imagine your company is launching a brand new, super data-heavy software service. How do you actually apply Article 32? You'd follow these exact steps. First, pinpoint your specific processing risks. Are we talking accidental loss here, or maybe an unauthorized disclosure from an outside hack? Second, implement targeted measures. That means technical stuff, like database encryption, but also organizational stuff, like making sure your team is trained not to click on obvious phishing links. And third, and people miss this all the time, continually test and evaluate those measures. Security isn't some set-it-and-forget-it project. It requires constant resilience.
Okay, time for Section 5, Knowledge Check to test your Article 32 understanding.
Let's run through some certification-style questions to make sure this is all sticking. Question 1. In an action for damages after a cyber attack, who bears the burden of proving that the implemented security measures were appropriate under Article 32? Is it A, the data subject, B, the supervisory authority, C, the processor, or D, the controller? Give it a second and think back to that CJU ruling we just talked about.
If you guess D, the controller, you hit the nail on the head. Ultimate accountability for proving compliance rests entirely on the controller's shoulders. You've got to have that evidence ready to prove your defenses were appropriately matched to the risk.
Moving on to question 2. Does Article 32 require a controller to implement measures that guarantee absolutely no data breaches will ever occur? A. Yes, 0 breaches are required. B. No, measures must simply be appropriate to the risk. C. Only for sensitive health data. Or D. Only if the company has over 250 employees. Think about how the law balances risk with available technology.
The correct answer is B. No, measures must be appropriate to the risk. The law is actually quite pragmatic here. It expects a rigorous risk-based defense, for sure, but not impossible perfection. As the courts noted, if 0 breaches were required, then proving your measures were appropriate wouldn't even make sense.
All right, question 3. According to Article 32, Paragraph 3, what is one specific way a processor or controller can demonstrate compliance with these security requirements? A. Publishing a public apology. B. Using only European servers. C. Adherence to an approved code of conduct or certification mechanism. Or D. Relying solely on a written privacy policy. This is a really great tool built right into the GDPR.
And the answer is C, adherence to an approved code of conduct or certification mechanism. Engaging with an approved code of conduct is a fantastic way to document your commitment to security. It proves to regulators that you aren't just making things up as you go, but you're actually following vetted, recognized standards.
Final question, number 4. When assessing the appropriate level of security, Article 32, Paragraph 2 states account shall be taken of the risks presented by processing, in particular from what? Is it A, economic inflation, B, accidental or unlawful destruction, loss, alteration, or unauthorized disclosure, C, hardware depreciation, or D, competitor espionage? Think about the core threats to data that the GDPR actually cares about.
The answer is B, accidental or unlawful destruction, loss, alteration, or unauthorized disclosure of personal data. These specific risk factors literally have to form the baseline of every single security risk assessment you do. Whether a server crashes by accident or a hacker steals a password intentionally, these are the exact risks you're required to mitigate.
Section 6, Takeaways and Next Steps. Let's get into some final thoughts. Let's wrap this explainer up by distilling everything down to the most critical lessons. If you take absolutely nothing else away today, remember these 4 pillars. First, security is scalable. A local shop doesn't need an enterprise budget, but measures must match the actual risk. Second, the burden of proof is on you. Controllers have to proactively prove their security was appropriate. Third, continuous evaluation. Your security posture has to be a living, breathing process that adapts to new tech and new threats. And finally, prove your compliance by using recognized tools like approved codes of conduct. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience.
And just as a quick reminder, disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. So, knowing that the burden of proof sits entirely on your shoulders, are you ready to fundamentally rethink your organization's approach to Article 32? Thanks so much for learning with us today, and stay secure out there.
Picture this. It's Friday evening, you're just about to log off, and suddenly, your IT security team spots something weird on the network. A database full of customer information has just been accessed by an unauthorized third party. I mean, let's be honest here, absolutely no one wants to deal with a ransomware attack when they're just trying to start their weekend. But here's the real kicker. What actually happens the exact second you discover that data breach? Well, from that very moment, a 72-hour countdown begins. This ticking clock is essentially the ultimate compliance safety net of the GDPR, specifically Article 33. And you know, understanding this rule, it's not just about avoiding those massive regulatory fines. It's really about protecting real people, maintaining trust, and knowing exactly how to handle a crisis before it even blows up. Okay, so let's jump right into our roadmap for today's explainer. We'll start with an Article 33 overview, move into a 72-hour walkthrough, check out some real-world scenarios, discuss enforcement and pitfalls, tackle a case study and knowledge check, and finish up with our key takeaways and wrap-up. All right, Section 1, Article 33 Overview, the ultimate safety net. So at its core, Article 33 is all about transparency and damage control. Lawmakers built this into the GDPR framework to guarantee that when things go sideways, and let's face it, they sometimes do, the right authorities are brought into the loop immediately. The legal text itself says that if there's a personal data breach, the data controller has to notify the supervisory authority, basically the regulator, without undue delay and, where feasible, not later than 72 hours. To put that into plain English, if your organization decides how and why data is processed, you literally have 3 days to tell the regulator you've been breached. Is there an exception? Just one. If the breach is unlikely to result in a risk to the rights and freedoms of individuals, you don't have to notify the regulator. But don't let your guard down, because even then, you still have to keep an internal record of it. Moving right along to Section 2, the 72-hour walkthrough, mechanics and recitals. The timeline of a breach is absolutely critical to understand. Time zero is the exact moment the incident happens in the real world. But here's the thing. The 72-hour clock doesn't necessarily start ticking right then. The European Data Protection Board, or EDPB, has clarified that the clock officially starts at awareness. And what does awareness actually mean? It means you have a reasonable degree of certainty that an incident occurred and personal data was compromised. The second you cross that threshold, bam, your 72 hours start. Now, what if you can't get all the facts within that tight 3-day window? No worries. The law allows for phased reporting. This means you can give the regulator initial details and provide ongoing updates as your investigation unfolds. We also need to get crystal clear on the different roles here. If you're the data controller, meaning you're the main organization accountable for the data, you own that 72-hour deadline. It's your responsibility to notify the regulator. But what if you're a data processor, say a third-party cloud hosting provider? Well, under Article 33, Paragraph 2, a processor has to notify the controller without undue delay the moment they become aware of a breach. Processors aren't there to assess the risk, and they certainly don't go rogue and call the regulator. Their one job is to immediately ring the alarm for the controller so the controller can kick off their own 72-hour clock. To really wrap our heads around Article 33, we have to look at the supporting recitals. Think of them as the why behind the rules. Recital 87 is a big one. It makes it extremely clear that lawmakers expect you to already have technical and organizational measures in place to spot a breach the second it happens. You can't just stick your head in the sand, ignore your security, and later claim, well, we weren't aware. That doesn't fly. You are legally expected to have proactive detection systems so you can jump in and mitigate those risks promptly, which is exactly what Recital 85 demands. Let's ground this in Section 3, Real-World Scenarios. Article 33 in practice. This is where it gets interesting because the rules apply differently depending on the context. Imagine a massive SaaS company gets hit with ransomware and their data gets encrypted. Even if the hackers didn't steal a single byte of data, this is still considered a loss of availability. That triggers Article 33, and they have to notify the regulator within 72 hours. Now contrast that with a local shop owner who accidentally leaves a work laptop in a coffee shop. If that laptop has state-of-the-art encryption and the decryption key is perfectly safe, the EDPB says this is highly unlikely to pose a risk to anyone, so no regulator notification needed. But remember that exception we talked about? Under Article 33, Paragraph 5, that shop owner still has to document the lost laptop internally. And finally, if an organization just flat out ignores their system logs, that's a textbook compliance failure. Regulators will hand down massive fines, not just for the poor security, but for failing to report the breach entirely.
Moving on to Section 4, Enforcement and Pitfalls, the regulator's perspective. So, how do European regulators and courts actually treat this? Well, a huge mistake organizations make is waiting for their forensics team to finish their entire investigation before picking up the phone. Don't do that. The clock is ticking. Use phased reporting instead. Another common trap is failing to document those low-risk breaches we just mentioned. If a regulator comes knocking and you have zero internal records, you're in trouble. In fact, if we look at case C654-23, the courts made it clear that early cooperative notification is a mitigating factor. It can literally lower your fine. And case C340/21, it firmly established that the burden of proof is entirely on the controller. You have to prove you acted properly. The regulator doesn't have to prove you didn't. All right, let's put this into practice in Section 5, Case Study and Knowledge Check, Test Your Readiness. Let's put on our privacy practitioner hats for a second. Here's the scenario. It's late Friday night and a ransomware variant encrypts your main customer database. Now, you do have offline backups, which is great, but it's going to take your team a few days to restore everything. So here's the GDPR question. Is this a notifiable breach? The answer is a resounding yes.
The EDPB explicitly states that even a temporary loss of data availability counts as a data breach. You've got to notify the supervisory authority within 72 hours of establishing a reasonable certainty that the attack happened, even if you're still scrambling to figure out the exact number of users affected. Let's jump into our certification-style knowledge check to really test your grasp of the starting line. Question 1. When does the 72-hour notification clock officially start for a controller? Is it A, when the security alert first triggers? B, when the controller has a reasonable degree of certainty a breach occurred? C, when the forensics team finishes their report? Or D, when the processor fixes the vulnerability? Have a think about it.
And the answer is B. As we discussed, the EDPB guidelines are super clear that the clock starts at awareness. And awareness means you have a reasonable degree of certainty that personal data was actually compromised. You definitely don't wait for forensics to wrap up, and it's not always the exact microsecond a raw, unverified security alert pops up.
Okay, moving to question 2. Let's look at the processor's role. What is a processor's obligation under Article 33 when they discover a data breach? A, assess the risk and notify the SA. B, notify the data subjects directly. C, notify the controller without undue delay. Or D, wait 72 hours before reporting.
The correct answer here is C. Remember, processors are not there to assess risk, and they don't generally talk to the regulator or the data subjects. Their absolute priority is to alert the controller immediately, without undue delay, so the controller can take the steering wheel and start their own 72-hour clock.
Here is question 3, and this is a classic real-world dilemma. You are 70 hours into an incident response investigation. You still don't have the exact numbers of affected users, and your clock is almost entirely run out. What should you do? A, wait until you have exact numbers to notify. B, notify the SA with available info and use phased reporting. C, cancel the notification. Or D, ask the processor to notify instead.
If you guessed B, you hit the nail on the head. Article 33, paragraph 4 is a lifesaver here because it allows for phased notification. You submit the initial report with whatever information you have right then and there before the 72 hours expire. You just tell the regulator, hey, more details are coming as we continue our investigation.
And finally, Section 6. Key takeaways and wrap-up, securing your compliance. Let's quickly synthesize everything we've talked about so you can bring this straight back to your organization. First, you've got to track that clock. The 72 hours begin the moment you reach reasonable certainty. Second, if you are acting as a processor, your job is to communicate fast, without undue delay. Third, do not miss your deadline just because the picture's a bit fuzzy. Use phase reporting to buy yourself time. And fourth, document absolutely everything. Even if a breach is so tiny and low risk that the regulator doesn't need to know, Article 33, paragraph 5 makes it a strict legal requirement to keep an internal record of the whole shebang. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience.
Disclaimer. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes.
I want to leave you with one final provocative thought to take back to your team and your leadership. Honestly ask yourselves, are your internal detection systems actually fast enough to identify a threat, establish certainty, and beat that ticking 72-hour clock? Thanks for hanging out with me for this explainer. Keep learning and keep your data safe.
All right, let's dive right in. Welcome to Privacy Trainer. Today, we're tackling the high-stakes world of GDPR Article 34. In this explainer, we're going to walk you through what is essentially the ultimate crisis management protocol. Whether you're a privacy pro, a business leader, or a student just dipping your toes into data protection, this is the exact article that defines what you say and how you communicate when things go horribly wrong.
We've got a packed agenda today. We'll be running through 1. The Article 34 crisis. 2. Breaking down the rules. 3. Recitals explained. 4. Scenarios and mistakes. 5. Case study and enforcement. And finally, 6. Test your knowledge and takeaways. Let's get started. Okay, picture this. You just got the call. Your servers are compromised, the databases have been leaked, and honestly, panic is setting in across the entire executive team. The absolute first question you're asking is, who do we need to tell and how fast? It's literally one of the most stressful moments any organization can face. But I want you to think of Article 34 not as just another piece of bureaucratic red tape, but as a critical flashlight in the dark. It exists to protect vulnerable people from immediate harm like identity theft or financial loss. It's about giving individuals the power to protect themselves when you, unfortunately, can no longer protect their data.
Section 1. The Article 34 Crisis, an overview.
So here's a crucial pivot you absolutely have to understand, because people mix this up all the time. Article 33, that's about telling the supervisory authority, or the regulator, when there's simply a risk to individuals. But Article 34 demands you tell the individual data subjects themselves. And notice the trigger here is much higher. There has to be a high risk. You know, you don't want to cause unnecessary notification fatigue for every single minor IT glitch. But when the threat is severe, you have to speak directly to the people affected.
Moving on to Section 2, breaking down the rules. Let's translate this legal text into plain English. We keep tossing around the phrase high risk, but what does that actually mean on the ground? Basically, it means the affected person could suffer real, tangible harm. The European Data Protection Board guidelines outline that this includes things like discrimination, identity theft, fraud, or even serious reputational damage. So if someone's credit card numbers or medical records are out there, yeah, that easily hits the high-risk threshold, which means you have to communicate with them without undue delay. Now, if you hit that high-risk threshold, Article 34, Paragraph 2 kicks in and dictates exactly what your email or letter has to say. And here is the golden rule. Seriously. No legal jargon. You absolutely cannot just copy and paste the dry technical report you sent to the regulator. You have to use clear, plain language to explain what happened. You need to provide the name and contact details of your data protection officer, outline the likely consequences, and crucially, explain exactly what measures you're taking to fix it and how the individual can protect themselves, like telling them to go change their passwords immediately. But wait, what if you have millions of users? There's a relief valve built into the law for that. Article 34, Paragraph 3 outlines when you don't actually have to email everyone. First, if you had strong, state-of-the-art encryption in place, the data is unintelligible to the hackers. No risk, no notification. Second, if you instantly neutralize the threat before any harm could be done. And third, if contacting everyone requires a disproportionate effort. But be super careful with that last one. If you invoke it, you are still legally required to issue a public communication, like a massive press release or a very prominent website banner.
Section 3. Recitals explained.
To really grasp how the lawmakers were thinking here, we have to look at the hidden gems of the GDPR, the recitals. Recital 85 brilliantly illustrates the why behind all this. It reminds us that a data breach isn't just a technical IT problem. It is a human problem. It's all about preventing loss of control, financial ruin, or damage to someone's reputation. If a breach is mishandled, real people suffer. And this recital, it's exactly what regulators point to when calculating massive administrative fines for companies that try to sweep a breach under the rug.
Section 4, Scenarios and Common Mistakes.
Let's anchor this in reality with some practical examples straight from the EDPB guidelines. Look at the tech company here. They avoid notifying users entirely because their stolen laptops had full disk, state-of-the-art encryption. The data is securely locked, so the high risk is mitigated. On the flip side, imagine a small business where a flooded warehouse destroys all their physical paper records. They've literally lost the contact details of their clients. This triggers the disproportionate effort exception. You can't mail letters to addresses you don't have, right? So they have to use a public notice instead. And the third scenario, the classic compliance failure. Ignoring a breach because you're scared of bad PR is a guaranteed way to turn a manageable IT headache into a massive regulatory nightmare. Now let's talk timing, because this specific number trips up a lot of seasoned pros. Article 33 gives you exactly 72 hours to notify the regulator. But Article 34, it just says you must notify individuals without undue delay. What does that actually mean? Well, if there's an immediate threat, like compromised passwords where attackers could be draining bank accounts right this second, you can't just sit around and wait 72 hours. You have to act instantly so your users can protect themselves.
Section 5, Enforcement and Case Study. Regulators heavily scrutinize Article 34 during audits. They want to see your homework. They look for documented evidence of your risk assessment to see exactly why you decided a breach was or wasn't high risk. So let's walk through a mini case study. Ransomware hits a hospital network, and unencrypted patient health records are exposed to the attackers. The business challenge is getting systems back online, but the privacy issue is absolutely massive. Does Article 34 apply here? Absolutely, because health data is a special category under the GDPR. Exposing it creates a severe, automatic high risk to those patients. The correct analysis mandates immediate, plain language communication directly to the patients, right alongside your regulatory notification.
Section 6, test your privacy knowledge. Okay, time to put your skills to the test with a certification-style scenario question. These are designed to challenge your deep understanding, not just your memory. Imagine this. A retailer loses an unencrypted database of customer addresses, but the backups are totally corrupted and all the contact emails are gone. Take a second to think about the exceptions we discussed regarding disproportionate effort. Looking at the options, which one is the most compliant action? And the correct answer is C. As outlined in the EDPB guidelines, losing those contact details makes direct communication literally impossible, which legally triggers the disproportionate effort exception. But remember, you don't get to just walk away and wash your hands of it. You still have to inform the public in an equally effective manner, like splashing a banner on your homepage or issuing a press release, so those customers at least have a chance to know their data was compromised.
Let's wrap this up with our key takeaways.
Let's lock in the most critical takeaways from our deep dive today. First, remember Article 34 is only triggered by a high risk to individuals. Second, your communication has to be in plain English. No legalese allowed. It needs to detail the nature of the breach, the consequences, and how they can mitigate harm. And finally, while you must act without undue delay, remember that strong, state-of-the-art encryption is your absolute best friend when it comes to avoiding mass notification fatigue.
If you're enjoying these GDPR explainers and want to support the channel, please consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education globally.
And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam certification prep, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available right here, while privacyuni.com is designed for learners who prefer a more structured, step-by-step experience.
Finally, just a quick reminder that this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes, so always consult qualified legal counsel for your specific crisis situations. Thanks for joining me on this explainer, but before you go, ask yourself this. If your database leaked tonight, would you know exactly who to email tomorrow morning? Keep protecting that data, and I'll see you in the next one.
Hey everyone, welcome back to another explainer. Today we're unpacking an absolute heavyweight of the GDPR, Article 35. You can really think of Article 35 as your ultimate navigational map for launching new technology safely. We're going to dive deep into data protection impact assessments, or DPIAs, and transform all that dense legal text into a practical, everyday strategy you can actually use.
All right, let's take a quick look at our agenda for today. First, we'll look at the high-risk privacy problem. Then we'll translate the DPIA rules, run through some real-world DPIA scenarios, and look at common mistakes and regulatory focus. After that, we'll do a quick Privacy Pro knowledge check and wrap it all up with key takeaways and resources.
Okay, kicking things off with Section 1, the high-risk privacy problem. So, to really get why Article 35 matters, we kind of have to look at the problem it was built to solve. The GDPR isn't just some punishing rulebook, you know? It's fundamentally a vital safety net for innovation. Imagine your company is about to roll out a massive new AI tool, or maybe some facial recognition software. The big question is, launching new tech? Wait a second, have you mapped the risks? Because if you blindly launch high-risk processing without that safety net, you're literally stepping onto a landmine of catastrophic compliance failures, massive fines, and most importantly, severe harm to the actual people whose data you hold.
And that's exactly where our solution comes in. A Data Protection Impact Assessment, or DPIA, is a mandatory process under Article 35 to evaluate and mitigate high risks to the rights and freedoms of individuals right before you start processing anything. And I want to emphasize, this isn't just bureaucratic paperwork. It's a preventative hazard check. It forces you to pause, look at the tech, figure out how it could potentially exploit or harm people, and build in safeguards before a single piece of data is ever processed.
Moving right along to Section 2, translating the DPIA rules.
So, you might be wondering, when exactly do we have to do this? Well, let's break down the actual legal text of Article 35, Paragraph 3 into a plain English toolkit. The law uses these super dense phrases like systematic and extensive evaluation, but in practice, this means automated decisions and AI profiling that actually affect people's lives, like an algorithm deciding if you're going to get a mortgage. Another clear trigger is the large-scale processing of sensitive data, so things like health records or biometrics. The third is large-scale monitoring of public areas, think citywide CCTV. And as a general rule of thumb, the European Data Protection Board highlights that using new, unproven technologies almost always warrants a DPIA.
But hey, what happens if you do the assessment and the risk is still, dangerously high? Well, this brings us to a really critical companion to Article 35, which is Article 36 and Recital 94. It basically says that if your DPIA shows a high risk that you simply cannot mitigate with your current technology or budget, you can't just shrug and move forward. You absolutely must stop and consult your supervisory authority before hitting the launch button. It's a mandatory regulatory reality check.
All right, Section 3, Real-World DPIA Scenarios.
Let's step into the real world for a second and look at a quick comparison based on those EDPB guidelines. Scenario 1. A tech company rolling out AI facial recognition. Do they need a DPIA? Absolutely yes. It's the systematic processing of special biometric data. Scenario 2. A small business running their standard payroll.
DPIA required? Nope. It's not large-scale and it's not inherently high risk to fundamental freedoms. Scenario 3. A company rushing a virtual voice assistant to market without even checking what background audio it captures. Did they need a DPIA? Yes, but they ignored it. And guys, this is a classic compliance failure that regulators will penalize heavily.
Let's zoom in on a specific mini case study straight from the EDPB guidance on connected vehicles. Step 1. The business challenge. A company wants to launch a fleet tracking system. Step 2. The privacy issue. This is going to involve large-scale, continuous location data collection of their drivers. Step 3. The GDPR analysis. By doing a DPIA early in the design phase, the company identifies the risk of excessive surveillance. Because they caught it early, they can implement data minimization and strict access controls before the software is even written, literally saving the project from a future legal disaster.
Next up, Section 4. Mistakes and regulatory focus.
You know, even with all these guidelines out there, organizations still get this wrong all the time. Here is the absolute most dangerous misconception we see: treating the DPIA as a one-time checkbox that you just fill out right before launch. This is fundamentally wrong. The correct approach, which is mandated by the law, is that a DPIA is a continuous, ongoing process. You have to start it during the early design phase, and you have to review and update it whenever the risks of your processing operations change.
Because when regulators come knocking, they know exactly what they're hunting for. First, they'll check if your processing falls under their published mandatory DPIA lists. And they aren't just looking for empty promises. They're evaluating concrete evidence of exactly how you mitigated those risks. They're going to check if you did your Article 36 prior consultation when residual risks were too high. I mean, just look at the sweeping enforcement actions we've seen, like the French CNL's €20 million fine against Clearview AI for unlawful biometric processing. Ultimately, your DPIA is your primary proof that you actually baked data protection by design into your operations.
Okay, time for Section 5, the Privacy Pro-Knowledge Check.
Let's see how well you've grasped Article 35 with 4 rapid-fire, scenario-based certification questions. Here's question 1. Which scenario automatically triggers a mandatory DPIA under Article 35, Paragraph 3? Is it A, a small cafe using a basic CRM? B, a single doctor managing a patient list? C, a bank using AI profiling to deny loans? Or D, an employer reimbursing travel expenses? Take a quick second.
And the answer is C, a bank using AI profiling to deny loans. Just like we translated earlier, automated decision-making that produces a legal or significant effect on a person is a direct, explicit trigger for a mandatory DPIA under the GDPR.
All right, question 2. Your DPIA reveals a high privacy risk, and despite your best efforts, you simply cannot find the technology or budget to mitigate it. What is your next required step? A, launch anyway. B, consult the supervisory authority. C, ask users for broad consent. Or D, delete the DPIA.
The correct answer is B. Consult the supervisory authority prior to processing. Remember, Article 36 and Recital 94 are super strict about this. If those residual risks remain high and you can't fix them, you absolutely cannot proceed without regulatory consultation.
Moving on to question 3, and this one is anchored right in the EDPB guidance. A law enforcement agency wants to deploy facial recognition technology. How should they handle the DPIA? A, it's optional for law enforcement. B, do it after the pilot program. C, mandatory before deployment. Or D, only required if the public complains.
It's C, mandatory before deployment. The EDPB is clear that facial recognition inherently involves the systematic, automatic processing of special categories of data. So a prior DPIA is an absolute requirement, no exceptions for pilot programs.
And our final question. Question 4. Does the processing of personal data from patients by an individual physician require a DPIA? A, yes, because health data is sensitive. B, yes, if they use a computer. C, no, they are exempt from all GDPR rules. Or D, no, it is not considered large-scale.
The answer is D. No, it is not considered large-scale processing. Now, while health data is absolutely sensitive, the GDPR actually explicitly states in Recital 91 that processing by an individual healthcare professional is not large-scale, which means a DPIA isn't automatically mandated.
And that brings us to Section 6, Key Takeaways and Resources.
That last question brilliantly illustrates the nuance of the law, doesn't it? It's all about scale, risk, and context. So let's bring everything we've learned together. Here are your core lessons. First, DPIAs are continuous tools to map and mitigate high risks early in the design process, not just right before you launch. Second, they're mandatory for things like AI profiling, large-scale sensitive data use, and public monitoring. Third, if you can't mitigate a high risk, Article 36 demands that you consult regulators. Now, if you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer.
Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale that education globally. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and certification prep resources, you can explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available, while privacyuni.com is really designed for learners who prefer a more structured, comprehensive learning experience. And finally, a quick disclaimer. This content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. So, I'll leave you with this to think about. What high-risk tech are you launching tomorrow, and is your DPIA actually ready?
Welcome to Privacy Trainer. Today, we're diving into GDPR Article 36, which is all about prior consultation. You can really think of this as the GDPR's ultimate safety valve. So, what actually happens when you want to do something highly innovative with personal data, but the privacy risks are just, well, incredibly high? If you misunderstand this article, you could be staring down outright bans on your processing and, of course, massive fines. But if you get it right, it becomes this amazingly powerful collaborative shield between you and the regulator.
Okay, let's dive into this. Here's our quick roadmap for today's explainer. We've got 1. The safety valve. 2. An Article 36 walkthrough. 3. Real-world scenarios. 4. A case study. 5. A knowledge check. And finally, 6. Key takeaways. Let's get moving.
All right, kicking things off with Section 1, the safety valve.
So, processing high-risk data obviously comes with some massive challenges. And sometimes, despite your absolute best efforts, you just hit a total roadblock in your compliance journey. The big question is, what happens when your privacy risks are simply too high to mitigate? Well, imagine you're building a massive new fireworks factory. You've added the sprinklers, you put in the fire doors, and that's your risk mitigation, right? But the fundamental risk of, well, an explosion, it's still there. You don't just open the doors and cross your fingers. No way. You call the fire marshal. You consult the experts. And under the GDPR, Article 36 is essentially that mandatory call to the fire marshal when you just can't lower the danger yourself. So what exactly is Article 36? Let's break it down. It's the mandatory process of seeking advice from the supervisory authority before you start processing data. And this is triggered specifically when a data protection impact assessment, that's your DPIA under Article 35, shows unmitigated high risks. In plain English, it's basically a collaborative pause button. You did your DPIA, you really try to lower the risks, but they're still stubbornly high. Article 36 is your legally required next step.
Let's see how this actually builds into a practical workflow. First up, you conduct your DPIA. Second, you identify that despite all your safeguards, an unmitigated high risk still remains. Third, you submit your planned processing to your Data Protection Authority, or DPA. And fourth, and this is absolutely crucial, you wait. The DPA has up to 8 weeks to provide written advice, and honestly, they can even extend that by another 6 weeks if the processing is complex. You absolutely cannot start processing during this mandatory waiting period, so don't even try it.
Now, what's really interesting here is exactly what you have to hand over to the regulator. Article 36, paragraph 3, lays out the required submissions, and they essentially need your exact blueprint. You've got to provide the purposes and means of the intended processing, the measures and safeguards you've built, the contact details of your data protection officer, the full DPIA document, and the respective responsibilities of the controllers and processors involved. So complete transparency is legally required here, just so the authority can accurately assess the danger.
To really grasp the spirit of this law, we need to look at the recitals. Recital 94 clarifies that this consultation has to happen prior to processing when the risk cannot be mitigated by reasonable means in terms of available technologies and costs. This actually aligns perfectly with the EDPB guidelines on DPIAs, specifically WP 248, which heavily emphasizes proactive risk management. And then Recital 95 adds a really important layer. If you're a data processor, you are legally mandated to actively assist the controller in this whole consultation process. It's a complete team effort to ensure data safety.
And this brilliantly illustrates how this plays out in the real world based on guidance from the European Data Protection Board. Let's compare compliance versus failure. A compliant approach, well, that's a tech company pausing the deployment of an AI facial recognition system for law enforcement so they can consult the supervisory authority because they recognize the intrinsic high risks to people's freedoms. But a massive failure? That would be an automotive company launching some highly intrusive connected vehicle tracking that monitors driver behavior, totally ignoring the unmitigated risks found in their DPAI, and just completely skipping the consultation. Don't be that company.
Those failures usually stem from a few very common mistakes. The absolute biggest one is treating Article 36 as just some bureaucratic formality. It's really not. It's a genuine, serious safety check. Other major errors include leaving the data protection officer out of the communication loop, ignoring the really valuable insights from your data processors during the assessment, or, and this is a big one, prematurely launching the product. Like falling into the timeline trap and deploying on week 7 of that critical 8-week regulatory review window.
So the crucial point to remember here is how regulators actually view this. They aren't just taking your paperwork and filing it away in a dusty cabinet somewhere. They are rigorously evaluating the adequacy of your risk mitigation attempts and the completeness of your DPIA. Under Article 58, the supervisory authority has the investigative and corrective power to literally ban your processing entirely if they feel the risk to data subjects is just too severe. They expect strict, total adherence to their written advice.
Okay, let's put this into practice with a mini case study. Imagine a large retail chain wants to implement AI-driven behavioral tracking across all its physical stores to hyper-personalize their marketing. But there's a catch. Their DPIA reveals extreme profiling risks, and the cost or the tech required to fully anonymize that shopper data is just simply out of reach for them, so the risk remains completely unmitigated. What on earth do they do?
Well, here is the exact step-by-step analysis to solve this correctly under Article 36. Step 1, halt deployment immediately. Just stop.
Step 2, the data protection officer officially engages the supervisory authority. Step 3, they submit the full DPIA outlining the AI technology and whatever safeguards they actually did manage to afford. And finally, Step 4, they wait for and strictly follow the SA's written advice. And keep in mind, that advice might actually mean altering the technology entirely, or just accepting that they simply cannot deploy it in its current form.
All right, time to test your knowledge with a few certification-style questions to make sure this is all really sinking in. Question 1. When is a prior consultation strictly required? Is it A, after a data breach, B, unmitigated high risk in a DPIA, C, when hiring a DPO, or D, transferring data?
And the answer is B. Article 36 is specifically triggered when a data protection impact assessment indicates a high risk that the controller cannot mitigate. Remember, without that unmitigated risk identified in the DPIA first, Article 36 just isn't triggered. Moving right along, let's look at statutory timelines. Question 2. How long does the supervisory authority initially have to provide written advice once you submit your request? Is it A, 4 weeks, B, 6 weeks, C, 8 weeks, or D, 12 weeks?
The correct answer is C. The authority has up to 8 weeks upon receipt of the request. Now, keep in mind, they can actually extend this by an additional 6 weeks for highly complex processing. And actually, the clock can even be totally suspended if they need to request more information from you.
Okay, for our third scenario, let's talk about accountability. Question 3. According to the GDPR, who acts as the primary contact point for the supervisory authority during this consultation process? Is it the A, CEO, B, lead developer, C, data protection officer, or D, marketing head?
And the answer is C, the data protection officer. Under Article 39, the DPO is legally mandated to act as the official contact point for the supervisory authority on any issues relating to processing, and this explicitly includes prior consultation under Article 36.
All right, for our final challenge, question 4. If the supervisory authority does not respond within that 8 to 14-week window, what happens? Do you get A, total immunity, B, the SA can still prohibit processing later, C, processing is automatically banned, or D, the DPIA becomes void?
The answer is B. Recital 94 warns us clearly about this, folks. Regulatory silence is absolutely not a golden ticket. The absence of a reaction doesn't prejudice the authority's power to intervene, or even ban the processing operations later on if they find it infringes the GDPR. At the end of the day, you still carry the accountability.
So let's wrap all this up with our key takeaways. Number 1, Article 36 is the GDPR's ultimate safety valve. Number 2, it is strictly triggered by unmitigated high risks found in your DPIA. Number 3, it enforces a mandatory 8 to 14-week pause on your project. And number 4, it demands complete operational transparency with your regulator.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone.
If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. As you review your own compliance, I want to leave you with this provocative thought. Are your current risk assessments actually catching the fires before you open the doors? Thanks so much for learning with me today, and I'll see you in the next explainer.
Hey everyone, welcome back to Privacy Trainer. So, if you're navigating the kind of crazy world of privacy law, you've probably asked yourself at some point, who exactly is responsible for keeping this entire organization in check? Well, the GDPR actually has a very specific answer for that. Today, we're diving straight into an explainer on Article 37, which is the legal mandate that literally forces certain organizations to appoint an independent privacy expert. It's one of the most critical, yet honestly most misunderstood parts of the whole regulation. Here's our quick roadmap for today. We're going to cover the DPO mandate, look at some real-world applications, touch on compliance risks, walk through a mini case study, and then wrap up with a knowledge check and some key takeaways. Now, you might be wondering, why should I care about this specific article? Well, what actually happens when an organization gets Article 37 wrong? The stakes are incredibly high here. Getting this wrong isn't just a slap on the wrist, you know? It can lead to chaotic regulatory investigations and absolutely massive fines. Regulators are actively looking to see if you have the right oversight in place. And if you don't, it's a glaring red flag that your entire privacy program might just be fundamentally broken. Okay, let's establish a baseline. Article 37 covers the designation of the Data Protection Officer, or DPO. In simple terms, this article solves the whole accountability problem by forcing specific organizations to basically put a dedicated independent privacy referee on the field. It dictates exactly when you absolutely must appoint an expert whose sole job is to monitor your compliance, advise your staff, and cooperate with supervisory authorities. They are literally the cornerstone of your privacy defense. All right, moving right along to Section 1, the DPO mandate. So the legal text builds the foundation for these appointments using 3 distinct triggers. You are legally required to designate a DPO in 3 very specific scenarios. First, if the processing is carried out by a public authority or body. Second, if your core activities consist of processing operations that require regular and systematic monitoring of data subjects on a large scale. And third, if your core activities consist of processing special categories of data, like say health or biometric data or criminal conviction data, again on a large scale. If you hit even just one of these triggers, no way around it. A DPO is absolutely mandatory. And Recital 97 brilliantly illustrates why lawmakers included this rule in the first place. It tells us that the DPO simply cannot be a yes man. Whether they're an internal employee or an external contractor, they must be empowered to independently challenge the business without any fear of penalty.
It's like having an internal regulator, ensuring that the fundamental rights of individuals aren't just tossed aside for the sake of corporate profit or moving fast.
Let's jump into Section 2, Real-World Applications.
So how does this actually translate from legal theory into daily business operations? Well, the crucial point here is understanding the phrase core activities. Let's say you're a tech company globally tracking user locations. You absolutely need a DPO. That systematic monitoring is literally your core business on a massive scale. On the flip side, what about a local bakery sending out a monthly email newsletter? Yeah, they don't need one. Their core activity is baking croissants, not monitoring data. But take a hospital processing huge amounts of highly sensitive health data. Failing to appoint a DPO in that scenario is a massive compliance failure.
Okay, Section 3, Compliance Risks. Let's look at this from the enforcement side of things. Regulators are actively hunting for weak DPO setups. A really common misconception is that a business can just slap the DPO title onto their head of IT or maybe their EU representative just to save some money and check a box. But the regulator reality, it's vastly different. The European Data Protection Board specifically notes that roles like the EU representative are fundamentally incompatible with the DPO. Why? Well, because an EU rep acts on direct instructions from the company, while a DPO must independently audit them. You can't grade your own homework. Plus, landmark cases like the Lystritz case guarantee the DPO's functional independence. That means they can't be fired or penalized for just doing their job and pointing out a problem.
Moving to Section 4, let's do a mini case study and walk through a compliance analysis step by step. Imagine a fast-growing startup that just launched this new AI-driven mental health app. That's our challenge. The primary issue here is the nature of the data. Mental health data is classified as special category data under the GDPR, meaning it requires a much higher level of protection. So the big question, does Article 37 require a DPO? Our analysis leads us to a resounding yes, because that mental health data is totally central to the app's functionality and it's processed on a large scale across their user base. Appointing a DPO falls directly under Article 37, paragraph 1, point C. It's a strict legal requirement, definitely not a voluntary choice.
Section 5, Knowledge Check Time. Let's test your practical understanding with some scenarios. Okay, here is our first question. A non-EU company appoints an EU representative under Article 27. Can this exact same person also act as the company's mandatory DPO under Article 37? Is it A, yes, if they have legal expertise? B, yes to streamline compliance? C, no, it creates a conflict of interest? Or D, no, unless approved by a supervisory authority? Think back to the independence we talked about earlier. If you guessed C, you hit the nail on the head. The EDPB explicitly states that the EU representative role is subject to a mandate and direct instructions from the controller. This fundamentally conflicts with the DPO's legal requirement to operate with total autonomy and independence. It brilliantly illustrates why you just can't combine operational mandates with independent oversight roles. It's a massive conflict of interest.
All right, let's move to question 2. Which of these organizations is legally obligated to appoint a DPO under Article 37? A, a boutique law firm with 3 lawyers. B, a regional public tax authority. C, a small B2B hardware supplier. Or D, a restaurant using CCTV for security. Focus on those explicit triggers we discussed regarding public bodies and scale.
The correct answer is B. Under Article 37(1)(a), any processing carried out by a public authority or body automatically mandates the designation of a DPO. So the public tax authority hits that very first trigger of Article 37, making the appointment mandatory, regardless of how much data they actually process or what their other core activities might be. The other organizations on that list simply don't meet the criteria of large scale or systematic monitoring based on the facts provided. Question 3. A company wants to fire its DPO because the DPO advised against launching a highly profitable but totally non-compliant data product. Is this allowed? A, yes if the CEO approves it. B, yes, DPOs are at-will employees. C, no, DPOs cannot be penalized for performing their tasks. Or D, no, DPOs have lifetime tenure. Try to recall that Lystritz case and the specific protections for the DPO function.
And the answer is C. Article 38(3) of the GDPR, backed by established case law from the European Court of Justice, dictates that a DPO shall not be dismissed or penalized by the controller for performing their designated tasks. The crucial takeaway here is that functional independence is legally protected. This acts like a shield for the DPO, allowing them to give honest, objective advice without the constant fear of losing their livelihood.
Okay, final question. Does Article 37 require the DPO to be a direct, full-time employee of the organization? A, yes, they must be internal. B, yes, unless they are a public body. C, no, they can fulfill tasks via a service contract. Or D, no, but only if they work for free. Consider how smaller organizations might really struggle if they were legally forced to hire a full-time, expensive privacy expert. The correct answer is C. Article 37(6) explicitly states that the DPO may be a staff member of the controller or processor, or they can fulfill the tasks on the basis of a service contract. This is a game-changer provision because it gives businesses the flexibility to outsource this function. They can bring in external privacy experts to act as their DPO while remaining completely 100% legally compliant. Section 6. Key takeaways. We have covered a lot of ground today. So what's your compliance strategy going forward? First, always remember to document your working out. Even if you analyze Article 37 and decide you don't need a DPO, you must document that rationale. Regulators absolutely want to see the evidence. Second, independence is not a suggestion, it's a strict legal requirement. Avoid those conflicts of interest. Your head of IT simply cannot wear the DPO hat. Third, remember that leveraging external service contracts is a perfectly valid strategy. And finally, view your DPO as a strategic asset. They aren't just a compliance checkbox, they're there to help you build trust and navigate complex data operations safely. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone.
And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam prep resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thank you so much for watching, and ask yourself, how will you structure your organization's privacy defense today? Welcome back to Privacy Trainer. I'm so thrilled to have you joining us for another explainer. Today, we're zooming in on a truly fascinating part of the GDPR, and that's Article 38. You know, if you've ever wondered how an organization practically manages its data privacy on the inside, the answer almost always revolves around the Data Protection Officer, or the DPO. But here's the catch. A DPO is pretty much useless if they don't actually have any power. And that is exactly why I like to think of the DPO under Article 38 as an organization's independent guardian. We're going to break down exactly what that means, how you build this role the right way, and, importantly, the massive legal landmines companies step on when they get it wrong. Okay, to kick things off, I want to pose a question to you, a scenario I like to call the DPO dilemma. Can a CEO actually fire their data protection officer for basically doing their job too well? Just picture this for a second. A DPO completely blocks a massive multi-million-dollar marketing campaign because they realize it blatantly violates privacy laws. The executive team is understandably furious. So can they just terminate the DPO right then and there? Well, misunderstanding the answer to this exact question is what leads to massive regulatory fines and legally voided dismissals. And this isn't just theory, guys. This exact scenario is playing out in boardrooms right now. All right, let's dive into this. Before we hit the core text of Article 38, we really need to look at Recital 97. This sets the absolute foundation for everything we're about to discuss today. It explicitly states that data protection officers should be in a position to perform their duties and tasks in an independent manner. That right there, that's the magic phrase, independent manner. Whether the DPO is a full-time internal employee or an external consultant you've brought in on a contract, their functional independence is the absolute bedrock of the GDPR's compliance framework. Simply put, if they aren't independent, the entire system just falls apart. So how does Article 38 actually guarantee this independence in the real world? Let's break down paragraphs 1, 2, and 4 in plain English. The GDPR mandates that the DPO absolutely must be involved from day one in all issues relating to personal data protection. You can't just loop them in at the 11th hour of a project to rubber stamp it. To make this happen, the organization has to provide the necessary budget, the right tools, and direct access to personal data and processing operations. Basically, they need the tools to actually do their job, plus the resources to maintain their expert knowledge. And on top of that, data subjects like your everyday customers or employees must be able to directly contact the DPO about their privacy rights. Now, these next requirements, this is where Article 38 really gets its teeth. Think of these as the core protections, which are laid out in paragraphs 3, 5, and 6. First off, leadership cannot dictate how a DPO investigates a breach or tell them what legal interpretation to adopt. No instructions allowed, period. Furthermore, the DPO simply cannot be dismissed or penalized for doing their job. To ensure this actually happens, they have to report directly to the highest management level, like the board of directors, bypassing middle management entirely. And lastly, they are bound by strict secrecy and confidentiality, which ensure they can be a genuinely trusted confidant for highly sensitive compliance issues. Let's step out of the legal text for a second and see how this plays out in practice. Imagine a tech company that's developing a cutting-edge AI tool. A fully compliant approach means they empower their DPO to review the algorithms super early on, granting them full, unrestricted access to the datasets. Now, a small business, on the other hand, might not have the budget for full-time executive DPO. So what do? They use an outsourced external DPO to ensure they have the necessary resources and independence without taking on massive overhead. But on the flip side, a critical compliance failure looks like this. A company demotes or slashes the bonus of their DPO because that DPO correctly blocked a non-compliant email marketing campaign. That is a direct, undeniable violation of Article 38. Honestly, you'd be surprised how often companies mess this up. Let's look at a super common structural mistake. A legally compliant reporting structure gives the DPO a direct, totally unobstructed line to the board of directors. A classic compliance failure, however, is making the head of IT the DPO. Now, why is this a problem? Well, because the head of IT is responsible for designing the very systems that process the data. You can't be the person building the machine and also act as the independent auditor grading the safety of that exact same machine. It is a fundamental conflict. Which brings us to a massive, game-changing ruling from the Court of Justice of the European Union, case C534/20, better known as the Leistritz case. Regulators aggressively protect DPOs, and this case proves it. The court ruled that the phrase dismissed or penalized protects the DPO against literally any decision that places them at a disadvantage specifically for performing their tasks. So that shield is incredibly strong. However, and this is a big however, the court also clarified that this is functional independence. It's not absolute immunity. A DPO can absolutely still be fired for normal just cause employment issues, like, say, stealing from the company, as long as the dismissal has absolutely nothing to do with their actual data protection duties. Equally crucial is our next big CJEU ruling, case C453/21, the XFAB case. This one tackled the conflict of interests rule head-on. The court defined that a conflict exists whenever a DPO is entrusted with duties that determine the objectives and methods of processing personal data. In this specific case, they ruled that an employee who was acting as the chair of the Works Council could not simultaneously serve as the DPO. The logic makes sense, right? The DPO has to independently review processing, which is literally impossible if they're also the one deciding how the data is processed in their other role. Let's put this into perspective with a quick mini case study. Imagine a company that's dealing with some really severe budget cuts. In a desperate attempt to save money, the CEO decides to eliminate the dedicated DPO role entirely and just hands the title over to the Chief Marketing Officer. Okay, let's run a GDPR analysis on this based on the XFAB ruling. This fails immediately. Why? Because the CMO's core job is to determine the objectives and methods of marketing data, how to collect it, and how to use it to drive sales. They simply cannot independently audit their own marketing campaigns. It's an illegal conflict of interest. All right, time to test what we've been talking about. Let's jump into a quick certification-style knowledge check. Here's the scenario. A CEO demands that the DPO approve a new, highly risky data sharing agreement by Friday. Which part of Article 38 does this violate? Take a second to read through the options, A, B, C, and D, and think back to the core protections we just discussed. And the answer is B, the no instructions rule. You probably nailed that one. Article 38, paragraph 3 strictly prohibits the controller, which in this case is the CEO, from giving the DPO instructions on how to exercise their tasks. A CEO can certainly ask for a review to be completed by a certain date, but they absolutely cannot demand that the DPO reach a specific conclusion or force them to approve something that the DPO genuinely feels is legally risky.
Let's keep the momentum going. Based on the XFAB case we just reviewed, take a look at the roles on your screen. Which of these is most likely to create a conflict of interest for a DPO? Remember the golden rule here. Who decides how the data is processed?
If you went with A, the HR director, you are absolutely right. The HR director's core function is determining the objectives and methods of processing employee personal data. We're talking things like payroll, performance reviews, recruitment tracking, all of that. Because they dictate exactly how that data is processed, they cannot act as the independent auditor of those exact same processes without directly violating Article 38, paragraph 6.
Awesome. On to question number 3. Picture this. A company outright fires its DPO for stealing office equipment. The DPO turns around and claims protection against dismissal under Article 38. Based on what we learned from the Lystritz case, does that shield actually hold up here? Review the options and lock in your answer.
The correct answer here is B. Yes, the dismissal is totally valid if it's for just cause that's completely unrelated to their DPO tasks. The GDPR provides a really powerful shield to ensure the DPO can speak truth to power without fear of retaliation for doing their privacy work. But it does not grant them general immunity to just do whatever they want. Standard workplace misconduct or criminal behavior like stealing laptops, yeah, that'll still get you fired.
All right, final question. A startup brings on a new DPO, but tells them they need to report to a mid-level IT manager in order to streamline operations. Take a look at the choices. Is this legally compliant under the GDPR? And the answer is C. No, they must report to the highest management level. You simply cannot bury your DPO deep down in the IT department, or the legal department for that matter. To ensure true functional independence and to guarantee that serious privacy risks are actually visible to the people running the company, the GDPR clearly mandates a direct line to the board or the equivalent highest management.
Wow, we've covered a ton of ground today. Let's just quickly run through the key takeaways so this really sticks. Number 1, functional independence is absolute. 2, as established in the Lystritz case, DPOs absolutely cannot be penalized just for doing their job. 3, you've got to avoid dual role conflicts where the DPO determines how data is processed, exactly like we saw in the XFAB case. 4, ensure direct board reporting. And finally, number 5, provide the DPO with adequate resources and get them involved early in all data initiatives.
If you're enjoying these GDPR explainers and want to support what we're doing, please consider becoming a member of Privacy Trainer. Memberships are exactly what help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale that education globally. And hey, if you're looking for more structured training, we're talking guided learning paths, workshops, practice questions, and certification prep, definitely go explore privacyuni.com. Privacy Trainer is all about making knowledge freely available right here, while privacyuni.com is designed for those of you who really prefer a more structured, deep dive learning experience. So before we wrap up, I want to leave you with a thought. Is the DPO in your organization a truly independent guardian, or are they just a rubber stamp to make things look good? Getting this wrong isn't just bad practice, it is a massive legal liability. Think about it. Now, as a quick reminder, this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. Thank you so much for learning with me today, and I cannot wait to see you in the next explainer.
Everyone, welcome to Privacy Trainer. Today, we're tackling the ultimate compass for navigating the honestly pretty stormy waters of data privacy. We're talking about GDPR Article 39. You know, if the entire General Data Protection Regulation is this massive ocean, Article 39 is essentially the official map and sextant for the Data Protection Officer, or DPO. I am so pumped to guide you through this explainer today because really understanding the exact tasks of a DPO, that's the absolute bedrock of a successful privacy program.
So why should you actually care about Article 39? I mean, what happens when you try to sail without that compass? Well, to put it bluntly, misunderstanding a DPO's tasks leads to massive, systemic compliance failures. We're talking about severe conflicts of interest, completely misallocated resources, and ultimately, some pretty heavy regulatory fines. If you are touching data, managing a team, or acting as a privacy professional yourself, this article is absolutely critical. It defines exactly what a DPO must do, and honestly, just as importantly, what they must avoid doing. Okay, let's dive into this. Here's our roadmap for the explainer. We'll start with the article overview, unpack the specific DPO tasks, look at some real-world scenarios, do a mini case study, jump into a quick knowledge check, and wrap it all up with key takeaways. Let's get to it. So let's start with the big picture. What exactly is Article 39? To put it simply, it's literally the official job description for a data protection officer, written right there into the text of the GDPR. It exists to make sure that organizations have dedicated, independent experts guiding their privacy compliance. Think of the DPO as this vital, independent bridge. They connect the organization that's processing the data, the actual people whose data is being processed, and the supervisory authorities who enforce the law.
If we look at Article 39, paragraph 1, it establishes 5 foundational pillars for the DPO's day-to-day life. First up, they inform and advise the organization and its employees about their GDPR obligations. Number 2, they monitor compliance, which covers everything from training staff to doing internal audits. Third, they provide crucial advice on data protection impact assessments, or DPIAs, and monitor how those are performing. Fourth, they cooperate closely with the supervisory authority. And finally, number 5, they act as the official contact point for the regulator on any issues relating to processing.
Okay, let's translate some of that heavy legalese into plain English, right? When the GDPR talks about monitoring compliance, awareness raising, and training, what that actually looks like on the ground is check that the company is actually following the rules and teach employees how to handle data safely. A huge, absolutely crucial distinction to make here is that the DPO is an advisor and an auditor. They are not the ones making the final business decisions about the data, and they aren't the ones actually implementing the technical controls. They guide, they monitor, and they report. That's the gig.
Now, what's really interesting about this is how Recital 97 ties right into Article 39.
It flat out dictates that a DPO has to be in a position to perform their duties and tasks in a totally independent manner. And this is vital because courts scrutinize this heavily. If a DPO is handed specific instructions on how to investigate a complaint, or they get pressured by management to rubber stamp a risky project, well, that functional independence is completely compromised. The DPO literally has to be free to call out non-compliance without any internal interference. Moving down to Article 39, Paragraph 2, we hit the risk-based approach. And honestly, lawmakers were pretty smart to include this. They did it so DPOs don't get trapped just endlessly auditing minor, low-risk administrative stuff. Instead, they have to prioritize. They look at the nature, scope, context, and purposes of processing and point their resources at the biggest threats to data subjects. Like, if your company processes massive amounts of highly sensitive health data, your DPO's radar should be firmly locked onto that, instead of spending 3 weeks aggressively auditing the company birthday calendar, you know? Let's bring this into the real world and see how it applies across different setups. In a huge tech company, a DPO might spend their day advising engineering teams on the high risks of deploying a new AI profiling tool. In a small business, their main job might be hands-on training for the HR staff on how to securely handle employee records. But check out column 3. This is a classic compliance failure. If an organization makes their head of marketing the DPO, they've just created a massive conflict of interest. The head of marketing's job is to use data to sell more stuff. The DPO's job is to impartially audit that use. Making your CMO your DPO is literally like putting a fox in charge of auditing the henhouse's security. You just can't grade your own homework.
Okay, as we navigate these waters, let me wave a massive red flag about a few common traps we see all the time. Trap number 1, expecting the DPO to actually sit down and write the Data Protection Impact Assessment. The GDPR states the DPO advises on the DPIA. The controller, meaning the business, is responsible for actually carrying it out. Trap number 2, like we just saw, combining the DPO role with C-suite decision-making roles like CEO, COO, or CMO. Just don't do it. And trap number 3, failing to provide the DPO with adequate resources. You can't just give someone a shiny title and then deny them the budget, time, or staff they actually need to monitor compliance.
And you know, regulators take this incredibly seriously. The European Court of Justice fiercely protects the DPO role. Take case C45321, the XFAB Dresden case. The court confirmed there that a DPO absolutely cannot hold roles where they determine the purposes and means of processing data. It just inherently destroys their independence. And then in case C53420, Leistritz, the court reinforced that a DPO cannot be fired or penalized simply for doing their Article 39 tasks. Basically, the law provides a heavy-duty shield so the DPO can freely speak truth to power. And this brilliantly illustrates how the whole shebang comes together in practice. Let's look at a quick case study. Step 1, the business challenge. We're launching a high-risk health app. Step 2, the privacy issue. The app processes sensitive biometric data. Step 3, the GDPR question is, what is the DPO's actual role in this launch? So, Step 4, our analysis. According to Article 39, the DPO does not build the app. Instead, they advise the product team on the DPIA. They monitor to ensure the engineers actually implement the recommended security measures. And if the residual risk stays unacceptably high, the DPO is the one who steps in and consults the supervisory authority prior to launch.
All right, time for a quick knowledge check to see if you've been paying attention. Question 1. A controller asks the DPO to draft and sign off on a new DPIA because, hey, the DPO is the privacy expert. Is this compliant with Article 39? Is it A, yes, the DPO must complete it. B, yes, if management approves. C, no, the DPO only provides advice and monitors its performance. Or D, no, only the supervisory authority can draft a DPIA. Take a second.
If you guessed C, you hit the nail on the head. No, the DPO only provides advice and monitors its performance. Under Article 39(1)(c), the controller, the organization itself, has to actually draft and execute it. Having the DPO draft the DPIA and then turn around to audit their own work, that creates an unacceptable conflict of interest. That's a crucial takeaway.
Moving right along to question 2. Imagine a total crisis, a severe personal data breach. Who does Article 39 explicitly designate to act as the contact point for the supervisory authority? Is it A, the chief executive officer? B, the data protection officer? C, the head of IT security? Or D, the lead legal counsel?
And the answer is B, the data protection officer. I know, in a panic, the CEO or the lead legal counsel might want to grab the wheel, but Article 39(1)(e) and the EDPB guidelines make it a mandatory statutory task of the DPO to act as the contact point for the regulator. They are the official independent liaison.
Okay, question 3. Let's say an organization has really limited resources. How exactly should the DPO prioritize their monitoring and auditing tasks according to Article 39? A, alphabetically by department. B, based on the risk associated with processing operations. C, by focusing only on employee data. Or D, by waiting for management instructions.
The correct answer is B, based on the risk. Remember our little birthday calendar example from earlier? Article 39(2) explicitly requires the DPO to prioritize their workload based on the risk associated with the processing operations. You've got to tackle the highest risk activities first, for sure. All right, final question. Let's see if you caught this one a few minutes ago. A DPO discovers severe non-compliance during an internal audit and bravely reports it. But then, the company turns around and fires the DPO for disrupting business. Which case law protects the DPO here? A, case C45321, XFAB. B, case C53420, Leistritz. C, EDPB guideline 2018-04. Or D, the DPO has no protection.
And the correct answer is B, the Leistritz case. This was a massive ruling because it reinforced the legal protections that allow a DPO to perform their Article 39 tasks, like reporting severe non-compliance, without the threat of being fired or penalized. Like I said, it is the ultimate legal shield.
Okay, to wrap up, let's hit the absolute must-remember key takeaways here. Number 1, DPOs advise and monitor. They do not execute the compliance work or dictate business memes. Number 2, independence is absolutely non-negotiable. You have to avoid conflicts of interest at all costs. Number 3, the DPO acts as the official, statutory bridge to the supervisory authorities. And lastly, number 4, a DPO's tasks must always be prioritized using a risk-based approach.
Hey, real quick, if you're enjoying these GDPR explainers and you want to support what we do here, definitely consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our whole mission is to make high-quality privacy knowledge accessible to everyone, and we use AI to help scale that education globally. Also, if you're out there looking for something a bit more structured, like guided learning paths, workshops, practice questions, or exam and certification prep, head over and check out privacyuni.com. Privacy Trainer is all about making knowledge freely available right here, while privacyuni.com is designed for folks who prefer a more structured, comprehensive learning experience. Just a quick disclaimer before we go. This explainer is strictly for educational purposes. It is not legal advice, and hey, content might include mistakes. But as you log off today, I really want you to ask yourself this one critical question. In your own organization, is the DPO truly empowered to be an independent shield for privacy, or are they just sitting there as a scapegoat waiting for a breach? Thanks so much for exploring Article 39 with me today, and keep navigating those privacy waters safely.
Welcome back to Privacy Trainer. You know, have you ever looked at the GDPR and thought, man, this is just way too broad for my specific industry? I mean, what if instead of wrestling with these abstract rules, your sector had its own tailored, legally approved rulebook, something that actually made compliance actionable and honestly crystal clear? Well, that is exactly what we're diving into today as we unpack Article 40 of the GDPR. Okay, let's take a quick look at our roadmap. First, we'll explore the Article 40 rulebook, then recitals and application. After that, we'll hit some common mistakes and a case study, do a quick knowledge check, summarize with key takeaways, and finally wrap up with support and learning resources. Let's get to it. All right, Section 1, the Article 40 Rulebook. We're going from abstract regulation to actionable industry standards. So I want you to think of the GDPR as this massive one-size-fits-all fabric. Sure, it covers everyone, but let's be real, it doesn't always fit perfectly. Well, Article 40 Codes of Conduct totally changed that game. They basically act as a tailored suit fitted to your industry's exact measurements. Trade associations or bodies that represent a specific sector can actually create these codes. It's brilliant because it helps their members comply in a way that's efficient, cost-effective, and highly specific to what they actually do day to day. Now, what's really interesting here is how lawmakers built a bridge straight from legal theory to practical reality. Let's break it down. Paragraph 1 encourages sector codes. In plain English, industries can just write their own specific privacy rulebooks. Paragraph 2 specifies the application, giving us much-needed clarity on things like consent and security. Then, Paragraph 4 introduces a totally vital enforcement piece, mandatory monitoring by an accredited independent body. You've got to have someone checking the work. And finally, Paragraph 5 requires the competent supervisory authority to approve it. Basically, regulators have to review and officially stamp the code as safe. Moving right along to Section 2, Recitals and Real-World Application, where we bring this rulebook to life. Now, this recital right here, Recital 98, is absolutely crucial. It confirms that the GDPR fully expects your compliance obligations to scale based on your specific risks. It expressly points out that codes should take into account the specific needs of micro, small, and medium enterprises. Think about it. Lawmakers are acknowledging that a small local shop absolutely does not have the same risk profile or resources as a massive multinational tech giant. So their obligations should be calibrated to match. Makes total sense, right? Let's look at how this actually plays out there in the real world. For a tech company, imagine cloud providers getting together and creating a unified code to standardize safeguards for international data transfers. Huge time saver. Or for small business, maybe local retailers adopt a code that gives them simplified, pre-approved privacy policy templates. But, and this is a big but, beware the compliance failure. Imagine an organization claiming they follow a code, but they completely fail to actually use an accredited monitoring body. Without that independent check, the whole code implementation is literally invalid. All right, on to Section 3, Mistakes, Regulators, and a Case Study. Let's navigate the boundaries and see how this is enforced. Okay, so there's this major misconception floating around out there that a code of conduct can somehow magically override or change the fundamental rules of the GDPR. No way. The reality? A code only specifies the GDPR. The crucial point here is precedent as a guardrail. The CGEU judgment in the Schufa case, that's case C26/22, clearly established that while industry codes are great for guidance, the conditions for lawfulness they lay down can never, ever differ from the core conditions in Article 6, Paragraph 1. Bottom line, you can't just write an industry code that gives you permission to break the primary law. So what do regulators actually care about? Well, they want to see proof. They focus heavily on active, continuous adherence. You have to maintain rock-solid evidence of audits by your accredited monitoring body. And here's a huge advantage. According to the EDPB, adhering to an approved code can actually mitigate potential administrative fines if a breach occurs. Why? Because it proves you have a proactive commitment to accountability. But be warned, regulators are absolutely going to verify if the code accurately reflects your actual day-to-day processing operations. Let's walk through a quick scenario step by step. Imagine a health tech startup. Their business challenge? They're trying to scale a health app across Europe, but they've got a very limited legal budget. The privacy issue here is massive because they're handling highly sensitive health data, which requires strict, complex safeguards under Article 9. So for their GDPR analysis, they decide to join an already approved Article 40 Health Tech Code of Conduct. Boom. By leveraging this existing code, the startup solves a massive privacy headache. They get a pre-approved, actionable strategy that regulators already trust without having to reinvent the wheel. Time to switch gears. Welcome to Section 4, Certification Knowledge Check. Let's test your practical understanding. Question 1. Who is primarily intended to prepare a draft code of conduct under Article 40? Is it A, the European Data Protection Board, B, associations representing categories of controllers or processors, C, the European Commission, or D, individual data subjects? And the correct answer is B. Associations and representative bodies, like trade organizations, are explicitly empowered by Article 40, Paragraph 2 to draw up these tailored rulebooks for their sectors. This whole concept is fundamentally an industry-led initiative. Let's try question 2, which tests the boundaries of the law. A financial industry code states data can be retained for 3 years, but a GDPR Article 6(1)(f) analysis limits it to 6 months. Based on the Schufa judgment, what applies? A, the code of conduct overrides the GDPR. B, the data controller can choose which rule to follow. C, the code cannot differ from Article 6(1) conditions. Or D, the supervisory authority must rewrite the GDPR.
Got your guess? The correct answer is C. The SC Jufa case, C26/22, confirms that a code of conduct specifies the GDPR, but it absolutely cannot alter the fundamental lawfulness conditions of Article 6. Remember, a code cannot give you a free pass to override primary law. Question 3. According to Recital 98, why should codes of conduct take into account the specific needs of micro, small, and medium enterprises, or SMEs? A. To exempt SMEs from the GDPR entirely? B. To calibrate obligations based on risk and make compliance accessible? C. To force SMEs to hire independent data protection officers? Or D. To allow SMEs to transfer data globally without safeguards? The correct answer is B. Remember that tailored suit analogy we talked about? Codes are specifically designed to calibrate obligations so that compliance becomes accessible and directly proportional to the actual risk for those smaller businesses.
All right, final question number 4. Under Article 40, Paragraph 4, what mandatory mechanism must an approved code of conduct contain? A. A loophole for marketing consent? B. Mechanisms for mandatory monitoring by an accredited body? C. A standardized template for privacy policies only? Or D. A guarantee of zero administrative fines?
And the correct answer is B. A code is only valid if it includes mechanisms enabling an accredited monitoring body to carry out mandatory compliance checks. Let's be real, without an accredited independent body keeping watch, a code of conduct is basically just a piece of paper. All right, let's wrap this up with Section 5 key takeaways. Summarizing Article 40. Let's distill all of this down to the essentials. First, codes act as a tailored industry-specific rulebook for GDPR compliance. Second, they provide specific, practical guidance for SMEs to proportionally calibrate their obligations. Third, and you gotta remember the Shufa case here, codes cannot override the core lawfulness requirements of the GDPR. Fourth, getting approval requires mandatory monitoring by an accredited independent body. And finally, adherence can help you seamlessly demonstrate compliance and actively mitigate potential fines. When used correctly, Article 40 is just an incredibly powerful tool. And finally, Section 6, support and structured learning. Continue your privacy education. Hey, if you enjoy these GDPR explainers, please consider becoming a member of Privacy Trainer. Memberships are what help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education globally. Now, if you're looking for more structured privacy, security, or AI training, stuff like guided learning paths, workshops, practice questions, or exam prep, you should definitely explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available right here, while privacyuni.com is designed for folks who prefer a more structured, deeper learning experience. And quickly, a short disclaimer. This content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. Thank you so much for joining me today. I want to leave you with one final thought to chew on. What specific tailored rules does your own industry desperately need to draft next? Think about it. See you next time.
All right, let's dive right into this explainer of GDPR Article 41, where we're looking at the absolutely essential role of monitoring bodies in privacy codes of conduct. If you've been following our journey through the General Data Protection Regulation, you already know that accountability is basically everything. But you might be wondering, who exactly holds organizations accountable when they create their own industry-specific privacy rules? Well, that is exactly what we're going to master today.
Think about it like this. If Article 40 sets up the rules of the game for a specific industry, say a code of conduct for cloud service providers, then Article 41 introduces the referee. Because let's be honest, rules only matter if someone is actually making sure they're being followed. Without this crucial article, a code of conduct would literally just be a piece of paper, just a nice promise with zero enforcement. And if organizations misunderstand Article 41, their entire code of conduct can be completely invalidated by regulators, which leads to a total collapse of consumer trust and some potentially massive compliance gaps. We've got a really packed agenda today. We'll be unpacking the legal text, looking at real-world scenarios, diving into enforcement with a case study, running through a privacy knowledge check, and wrapping up with our key takeaways. So let's get right to it.
Now, what's genuinely fascinating here is how we take this super dense legal language and translate it into a really simple, actionable concept. Article 41 states that the monitoring of compliance with a code of conduct must be carried out by a body that has an appropriate level of expertise and is officially accredited. In plain English, the monitoring body is the independent guardian of accountability. They are the ones who check the homework, blow the whistle on fouls, and ensure that the privacy promises made to the public are actually kept.
Section 1. Unpacking the legal text. Let's see what regulators actually demand from these bodies.
According to Article 41, Paragraph 2, and, those incredibly detailed EDPB guidelines, a monitoring body has to be accredited by hitting 4 very strict criteria. First off, they must demonstrate absolute independence and expertise. They literally cannot be influenced by the companies they're monitoring. Second, they need established procedures to assess whether a company is even eligible to join the code in the first place. Third, they must have transparent structures to handle public complaints. And fourth, they have to prove there is absolutely no conflict of interest. Lawmakers put this in so self-regulation doesn't just turn into a meaningless rubber-stamping exercise.
The really crucial point here is that this referee, they've got real teeth. They aren't just sitting on the sidelines watching the game. Under Article 41, Paragraph 4, they're legally required to take appropriate action if a company breaks the rules. They can issue warnings, demand corrective actions, and, if push comes to shove, completely suspend or exclude a member from the code of conduct. But here's the kicker. They are mandatorily required to inform the competent supervisory authority of these actions. They act as a partner to the government regulators, not a replacement for them.
Moving on to Section 2, real-world scenarios. Let's ground all this theory in reality.
This slide brilliantly illustrates a really common compliance failure. A lot of folks just assume a monitoring body has to be some totally separate external company. Well, actually, the EDPB guidelines say you can use an internal monitoring body, but, and this is a massive but, it absolutely must be structurally independent from the business operations. If your internal monitoring team reports to the same CEO who drives sales, well, that's a massive conflict of interest. The correct approach is a fully ring-fenced committee that's protected from any internal corporate sanctions or interference. Their independence has to be bulletproof.
You see, regulators are pretty practical. The monitoring body scales its oversight based on actual risk. For a tech giant acting as a cloud service provider, the monitoring body is probably going to conduct heavy, complex, unannounced audits to ensure those massive data flows are fully compliant.
But for a small local retailer participating in their association's code, the monitor might just use scaled proportionate checks, like annual questionnaires or self-assessments. It's all about effective oversight, not bankrupting small businesses with massive audit fees.
All right, Section 3, Enforcement and Case Study. Let's step into the shoes of an investigator for a minute.
Picture this scenario. A company, let's call them TechCo, joins an approved code of conduct. 6 months down the line, a whistleblower reveals they're hoarding unnecessary user data, which is a clear breach of the code's data minimization rules. The monitoring body immediately steps in, investigates, and confirms the breach. They order TechCo to delete the data, but TechCo refuses. Following Article 41 to the letter, the monitoring body officially suspends TechCo from the code and, crucially, hands all the evidence right over to the supervisory authority. The monitoring body did its job perfectly here. We've seen real regulatory scrutiny just like this from authorities like the French CNL, ensuring that when the rules are broken, the government regulator can step right in to issue those administrative fines under the GDPR.
Section 4, Privacy Knowledge Check. It's time to test your practical understanding with 4 certification-style questions to challenge your grasp of Article 41. Let's see how you do.
Okay, question 1. A retail association wants to appoint a monitoring body for its new code of conduct. Who is legally responsible for accrediting this monitoring body? Is it A, the EDPB, B, the Competent Supervisory Authority, C, the European Commission, or D, the Retail Association's Board of Directors? Think carefully about who holds that ultimate authority. And the answer is B, the Competent Supervisory Authority. If you got that, excellent work. They are the ultimate gatekeeper for accreditation. While they do share their draft criteria with the EDPB to make sure things are consistent across Europe, it's the national regulator, the supervisory authority, that actually hands down the accreditation.
Moving right along to question 2. During the routine audit, a monitoring body discovers a code member has been unlawfully processing sensitive data. What is the monitoring body required to do under Article 41(4)? A, issue a €20 million fine. B, take appropriate action like suspension and inform the supervisory authority. C, immediately delete the member's data servers. Or D, handle the issue privately without notifying regulators. Consider the limits of their power here.
The correct answer is B, take appropriate action and inform the supervisory authority. This perfectly illustrates that partnership we talked about earlier. Monitoring bodies are incredibly powerful within their code. They can kick you out, but they are not government agencies. They absolutely cannot issue those massive GDPR administrative fines themselves. They take corrective action, but the regulator still needs to be kept in the loop.
All right, question 3. Can an organization act as the monitoring body for a code of conduct if it's an internal department of the association that created the code? A, yes, provided they demonstrate strict independence and no conflict of interest. B, no, Article 41 strictly requires a third party. C, yes, but only for micro and small enterprises. Or D, no, they must be government agencies.
The answer is A. Yes, they absolutely can. This is a super common misconception that actually trips up a lot of privacy pros on exams. Internal referees are totally allowed under the EDPB guidelines, but their independence literally has to be flawless. They have to be protected from being fired or sanctioned by leadership just for doing their job.
Okay, final question, number 4. If a competent supervisory authority discovers that a monitoring body is no longer handling complaints properly, what is the most severe consequence? A, automatic fines for all members. B, revocation of accreditation, which might suspend the entire code. C, the European Commission takes over. Or D, nothing. The SA has no power after initial accreditation. What happens when the referee themselves stops following the rules?
And the answer is B. The supervisory authority revokes their accreditation. Regulators absolutely will not hesitate to pull that status if the monitoring body drops the ball. And honestly, this causes a massive domino effect because a code of conduct has to have a monitoring body to be valid under the GDPR. Losing your monitoring body could collapse the entire code of conduct for everyone involved.
Section 5. Key takeaways. Let's wrap up this explainer by distilling everything down to the essentials. Here is what you absolutely need to remember. First, referees are mandatory for any approved code of conduct. Second, their independence from the businesses they monitor is absolutely sacred. Third, having transparent complaint handling is totally non-negotiable. Fourth, they have real, tangible power to suspend or exclude rule breakers. And finally, they answer directly to the supervisory authorities who oversee them and can revoke their status. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification preparation resources, you can also explore privacyunit.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyunit.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks so much for joining me today to unpack Article 41. I'll leave you with this final thought. If your organization relies on an industry code of conduct, do you know exactly who is acting as the independent referee for your privacy promises? And more importantly, are you truly ready if they blow the whistle? Keep learning, and I'll see you in the next explainer.
Welcome to this explainer on GDPR Article 42. Today, we are decoding how organizations can actually prove they're doing privacy right. You see, the GDPR places a ton of obligations on businesses, but honestly, one of the biggest challenges isn't just following the rules. It's proving to your customers, your partners, and the regulators that you're following them. So what happens if you misunderstand this? Well, you end up drowning in endless vendor questionnaires, you lose out on big B2B deals because you just can't demonstrate trust, or worse, you face much harsher fines during a regulatory audit simply because you lacked formal evidence of your safeguards. Article 42 completely solves this by introducing a formal certification mechanism.
Okay, let's dive into our agenda. We're starting with the core business challenge of trust, then moving straight through how the legal mechanics actually operate. We'll look at real-world applications, see exactly how regulators view these certifications, run through a mini case study with a quick knowledge check, and then wrap it all up. Let's start with Section 1 and explore the fundamental problem that Article 42 was designed to solve.
Pretty much every business leader faces this absolutely crucial question. When a partner or a customer asks if their data is safe, how do you tangibly prove your safeguards without subjecting your whole team to a massive, expensive, and time-consuming audit every single time? In our digital economy, data is flowing constantly between vendors, cloud providers, and clients. Just saying, hey, trust us, we're compliant, just doesn't cut it anymore. People want proof. And this is exactly where Article 42 comes to the rescue. It introduces voluntary certifications, data protection seals, and marks. I want you to think of it essentially as a nutrition label for data privacy. Just like you can grab a box of cereal, look at the back, and instantly understand what's inside it, a GDPR certification allows an organization to quickly and reliably demonstrate that their specific data processing operations meet a highly objective standard of data protection. This brilliantly illustrates what the lawmakers actually intended. Recital 100 explicitly states that these mechanisms are built to enhance transparency and allow consumers, or data subjects, to easily assess data protection levels. The drafters of the GDPR totally understood that legal jargon is confusing for the average person, so a recognized seal or mark instantly bridges that gap, building immediate trust in the marketplace. All right, moving on to Section 2, let's look at the actual text and see how this builds into a practical framework. The mechanics outlined in the article are pretty straightforward, but they are rigorous. First up, under Article 42, Paragraph 3, certification is entirely voluntary. The GDPR does not force you to get certified just to do business. Number 2, you're evaluated against criteria that have been officially approved by a supervisory authority or the European Data Protection Board. You can't just make up your own passing grade. And finally, under Article 42, Paragraph 7, a certification is issued for a maximum of 3 years. It's not some lifetime achievement award. You have to maintain your standards and renew it to prove ongoing compliance. Now, what's really fascinating about the EDPB guidelines is that they highlight an incredibly rigorous accreditation process. You don't just get certifications from anybody. Under Article 43, the independent third-party bodies that issue these certifications must themselves be heavily scrutinized and accredited by national authorities. This ensures that when you see a GDPR seal, it genuinely means something. It generates real market trust, mostly because the people handing out the grades are being closely watched by the regulators themselves. So, into Section 3, how does this actually play out in the real world across different types of organizations? Let's consider 3 distinct scenarios. First, imagine a mid-sized tech company offering cloud storage. For them, an Article 42 certification acts like a fast pass, bypassing dozens of custom security questionnaires so they can accelerate their B2B sales. Second, think about a small business. They might just use a localized scheme specifically for HR data to build trust with their own employees. And finally, the classic compliance failure. A company gets the seal, pops the champagne, and then completely stops monitoring their systems. Big mistake. Regulators can and absolutely will revoke that seal if you let your standards slip. And that brings us to dispelling probably the most dangerous myth in privacy circles. This idea that a certification guarantees 100% GDPR compliance and grants you some sort of get-out-of-jail-free card. No way. The reality, which is clearly stated right in Article 42, Paragraph 4, is that obtaining a certification does not reduce your legal responsibility. You, the controller or processor, always retain full liability. The certification is a tool to demonstrate your safeguards. It's not a shield to hide behind if you act negligently down the road. This brings us to Section 4, and a really important question. How do the supervisory authorities, the ones who actually hand out the fines, view these certifications during an investigation? Well, regulators view certifications very favorably, but realistically, they're quick to emphasize that a seal does not replace their oversight, and you still have to maintain your own internal evidence of continuous compliance. However, and this is a massive benefit for businesses, under Article 83, Paragraph 2, letter J, having an approved certification is explicitly listed as a mitigating factor. This means if a data breach does happen, the regulator will look at your certification and say, okay, well, they clearly made a formalized, verified effort to protect the data, and that can actually reduce the administrative fines you might otherwise face. Section 5. Let's put your knowledge to the test with a realistic scenario and a quick certification-style quiz. Imagine a company called CloudCorp. They're launching this powerful new B2B analytics tool to assure their international partners that their data processing is secure, and honestly, to avoid subjecting their engineering team to constant, exhausting vendor audits, CloudCorp decides to proactively pursue an Article 42 certification. Okay, question 1. If CloudCorp obtains this certification, are they suddenly immune from administrative fines if a data breach occurs? Does liability transfer? Is it a temporary immunity? The correct answer is D, no immunity. As we just discussed, Article 42 explicitly states that a certification does not reduce the controller's responsibility for compliance, though it might mitigate the fines. Question 2. How long can CloudCorp's new certification remain valid before it absolutely must be renewed? 1 year? Indefinitely? The correct choice here is B. The GDPR limits these to a maximum of 3 years, meaning CloudCorp has to continuously monitor their systems to pass that future renewal audit. Moving to question 3, is CloudCorp legally required by the GDPR to obtain this certification just because they're processing B2B data? Are all processors required to? The answer is C, no. Article 42 makes these mechanisms strictly voluntary for all organizations. It's a strategic business choice, not a legal mandate. Finally, question 4, can CloudCorp use this certification to demonstrate appropriate safeguards for transferring data outside the EU? Can they skip standard contractual clauses? The answer is A, yes. Article 42 specifically allows certifications, when combined with binding commitments, to act as a valid safeguard for those international transfers. And finally, Section 6. Let's wrap up with the most critical lessons from this explainer, pulling together everything we've covered today. Here are your key takeaways. Certifications are powerful, voluntary trust signals that help you prove compliance without suffering through endless audits. They are valid for a maximum of 3 years to ensure you don't drop the ball. They absolutely do not erase your liability, but they can significantly mitigate regulatory fines if something goes wrong, and they provide a fantastic avenue to assist with international data transfers. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone.
If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Always consult with a qualified legal professional for your specific situation. So, as you look at your own organization's data protection practices, ask yourself, if a regulator walked through your door today, could you easily prove your compliance, or would you be scrambling for evidence?
Welcome back to Privacy Trainer. Today, we're demystifying a truly fascinating piece of the GDPR, Article 43. You know, when you're browsing the web or maybe looking to hire a cloud provider, you've probably seen those glowing digital seals of approval, a badge that proudly says GDPR certified. But here's the million-dollar question. Who actually decides if that badge is worth the pixels it's drawn with? Well, that is exactly the problem Article 43 solves. Because if organizations misunderstand this, those trust seals become completely meaningless, and the whole system just falls apart. Seriously, think about it for a second. What happens if a company falsely claims to be GDPR certified? Or honestly, what if the organization handing out these certifications doesn't actually know the first thing about privacy? No way we can let that happen, right? So Article 43 acts as the ultimate rulebook for the gatekeepers of trust. It makes absolutely sure that the bodies issuing these coveted certifications are heavily vetted, strictly independent, and deeply, deeply knowledgeable.
All right, let's dive right in. Here's our roadmap for today. First, the trust blueprint. Second, rules of accreditation. Third, real-world certification. Then, the regulator's view, a case study, and we'll wrap it up with a knowledge check and key takeaways.
Part 1. The Trust Blueprint. This is the absolute foundation of GDPR trust.
Article 43 establishes the absolute baseline of trust for the entire GDPR certification ecosystem. Without it, a certification is literally just an empty promise. Let's look at the core definition we need to grasp here. A certification body is defined as a qualified, independent, third-party conformity assessment body. Now, in plain English, it's simply an independent auditor officially authorized to issue GDPR certifications and seals. Lawmakers specifically included this because, well, you can't just let anyone hand out a seal of approval. The legal text states these bodies must possess an appropriate level of data protection expertise. They are essentially the frontline defenders of GDPR compliance, carrying the heavy responsibility of making sure businesses actually do what they promise to do with your data. Moving on to Part 2, rules of accreditation. Let's look at how these bodies actually get their authority. Now, you might be wondering, how do these certification bodies actually get their power in the first place? Well, the European Data Protection Board outlines this really fascinating dual-path system. Basically, Article 43 gives member states some flexibility. Route 1 is a direct accreditation by the local supervisory authority. That's your primary data protection regulator. But then there's Route 2, which goes through a national accreditation body, or NAB. If you go the NAB route, you have to meet some incredibly strict international standards, specifically ISO 17065, plus any extra requirements set by the supervisory authority. The EDPB has actually put out specific guidance on this, like EDPB Opinion 14/2022, which rigorously details the exact criteria regulators have to use. It's honestly a brilliant way to ensure consistently high standards across Europe, while still letting countries use their existing accreditation infrastructure. Part 3, real-world certification. How this affects everyday operations. Let's see how these accreditation rules actually play out in the real world. Imagine a tech company that needs a GDPR seal for a new cloud tool because they want to land a massive enterprise client. A super common mistake here is buying a badge from an unaccredited, self-proclaimed expert just because it's cheaper or faster. But under the GDPR, only bodies accredited via Article 43 hold actual legal weight. If you buy a fake badge, guess what? You're going to fail your vendor risk assessment. And consider this massive compliance failure. Imagine a certification body provides GDPR consulting to a software firm, helping them build their databases, and then later audits that exact same firm to issue a certification? No way. That is a massive violation of the strict conflict of interest rules in Article 43, Paragraph 2. Independence is absolutely non-negotiable here. Up next, Part 4, the regulator's view. We're talking investigations and enforcement powers. So what happens when things go wrong? Well, take a look at this powerful quote from Article 43, Paragraph 7. It says they shall revoke an accreditation if conditions are no longer met. Shall revoke. That is not a suggestion, folks. It's a mandate. Furthermore, Recital 100 dictates that certifiers have to maintain continuous public records of valid certifications. Why is this recital such a big deal? Because regulators care heavily about transparency and public trust. The whole system relies on anyone being able to instantly verify a claim. If a certification body loses its independence, stops updating its public register, or just stops monitoring its clients properly, the regulator will instantly strip them of their power. So the evidence organizations must maintain is very clear, documented proof of ongoing independent assessment.
Let's jump into Part 5, a certification case study. Time to see this in action. All right, here is a very realistic business challenge for us to solve. A cloud provider wants a formal GDPR seal to help win enterprise contracts. They go ahead and select a certification body, but during the due diligence process, their legal team discovers the certifier actually does not have an accreditation from the national accreditation body. So, is this a privacy issue? Can they legally certify the cloud provider? Let's walk through the analysis step by step. And the answer is yes, they actually can. Lack of an NAB accreditation isn't an automatic deal breaker, as long as the certifier is directly accredited by the competent supervisory authority under that route one we discussed earlier. You just need to go verify their status on the regulator's public register to ensure their authority is totally valid and current. Easy as that.
Finally, Part 6, knowledge check and takeaways. Let's test your learning. All right, let's see how much you've picked up. Question 1. Under Article 43.4, what is the maximum initial period an accreditation can be issued for a certification body? Is it A, 2 years, B, 3 years, C, 5 years, or D, indefinitely? Take a quick second to lock in your answer.
And the correct answer is C, 5 years. Lawmakers specifically included the sunset clause to force certifiers to continuously prove their competence. You don't just pass the test once and get to keep your status forever. Privacy is always evolving, and the certifiers absolutely must evolve right along with it.
Let's try question 2.
Who has the legal authority to accredit a GDPR certification body? A, only the EDPB, B, only a national accreditation body, C, only a supervisory authority, or D, a supervisory authority and/or a national accreditation body. Think back to that dual path map we looked at earlier. The answer is D, a supervisory authority and/or a national accreditation body. The crucial takeaway here is that Article 43(1) gives member states the flexibility to decide exactly who hands out the accreditation in their specific country, as long as the strict standards are met. Okay, question 3. This is a highly practical scenario. A certification body provides GDPR consulting to a software firm and then subsequently audits them for a GDPR seal. Why is this a compliance failure? A, it's too expensive. B, it creates a conflict of interest. C, it violates territorial scope. Or D, it requires EDPB approval. You probably nailed this one. The answer is B. It creates a massive conflict of interest. You simply cannot grade your own homework. Lawmakers included Article 43(2)(e) and ISO 1765 to ensure that the GDPR seal of approval stays completely objective and is never, ever influenced by lucrative prior consulting relationships. Final question. Let's test your knowledge of the regulator's powers. Question 4. What happens if an accredited certification body stops following GDPR rules or ISO 17065 standards? A, they receive a mandatory warning. B, their accreditation shall be revoked. C, the EDPB takes over their clients. Or D, they're fined but keep their status. And the correct answer is B, their accreditation shall be revoked. The entire system of trust we've been talking about only works if regulators actively police the certifiers and immediately pull their credentials the second standards drop. Okay, let's rapidly summarize our key takeaways from today's explainer. Number 1, certification bodies are the ultimate trust gatekeepers. They make the whole system work. Number 2, remember those dual paths to accreditation? Countries can use either their supervisory authority directly or a national accreditation body. 3, independence is totally non-negotiable. You absolutely cannot consult and audit the same client. 4, accreditations aren't forever. They expire after a maximum of 5 years to ensure active competence. And 5, regulators hold the ultimate revocation power to keep the system honest. Understanding these points is absolutely vital for any privacy pro seeking, evaluating, or relying on a GDPR seal. If you're enjoying these GDPR explainers and want to support the channel, consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to absolutely everyone and use AI to scale that education globally. Also, if you happen to be looking for more structured privacy, security, or AI training, stuff like guided learning paths, workshops, practice questions, and certification prep resources, definitely go explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available right here, while privacyuni.com is designed for learners who prefer a much more structured, comprehensive learning experience. I want to leave you with one final provocative thought today. If trust is truly the currency of the digital age, is your organization banking on truly accredited certifiers, or are you just buying empty badges? Go check those public registers. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks so much for learning with me today, and I'll catch you in the next explainer. Okay, let's dive into this. Picture this. You're planning a trip abroad. When you leave the European Union, you have to go through a passport checkpoint, right? They check your documents to make sure everything's in order. Well, in the digital world, data doesn't exactly carry a physical passport, but it absolutely has to clear a legal checkpoint. If organizations misunderstand this, they risk sending highly sensitive personal information to countries where privacy laws are, well, incredibly weak, or where government surveillance could completely compromise that data. The consequences of getting this wrong aren't just a slap on the wrist. We are talking about massive data breaches, regulators completely shutting down your operations, and of course, a total loss of consumer trust. Welcome to the Explainer. Today, we are mastering Article 44 of the General Data Protection Regulation. Think of Article 44 as the ultimate, fundamental digital checkpoint. Its entire purpose, the reason it exists, is to ensure that the high level of protection guaranteed by the GDPR is never, ever undermined when personal data leaves the European Economic Area. This is literally the bedrock of international data transfers. Here's our roadmap for today. We're going to start with the basics of Article 44, look at how it works in practice, explore enforcement and common mistakes, and run through a real-world case study. Then we'll test your knowledge with a certification-style quiz and wrap up with the key takeaways. All right, let's jump straight into Section 1, Article 44 Basics, the digital passport. So before we can even think about complying with Article 44, we need to know exactly what triggers it. According to the European Data Protection Board, or EDPB, a transfer happens when 3 very specific criteria are met. First, the data exporter, the one actually sending the data, has to be subject to the GDPR. Second, that exporter discloses or makes personal data available to another entity, which we call the importer. And third, that importer is located in a third country outside the European Economic Area or is an international organization. If your processing hits all 3 of these triggers, well, congratulations, you're making an international data transfer, and the Article 44 checkpoint rules apply to you. Now, how do we actually pass that checkpoint? It all comes down to the EDPB's mandatory 2-step test. And this brilliantly illustrates what lawmakers were going for in the GDPR's Recital 115, protecting data from extraterritorial laws. Step 1, you absolutely must have a lawful basis for the processing itself under Article 6. Think consent or legitimate interest. But actually, let me emphasize this. That's not enough. Step 2, you have to apply Chapter V safeguards, like relying on an adequacy decision or using standard contractual clauses. You literally cannot skip to Step 2 without clearing Step 1 first. It's a package deal. Moving right along to Section 2, Article 44 in practice, crossing the border. Let's see how this plays out for businesses. Imagine we have 2 different companies. On one hand, we've got a compliant tech enterprise. They have a valid Article 6 legal basis, let's say user consent, and they've implemented a valid Chapter 5 transfer tool that ensures the data remains protected overseas, so they pass the checkpoint with flying colors.
On the other hand, we have a super common mistake, a small business that assumes just because they have a user contract under Article 6, they can send that user's data wherever they want. They entirely skip the Chapter 5 safeguards. This is a massive compliance failure. The contract might make the processing lawful locally, but it does absolutely nothing to protect the data once it crosses the digital border. Which brings us to Section 3, Enforcement and Mistakes, failing the checkpoint. What actually happens when organizations get this wrong? So the crucial point here is that regulators do not mess around with Article 24. If you violate these transfer rules, you're looking at the highest tier of administrative fines under Article 83. We are talking up to 20 million euros or 4% of total worldwide annual turnover, whichever is higher. But wait, it gets even more serious from a business perspective. Under Article 58, Paragraph 2, letter J, supervisory authorities have the power to order the immediate suspension of data flows to a recipient in a third country. Think about that for a second. Regulators don't just fine you. They can literally cut the cord and stop your international business operations dead in their tracks. Let's look at Section 4, Real-World Case Study, the Cloud Vendor Dilemma. Okay, let's put this into perspective. An EU organization wants to hire a cloud hosting vendor located in the United States. Very common business challenge, right? But the privacy issue here is heavily influenced by a massive piece of case law, the Court of Justice case C-311/18, which you probably know as the Schrems second judgment. The court ruled that when transferring data, the third country must offer a level of protection that is essentially equivalent to the EU. So how does a company resolve this? By strictly applying the two-step test. First, they lock down their Article 6 legal basis. Then, they look at Chapter V. Since the US doesn't always have a blanket adequacy decision for every single vendor, the organization has to implement specific safeguards and assess the US laws to ensure foreign surveillance won't undermine their users' rights.
All right, it's time for Section 5, Test Your Knowledge, Certification Prep. Let's see how well you've grasped these concepts.
Question 1. What is the mandatory first step of the EDPB's two-step test for international transfers? Is it A, implement encryption, B, establish a legal basis under Article 6, C, sign standard contractual clauses, or D, request an adequacy decision? Take a second to think about that checkpoint sequence we talked about. If you guessed B, you hit the nail on the head. Before you ever look at Chapter V transfer mechanisms like standard contractual clauses, the processing itself has to be lawful under Article 6. It's simple logic. You can't safely transfer data if you never had the right to process it in the first place. Moving to question 2. According to Article 44, what is the primary goal that must be ensured when data is transferred? A, zero data breaches, B, data localization, C, the level of protection is not undermined, or D, cost efficiency for the controller. The correct answer is C. And what's really interesting about this is how Article 44 acts as this continuous, unbreakable umbrella of protection. The GDPR doesn't mandate data localization. You absolutely can transfer data out of the EU. But the overarching rule is that the high EU standard of protection has to travel with the data. It must never be undermined. Let's try question 3. Based on EDPB guidelines, which scenario actually constitutes a transfer? A, data sent between two EU processors. B, an EU exporter disclosing data to an importer in a third country. C, anonymized data published online. Or D, a physical hard drive moving within Germany. And the answer is B. Remember those 3 specific criteria from the EDPB: an exporter subject to the GDPR, a disclosure of data, and an importer situated in a third country. If you check those 3 boxes, you've officially triggered Article 44. And our final question, question 4. If an organization fails the two-step test, what specific power can regulators use under Article 58, Paragraph 2, letter J? A, seize physical servers. B, order the suspension of data flows. C, imprison the data protection officer. Or D, revoke business licenses. The answer here is B. Beyond handing out massive financial penalties, regulators have the explicit, practical power to order the immediate suspension of data flows. It literally allows them to shut down an organization's international data operations overnight. That brings us to our final section, takeaways and next steps wrapping up. Let's quickly solidify the core lessons here. Number 1, Article 44 is the digital border checkpoint for personal data. Number 2, always apply the EDPB two-step test. Legal basis first, then your transfer safeguards. Number 3, the core philosophy is that the level of protection guaranteed by the GDPR must never be undermined, no matter where in the world the data goes. And number 4, regulators don't just issue fines. They will actively suspend your non-compliant data flows. If you enjoy these GDPR explainers and want to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, and compliance education for learners around the world. And hey, if you're looking for more structured training like guided learning paths, practice questions, or certification prep, definitely go check out privacyuni.com. While we focus on free knowledge here, Privacy Uni is perfect for those of you who want a more structured learning experience to really master these concepts. Just a quick disclaimer to finish up. This explainer is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. And I'll leave you with this final provocative thought. As our global economy becomes entirely borderless, will our digital border checkpoints become stricter, or will we finally see a truly global standard for privacy emerge? Keep learning, and I'll catch you in the next explainer.
Imagine shipping a crate of incredibly fragile, highly valuable glass across the world. You wouldn't send it to a destination that has no rules for safe handling. The package would stop at a glowing red customs gate the moment it tried to leave a protected zone. This is the challenge for companies sending European personal data abroad. If that data lands in a country with weak privacy laws, it becomes vulnerable to state surveillance. For the sender, that transfer can trigger regulatory sanctions that reach 4% of global turnover. To solve this, the GDPR created a specific legal route that eliminates the need for separate, individualized contracts for every transfer. It allows data to cross borders based on the strength of the destination's own laws. That mechanism is built directly into Chapter 5 of the GDPR, specifically under Article 45, which establishes the primary option for international data transfers. When a third country earns what is called an adequacy decision, the legal friction disappears. Moving a database to that country is treated with the same legal status as moving it between France and Germany. This provides the necessary bridge. It maintains high standards for fundamental human rights without preventing the data flows required for global trade. But the power to grant this status rests exclusively with the European Commission. They subject the third country to a rigorous multi-part evaluation. First, the Commission examines the country's domestic laws. They require strict, legally binding limits on how much access government intelligence and law enforcement agencies have to citizen data. Second, the country must have an active, independent privacy watchdog. This supervisory authority needs the specific power to enforce rules and provide citizens with direct assistance. Third, the Commission formally audits the country's international commitments to ensure they uphold global privacy treaties and fundamental human rights standards. If a country fails to meet even one of these specific criteria, the Commission cannot grant approval, functioning as a rigorous gatekeeper against insecure data sharing. The baseline standard is outlined in Recital 104. The third country must offer protection essentially equivalent to the EU. This doesn't require a word-for-word copy of the GDPR. Underlying laws can differ, provided practical protections and judicial remedies match the European standard. This assessment is never static. Under Article 45, the Commission is legally required to continuously monitor approved countries and conduct a formal, comprehensive review at least every 4 years. If a country changes its laws to weaken privacy protections, the Commission has the power to repeal, amend, or suspend the decision. An adequacy decision is a temporary, living assessment. It requires continuous compliance rather than one-time approval. In practice, this simplifies daily operations. A French software developer can use a cloud hosting provider in Japan without the administrative overhead of individual data transfer agreements. Similarly, an Italian bakery can upload employee data into a payroll software platform in Argentina and remain fully compliant with Chapter 5. But companies must avoid the scope trap. In Canada, the adequacy decision only covers commercial organizations regulated under the PIPEDA law. Public sector data is not covered by this specific direct route. Furthermore, an adequacy decision only legalizes the geographic transfer. The company still needs a separate, valid legal basis to process that data in the first place. Article 45 removes the friction of crossing borders, but it does not remove the baseline responsibility to protect the data subject. Regulators are constantly watching these borders. Data protection authorities actively audit corporate records to ensure that international data flows are legally justified. When protections fail, the courts intervene. The landmark Schrems I and Schrems II rulings famously struck down major data transfer agreements between the EU and the United States. The court's logic rested on paragraph 94. U.S. national security laws allowed government access to European data without giving those citizens enforceable rights in court. That lack of redress failed the essentially equivalent test. These rulings confirmed that national privacy watchdogs retain the independent power to investigate and suspend transfers, even if the Commission has previously granted an adequacy decision. Extensive government surveillance makes an adequacy decision impossible to maintain. It proves that the EU will prioritize fundamental rights over the convenience of international trade. Let's apply this to a final case study. Imagine a startup called HealthSync that wants to migrate sensitive patient data to servers in Switzerland. Because Switzerland holds an adequacy decision, HealthSync can migrate those servers immediately. They bypass the significant costs and the multi-month delays of custom legal drafting. Quiztone. If a company wants to use a new analytics vendor located in New Zealand, does the data protection officer need to seek specific local authorization from the government first? The answer is no. Under Article 45, Paragraph 1, no specific authorization is required for countries that have already been proven to provide adequate protection. This direct path is the core efficiency of Article 45. But staying compliant means you must actively monitor the shifting geopolitical landscape of global data.
Welcome back to Privacy Trainer. Okay, let's just dive right into this explainer on GDPR Article 46. If you've ever wondered, how modern global businesses actually legally transfer personal data across borders without breaking the law, well, you're in exactly the right place today. Article 46 is, quite literally, a critical piece of the international data puzzle. And what happens if an organization misunderstands it? We're talking massive fines, immediately suspended data flows, and honestly, an absolute compliance nightmare. Today, we're going to make sure that doesn't happen to you.
Here's our roadmap for today. We're covering the Article 46 Transfer Toolbox, recitals and real-world realities, regulatory focused and a case study, a certification knowledge check, and finally, key takeaways. Let's get into it.
So let's start with the big problem. Data has to flow globally for modern business to function, right? But what happens when you need to send personal data to a country that lacks what the EU Commission calls an adequacy decision? You absolutely cannot just send it and hope for the best. The GDPR requires you to have a legally sound backup plan to ensure that data remains protected no matter where it lands.
I love this comparison because it brilliantly illustrates how the framework operates. Think of it like this. If Article 45, which covers adequacy, is your VIP direct flight where the EU Commission has already cleared the destination, then Article 46 is your connecting flight. It requires extra security screening, baggage checks, and the active implementation of appropriate safeguards by you before that data is ever allowed to leave the European Economic Area.
Section 1. The Article 46 Transfer Toolbox. Let's see how this builds your compliance toolkit.
Article 46 basically gives us a literal toolbox of safeguards to use when adequacy is totally off the table. First, you've got standard contractual clauses, or SCCs. These are essentially pre-approved templates you can just sign. For multinational groups, you have binding corporate rules, or BCRs, which are internal rules for safe intra-group transfers. And you can also leverage approved codes of conduct, certification mechanisms, or legally binding instruments between public authorities. These tools provide the contractual or internal rules to protect data when the destination country's actual laws fall short.
Now, here's the massive plot twist. This was introduced by the landmark CJEU case Schrems II, case C311/18.
The court effectively said that SCCs alone cannot bind foreign intelligence agencies. I mean, think about it. A contract acting as a shield is completely useless if a foreign government can legally compel the data importer to just hand over the data. This means simply relying on the toolbox isn't enough anymore. You might actually need to bolt on additional, supplementary measures to keep the data safe.
Section 2. Recitals and real-world realities. The crucial point here is understanding how lawmakers actually intended us to use these tools in reality, not just on paper. Translating the legal text into actual practice, recitals 108 and 109 brilliantly illustrate that you're actively compensating for a lack of protection. You are literally building a bridge. SCCs are just your baseline. If local laws threaten privacy, you must actively compensate by adding technical safeguards. And Recital 114, it reminds us that enforceable rights and effective remedies are mandatory. The data subject must actually be able to enforce their rights in practice, not just read about them in some privacy policy.
Let's look at how this plays out in the real world. A smart tech company, for example, might pair SCCs with strong encryption to safely use a foreign cloud provider, making sure they keep the decryption keys securely inside the EU. On the flip side, a super common small business mistake is just blindly signing SCCs with a third country vendor and throwing them in a drawer without ever checking local surveillance laws. And a major compliance failure? Relying on a code of conduct without securing those mandatory binding and enforceable commitments from the data importer. Big mistake.
Moving on to Section 3, Regulatory Focus and Case Study. Let's step into the shoes of the regulators for a minute and tackle a realistic business scenario. During an investigation, you've got to know that regulators aren't just taking your word for it. They're looking for 3 very specific things. First, your documented transfer impact assessment, or TIA, showing you actually went in and analyzed the destination's laws. Second, the validly executed safeguard itself, like the signed SCCs. And third, undeniable proof of your implemented supplementary measures. If any of these slices are missing, you're looking at a major violation.
Walking through a mini case study step by step really brings this to life. Imagine your business challenge is needing to use a highly efficient SaaS platform hosted in a third country. The privacy issue? Well, that country has surveillance laws, like FISA 702 in the US, compelling tech companies to hand over data. Your standard contract literally cannot stop a government subpoena. So what's the action here? The EU company executes the SCCs, conducts their TIA, and implements pre-transfer pseudonymization, making sure the attribution key remains exclusively locked away in the EU. Boom, compliant.
Section 4, Certification Knowledge Check. Okay, time to test your understanding. We're going to go through some scenario-based questions designed just like the professional privacy certification exams. Question 1. An EU organization wants to transfer HR data to its subsidiary in a non-adequate third country. Take a look at the options on screen. Which Article 46 safeguard is specifically designed for these intra-group transfers? Is it A, B, C, or D? And the correct answer is B. Binding corporate rules, or BCRs, are tailor-made for multinational groups of undertakings or enterprises engaged in a joint economic activity. This allows them to establish a global internal framework to legally transfer data across their own borders. Question 2. Following the Schrems II ruling, case C311/18, if an organization relies on SCCs to transfer data to a third country, what mandatory action must they take? Scan the choices on your screen. Is it about consent, local laws, registration, or pseudonymization? The answer is B. You absolutely cannot just sign SCCs and be done with it. You must actively verify the legal landscape through a transfer impact assessment and apply supplementary measures to bridge any gaps in protection caused by local laws. Question 3. According to the European Data Protection Board, or EDPB, how do we properly use pseudonymization as an effective supplementary measure? Look at the scenarios on screen here. Who exactly needs to hold the key for this to actually work?
The correct answer is C. For pseudonymization to actually protect data from foreign surveillance, the magic key that re-identifies the data must be kept completely separate and exclusively under the control of the EU data exporter. It can literally never leave the European Economic Area.
Final question. A third country court orders an EU processor to disclose personal data. Under Article 48, how should the processor handle this cross-border data request? Check out the options. Do you disclose, ignore, or rely on international treaties? The answer is B. Article 48 exists specifically to protect EU data from unauthorized foreign judgments. Disclosures must be backed by an international agreement, like a Mutual Legal Assistance Treaty, or MLAT. And honestly, even then, you still need a valid Chapter 5 transfer ground. Section 5. Key takeaways. Excellent job on that quiz. Let's wrap this up with the absolute most important lessons you should take away from this explainer.
So, the crucial point is this. Article 46 provides your compliance toolbox, your SCCs, BCRs, and codes of conduct for when adequacy is absent. But thanks to Schrems 2, we know these safeguards are definitely not magic wands. You must actively assess the destination country's laws. If those laws undermine your contracts, you are legally required to build supplementary technical or organizational bridges of protection. Because at the end of the day, enforceable data subject rights are just non-negotiable.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and certification prep resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. So after everything we've covered today, how will you evaluate your next international data transfer?
Every second, multinational companies route employee and customer data across international borders. But moving personal data out of Europe hits a strict legal wall. This document highlights the legal fallout when a data transfer framework collapses. When the CJEU invalidated the Safe Harbor decision, it confirmed that once data leaves the EU, it risks losing fundamental protections. Relying on an invalid framework leaves companies exposed to multi-million euro fines. So how does a global enterprise legally move data between its own international branches without breaking European privacy law? Without a regulator-approved mechanism, a company cannot legally sync its global databases. This forces regional offices to silo their information, fragmenting the data flows that modern multinationals rely on to manage payroll, customers, and global strategy. Here, we are looking at the official text of the GDPR, specifically pointing us toward Article 47. This is the specific legal mechanism designed for affiliated companies to transfer data internationally. Under Article 47, a company can construct binding corporate rules, or BCRs. This allows the organization to build its own custom internal legal framework. Recital 102 of the GDPR demands that any transfer outside the EU must never undermine the guaranteed level of data protection belonging to an individual. A BCR solves this by ensuring every branch of a company adopts identical privacy standards. Article 47 functions as a structural expansion of European law, allowing a corporation to project the protective bubble of privacy rights across its global footprint. A binding corporate rule relies on two non-negotiable structural requirements. The first is internal bindingness. Every single subsidiary, branch, and employee within the group must be legally compelled to follow the framework. Companies achieve this through internal policies and direct employment contracts. If an employee in another country mishandles data, the BCR framework requires documented disciplinary consequences. This regulatory checklist details the second requirement, external enforceability. Data subjects, everyday people, must be granted rights to file a complaint or sue the company if their data is mishandled. A BCR only provides legal cover if it successfully binds the corporation from the inside while giving the individual real tower from the outside. To draft this document, a corporation must map its exact corporate structure, define the types of data it transfers, and embed GDPR principles like data minimization directly into its daily operations. Companies cannot self-certify these rules. They must pass a formal review known as the consistency mechanism. This requires a dual approval process. First, the company submits the framework to their lead supervisory authority, such as the French CNIL seen here. Then, it requires a review by the European Data Protection Board. For many firms, standard contractual clauses are a faster alternative, as they use pre-approved templates for individual transfer pairings rather than a custom-built corporate framework. Article 47 is a specialized path. It requires months of drafting and intense regulatory scrutiny, but it provides a single, unified framework for a global organization's entire data network. Many companies fail implementation by treating a BCR like a generic optional internet policy. Regulators expect the rules to function as an absolute, enforceable mandate. This checklist shows exactly what authorities look for. They demand evidence of enforcement, specifically looking for disciplinary clauses written directly into employment contracts and active audit logs. Another common error is failing to limit the scope. BCRs only cover data transfers within the specific corporate group. They provide no legal authorization for sending data to external third-party vendors. Failing a regulatory stress test invalidates the entire framework. It removes the legal shield for international operations, leaving the company vulnerable to fines based on their global turnover. Let's look at a practical scenario. Global Corp needs to centralize European HR data into a single United States database. Step 1 is establishing a BCR controller framework. This sets exact rules for handling the EU data. Step 2 requires updating employment contracts for all U.S. HR administrators to include severe sanctions for violating EU data principles. Next, they deploy an EU data rights portal and secure final lead supervisory authority approval. This meticulous application of Article 47 creates a reliable legal bridge between European privacy rights and international server infrastructure. Let's test your retention of Article 47. You will have a brief moment to answer each of the following 4 questions. Question 1. What must a BCR explicitly confer on meta subjects to be approved? It must grant them enforceable third-party beneficiary rights. Question 2. What happens if a BCR is not legally binding on employees via sanctions? The entire framework can be invalidated by regulators. Question 3. Can a company use a BCR to authorize data transfers to an external vendor? No, they only authorize intra-group transfers. Question 4. Who is responsible for officially approving a binding corporate rule? The competent lead supervisory authority, acting through the consistency mechanism. Understanding these specific constraints is required for any professional managing cross-border data. Passing an audit requires more than just paperwork. It requires active enforcement. The 5 core takeaways are: BCRs function as localized privacy law. They are for intra-group transfers only. They must be binding via sanctions. They must grant enforceable rights. And they require regulatory approval. If you found this breakdown valuable, support Privacy Trainer memberships to help us scale free privacy and AI education globally. For professionals looking to advance their expertise, visit privacyuni.com for structured learning paths, workshops, and certification preparation. Please note, this video is for educational purposes only and does not constitute legal advice. Mastering Article 47 establishes a permanent, reliable channel for data that satisfies both international business needs and European regulators.
All right, welcome back to another Privacy Trainer Explainer. Today, we're unpacking what is basically the ultimate jurisdictional shield, GDPR Article 48. Whether you're a seasoned privacy pro, a business leader, or, just starting out on your compliance journey, getting a solid grip on this article isn't just helpful, it's absolutely vital for protecting your organization. Okay, let's dive right into a seriously high-stakes scenario. Picture this. You open your inbox, and there it is, a direct order from a third country court demanding you surrender the data of your European users. And of course, they're threatening severe sanctions if you ignore them. But here's the massive catch. If you just panic, comply, and hand over that data directly, you could face an enormous GDPR fine back home. So what do? Who do you listen to? Well, that exact dilemma is the problem Article 48 was built to solve.
So here is the roadmap for your defense strategy today. We'll unpack the core legal text, check out some real-world scenarios, do a quick mini case study, and wrap it all up with a knowledge check.
Let's jump into Section 1 and start with the law itself, the European Union's shield against extraterritorial overreach.
So, the absolute most crucial point here is this. Article 48 clearly states that any judgment from a third country court, or even an administrative authority, requiring you to transfer personal data, it is not automatically recognized in the EU. Period. For that foreign demand to hold literally any legal weight, it has to be based on an international agreement. To put that in plain English, a foreign judge is not your boss. They can't just reach across the border and demand European data whenever they feel like it.
And this brings us to a really brilliant concept, the MLAT, or Mutual Legal Assistance Treaty. If Article 48 is the shield blocking those unauthorized requests, the MLAT is the bridge. Think of it as a highly secure, authorized diplomatic bridge. Really, it's the only acceptable path for foreign authorities to cross. It's an official, formal treaty between the requesting country and the EU that ensures data gets shared safely, lawfully, and with all the proper oversight.
Now, to really get why this even exists, we have to look at Recital 115. This recital tells us exactly what lawmakers were thinking. It's designed to protect against foreign laws that might try to entirely bypass European sovereignty. Lawmakers wanted to make absolutely sure that another country's jurisdiction couldn't just be used to strip away the fundamental privacy rights guaranteed to people inside the EU. It's honestly a declaration of digital independence.
All right, moving into Section 2, let's see how all this legal theory actually plays out in the real world.
Let's look at a couple of everyday examples. First, imagine a large tech company gets a subpoena from US law enforcement asking for a user's communications. Or, second, a small European e-commerce business gets an audit demand from a foreign tax authority wanting customer purchase records. Whether you're a massive tech giant facing down the police or a tiny business dealing with a tax agency, the core issue is exactly the same, a jurisdictional conflict. In both of these cases, responding directly without an MLAT puts you in direct violation of the GDPR.
Now, what's genuinely fascinating here is the regulatory perspective. Notice the EDPB guidelines highlighted on this slide. Regulators aren't just checking to see if you handed the data over. During an investigation, they are strictly evaluating whether you documented your refusal of those direct, unauthorized requests. They expect to see a solid paper trail proving that you evaluated the request, realized there was no MLAT, and formally pushed back.
Which brings us to a massive, frankly very common compliance failure. The biggest mistake organizations make? Panicking. They see a scary foreign subpoena threatening sanctions, and they just hand the data straight to the foreign court to avoid trouble. The correct action is to hold your ground. You absolutely must refuse the direct request and instruct that foreign authority to submit their demand through the proper channels, like an established MLAT or your national competent authority.
Let's head into Section 3 and walk through a quick mini case study of exactly what you should do when one of these demands actually hits your inbox.
You have to apply what the EDPB calls the two-step test. Step 1, you need a valid legal basis under Article 6 just to process the data in the first place. If you have an MLAT, this might be a legal obligation. Step 2, since you're sending data out of the EU, you need a Chapter V transfer ground. And Step 3, which is critical, as the data controller, you are completely expected to review the legality of the request and challenge it if it's unlawful or disproportionate. You don't just blindly comply, right? You actively defend the data. All right, Section 4. Time for a quick knowledge check to test your skills with some certification-style questions. Here's your first scenario. A foreign tax agency demands EU employee data directly, and there is no MLAT in place. What is your correct initial action? Do you comply immediately, refuse and refer them locally, delete the data, or just send it anonymized? Take a second and think about it. If you went with B, you hit the nail on the head. As we just discussed, EU companies should generally refuse direct requests when there's no international agreement in place. You've got to force that foreign entity to use proper diplomatic channels.
Moving on to question 2. This one tests a very common misconception. According to the EDPB, does a direct order from a foreign judge automatically constitute a lawful Article 6 basis? Always? Never? Or does it depend on the case?
The correct answer here is C. Look, a foreign court order is not a magic wand. The EDPB explicitly states that a request from a foreign authority does not, in and of itself, grant you an Article 6 legal basis to process or transfer that data. Okay, question 3. If an MLAT actually does exist and makes disclosure mandatory under EU law, which Article 6 basis applies? Is it consent, legitimate interest, legal obligation, or contract?
For this one, you'd rely on C, legal obligation. When a valid international agreement, like an MLAT, is in play, it effectively transforms that foreign request into a binding legal obligation under European law, and that neatly satisfies your Article 6 requirement.
Final question, and this one is tough. What if there is no MLAT, but you're facing severe foreign sanctions if you don't comply? You are literally caught between a rock and a hard place. Do you just save the business, or do you use a derogation?
As brutal as it sounds, the correct choice is C. While you might try to claim a legitimate interest to avoid foreign fines, the EDPB strongly warns that fundamental privacy rights will usually override your corporate interests in avoiding those sanctions. You simply cannot sell out your users' rights just to save yourself from a foreign penalty.
So, to wrap the whole shebang up, here are your big takeaways. 1. Foreign orders absolutely need MLATs to be enforceable in the EU. 2. A direct request from a foreign authority is never a legal basis on its own. 3. Always apply the two-step test. Find an Article 6 basis and a Chapter V transfer ground. And 4. Don't be afraid to push back and challenge unlawful extraterritorial requests.
Before we go, if you enjoy these GDPR explainers and want to support the channel, consider becoming a member of Privacy Trainer. Your memberships actually help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and really use AI to scale education globally. Also, if you're looking for more structured training, like guided learning paths, workshops, practice questions, and certification prep, definitely go explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available right here, while Privacy Uni is designed for folks who prefer a more structured, step-by-step learning experience. So, I'll leave you with this thought. The next time a foreign subpoena randomly lands in your inbox, what will your very first move be? Thanks so much for joining me on this deep dive into Article 48. Disclaimer, this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. Stay compliant out there, and I will see you in the next explainer. Welcome to Privacy Trainer. Let's dive straight into this explainer and explore the absolute last resort for international data transfers, GDPR Article 49.
Now, if your organization transfers data across borders, you already know the standard front doors. Things like adequacy decisions or standard contractual clauses are getting way harder to use. But what happens when those doors slam shut? Can you still move data? Well, yes, but only through a heavily guarded emergency exit. Misunderstand this article and you're looking at massive compliance failures and some seriously heavy regulatory fines. So today, we're going to decode Article 49 so you know exactly when to pull that emergency alarm and when to just keep your hands off it. Here is our roadmap for today. We'll start with the transfer emergency exit. Decode the actual text of Article 49. Look at some practical scenarios. Check out the regulators and failures, run through a quick knowledge check, and wrap up with key takeaways. Okay, so here's the core problem we're facing. What do you actually do when the standard front doors for data transfers are firmly locked? Chapter V of the GDPR is built to guarantee that when data leaves the European Economic Area, its protection travels right along with it. Normally, you'd rely on an adequacy decision under Article 45, or appropriate safeguards like SCCs under Article 46. But let's be real, things break, negotiations fall apart, contracts can't get signed, or an absolute emergency strikes out of nowhere. Lawmakers knew they couldn't just paralyze global data flows in those exceptional circumstances, so they created Article 49 to solve this exact problem. The absolutely crucial point to remember is that Article 49 is the emergency exit. It is not meant for your daily business operations. It operates as a derogation, and in legal terms, a derogation is really just an exception to the general rule. Because it's an exception, European law dictates it must be interpreted super restrictively. You simply cannot use Article 49 for routine, systematic, or continuous data transfers. It applies only in specific, occasional situations. And most importantly, to use almost any of the options under this article, you've got to pass a strict necessity test. The transfer can't just be helpful, it literally has to be necessary.
When we look at the actual legal text of Article 49, the heading itself kind of gives away the secret: derogations for specific situations. It explicitly states that these conditions only apply in the absence of an adequacy decision or appropriate safeguards. Lawmakers put this in there to make sure fundamental rights aren't just completely abandoned the second our standard tools fail. But they also recognize that in a highly globalized world, a total hard stop on data could actually harm the very people that GDPR is trying to protect, like someone needing emergency medical care abroad.
Let's break down the first 3 keys that can actually unlock our emergency exit. First up, explicit consent. Now, this is not your standard everyday cookie banner consent. The user has to be fully informed of the specific risks of the transfer because of the lack of safeguards. It's a very high threshold and it's easily withdrawn, which makes it pretty terrible for stable business operations. Next is contract performance. This is where that necessity test really shines. The transfer must be objectively indispensable to fulfill a contract requested by the user, like an EU travel agent transferring your name to a hotel in Asia so you actually have a room when you show up. Third, we have public interest. This has to be recognized in EU or member state law. Think along the lines of international cooperation on tax fraud or tracking contagious diseases.
Moving to the remaining derogations, we have the establishment, exercise, or defense of legal claims. If your company gets sued abroad, you can transfer data to defend yourself, but it must be highly targeted. Absolutely no massive data dumps allowed here. Then there's vital interests. This one is literally life or death. It applies when the data subject is physically or legally incapable of giving consent, like during a severe medical emergency. Finally, notice how the compelling legitimate interest provision is the most restrictive of the bunch. It is the absolute last resort. If you end up using this, the transfer cannot be repetitive, it can only affect a limited number of people, and you are legally required to notify your supervisory authority.
This quote from Recital 111 is absolutely vital because it acts as a sort of decoder ring for Article 49. The European Data Protection Board, the EDPB, in their Guidelines 2/2018 rely heavily on this exact recital to emphasize that exceptions cannot become the rule. The word occasional is your biggest guardrail here. If a transfer happens regularly within a stable relationship between a data exporter and an importer, it's systematic, it's not occasional. And therefore, Article 49 cannot be your legal basis. Let's see how this actually plays out in practice. Imagine a multinational technology SaaS company decides to centralize all of its European human resources data in a non-EU country, and they try to claim it's necessary for the employment contract under Article 49. That is a massive compliance failure. Why? Because HR processing is continuous, systematic, and structural. It's the exact opposite of occasional. On the flip side, look at our second scenario, a small EU travel agency. They book a specific tour in South America for a client. That transfer of the client's details to the local tour guide is occasional, and it's strictly necessary to perform that one specific contract. That is a textbook, perfect use of Article 49. Now, the most dangerous trap privacy professionals fall into, especially in the fallout of the Schrems II ruling, is treating Article 49 as a convenient quick-fix workaround when standard contractual clauses just seem a bit too difficult or expensive to implement. But the reality? Article 49 is highly restrictive. It demands a rigorous necessity test, and it legally cannot support your continuous day-to-day business operations. Trying to use it as a shortcut is basically a fast-track to regulatory penalties.
So what happens when a regulator actually comes knocking on your door? Well, they're going to immediately look for documented evidence of your necessity test. Regulators strictly follow EDPB Guidelines 2/2018. Ever since the landmark case C211/18, better known as Schrems II, any international transfer is put under a massive microscope. Regulators will lean right on case law, like the Meta Platforms case C252/21, which definitively states that necessity means objectively indispensable. If your documentation shows that transferring the data was merely useful, convenient, or just good for business analytics, you're going to fail the test and face enforcement action. Let's walk through a mini case study to really cement this. Imagine your EU-based company faces a huge lawsuit in a US court. The US judge issues a discovery order demanding access to all of your employee emails. Under GDPR Article 48, a foreign court order just isn't enough on its own without an international agreement, like a mutual legal assistance treaty. So you've got a major conflict of laws on your hands. The solution here is Article 49(1)(e), a transfer necessary for the defense of legal claims. But you can't just dump your entire server over to the US. You have to perform a strict necessity test, heavily redact any unrelated personal data, and transfer only the specific, relevant emails. You're squeezing the data through the emergency exit. You are not opening the floodgates. Okay, time for our certification-style knowledge check. These questions are designed to test your practical understanding, not just rote memorization. Here's scenario 1.
A SaaS company regularly transfers all of its EU customer support tickets to a team in India, claiming Article 49 contract performance. Is this compliant? Is it A, yes, it's necessary for support, B, yes, if customers agree in the terms of service, C, no, because the transfers are repetitive and systematic, or D, no, they must use explicit consent instead? Take a second and lock in your answer.
If you guessed C, you hit the nail on the head. Regular systematic business operations have to rely on Chapter V safeguards like standard contractual clauses, not Article 49 derogations. Because customer support is a continuous, daily operation, it utterly fails the occasional requirement outlined by the EDPB. You simply cannot run your global support desk through the emergency exit.
Let's move to scenario 2. To perform a contract, a non-EU vendor requests extra marketing analytics data, claiming it would be useful to improve the service. Can Article 49(1)B apply here? Is it A, yes, as long as it improves the service? B, no, the processing must be objectively indispensable? C, yes, if it is an occasional transfer? Or D, no, marketing data requires vital interests? Think really carefully about that necessity test threshold we talked about.
And the answer is B. The Court of Justice made it crystal clear in cases like C-252/21 and C-17/22 that merely useful is never enough. To pass the necessity test, the data transfer must be objectively indispensable for the main subject matter of the contract. If the contract can still be completely fulfilled without those extra marketing analytics, then transferring that data is illegal under Article 49.
All right, scenario 3. A third country regulator demands massive generalized access to an EU bank's records, but there's no international treaty or agreement in place. What should the bank do? A, send all data. B, ignore completely. C, apply strict necessity. Or D, rely on Article 45. Make your choice. The correct answer here is C. You have to fiercely protect the data. A general demand for massive access is never going to be compliant. If there's a specific, formalized legal procedure, you might be able to use Article 49(1)E for the defense of legal claims, but you must apply that strict necessity test and only send the absolute minimum amount of data required for that one specific claim. Our final question looks at a high-stress, real-world emergency. An EU citizen is unconscious in a foreign hospital. The hospital urgently requests their medical history. Which derogation applies here? A, Article 49(1)(B), contract. B, Article 49(1)(A), consent. C, Article 49(1)(F), vital interests. Or D, Article 49(1)(D), public interest.
The answer is C. This is the absolute textbook use case for the vital interest derogation under Article 49(1)(F). It is specifically designed to protect life or physical integrity when the data subject is physically or legally incapable of giving consent. I mean, you definitely wouldn't wait for SCCs to be signed while someone's life is literally on the line.
To wrap up this explainer, let's consolidate what we've learned. The biggest takeaway is that Article 49 is the emergency exit, never the front door. These derogations are exceptions to the fundamental right of data protection, and regulators interpret them highly restrictively. Remember the golden rule. Transfers here must generally be occasional, never continuous or systematic business processes. Your necessity test has to prove the data is objectively indispensable, not just convenient. And finally, if it isn't documented, it didn't happen. Keep robust records of your necessity analysis to satisfy any inquiring regulators.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone.
If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience.
This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I'll leave you with this final thought. Take a hard look at your data flows today, especially the ones involving foreign vendors or remote teams. Ask yourself, is your emergency exit accidentally being propped wide open for daily traffic? Because if it is only a matter of time before a regulator walks right through it. Thanks for joining us, and keep your data safe.
Welcome to this explainer on GDPR Article 50. Today, we're tackling the ultimate border versus borderless challenge in global data privacy. Think about it for a second. Data travels at the literal speed of light across the globe, but regulators, well, they're historically stuck behind physical, national borders. So today, we're going to explore exactly how the GDPR bridges that gap to protect your data no matter where it ends up. Before we jump in, if you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Okay, let's get right into it.
Here's our quick roadmap for today. We'll start with why Article 50 matters, decode the actual legal text, look at some real-world applications, and then finish up with a knowledge check and our key takeaways.
Section 1. Let's look at why Article 50 actually matters in the real world. So, data flows instantaneously across the planet, right? You could literally be sitting at a cafe in Paris using an app developed by a team in Tokyo, all while your data is hosted on servers over in the United States. It's totally seamless for us, but for regulators restricted by their national borders, it creates a massive jurisdictional headache. And that brings us directly to Article 50, which is basically the GDPR solution for global enforcement. Let's look at the mechanics of how these different authorities actually team up to make this work. Section 2, decoding the legal text. Let's break down what the law actually says. When you read the text of Article 50, it's pretty fascinating because it explicitly gives regulators a clear mandate to team up. It directs the European Commission and national supervisory authorities to develop mechanisms that facilitate effective enforcement. We're talking about specific actions here: complaint referral, investigative assistance, and active information exchange. It's essentially building a giant global neighborhood watch program for data privacy. And this whole mandate is deeply rooted in Recital 116. Lawmakers recognize a huge loophole. When personal data moves outside the EU, the risks to citizens absolutely skyrocket.
Why? Because a single national authority usually just doesn't have the resources or the jurisdiction to investigate a foreign company entirely on its own. So, Recital 116 explains that authorities absolutely must connect globally to overcome these practical obstacles and navigate around inconsistent legal regimes.
So, let's translate this legal jargon into our everyday reality. When Article 50 says regulators need to develop international cooperation mechanisms, what it means in plain English is that they are instructed to build treaties, protocols, and working groups. This allows them to investigate and ultimately penalize foreign companies together. Lawmakers purposely included this so that a privacy violation in Europe, caused by a company based thousands of miles away, doesn't just hit a dead end at the border.
Section 3. Real-world application. Let's see how this actually plays out on the ground.
Practically speaking, Article 50 hits differently depending on the size of your organization. If you're a massive global tech giant, this means you're likely going to face coordinated investigations where an EU authority and a foreign authority are actively sharing notes on your data breach. Now, if you're a small EU e-commerce business using a foreign analytics vendor, and that vendor messes up and misuses data, your local EU authority can use Article 50 to tap the vendor's local regulator for help. And what about a massive compliance failure? That happens when a foreign processor just flat out ignores an EU data protection authority, assuming the EU has zero jurisdiction over them.
Let's actually zoom in on that compliance failure for a second because it is a very common misconception. A lot of foreign companies mistakenly believe that the GDPR only has enforcement teeth inside Europe. They think, well, I'm not in the EU, so they can't touch me. But the compliance reality is a whole different ballgame. Article 50 allows EU regulators to leverage foreign authorities to investigate you locally. So if you ignore an EU regulator, they're just going to knock on the door of your local national regulator and say, hey, we have a mutual assistance agreement. We need you to look into this company right now.
From a regulatory and enforcement perspective, authorities are super focused on formalizing these bridges. They rely heavily on mutual legal assistance treaties, or MLATs, and other international agreements. Plus, as we saw in the landmark CJU case, CED 252/21, regarding meta platforms, there's a massive emphasis on sincere cooperation. This means that even when a totally different body, like a competition authority, is looking into data processing, they have to cooperate sincerely with the lead data protection authority to make sure the GDPR is applied consistently. Information sharing isn't just a nice to have anymore, it's a strict mandate.
Let's walk through a mini case study to really cement this. Imagine a European hospital sends patient data to a processor in a third country for advanced analytics. That's step 1. In step 2, that processor suffers a breach, but they decide to just completely ignore the EU Supervisory Authority's emails and inquiries. Step 3. Instead of just giving up, the EU authority invokes an Article 50 mechanism and contacts their equivalent counterpart in that third country. Finally, step 4. The third country authority uses its own local powers to demand answers, do the investigation, and share the findings right back with the EU. That coordinated joint enforcement forces the processor into compliance. You just can't hide behind a border anymore.
Section 4. Knowledge check and takeaways. It's time to put on your privacy professional hats and test what we've covered.
All right, read through this scenario carefully. An EU supervisory authority is struggling to investigate a data broker located in a third country. Under Article 50, what action should they take? Is it A, impose an immediate fine without an investigation? B, issue a direct ban on the third country's internet traffic? C, seek investigative assistance and information exchange with the third country's equivalent authority? Or D, refer the case to the World Trade Organization? Take a second to lock in your answer.
If you guessed C, you nailed it. Article 50 explicitly mandates mutual assistance, which includes complaint referral and investigative cooperation. It's all about building bridges for enforcement, not imposing wild unilateral trade bans or acting without due process.
Let's move on to question 2. This one tests your knowledge of the legislative intent behind the article, specifically outlined in Recital 116. Why is international cooperation among supervisory authorities necessary? Is it A, because data subjects can't travel to file complaints? B, to overcome practical obstacles like resource constraints and inconsistent legal regimes? C, to standardize global corporate tax rates? Or D, because the GDPR requires all third countries to adopt EU law entirely? What do you think?
The correct answer here is B. Lawmakers specifically noted in Recital 116 that supervisory authorities are really hampered by their own borders, inconsistent legal regimes, and a lack of resources. So international teamwork is totally vital to overcome these practical hurdles and actually protect people.
Question 3. A third country administrative authority directly demands personal data from an EU processor. Relying on the broader context of Chapter V and Article 48, how should this be handled? This question is great because it tests how international cooperation intersects with the broader rules on data transfers. Is it A, transfer data immediately? B, only recognize the request if based on an international agreement like an ML8? C, ignore all foreign requests permanently? Or D, ask the data subjects to vote on the transfer?
The answer is B. As the EDPB guidelines on Article 48 make clear, foreign judgments or administrative decisions that require a data transfer can generally only be recognized if they're based on a formal international agreement, like an MLT. That's how we ensure fundamental rights are actually upheld.
And for our final question, consider the regulatory and enforcement perspective. Based on the principles seen in cases like C25221, the Meta Platforms case, how are national authorities expected to act when overlapping data issues occur? A, compete to issue the highest fine. B, act in isolation. C, engage in sincere cooperation. Or D, delegate all decisions to the European Commission. Take a guess.
Answer C is absolutely correct. The overarching spirit of the GDPR, both internally and internationally, is sincere cooperation. Regulators are legally bound to work together, share information, and respect each other's competences so they can maintain a consistent level playing field for data protection globally. So, to wrap up today's explainer, here are your key takeaways. Always remember that data has no borders, and Article 50 is the vital bridge that gives the GDPR its global reach. It legally codifies mutual assistance, complaint referrals, and intelligence sharing between regulators. It specifically addresses those severe risks of cross-border data flows that we saw highlighted in Recital 116. And ultimately, it's the exact mechanism that allows regulators to work together to protect your data no matter where it goes. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam, and certification preparation resources, you can also explore PrivacyUni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while PrivacyUni.com is designed for learners who prefer a more structured learning experience.
Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. As we wrap up, consider this. With new data privacy laws emerging globally every single day, will Article 50 become the blueprint for a truly worldwide privacy treaty, or will national interests keep our data enforcement fractured? Thanks for watching. Stay curious and keep learning. Picture this for a second. You're watching a massive, high-stakes championship game. It's tied up, the tension is just off the charts, and suddenly the referee makes a highly controversial call that completely hands the win to one side. Now, what if you found out that the very next day that the referee was secretly on the payroll of that winning team? The entire integrity of the game would just vanish overnight, right? Well, that exact same principle applies directly to the world of data privacy. Welcome to This Explainer. Today, we are unpacking GDPR Article 51. This is the critical rule that stops that compromised referee scenario dead in its tracks by setting up what we call the independent privacy watchdogs. Honestly, without this specific article, all those grand rights and protections in the GDPR, they'd just be ink on a page. All right, let's take a super quick glance at our agenda. We're going to cover the privacy watchdogs explained, the complete independence mandate, real-world scenarios and mistakes, a step-by-step case study, a certification knowledge check, and finally, takeaways and next steps. Let's dive right in.
Part 1. The privacy watchdogs explained. Let's look at what the law actually says in plain English.
Basically, Article 51 explicitly tells every single EU country, you absolutely must set up one or more independent public bodies. We call these supervisory authorities, or SAs for short. And their job? It's to monitor how the GDPR is applied, fiercely protect people's fundamental privacy rights, and actually help data flow freely. So the big takeaway here is that Article 51 demands the creation of totally impartial referees. They're there to make sure privacy rules are actually enforced, not just tossed around as friendly suggestions.
Now, to really get why lawmakers built it this way, we've got to peek at Recital 129. And it makes total sense. The goal was consistent monitoring and enforcement everywhere in the Union. Lawmakers wanted to be absolutely certain these watchdogs had real teeth. I'm talking investigative powers to demand your internal records, corrective powers to drop massive fines, and the actual authority to drag bad actors into legal proceedings. They are definitely not just advisory boards. They are heavily armed enforcers.
Moving on to Part 2, the complete independence mandate. Because setting up a regulator is one thing, but keeping the politicians out of their business, that's a whole different story. Governments have historically loved trying to put pressure on these regulators, and the courts have had to step in time and time again to swat them away. This is a perfect example of the rule plus case method. The Court of Justice of the EU, the CJEU, has been relentless here. Back in 2010, case C518/07 against Germany, the court said state monitoring completely violates independence. Then in 2012, case C614/10 against Austria, they ruled that if a watchdog relies on the government for IT and staff, it's not actually independent. And in 2014, case C288/12 against Hungary, the court said you absolutely cannot fire the head of the authority early just because they did something you didn't like. Complete independence literally means zero instructions and zero improper oversight, period. So you can clearly see the contrast we're dealing with here. Complete independence means acting completely freely. No instructions, no looming threats, just pure objective decision-making. On the flip side, improper influence usually sneaks in through back doors. Think forcing the regulator to share a budget with a political ministry, making them use government staff, or dangling their job security over their head. Operational freedom is just absolutely essential here. All right, Part 3, real-world scenarios and mistakes. Let's bring this down to earth and see where companies usually trip up.
So how does this actually play out? Well, if you're a massive tech giant, you'll probably be dealing with cross-border investigations from a lead supervisory authority. If you're a local mom and pop shop, you might actually reach out to them for objective advice. But listen, the single biggest compliance failure I see across the board is organizations completely misunderstanding who they're dealing with. They ignore corrective orders because they think, it's not a real court. Big mistake. Confusing these independent enforcers with an optional advisory board is pretty much a fast track to ruinous fines.
And trust me, from an enforcement standpoint, these investigators are fiercely protective of their mandate. If they come knocking, you better be ready to prove you respect their binding powers. You need to treat their inquiries with the exact same gravity as a subpoena from a federal judge. No exceptions.
Let's put this into practice with a quick case study. Imagine this. A country passes a shiny new law demanding that the national privacy watchdog must report all its upcoming fines to the Ministry of Economy before actually issuing them. So what's the privacy issue? Well, does this threaten objective enforcement? Apply Article 51 in that Austrian case law we talked about. Because the ministry could subtly pressure the watchdog to lower a fine to, say, protect a local business, the conclusion is a no-brainer. The law is totally invalid. It shatters that absolute shield of complete independence.
Okay, let's jump to Part 5, the certification knowledge check. Let's see how much of this is actually sticking with 4 quick scenario questions. Question 1. A member state passes a law allowing the Prime Minister to fire the head of the supervisory authority early if they disagree with a huge fine against a local tech star. Is this compliant? Take a second, think about the case law on premature termination.
And the answer is B. No way is that compliant. Just like we saw in the Hungarian case, cutting a term short destroys the regulator's freedom from political threats.
Let's try question 2. A national competition authority is investigating a company for antitrust stuff, but oops, they discovered GDPR breaches too. Can the competition authority just act as the Article 51 supervisory authority and issue those GDPR fines themselves? Got your answer? It's B. Look, government agencies can absolutely talk and share notes, but only the specifically designated, entirely independent Article 51 authority has the actual legal mandate to enforce the GDPR and drop those fines. Question 3. A national government wants to save some cash, so they force the supervisory authority to use the Ministry of Interior's IT systems and HR staff. Does this comply with Article 51? Think about operational realities here.
The correct answer here is C. Just like the court ruled in the Austrian case, if you rely on a government department for your basic workforce or servers, you're not actually independent. You just can't bite the hand that pays your staff and runs your email.
Last one, question 4. A business gets hit with a corrective order from the SSA, and they are not happy about it. What is their legally correct next step? How do they fight back? The answer is D. Since these authorities act totally independently of politicians and lawmakers, the only way to challenge their binding decisions is to take it up through the formal judicial system in a real national court.
Let's quickly wrap up with the absolute must-know takeaways. First, SAs are the required independent privacy watchdogs in every EU country. Second, complete independence means zero external influence, direct or indirect. Third, this independence is aggressively, and I mean aggressively, protected by CJEU case law. And lastly, SAs wield powerful, binding, investigative, and corrective powers. Article 51 is quite literally the bedrock of GDPR enforcement. If you're enjoying these GDPR explainers and want to support the channel, consider becoming a member of Privacy Trainer. Memberships really help us keep creating free privacy, security, AI, and compliance education for people all over the world. Our mission is to make high-quality knowledge accessible and use AI to scale education for everyone. Also, if you're looking for more structured training, like guided learning paths, workshops, practice questions, or certification prep, definitely check out privacyuni.com. Privacy Trainer is all about making knowledge freely available right here, while Privacy Uni is built for learners who want that deeper, structured experience.
Just a quick wrap-up note. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thank you so much for joining me on this explainer. I'll leave you with this one thought to chew on. As data continues to literally run the global economy, who watches the watchdogs if their independence is ever compromised? Keep learning, and I'll catch you in the next one.
Welcome back to Privacy Trainer. Today, we are diving deep into Article 52 of the GDPR. And honestly, you can think of this as the ultimate shield. It's the law that protects our data watchdogs and ensures that your privacy rights are enforced without any political or corporate interference. So whether you're a privacy pro, a business leader, or a student just getting started, mastering this concept is absolutely foundational. Let's get into it.
So think about this for a second. Who actually watches the watchdogs? Imagine a world where the referee of a championship game is literally paid by the home team. I mean, what could go wrong, right? Well, quite a lot. If organizations and governments control the very privacy regulators meant to police them, public trust completely collapses. And that is exactly why Article 52 exists. It guarantees that supervisory authorities, the DPAs, can act as totally impartial guardians of our personal data. If governments misunderstand this, they risk having their entire regulatory framework invalidated by the courts.
All right, here's our roadmap for today's explainer. We'll start with the complete independence shield, then look at case law and real examples, move into mistakes and enforcement focus, tackle a compliance mini-case study, test your skills with a certification knowledge check, and finally wrap up with takeaways and next steps. Okay, Section 1, the complete independence shield, breaking down the legal text. What's really fascinating here is just how comprehensive the law actually is. Think of this as the referee rule. Article 52 contains 6 specific paragraphs that systematically lock down every single avenue of potential influence. Paragraph 1 establishes the absolute baseline, complete independence. Paragraphs 2 and 3 mandate that members remain totally free from external influence, they can't seek or take instructions from anyone, and they're strictly prohibited from holding any incompatible occupations during their term, whether that's a paid gig or completely unpaid. Then we get to paragraphs 4, 5, and 6, and these are all about the resources. They demand separate premises, adequate staff, and an independent public financial budget. Lawmakers put this in because, let's face it, a watchdog without teeth or a budget isn't much of a watchdog at all. And this is powerfully backed up by GDPR recitals 117 and 118. Just picture an impenetrable glass shield protecting a data server. There must be a complete operational separation from the state. Moving on to Section 2, case law and real examples, precedents that defined independence. The Court of Justice of the European Union, the CJEU, has made its stance incredibly clear on this. Across multiple rulings, they've noted that supervisory authorities simply must perform their duties completely free from external influence. And they highlighted something super crucial here. Even the mere risk of political influence is enough to hinder a data protection authority's ability to act. If a regulator is sitting there fearing budget cuts or political backlash, they might engage in what the court calls prior compliance, basically watering down their own enforcement just to keep the government happy. And looking at the history brilliantly illustrates this point. We have 3 landmark cases that really defined Article 52. First up, case C518/07 in Germany, where the court ruled that subjecting regional data authorities to state scrutiny created an unacceptable risk of political influence. Next is case C614/10 in Austria. Now here, the privacy watchdog was functionally independent, sure, but their staff, budget, and IT were legally tied to the federal chancery. The court basically said no way. Whoever controls the payroll and the servers controls the regulator. Finally, we have case C288/12 in Hungary, where the government prematurely ended the term of the DPA head. The CJEU stepped in and ruled that a regulator can only be truly independent if they're guaranteed to serve their full term without fear of getting fired for just doing their job.
All right, Section 3, mistakes and enforcement focus, where compliance fails.
So, the really crucial takeaway here is that a government simply stating a regulator is independent on paper is a massive failure if they secretly control the operational reality. We see mistakes all the time, like merging the DPA's IT systems with a government ministry, or relying on another department for hiring, or, and this is a big one, allowing DPA members to hold side jobs that conflict with their duties. Regulators and courts look incredibly closely at the budget and the org chart. For instance, if a global tech giant is under investigation, the DPA needs the sheer financial bandwidth and technical experts to go toe-to-toe with corporate lawyers without having to beg for emergency funding from the state. On the flip side, if they're advising a small local business, they have to do so without political directives telling them which industries get leniency. If a government uses budget cuts to silently restrict enforcement against, say, a state-owned enterprise, that is a direct, blatant violation of Article 52.
Now for Section 4, compliance mini-case study, analyzing a realistic business challenge.
Let's walk through this case study step by step. Here's the challenge. A government decides to merge the Data Protection Authority's payroll and IT infrastructure with a central government ministry to save administrative costs. Honestly, it sounds like an innocent, highly efficient business decision, doesn't it? But here is the major issue. The DPA staff are now hierarchically linked to the ministry for their paychecks and their tech support. If we look at the precedent, specifically CJEU case C614/10 regarding Austria, the court explicitly forbids this. So the conclusion is crystal clear. This seemingly innocent cost-saving measure actually destroys the structural independence of the privacy watchdog, which results in a direct violation of Article 52.
Moving right along to Section 5, certification knowledge check. Let's test your practical understanding.
All right, question 1. A government disagrees with a DPA's tech ruling and fires the DPA head before their term ends. Which case law makes this illegal? Is it A, B, C, or D? Take a second and think back to the precedents we covered regarding term limits and political retaliation. Got it? The answer is B. The Hungary case, C-288/12, clearly established that allowing a DPA to serve its full term of office is an absolute mandatory requirement. You simply cannot fire the referee just because you don't like the call. Okay, question 2. A DPA member takes a weekend, unpaid advisory role at a local data analytics startup. Does this violate Article 52? Let's evaluate exactly how the GDPR handles conflicts of interest and outside activities. And the correct choice is C. Article 52, paragraph 3 explicitly forbids DPA members from engaging in any incompatible occupation during their term. It literally doesn't matter if the role is highly paid or completely voluntary. The conflict of interest alone compromises their complete independence. Question 3. A ministry claims the DPA is completely independent because they don't issue orders, despite controlling the DPA's server infrastructure. Is this compliant? Think about the difference between having functional independence on paper versus actual operational reality. The answer is B. Just like we saw in the Austrian case, true independence requires member states to provide totally separate premises, resources, and technical infrastructure. Relying on shared ministry servers is a fundamental violation of Article 52, paragraph 4. And our final question, if a DPA is investigating a state-owned tech company, what is their primary obligation under Article 52(2)? When the government itself is under the microscope, how must the data watchdog act? Yep, the answer is C. Under Article 52, paragraph 2, they must remain completely free from external influence. They can neither seek nor take instructions from anybody. Maintaining that strict impartiality is literally the only way to protect citizen rights. Finally, Section 6, takeaways and next steps, wrapping up Article 52. So to summarize all of this, Article 52 ensures that the referee enforcing privacy laws is fully funded, fully autonomous, and completely shielded from both political manipulation and corporate capture. It demands complete independence, which protects against even the risk of indirect influence. This means guaranteed separate budgets, staff, and tech, all firmly backed by strict CJEU precedents. It's not just a polite suggestion from lawmakers, it's a structural necessity for the GDPR to actually function in the real world. Hey, if you enjoy these GDPR explainers and want to help support the channel, consider becoming a member of Privacy Trainer. Memberships are what help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and to use AI to scale that education globally. Now, on the other hand, if you're looking for more structured privacy, security, or AI training, which includes guided learning paths, workshops, practice questions, and exam prep, you should definitely explore privacyuni.com. Basically, Privacy Trainer focuses on making this knowledge freely available, while privacyuni.com is designed for learners who prefer a more structured, step-by-step experience. Quick disclaimer, this content is provided for educational purposes only and does not constitute legal advice. And of course, content might include mistakes. Thank you so much for learning with me today. Remember, the true strength of privacy law lies entirely in the independence of those who enforce it. So ask yourself, if your local data watchdog was pressured by your government tomorrow, are you absolutely confident their shield would hold up? Keep exploring, keep questioning, and I will see you in the next explainer. Hey everyone, welcome back to Privacy Trainer. Today we're diving into the really fascinating life cycle of GDPR oversight. We're talking about everything from independent guardians all the way to heavy gavels. Now, you might be wondering, what problem does this framework actually solve? Well, think about it. Without a strong, fiercely independent system of checks, balances, and real enforcement, the GDPR, it would literally just be a list of polite suggestions. And if organizations misunderstand this whole oversight ecosystem, they are risking massive fines and, frankly, catastrophic compliance failures. Let's get into it. Quick look at our agenda for this explainer. First up, we've got the Guardian. Then we'll look at the guide. Third is the gavel. After that, we'll do a quick knowledge check and finish up with a wrap-up. So to really understand how enforcement works here, we first have to ask a pretty crucial question. Who watches the watchers in the GDPR framework? Seriously, what actually guarantees that the regulators themselves act fairly, completely free from bias or political pressure? Let's start with Section 1, the Guardian. This is all about the foundation of complete independence. You know, this concept of independence is the absolute bedrock of European data protection. Based on landmark rulings from the Court of Justice of the European Union, specifically case C518/07, this idea of complete independence isn't just a nice-to-have suggestion. It literally means having the financial and operational autonomy to investigate anyone, totally free from state or corporate interference. Article 52 of the GDPR explicitly mandates that these watchdogs must be free from any direct or indirect external influence. A regulator simply cannot protect your privacy if their budget or their staffing is being held hostage by the very politicians or corporations they're supposed to be policing. They absolutely must possess their own dedicated staff and sufficient resources to actually do their job. Moving on to Section 2, the guide. We're looking at GDPR certification mechanisms here. Now, beyond just policing and punishing, the GDPR actually actively guides compliance through structured certifications. It's best to think of a GDPR certification kind of like a digital badge of trust. Under Article 43, these specialized accredited bodies assess an organization's processing activities against some incredibly rigorous criteria. Lawmakers included this to give businesses, especially small and medium enterprises, a really practical, transparent way to demonstrate their compliance to clients and users. For example, picture a small cloud hosting startup. They can use the certification to prove to a massive enterprise client that their data is handled securely, rather than just saying, hey, trust us. It's a real game changer. But that begs the question, who tests the testers? Before they can issue those badges of trust, these certification bodies must themselves be accredited through one of two strict pathways. This proves their absolute competence and independence. Path A involves a national accreditation body using strict ISO standards combined with additional supervisory authority requirements. Then there's Path B, which allows the supervisory authority itself to evaluate the body directly. Either way, they have to prove they have absolutely zero conflicts of interest and possess deep technical and legal expertise. The whole shebang. All right, on to Section 3, the gavel. Let's talk about enforcement and fines.
So when guidance fails, when certifications are totally ignored, and when rules are broken, these independent authorities have to step up and enforce the law. Article 83 is the heavy hitter here. It provides regulators with the explicit power to penalize compliance failures. And the ultimate goal here isn't simply just to collect money. It's to ensure a consistently high level of data protection across the entire European Union by making these fines effective, proportionate, and highly, highly dissuasive. And this brilliantly illustrates how enforcement actually works out in the real world. In the landmark Deutsche Wohnen case, the Court of Justice ruled that regulators can fine a corporate entity, a legal person, directly. They don't even need to pinpoint the specific natural person or employee who actually caused the breach. Just imagine a multinational tech company where systemic negligence causes a massive data leak. The regulator doesn't have to go digging to identify the one junior developer who made a coding error. No way. The organization itself bears the full weight of the gavel for failing to implement proper safeguards.
Okay, let's jump into Section 4. Time for a quick knowledge check. Let's test your practical understanding with some scenario-based questions. Imagine a business challenge where a B2B service provider needs to prove compliance to land a massive enterprise client. They want a GDPR compliance seal. So who actually grants them the certification directly? Is it A, the EDPB, B, a national court, C, an accredited certification body, or D, the European Commission? Give it a thought.
If you guessed C, you hit the nail on the head. Under Article 43, it's the specialized third-party accredited certification bodies that issue the physical or digital certification, not the EDPB or the courts.
Okay, next question. If a massive compliance failure occurs due to corporate negligence, who bears the direct legal burden? Must a regulator identify the specific employee who breached the rules to issue fines under Article 83? Take a look at your options here. A, yes, always. B, only for minor fines. C, no, legal persons can be fined directly. Or D, yes, if the act was intentional. And the correct answer is C. As we discussed, the Deutsche Wohnen case confirms that fines apply directly to the organizational controller. Regulators do not have to play detective to find one careless employee. Corporate accountability is completely unavoidable here.
Question 3. Thinking back to our very first pillar, the Guardian, what defines their core operational mandate of complete independence? Is it A, ability to rewrite the GDPR, B, freedom from any direct or indirect external influence, C, mandatory reporting to local tech companies, or D, immunity from national courts? The answer is B. They absolutely must be completely insulated from political or corporate sway, taking instructions from literally no one, and possessing their own dedicated financial and human resources.
All right, for our final question. What is the maximum duration a certification body can be accredited under Article 43 before needing renewal? Essentially, how long does a body's permission to act as a guide last before it must be reevaluated? Is it A, 1 year, B, 3 years, C, 5 years, or D, 10 years? The correct answer is C, 5 years. Accreditation is strictly capped at 5 years. This is so crucial because it ensures ongoing, up-to-date expertise in the ever-changing privacy and technological landscape. Let's wrap things up. Section 5, wrap up and takeaways. Let's distill all of this down. Remember, GDPR oversight is this brilliant interconnected lifecycle. First, we have independent guardians with dedicated resources. Those guardians then accredit expert guides who issue voluntary certifications based on strict standards. And finally, when it's absolutely necessary, the guardians drop the gavel, targeting the organization itself directly with substantial fines. It's a complete ecosystem.
Before we go, if you enjoy these GDPR explainers and would like to support the channel, please consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale that education globally.
Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam preparation resources, you can totally explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available here, while privacyuni.com is designed for learners who prefer a much more structured learning experience.
Finally, please note this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. As you leave today, I want to leave you with a thought. If the GDPR regulators audited your organization tomorrow, would it be the guardian, the guide, or the gavel that arrives at your front door? Stay curious and stay compliant.
Hey everyone, and welcome to Privacy Trainer. Let's jump straight into it today. Have you ever wondered what exactly keeps data protection authorities from just, becoming political puppets? Well, today we're decoding GDPR Article 54 to look at the actual anatomy of a privacy watchdog. Because honestly, if you don't understand this structural shield, the entire enforcement system of the GDPR basically just falls apart.
So the core problem that Article 54 is trying to solve is actually pretty simple. Who watches the watchdogs? And how do we ensure they're actually independent? I mean, think about it for a second. Without an absolute impenetrable firewall against political influence, what's stopping a massive organization from just lobbying the government to quietly call off a privacy investigation? Exactly.
All right, so here is our certification-style path for this explainer today. We're going to cover 1, the watchdog blueprint, 2, breaking down the law, 3, independence in practice, 4, the CJ-EU battles, 5, a practical knowledge check, and finally, 6 key takeaways. Let's get into it.
Section 1, the watchdog blueprint, regulatory independence.
So while Article 51 says independent authorities have to exist, it's Article 54 that provides the exact, concrete architectural blueprint that member states absolutely must follow to build them. You can't just slap a sign on an agency and declare it independent. You literally have to structurally fortify it against outside pressure, kind of like building a fortress.
Moving on to Section 2, breaking down the law, Article 54 foundations. Now, looking at the actual text, the law mandates several non-negotiable requirements. It demands completely transparent appointments, so no secret backroom deals allowed. It also requires clear qualifications and a minimum 4-year term. And that 4 years, that's totally on purpose. Lawmakers designed it that way to outlast your typical political election cycles. Oh, and it also dictates really strict professional secrecy obligations for all staff. And this is a great way to picture what recitals 120 and 121 add to the mix. They establish that an independent authority must have its own separate, public, annual budget. Why? Well, because a watchdog can't exactly bite if the government controls its food supply. Furthermore, the authority must have the power to choose its own staff, totally free from government meddling or those hiring freezes politicians love to dictate.
All right, Section 3, Independence in Practice. Moving from theory to reality. So in the real world, whether it's a massive multinational tech company or just a local small business, they're relying on a DPA that operates compliantly with fully independent budgets and staggered terms. But a really common compliance failure happens when member states think, oh, functional independence is enough. No. If DPA staff are taking even subtle directives from a government minister, or if the DPA head can just be fired prematurely, then those structural firewalls have completely failed. And if you want to see exactly how regulators view this, just look at the landmark German case C518/07. The Court of Justice of the European Union ruled that regulators will ruthlessly investigate any setup where a state applies even indirect pressure. I mean, to be truly independent, the DPA has to be completely above all suspicion of partiality.
Which brings us to Section 4, the CJEU battles, the Hungary case study. Okay, so check this out. In case C288/12, Hungary basically tried to prematurely end their data supervisor's term. Their excuse? They claimed they were just executing an institutional reorganization. Well, the court ruled firmly against them. They declared that Article 54's term limits are an absolute bulletproof shield. You absolutely cannot just rearrange the organizational chart as an excuse to fire the boss.
All right, Section 5, Knowledge Check. Let's test your practical understanding. Here's question 1. Imagine a scenario where a member state is drafting legislation to create its new data protection authority. Under Article 54, what is the minimum duration they can legally set for the supervisor's term? Is it A, 2 years, B, 3 years, C, 4 years, or D, 5 years? Lock it in. Okay, the correct answer is C, 4 years. Article 54 explicitly mandates this minimum duration to ensure the watchdog's tenure doesn't align with standard governmental election cycles. It insulates them from any immediate pressure by a newly elected administration.
Moving to question 2, a newly elected government reorganizes its regulatory bodies and decides to fire the current DPA head halfway through their term. Is this permitted under GDPR? A, yes, if the institutional model changes. B, no, unless there are overriding and objectively verifiable reasons. C, yes, if Parliament votes on it. Or D, no, DPAs serve lifetime appointments.
And the answer is B, no. Just like we saw in that Hungary case, right? Once a term is set, the member state absolutely must respect it. Simply changing the institutional model is not an overriding or objectively verifiable reason to dismiss someone. Question 3. Let's say a former DPA investigator writes a tell-all book revealing confidential details about a tech company's data breach investigation. Which Article 54 rule does this violate? A, the rule on reappointment. B, the rule on transparent procedures. C, the duty of professional secrecy. Or D, the minimum term requirement. The answer here is C, the duty of professional secrecy. Article 54 ensures that this duty binds DPA staff literally for life. This is super critical for protecting sensitive corporate and personal data long after an investigator actually leaves the job.
Okay, final question. A privacy group sues a member state, claiming the DPA head was secretly handpicked by a minister without any public oversight. Which requirement did the state likely fail? A, staggered appointments. B, transparent appointment procedures. C, financial control. Or D, substantive operational powers.
The answer is B. They failed on transparent appointment procedures. Secret backroom appointments just completely destroy public trust and that absolute independence that the GDPR requires. The rules and procedures have to be established by law, and they have to be totally transparent to the public.
All right, Section 6, Key Takeaways. Here's your Article 54 summary.
So what do we need to remember? Article 54 isn't just administrative fluff. It is the vital structural blueprint for DPA independence. Appointments must be transparent and legally defined. Supervisors absolutely need that minimum 4-year term. Professional secrecy applies during and after employment. And as we've seen, the CJEU will strictly enforce these protections against any state interference.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone.
And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available here, while privacyuni.com is designed for learners who prefer a more structured learning experience.
Finally, our disclaimer. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. But definitely ask yourself, after learning all of this today, is the watchdog in your jurisdiction truly as independent as Article 54 demands?
Hey everyone, and welcome back to the Privacy Trainer. I'm absolutely thrilled to have you here for another explainer. Today, we're officially launching our jurisdiction journey as we break down Article 55 of the General Data Protection Regulation. You know, if you've ever found yourself totally lost in the maze of European regulators, just wondering exactly who has the legal right to knock on your organization's door, well, you are in the exactly right place. So grab your notes because we're going to make this crystal clear. So here's the fundamental problem we're tackling today. Data flows borderlessly across the internet, literally at the speed of light. But regulators, well, regulators are strictly bound by physical geography. So what actually happens when an organization completely misunderstands who their traffic cop is? Best case scenario, you waste a ton of time and legal fees responding to the wrong authority. But the worst case, you ignore a local regulator thinking they have zero jurisdiction over you, only to face a massive, painful enforcement action. Knowing who polices your data isn't just an academic theory. It's the absolute foundation of your compliance strategy.
Okay, let's dive right into this. Looking at the primary source from the official journal of the European Union, Article 55 establishes the foundational rule of local territorial competence. The general rule is actually pretty simple. Each supervisory authority is competent to perform its tasks and exercise its powers right on the territory of its own member state. So if you're processing data in France, the French authority, the CNIL, is your regulator. Sounds incredibly straightforward, right? But as with literally all things GDPR, the devil is entirely in the details and the exceptions.
Here is our roadmap for today. We'll start with a high-level article overview, unpack the rules and exceptions, look at some real-world applications, dive into a mini case study, tackle a quick knowledge check to see what stuck, and wrap it all up with our key takeaways.
Section 1. Article Overview. The GDPR Framework. All right, let's translate that dense legal text into plain, actionable English. To truly understand Article 55, you kind of have to contrast it with Article 56. Article 55 dictates local competence, meaning local processing equals local enforcement. If you're a local business, your local supervisory authority is your regulator. Boom, simple. But then we have Article 56, which introduces the one-stop shop mechanism for cross-border processing, allowing a company that operates all across the EU to deal primarily with just one single regulator. So Article 55 is your default. Article 56 is the cross-border exception. Knowing the exact boundary between these two is absolutely crucial. Section 2. Rules and exceptions. Who is exempt? And this brilliantly illustrates the secret here. Not everyone gets to use those fancy one-stop shop cross-border rules. The GDPR specifically carves out certain entities. For example, if you are a public authority or a private body acting under a public task, the one-stop shop explicitly does not apply to you. You strictly answer to your local state authority, period. Even if a local tax authority or a public university is processing the data of citizens from other EU countries, they don't get a lead supervisory authority. Regulators aren't exactly known for willingly giving up their jurisdiction, and right here the law ensures they don't have to. Now, let's talk about paragraph 3. The GDPR states that supervisory authorities absolutely shall not be competent to supervise the processing operations of courts acting in their judicial capacity. Why? Well, to protect judicial independence. Recital 20 explicitly states this is to safeguard the independence of the judiciary, and this was strongly reinforced by the Court of Justice of the European Union in case C-245/20. The court essentially ruled that any processing by a court that could even indirectly influence a judge's independence is completely off limits to the Data Protection Authority. The separation of powers is paramount here. Section 3. Real-world applications, common failures. Okay, let's pivot from the legal theory to some highly practical business applications. I've got 3 rapid-fire examples for you. First, a tech company headquartered in Berlin offering an app across Europe. They can leverage Article 56 and primarily deal with the Berlin regulator. Second, a small retail shop in Rome selling strictly to local customers. That falls squarely under Article 55, and they answer solely to the Italian Garante. Third, a massive common compliance failure. A local public hospital in Madrid processes the health data of visiting French tourists and just assumes they can use the one-stop shop. Wrong, because they're a public authority carrying out a public task. They're locked to the Spanish regulator. Trust me, regulators absolutely love to test this boundary during investigations. Section 4. Mini case study, jurisdiction analysis. Let's move to a step-by-step analysis and see how this builds in a real scenario. Imagine a French e-commerce company that decides to expand its targeted marketing exclusively to consumers residing in Germany, but they have absolutely no physical office in Germany. So they assume that because they're based in France, only the French CNIL can enforce against them. While the GDPR jurisdictional analysis tells a very different story. Recital 122 clarifies that a supervisory authority is competent over processing that targets data subjects residing on its own territory. So the German authority absolutely has the competence to enforce the GDPR against this French company. No physical office required.
Section 5. Knowledge check. Test your skills.
I really hope you've been paying close attention because it's time for a certification-style quiz to test your retention. Let's go. Question 1. A public hospital in Spain processes patient data under a public task. They happen to treat patients visiting from Portugal. Who is their competent regulator? Is it A, the European Data Protection Board, B, the Spanish Supervisory Authority only, C, the Portuguese Supervisory Authority, or D, a Leeds Supervisory Authority under Article 56? And the answer is B, the Spanish Supervisory Authority only. Why? Well, because Article 55, Paragraph 2 strictly dictates that public authorities acting on public tasks cannot use the Article 56 one-stop shop. They are forever bound to their local regulator, regardless of whose data they process. Moving briskly along, let's look at question 2. An Italian judge reviews personal data entered into evidence during a criminal trial. Which authority supervises this specific processing operation? A, the Italian Supervisory Authority, B, the EDPB, C, no supervisory authority has competence, or D, the Ministry of Justice? The answer is C, no supervisory authority has competence. So the crucial point here is Article 55, Paragraph 3. The GDPR explicitly exempts courts acting in their judicial capacity. And as we learned from the CGU case law, this absolute separation is entirely non-negotiable in order to protect the independence of the judiciary from any administrative interference. All right, question 3. A retail startup established solely in Warsaw processes the data of local Polish customers. Which rule determines their regulator? A, Article 56, B, Article 55.1, C, Recital 20, or D, Article 55.3? Let's bring our focus back to the foundational rule. The answer is B, Article 55, Paragraph 1. This right here is the bedrock of GDPR enforcement. The general rule is that each supervisory authority is competent on the territory of its own member state. Local processing means you answer directly to the local traffic cop. Okay, our final and definitely trickiest question. Question 4. A U.S. company with absolutely no physical EU establishment actively targets consumers residing in Germany. Who enforces the GDPR against them? A, the US FTC, B, the German Supervisory Authority, C, any EU Supervisory Authority, or D, the Leeds Supervisory Authority? The answer is B, the German Supervisory Authority. Now, what's really interesting here is how the GDPR empowers regulators to reach way beyond their borders. According to Recital 122, a local authority's competence includes processing carried out by a controller not established in the Union when they target data subjects residing on that authority's territory. They don't need a physical office in Germany for the German regulator to wield their authority over them. Section 6. Key takeaways. Crucial reminders. Let's bring this all together and distill it into the absolute essentials. Number 1, Article 55 is the default. Local authorities govern local processing. Number 2, the major exception. Public bodies cannot use the cross-border one-stop shop. Number 3, courts acting in their judicial capacity are entirely exempt to ensure total judicial independence. And number 4, regulators aggressively protect their territorial turf, even against foreign entities targeting their local residents. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam, and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thank you so much for joining me on this explainer. I'll leave you with this final thought. Is your organization's jurisdictional map actually up to date, or are you unknowingly preparing to answer to the exact wrong regulator? See you in the next one.
Okay, picture this. You are running a business that operates all across Europe. Suddenly, you're facing data protection inquiries from Germany, France, and Spain, all at the exact same time. Sounds like an absolute nightmare, right? Well, let's dive into this explainer on GDPR Article 56, because this is the exact problem it aims to solve. Today, we're exploring the promise of simplicity versus the reality of regulatory complexity for cross-border businesses. If you're operating across European borders, Article 56 is arguably one of the most critical operational lifelines in the entire general data protection regulation. It introduces what we call the one-stop shop mechanism. But as you'll see, misunderstanding how this mechanism actually works can lead to a massive false sense of security, overlapping fines, and a total regulatory headache. So here is our roadmap for today. We're going to start with a quick overview and walkthrough, break down the relevant recitals, and look at some real-world applications. Then we'll dive into common mistakes, walk through a realistic case study, and wrap it all up with a certification-style knowledge check. Let's get right into it.
Part 1, Overview and Walkthrough, the promise of simplicity.
Now, before the GDPR came along, cross-border businesses literally had to deal with up to 27 different European regulators simultaneously. It was exhausting. Article 56 cuts through all that red tape by allowing you to designate a single lead supervisory authority. But, and this is a huge but, to actually benefit from this, you absolutely need a main establishment. This is a concept defined over in Article 4, Paragraph 16, and it essentially acts as your regulatory anchor. This is the whole cornerstone of the one-stop shop. Your main establishment determines exactly who your lead supervisory authority is going to be. So if your central administration is sitting in Dublin, the Irish Data Protection Commission is your lead. But remember, this isn't just about where you register some shell company. It has to be the place where the actual real-world decisions regarding data processing are being made.
And there's a really fascinating tension built right into the law here. The lead authority usually takes charge under Article 56, Paragraph 1, but local authorities can absolutely still intervene under Article 56, Paragraph 2 if a privacy issue exclusively affects their local citizens. So, while you might have a lead authority as your main point of contact, a local regulator in Italy can still jump in and handle a complaint if the issue only relates to an Italian establishment, or if it substantially affects only Italian data subjects. It's this very careful balance between centralized power and local protection.
Let's look at the recitals to see how this all connects. Lawmakers explicitly noted in Recital 36 that merely having some technical servers humming away in a country doesn't magically make it your main establishment. You need an effective and real exercise of management activities. Furthermore, Recitals 123 and 130 make it crystal clear that the lead authority cannot just act like a dictator. They are legally obligated to cooperate with local authorities and take utmost account of their views when handling these cross-border complaints.
Part 2, Application and Scenarios, Real-World Examples.
So what does this look like in practice? Let's break down 3 scenarios. In our first scenario, imagine a tech company making true operational processing decisions in Ireland. They get the Irish DPC as their lead authority. Perfect. The system works. Now scenario 2, a small business operating exclusively in Germany just deals with the German authority under Article 55. Simple enough? But our third scenario, this is a massive compliance trap. According to EDPB guidelines, if you are a US or Asian company, or any foreign entity with 0 EU establishments, you simply cannot use the one-stop shop mechanism. You don't have that stable arrangement in the EU, which means you must answer to every single local regulator where you have users.
Part 3, Common Mistakes and Regulatory Enforcement.
You know, a really common misunderstanding is that local authorities have zero power over tech giants. A lot of business leaders wrongly assume that once they have a lead supervisory authority, they can just completely ignore regulators in other member states. That is a dangerous, dangerous mistake. Regulators will ruthlessly evaluate your corporate setup. If your headquarters is just a mailbox in a tax-friendly country, you are going to fail the establishment test. When evaluating you, regulators look for hard evidence of stable arrangements. Are your privacy officers actually there? Are board meetings held there? Now, Article 56, Paragraph 6 does promise that the lead authority is your sole interlocutor, meaning your single point of contact. However, if a local authority objects to a decision, it immediately triggers the Article 60 cooperation mechanism. That means your lead authority actually has to negotiate with the other regulators to reach a consensus.
And this brings us to a huge landmark ruling, Case C645/19. This essentially proved that the lead supervisory authority cannot just ignore the views of other concerned authorities without risking local enforcement. In this incredibly famous case involving the Belgian Data Protection Authority, the Court of Justice of the European Union ruled that the lead authority must engage in sincere and effective cooperation. If they drag their feet, fail to act, or bypass those cooperation rules, a local authority actually retains the power to take the company to court right in their own member state. So the one-stop shop is a fantastic rule, but it is definitely not an absolute impenetrable shield. Part 4, Mini Case Study, the Local Dispute.
Let's walk through a realistic story to see how this plays out step by step. Let's say a user in Spain complains to the Spanish regulator about a company whose main establishment is over in France. Under Article 56, Paragraph 3, the Spanish regulator can't just jump in. They must immediately inform the French lead authority. The
The French authority then has 3 weeks to figure out if they want to handle it. If they say, yep, we'll take it, they lead the investigation. But if they decline, the Spanish authority steps right back in and handles it locally. Notice how sincere, structured cooperation is baked right into the timeline? The local authority never truly loses their voice.
Part 5. Certification Knowledge Check. Time to test what we've learned.
These are exactly the kinds of concepts you're going to need to master if you're taking professional privacy exams. So let's see how you do. Question 1. What primary factor determines a controller's main establishment under Article 416? Is it A, the location of their largest data servers, B, the place of central administration where data processing decisions are made, C, the member state where they generate the most revenue, or D, the location of their data protection officer? Take a second to think about what regulators actually look for when establishing jurisdiction.
Okay, the correct answer is B. Why? Because Recital 36 explicitly states that the mere presence of technical means or servers does not constitute a main establishment. Revenue and the DPO's location aren't the deciding factors either. At the end of the day, it always comes down to where the real exercise of management activities actually occurs. Moving on to question 2. Under Article 56.2, when can a local supervisory authority, meaning not the lead authority, handle a complaint regarding cross-border processing? A, at any time they choose. B, never. The lead authority has absolute exclusive power. C, only if the controller agrees to local jurisdiction. Or D, if the subject matter relates only to an establishment in its member state or affects only its data subjects. This one tests that all-important derogation clause we talked about.
And the answer is D. This is the explicit exception found right in Article 56, Paragraph 2, which preserves local authority power for localized issues. If an issue is entirely isolated to one single member state, the local regulator can take the reins without having to route a massive, complicated investigation through the lead authority.
Question 3. According to CJEU Case C645/19, can a local supervisory authority initiate legal proceedings against a cross-border controller if it is not the lead supervisory authority? A, yes, provided specific exceptions apply and cooperation procedures are respected. B, no, Article 56 absolutely prohibits this. C, only if the European Data Protection Board orders them to do so. Or D, yes, but only for organizations with fewer than 250 employees. Think back to that Belgian DPA case we discussed. The correct choice is A. The High Court ruled that local authorities actually can act under Article 58.5 if the lead authority fails to act or if those strict cooperation rules are bypassed. They can't just go rogue whenever they feel like it, but if the cooperation mechanisms are exhausted or ignored, they absolutely retain their fundamental power to enforce the law locally.
Last one, question 4. Can a company based entirely outside the EU with no physical establishments in the Union benefit from the one-stop-shop mechanism? A, yes, if they appoint an EU representative under Article 27. B, yes, if they pay a fee to a selected European regulator. C, no, EDPB guidelines state an establishment is required to use this mechanism. Or D, yes, if they process data of citizens from more than 3 member states. Watch out, this is a classic compliance trap.
And the answer is C. Without a stable arrangement and the real exercise of management activities inside the EU, you simply must deal with every local regulator where your users reside. A lot of folks think appointing a representative under Article 27 magically grants you one-stop-shop privileges, but it absolutely doesn't. It's a separate legal requirement, but it does not equal an establishment.
So, to wrap this all up, what are our key takeaways? First, the one-stop shop is an amazing tool to simplify cross-border compliance, but it demands rigorous corporate structuring. Your main establishment relies entirely on where real decisions are made, not just where your servers are plugged in. Remember that local supervisory authorities retain real power for localized disputes, and while the lead authority acts as your sole interlocutor, they cannot just ignore those local regulators. Sincere cooperation is the name of the game here.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience.
Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thank you so much for joining me today. Until next time, stay compliant, keep learning, and I want to leave you with one final thought. Is your organization's main establishment built on paper or on practice? See you in the next explainer.
All right, let's dive right into this explainer. Welcome to Privacy Trainer. Today we're exploring the honestly fascinating world of GDPR Article 57. We'll be looking closely at what privacy regulators actually do all day. Now, you might be wondering, why should a business leader, a developer, or a privacy professional care about the daily tasks of some government agency? Well, because Article 57 dictates exactly how authorities monitor you, investigate your operations, and handle complaints against your business. If your organization misreads the scope of these regulatory powers, you could find yourselves totally unprepared for a very real, very serious investigation.
So what's really interesting here is the core question. Who actually enforces the rules? You know, the GDPR isn't just some honor system that companies voluntarily self-enforce. Lawmakers knew for sure that relying on self-policing would be a disaster, so they created dedicated authorities mandated to step in. This solves the massive problem of fragmented and inconsistent privacy protection across Europe, setting the stage for a way more unified approach to protecting your digital rights.
Before we get into the weeds of Article 57, let's formally define our main character for today, the Supervisory Authority. Think of them as the official privacy watchdog of each country, established under Article 51 of the regulation. Essentially, they're the independent referees on the field. They protect our fundamental rights and freedoms when it comes to personal data. These are the folks who come knocking when things go wrong.
Here's our roadmap for today's explainer. We're going to cover the privacy watchdog, break down Article 57, look at some practical examples and a case study, test your knowledge, and then hit the key takeaways. Okay, moving right into Section 1, the privacy watchdog, breaking down Article 57. Let's see how this forms the foundation of a regulator's responsibilities.
Rather than reading you a dry legal textbook, I want you to think of this list as the ultimate daily to-do list for a privacy regulator.
Article 57 explicitly spells out their tasks. They have to monitor and enforce the law, promote public awareness, especially regarding kids, advise lawmakers, and crucially, handle your complaints and conduct investigations. Lawmakers included this exact list, which is backed up by Recital 129, to ensure that no matter where you happen to live in the European Union, the local authority has the exact same tasks and powers to give you consistent protection. This brilliantly illustrates how the highest courts actually interpret these tasks. We're talking about the famous Schrems case here, specifically case C311/18. The Court of Justice of the European Union made it crystal clear regulators can't just ignore a citizen's complaint. Under Article 57, they are legally bound to examine the nature of the complaint and handle it with all due diligence. They aren't passive observers, right? They have an active duty to act, investigate thoroughly, and communicate their findings. Next up, Article 57 in practice, examples and common mistakes. Let's look at how these tasks play out in the real world. A super common misconception is thinking the regulator only spends their time hunting down tech giants, but that's just not true. If a big tech firm has a complex cross-border algorithm issue, sure, authorities use Article 57 to cooperate and share information with the lead supervisory authority. But if a small local bakery mismanages their email list and a customer complains, the local regulator uses that exact same Article 57 to step in and handle the local grievance. The scale absolutely changes, but the statutory duties remain exactly the same. Let's move into our mini case study and enforcement perspective. Let's actually step into the shoes of an investigator for a minute. Imagine a retail app suffers a massive data breach that exposes user locations. Naturally, users are pretty upset and lodge formal complaints, claiming the app wasn't transparent about tracking them in the first place. Here's exactly how the regulator responds. Under Article 57, their specific task is to investigate this complaint. They're going to ask the company for documentation and solid evidence of compliance. And if they find a shortcoming, well, they don't just stop there. As recent case law like Land Hessen, case C768/21, shows once an investigation uncovers a violation, the authority is required to react appropriately and use their Article 58 corrective powers to remedy the situation. They investigate to enforce, not just to observe. Time to test your privacy knowledge. Let's jump into some scenario-based, certification-style questions to truly test your practical understanding. Read this scenario carefully. Think back to the exact phrasing we discussed earlier about a regulator's duty to citizens when a complaint lands on their desk. I'll give you a second to think it over.
And the correct answer is B. Regulators have a strict legal mandate to thoroughly investigate and communicate. They literally can't just ignore a small business, and they certainly can't jump straight to issuing a massive fine without investigating first. They must apply all due diligence and keep the citizen in the loop.
Okay, question 2. This is a fascinating crossover between competition law and privacy, directly inspired by the Meta Platforms case C252/21. How do two totally different types of regulators play in the same sandbox?
Answer C is correct. The CJEU ruled that a competition authority definitely doesn't replace the privacy regulator. However, because data is just so critical in the modern digital economy, they can look at GDPR compliance during an antitrust probe, provided they cooperate sincerely with the primary supervisory authority to make sure the rules are applied correctly.
Question 3. Think back to the very beginning of our explainer and the core historical reason why the GDPR was implemented across Europe in the first place. Answer B is the clear winner here. Consistency across the European Union is the fundamental goal. Think about it. If regulators had different tasks in different countries, the digital single market would totally fracture, and citizens' rights would be wildly inconsistent depending on where they happen to live. For our final question, consider the balance between a regulator's investigative duties and what comes next. Once they actually find a fire, what are they obligated to do? The correct answer is C. Regulators don't just investigate for fun. As the Land Hessen case confirmed, they are legally obligated to use their powers to actually fix the privacy violations they uncover in an appropriate and proportionate way. Let's move to our final section, key takeaways from Article 57. Let's wrap up with the most critical lessons from today.
Ultimately, Article 57 is what transforms the GDPR from a theoretical piece of paper into a living, breathing reality. It gives regulators a clear, undeniable mandate to monitor your organization, investigate breaches, cooperate across borders, and protect citizen data with all due diligence. It's the engine of enforcement.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience.
Disclaimer. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I sincerely hope this explainer left you with a practical understanding of how privacy laws are enforced on the ground. But it leaves us with one massive question for the future. As AI systems begin scraping data across borders faster than any human can track, will the watchdog's Article 57 powers be enough to keep up? Thanks for joining me and keep protecting that data.
All right, let's jump right into this explainer of GDPR Article 58. You know, if you've ever wondered what gives data protection authorities their actual real-world enforcement power, well, this is it. This is the absolutely crucial section of the law that builds the regulator's toolbox. Think about it for a second. What actually happens if a company just decides to ignore the law? I mean, without enforcement, regulations are literally just polite suggestions on a piece of paper, right? Article 58 is the ultimate solution to privacy compliance failures. It's exactly what gives the GDPR its teeth, empowering regulators to demand real answers and actively enforce the rules. So here's our quick roadmap for today. We'll do an overview, walk through the toolbox itself, hit some practical examples, check out the regulatory view, do a mini case study, and then finish up with a knowledge check. Okay, starting off with Section 1, an overview of the powers granted to supervisory authorities. So the whole purpose of Article 58 is to make sure that regulators have the exact specific authority they need to investigate, correct, and advise on data processing. And the law actually organizes these powers brilliantly.
Picture a literal toolbox with 3 distinct drawers. In the top drawer, you've got investigative powers. These are the tools used to demand information, access servers, and gather facts. Now, the middle drawer holds corrective powers. These are the hammers and wrenches used to fix noncompliance, everything from a stern warning to a massive financial fine. And finally, the bottom drawer has authorization and advisory powers, which are the tools to approve codes of conduct, issue formal opinions, and proactively guide organizations.
Now, how does this actually play out? Well, enforcement usually escalates in stages. Regulators almost always start at step 1, investigating and gathering data to see what's what. From there, if they spot a compliance gap, they might move down to step 2, issuing a warning or a reprimand to correct the behavior. But if the violation is severe, or if the company just completely ignores them, they escalate to step 3. That means enforcing definitive bans on processing or levying those heavy administrative fines we always hear about.
But here's the thing. Regulators can't just swing their heaviest hammer at every single problem. And this brings us right to Recital 129 of the GDPR. It explicitly states that each measure should be appropriate, necessary, and proportionate. To put that into plain English, regulators have to tailor their tool to the specific nail. They are legally required to look at the unique circumstances of each case, so they avoid punishments that are just unnecessarily harsh or completely out of proportion. Let's compare how this actually looks in practice. Say you have a massive tech giant systematically abusing user data without a valid legal basis. For them, a proportionate response might be a severe corrective power, like a complete definitive ban on their cross-border data processing. Boom. But flip that over to a local small business that just made a tiny administrative error on a website consent form. Dropping a multi-million euro fine on them would totally violate Recital 129. Instead, sending a written reprimand to just update those forms is the correct proportionate tool to use. Let's ground this in a real scenario with case C768/21. Imagine an employee at a savings bank unlawfully snooping on a customer's personal data. It's a clear compliance failure, no doubt about it. But the bank actually acted incredibly fast. They disciplined the employee, and they immediately reviewed all their access logs. So when the regulator stepped in, they used their discretion under Article 58 and just issued a reprimand, instead of a fine. And the European Court of Justice confirmed that this is perfectly legal. Regulators are absolutely not forced to issue fines if a reprimand adequately restores compliance.
Which leads us perfectly to some common, yet totally avoidable, mistakes organizations make. First is just believing that fines are always automatic or mandatory. As we literally just saw, they're not. Second, and honestly this is probably the most dangerous one, is ignoring early investigative requests. Look, if you ignore an Article 58 investigative order to provide information, you are practically begging the regulator to reach for their harsher corrective powers next. And third is viewing data protection authorities solely as punishers. Don't forget, they have advisory powers too, and those can actually help you achieve compliance before things go wrong.
All right, moving to Section 4, let's look at the regulatory view and what evidence they expect.
Let's talk about what regulators actually demand when they open up that toolbox and come knocking. When a regulator uses their investigative powers, they want hard receipts. We're talking server logs, access to your physical premises, and your records of processing activities. Now, if they're leaning towards corrective powers, they're going to want to see proof of mitigated damages. Basically, did you stop the bleeding? And for advisory powers, they will thoroughly scrutinize your data protection impact assessments, your DPIAs. Having proper documentation ready is honestly your best shield here. Okay, let's walk through a quick mini case study based on real European Data Protection Board guidelines. Imagine a city municipality launches a shiny new appointment app for its citizens. But, oops, there's a problem. The app is unlawfully transferring special categories of personal data to an unsecure server in a third country with zero adequate safeguards. When the regulator finds out, they use their Article 58 corrective powers. But not just to issue a fine, they step in to immediately impose a definitive limitation, basically suspending that data flow completely, right then and there, to protect the citizens from any further harm. All right, time for our knowledge check to see how well we've absorbed all this. Question 1. If a DPA finds a minor data breach, but the company quickly mitigated the harm, must the DPA issue a fine? Is it A, fines are automatic? B, no, they can issue a reprimand? C, only if requested? Or D, yes, at a minimum of 4% of turnover? And the answer is B. Based on that CJEU ruling we discussed in Recital 129, corrective powers give regulators the discretion to issue reprimands instead of fines. If a reprimand fixes the problem and a fine would just be overkill, the regulator has the total flexibility to choose the lighter tool. Okay, question 2. Under Article 58, which specific power allows a DPA to knock on your door and demand your server logs? A, corrective, B, advisory, C, investigative, or D, authorization powers? We're looking at C for this one. Under Article 58, Paragraph 1, investigative powers specifically allow DPAs to legally order you to provide any information they need. Remember, these investigations are pretty much always step 1 before any warnings or fines even enter the conversation. Moving right along to question 3. This is a big one. Can a DPA impose a definitive ban on a company's data processing? Meaning, can they legally force you to just stop processing data? A, yes, under corrective powers. B, no, only a judge. C, yes, under advisory. Or D, no, only fines. Think about the absolute maximum impact here. It's A. Article 58, Paragraph 2 explicitly lists the power to impose a temporary or even a definitive limitation, which includes a complete ban on processing. And let's be real, for a modern digital business, being legally banned from processing data is way more fatal than just cutting a check for a fine. Final question, and this one tests a slightly tricky jurisdictional rule that's popped up in recent court decisions. Can a non-lead local DPA bring a cross-border GDPR infringement to their own local judicial authority? A, never. B, yes, exceptionally. C, only against small businesses. Or D, yes, absolutely no restrictions.
The answer is B. While the standard one-stop-shop mechanism means the lead authority normally handles cross-border stuff, Article 58, Paragraph 5 exceptionally ensures that local DPAs still have a valid path to their local courts to protect their citizens. But they have to strictly follow the cooperation and consistency procedures first. What an incredibly powerful piece of legislation, right? Let's quickly wrap up with our key takeaways. Keep in mind, the regulator's toolbox has 3 distinct drawers: investigative, corrective, and advisory. Whichever tool they pull out, their actions must be proportionate to the specific case, all thanks to Recital 129.
Because they have that discretion, reprimands absolutely can, and often do, replace fines for companies that mitigate quickly. And finally, the absolute best way to survive the investigative toolbox is to document everything. Seriously, what you can prove is just as important as what you actually do. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam, and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. And finally, disclaimer. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. As you review your own compliance, ask yourself this. If the regulator opened their Article 58 toolbox and knocked on your door tomorrow, would you be completely ready for the investigation, or are you practically asking for the hammer? Keep protecting that data, and I'll see you in the next explainer. Hey everyone, if you work in privacy, compliance, or business leadership, one of the biggest questions you probably face is, what on earth is the regulator going to target this year? Well, what if I told you the GDPR actually has a built-in mechanism that answers this exact question? Today, we're diving into Article 59, which is a deeply strategic but honestly often overlooked part of the regulation. We're going to look at why this article matters, the problems it solves, and the massive fines your organization could face if you misunderstand its strategic value. So here's our roadmap for today's explainer. 1. Unpacking Article 59. 2. The why behind the reports. 3. Compliance in practice. And 4. A mini case study. Let's get right into it. You know, organizations are absolutely terrified of compliance blind spots. You can build the most robust privacy program in the world, but if you don't know where the regulatory crosshairs are currently aimed, you're essentially flying blind, right? How do you know if your local data protection authority cares more about cookie banners, or maybe employee surveillance, or data transfer impact assessments this quarter? The truth is, you don't need a literal crystal ball to foresee the regulator's next move. You just need to know exactly where to look. All right, Section 1, Unpacking Article 59, Activity Reports. Consider this your strategic masterclass. So what's the actual text say? The crucial takeaway here is that every single data protection authority, the folks who actually issue the fines, is legally required to publicly document their enforcement activities. In plain English, Article 59 says they must write an annual report. And it's not just some boring summary of how many meetings they had. No way. The law specifically states this report includes the types of infringements notified and the corrective measures taken under Article 58.2. Now remember, Article 58.2 is the heavy-hitting part of the GDPR. It gives regulators the power to issue warnings, ban data processing, and levy those massive multi-million euro fines. By mandating this report, Article 59 literally gives us a blueprint of their top priorities. Let's break down how this process actually works, step by step. First up, the Supervisory Authority compiles all their data on the corrective actions they've taken over the past year. Second, they can't just keep this info locked away internally, they're legally obligated to transmit it to their national parliament, their government, and other designated authorities. And step 3, this is the most important part for us, they must share it with the European Data Protection Board, the Commission, and the public. That means this incredibly rich, detailed intelligence regarding exactly who got fined and why is freely available to you. Moving on to Section 2, the why behind the reports. It really comes down to accountability versus independence. To really grasp why this matters, we have to look back at European case law, specifically Case C518/07. You see, the GDPR mandates that supervisory authorities must be completely independent. They can't take orders from politicians or corporations, but as we all know, with great power comes the need for great accountability. Because these authorities have the massive power to issue life-altering fines, the courts, supported by the principles in GDPR Recital 129, determined that complete independence without public transparency is downright dangerous. As the legal principle states, the absence of any parliamentary influence is inconceivable. So this activity report is the counterbalance required by Recital 129. It ensures democratic oversight, it proves to the public and the parliament that the regulator is actually doing its job, applying the law fairly, and ultimately protecting fundamental rights. Okay, Section 3, Compliance in Practice. Let's talk about translating these reports into real business value. Let's look at the huge difference between proactive privacy leaders who read these reports and reactive organizations who just end up getting caught off guard. Take a smart tech startup, for instance. Instead of trying to be 100% compliant in every single obscure area of the GDPR, which is practically impossible when you're moving fast, they use the Article 59 report to predict next year's trends and focus their engineering resources exactly there. A small business can do something really similar. They might have a super tight budget, so they focus every single euro on the top 3 issues the regulator published in the report. But then, there's the compliance failure. This is the company that gets completely blindsided by a fine for a common issue, like an unsecured database, that the regulator explicitly warned they were targeting in their latest public report. If you want to avoid those hefty fines, definitely do not make these common mistakes. The absolute biggest mistake? Treating these annual activity reports as boring government PR and just tossing them in the digital trash. Another major failure is ignoring your local supervisory authority-specific trends. For example, the regulator in France might be heavily focused on AI this year, while the regulator in Ireland might be laser-focused on children's data. You also cannot miss the link to Article 58 too. When you're reading the report, you aren't just reading dry statistics, you're reading a literal list of what behaviors trigger actual fines and bans. And finally, if you read the report but fail to adjust your internal company policies based on its findings, well, you've completely wasted a golden strategic opportunity. Which brings us to Section 4, a mini case study. Let's look at what we call the ad tech pivot. Imagine this very realistic scenario during a new product launch. The business challenge? An organization is about to launch a brand new cookie-based advertising tool. They do a standard privacy check and ask themselves, are we getting proper consent? Initially, the product team thinks their cookie wall, the thing that forces users to accept tracking to read articles, is perfectly fine. But the privacy officer decides to do an Article 59 analysis. They pull up their local regulator's latest annual report and discover a staggering 40% of recent fines were specifically targeting coercive cookie walls. Armed with this crucial intelligence, the organization executes a strategic pivot. They redesigned a consent flow to be totally voluntary before the launch. By simply checking that Article 59 report, they successfully reverse engineered the regulator's priorities and avoided a massive penalty. Pretty cool, right? All right, it's time to test your understanding with a scenario-based knowledge check designed to feel just like a professional privacy certification exam. Question 1. Under Article 59, to whom must the supervisory authority transmit its annual activity report? Is it A, B, C, or D? Take a second to think about it. And the correct answer is B, the national parliament, government, and other designated authorities. This ensures there's proper democratic oversight over the regulator's activities. Sending it only to fined companies would completely defeat the whole purpose of public transparency, wouldn't it? Let's move right along to question 2. According to the text of Article 59, what specific enforcement data may be included in these annual reports? Read for the options. Is it A, B, C, or D? Got your answer? It's C, types of infringements notified and measures taken under Article 5822. This is exactly why these reports are an absolute goldmine for understanding how corrective powers like bans and fines are actually being used out in the wild. The GDPR strictly protects trade secrets and personal data, so A and B are definitely off the table. Okay, question 3. From a strategic perspective, why should a business leader actually care about a supervisory authority's Article 59 report? Take a look at the choices. A, B, C, or D? The correct answer is B. It provides intelligence to benchmark compliance and anticipate regulatory priorities. Like we talked about, it acts as a regulatory crystal ball to help you allocate your privacy budget way more effectively. And no, unfortunately, there are no discount codes for GDPR fines. All right, for our final question, question 4, how does Article 59 balance the requirement in GDPR Article 52 that supervisory authorities act with complete independence? Is it A, B, C, or D? The answer is C. By ensuring public transparency and democratic accountability through reporting. This proves that while regulators are completely independent in their decision-making, they are never, ever free from public accountability and oversight. To wrap up this explainer, let's quickly hit the core takeaways you really need to remember. Number 1, Article 59 is not just administrative paperwork. It's a vital strategic intelligence tool. Number 2, it directly details the application of Article 58.2 corrective actions, meaning the fines and bans. 3, reading these reports actually allows you to predict future enforcement trends and avoid massive blind spots. 4, from a legal perspective, it ensures that the immense independent power of regulators is properly balanced with democratic oversight. And finally, number 5, it is absolutely essential reading for anyone involved in privacy budget planning or risk management. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam, and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Always consult with your legal team. As you plan your strategy for the upcoming year, ask yourself, are you driving your privacy program based on last year's news, or are you actually reading the reports that tell you exactly where the regulator is heading tomorrow? Stay proactive and keep anticipating that next move. Thanks for joining me. Picture this, the sheer absolute chaos of a multinational company trying to satisfy 27 different European privacy regulators at the exact same time. It would be like an orchestra, where every single musician is playing a completely different tune, from a different sheet of music at totally different tempos. It would be an absolute nightmare for the business, and, frankly, a nightmare for the citizens just trying to get their data rights protected. So what actually happens when you have that many cooks in the kitchen? Well, without a structured system, cross-border privacy enforcement across Europe would just be pure noise. Regulators would constantly step on each other's toes, companies would face conflicting fines for the exact same issue, and investigations would literally stall for years. And that is exactly the problem that Article 60 of the GDPR solves. It's the ultimate rulebook that forces everyone to play together. To make sense of all this, here is our roadmap for Article 60. We'll explore the cross-border engine, how the procedure works step by step, some common scenarios and mistakes, enforcement with a real case study, a quick knowledge check, and finally our key takeaways. Let's get right into it. All right, let's start with the basics. Article 60 is literally the engine behind the GDPR's famous one-stop shop mechanism. If a business is processing data across multiple European borders, they don't have to deal with 27 separate regulators. Instead, they deal primarily with one, the lead supervisory authority, or LSA. But, and this is a big but, guided by recitals 124 and 130, that lead authority cannot just act like a dictator. They absolutely must cooperate closely with the other regulators, known as the concerned supervisory authorities, or CSAs. The ultimate goal here? To reach a consensus. So how does this actually work procedurally? It runs on a super strict timeline. Step 1, the lead authority does the digging and writes the first draft of the decision. Step 2, they share this draft and the concerned authorities get exactly 4 weeks to review it. Step 3, if everyone agrees, fantastic, the decision becomes binding. But if a concerned authority objects, we hit step 4. The lead authority can revise their draft, or if they completely disagree with the objection, the European Data Protection Board, the EDPB, steps in to resolve the dispute. You really have to understand these two distinct roles to grasp Article 60. Think of the lead authority as the conductor of the orchestra. Under Articles 56 and 60, they act as the sole interlocutor for the company, meaning they're the main point of contact, and they write the actual decision. But the concerned authorities, they are the orchestra. They represent the citizens back in their local countries. Their job is to review the conductor's drafts, provide mutual assistance, and crucially, raise formal objections if they feel that draft just doesn't protect their citizens enough. But hey, what happens when the orchestra totally disagrees with the conductor? A concerned authority can't just fire off an email saying, we don't like this fine, make it bigger. No way. They have to issue what the GDPR officially calls a relevant and reasoned objection. As defined in Article 4, paragraph 24, they must explicitly and clearly demonstrate how that draft decision poses significant risks to the fundamental rights and freedoms of the data subjects. It absolutely has to be grounded in hard legal facts.
Let's ground this with a few practical examples so it really clicks. First up, imagine a massive tech giant with its main European headquarters in Ireland. The Irish Data Protection Commission acts as the lead authority. But because that tech company has millions of users in France, Germany, and Spain, those countries act as concerned authorities reviewing the Irish draft. Second example, a small bakery in Berlin only serving local customers. Article 60 doesn't apply here at all. It's purely a local matter. And third is a classic compliance failure scenario, a lead authority drafting a decision but completely ignoring the feedback of the concerned authorities. As we'll see in a second, the law really does not allow that. Now, this leads us right into a massive pitfall. One of the absolute biggest mistakes regulators and legal teams make is completely misunderstanding that strict 4-week objection window. If a concerned authority misses that deadline, they are legally deemed to be in agreement with the draft, period. Another huge mistake is submitting vague disagreements. As the EDPB guidelines stress over and over, an objection must be both relevant to the case and reasoned with actual legal arguments. If it's not, the lead authority can just reject it. And just so you know, from an enforcement standpoint, European courts do not play around with this. In a landmark ruling, CJEU case C645/19, which involved Facebook Ireland, the court made it crystal clear. They ruled that the lead authority cannot eschew essential dialogue. Sincere and effective cooperation is a strict legal requirement. The lead authority cannot just go rogue. They're legally bound to actually listen to the other regulators. It goes even further than that. Under a more recent case, T70/23, the General Court confirmed that if a concerned authority raises a valid point that the lead authority basically didn't investigate deeply enough, the EDPB actually has the power to step in. The EDPB can issue a binding decision forcing the lead authority to dig deeper and broaden the scope of its entire investigation. Meaning, companies can't just rely on a friendly lead authority to give them a quick surface-level review. Let's look at a quick mini case study to see all this in action. Picture a French user complaining to the French regulator, the CNIL, about a major data breach on a Spanish mobile app. The Spanish regulator, the AEPD, is the lead authority. They investigate and propose a tiny little fine. Well, the French CNIL receives the draft and formally objects within the 4-week window, arguing the fine is way too low and poses a real risk to citizens' rights. The Spanish regulator disagrees. Because they've had a stalemate, the matter is automatically escalated to the EDPB through the consistency mechanism to settle the tie with a final binding decision. All right, time to put you in the hot seat with a quick certification-style knowledge check. Question 1. Under Article 60, exactly how long do concerned supervisory authorities have to express a relevant and reasoned objection to a draft decision? Is it A, 2 weeks, B, 3 weeks, C, 4 weeks, or D, 1 month? Lock it in. And the correct answer is C, 4 weeks. The law strictly enforces this exact 4-week window to keep investigations moving efficiently while still allowing for that critical peer review. It is not a generalized 1 month, it is precisely 4 weeks. Moving on to question 2. This one tests what happens when the orchestra stops playing in harmony. If the lead authority flat out refuses to follow a relevant and reasoned objection raised by a CSA, what happens next? Does the LSA adopt it anyway? Does it go to the EDPB consistency mechanism? Does the CSA take over? Or does the European Commission jump in? The answer is B. Article 60, paragraph 4 prevents a permanent stalemate by escalating those unresolved disputes straight up to the EDPB. The EDPB then uses the Article 63 consistency mechanism to issue a final, binding ruling that both authorities are forced to follow. Okay, question 3. This is all about the threshold for actually raising a flag. According to the GDPR and EDPB guidelines, what must a relevant and reasoned objection actually demonstrate? A minor procedural disagreement, the significance of the risks to fundamental rights, a conflict with trade law, or just a desire to increase the fine? If you guessed B, you nailed it. As specifically defined in Article 4, paragraph 24, an objection can't just be some petty procedural grievance or a gut feeling. It must clearly demonstrate a tangible, significant risk to the fundamental rights and freedoms of the data subjects involved. All right, final question. Can a non-lead local supervisory authority ever take the reins and handle a cross-border case locally? Yes, without informing the LSA, only if the LSA passes on it after being informed, never, or only if the company agrees. Make your choice. The answer here is B. According to the tests, the lead authority generally gets the right of first refusal. The local authority has to inform them of the complaint. But if the lead authority decides they aren't going to handle it, then the local informing authority is absolutely permitted to step up and handle it locally under Articles 61 and 62.
So, bringing it all together, what are the big takeaways from this explainer? Let's recap real quick. First off, Article 60 is the absolute engine powering the one-stop shop. Second, the lead authority drafts the decisions and the concerned authorities review them. Third, there's a very strict 4-week window for raising objections. Fourth, those objections must be legally sound. They have to be relevant and reasoned. Fifth, as case law approves, sincere cooperation is not just a nice to have, it's legally required. And finally, if they just can't agree, unresolved disputes escalate directly to the EDPB. Well, if you're enjoying these GDPR explainers, I would like to support the channel. Consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners around the entire world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale that education globally. And hey, if you're looking for more structured privacy, security, or AI training, stuff like guided learning paths, workshops, practice questions, or certification prep, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while Privacy Uni is perfectly designed for learners who prefer a much more structured learning experience. Quick reminder, disclaimer, this content is provided for educational purposes only and does not constitute legal advice, and content might include mistakes. I'll leave you with this final thought. As cross-border technologies like AI become even more incredibly complex, will the Article 60 orchestra continue to play in harmony, or is the EDPB about to become the busiest conductor in all of Europe? Think about it, and I'll see you in the next explainer. Hey everyone, welcome back to Privacy Trainer. In this explainer, we are taking on a massive project, breaking down every single article of the General Data Protection Regulation one by one. And today, we're diving into Article 61. Now, if you've ever watched one of those classic buddy cop movies where two detectives from totally different cities are forced to team up to catch the bad guy, well, you already kind of understand the core concept we're dealing with today. Article 61 is literally the ultimate regulatory buddy cop mandate. It completely forces European data protection regulators to team up, share information, and directly assist each other across borders.
Here's our agenda for today. We're going to start by looking at the borderless data problem, then unpack the actual mechanics of Article 61, look at some real-world enforcement case studies, and finally, wrap things up with a quick knowledge check.
Section 1, the borderless data problem, why Article 61 actually exists. So you might be wondering, why should organizations actually care about Article 61? Well, think about it. We live in a world where data flows seamlessly across borders in literal milliseconds. A company sitting in France might be processing the data of citizens in Italy, but using servers located over in Germany. It's a web. But European data protection regulators, the supervisory authorities, they have these strict, highly traditional jurisdictional lines. So what does this mean for your compliance program? Well, it means that without Article 61, regulatory enforcement across Europe would be a chaotic, fragmented mess full of loopholes. Bad actors could just hide out in a country with an under-resourced regulator, and honest organizations would be faced with completely inconsistent rules. Article 61 is the bridge over that regulatory gap. Think of Article 61 as a highly specialized communication toolkit for supervisory authorities. You'll find it over in Chapter 7, which is all about cooperation and consistency. Basically, this article legally mandates what we call mutual assistance. It ensures that a regulator in one country can literally compel a regulator in another country to help them gather information or even carry out investigations. It's the absolute glue that allows these distinct national authorities to collaborate effectively. It makes them act almost like a single, unified, pan-European police force for data protection. Moving right along to Section 2, Unpacking Article 61, a step-by-step workflow. Okay, so let's break down how this actually works in plain English, because the mechanics here translate dense legal text into a surprisingly straightforward process. Step 1, an authority realizes they need help, so they send an information request to another authority. And the GDPR is super specific here. This must be done electronically using a standardized format to keep things efficient. Step 2, the clock immediately starts ticking. The requested authority has exactly 1 month to reply. Absolutely no undue delays are allowed. And then step 3, what happens if the requested authority just ignores the request or blows past that 1 month deadline? Well, the requesting authority doesn't just throw their hands up and give up. It triggers an urgent mechanism that allows them to adopt provisional measures right then and there on their own territory. To really get inside the heads of the lawmakers and understand their intent here, we have to look at Recital 133. It brilliantly summarizes the whole mechanism. It states, and I'm paraphrasing a bit here, that authorities should assist each other to ensure consistent enforcement. And importantly, a requesting authority may adopt a provisional measure if it receives no response within 1 month. Lawmakers specifically designed this fallback feature to prevent any single overburdened or maybe just uncooperative regulator from becoming a massive bottleneck for European justice. So how does this all play out in the real world? Let's quickly look at 3 different scenarios. Take a massive tech company, right? Their lead regulator might use Article 61 to request information from a foreign regulator about the local impacts of a huge data breach. Now, what about a small business that only operates locally but somehow impacts foreign citizens? Well, a foreign regulator can actually use this article to force the local regulator to go investigate them. And then you have a total compliance failure scenario. If a local regulator drops the ball and completely ignores a request, that foreign regulator just escalates the situation and takes temporary, urgent action against the company themselves. Now, this leads us to a massive and, frankly, super costly mistake that a lot of businesses make. The misconception is businesses sitting there thinking, well, we're headquartered in country A, so we only ever have to answer to country A's regulator. We're totally shielded from the rest of Europe, right? No way. The reality is that any supervisory authority in Europe can trigger an investigation into your business by leveraging Article 61 through your local regulator. Your local jurisdiction is not some impenetrable fortress. It's just a doorway that other regulators can legally knock on. All right, Section 3, Enforcement and Case Studies, Real-World Application. And listen, the European courts do not mess around with this. They take it incredibly seriously. Look at the landmark Court of Justice of the European Union case C645/19. The court made it abundantly clear that regulators cannot just sit on their hands. The law mandates what they call sincere and effective cooperation. Regulators are legally bound to work together. So for us, what does that mean? It means organizations must maintain absolutely impeccable evidence of their data processing activities, because a coordinated multinational investigation can literally be spun up in a matter of weeks. Let's walk through a mini case study, just to visualize the whole shebang. Step 1. Let's say a data subject down in Spain files a severe privacy complaint about an app built by a German tech company. Step 2. The Spanish supervisory authority can't exactly travel up and directly raid the German office. Instead, using Article 61, they send a formal electronic mutual assistance request over to the German supervisory authority. Step 3. That German authority now has a strict 1-month legal deadline to go investigate that tech company on behalf of the Spanish authority, gather all the evidence, and report back. You see, the whole system is perfectly designed to be fast and inescapable. Okay, time for Section 4, Knowledge Check and Takeaways. Let's test your understanding. All right, let's dive into Question 1. Under Article 61, what is the maximum time frame for a requested supervisory authority to reply to a mutual assistance request? Is it A, 14 days, B, 1 month, C, 3 months, or D, no strict deadline? Take a quick second to think about that timeline we just discussed. If you guessed B, 1 month, you hit the nail on the head. The GDPR explicitly dictates this strict 1-month turnaround. The exact legal text says they must reply without undue delay and no later than 1 month. This strict SLA basically ensures that these cross-border investigations don't just stall out indefinitely on someone's desk. Moving on to Question 2, what can the requesting supervisory authority actually do if the requested authority completely ignores the request beyond that 1-month deadline? A, close the case, B, issue a fine directly to the company, C, adopt a provisional measure, or D, ban the controller from operating? And the correct answer is C, adopt a provisional measure. If the whole buddy cop system completely breaks down and there is just total silence for a month, it triggers the urgency procedure under Article 66. This allows the requesting regulator to bypass the delay and take immediate temporary action on its own territory to protect its citizens. Next up, Question 3. Money talks, right? So can a requested supervisory authority charge a fee to another authority for providing this mutual assistance? A, always, B, yes, a flat rate, C, no, as a rule, or D, only for large tech investigations? The correct answer here is C, no, as a rule. The regulation is super clear that mutual assistance is generally free, and this is intentionally designed to encourage seamless, frequent cooperation without regulators constantly worrying about budgetary constraints, barring some highly exceptional, mutually agreed upon costs, of course.
All right, last question. Question 4. How should supervisory authorities ideally supply the requested information to each other? A, postal mail, B, by electronic means using a standardized format, C, public publication, or D, encrypted USB drives?
And the correct answer is B, by electronic means using a standardized format. Efficiency is legally required here. Lawmakers absolutely did not want regulators getting bogged down in bureaucratic paperwork delays, so they mandated a modernized electronic approach for sharing all this critical data.
So let's wrap this all up with our key takeaways for Article 61. First, always remember that regulators act as a powerful network team. You aren't just dealing with one isolated authority anymore. Second, that 1 month clock for them to assist each other is absolute, which keeps investigations moving lightning fast. Third, if a regulator fails to cooperate, those provisional measures ensure that noncompliance cannot just hide behind jurisdictional borders. And finally, as backed by CJEU case law, sincere cooperation is legally mandated. The European enforcement landscape is incredibly interconnected for sure.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and certification preparation resources, you can totally explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available right here on YouTube, while privacyuni.com is designed for learners who prefer a much more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. To leave you with one final thought today, in a world where your data moves in milliseconds, will cross-border enforcement finally catch up, or are the bad actors still going to stay one step ahead? Keep learning, and I'll see you in the next explainer.
Okay, let's dive right into this explainer on GDPR Article 62. We're going to discover exactly how European regulators team up to tackle those massive cross-border privacy issues. You know, if you've ever wondered how the EU actually enforces privacy laws when a giant tech company operates across 20 different countries, well, you're in the right place. Today, we're breaking down the exact legal mechanism that forces national regulators to play nice, share power, and launch joint investigations. Here is a quick look at our roadmap for today. First, we've got the hook and deconstruction of cross-border breaches. Second, we'll see these operations in practice. And third, we'll wrap up with the certification-style knowledge check.
Section 1. Hook and deconstruction. Let's see how Article 62 builds the foundation for regulatory cooperation.
Imagine a massive data breach at a huge tech company, and it's affecting millions of users in France, Germany, and Spain all at once. Without Article 62, we'd literally have absolute regulatory chaos. You'd have French investigators, German authorities, and Spanish regulators all launching separate overlapping investigations. They'd be demanding the exact same documents and probably issuing completely conflicting fines. It would be a total nightmare for the business and honestly highly inefficient for the data subjects too. So Article 62 was written specifically to solve this exact problem.
The text of the GDPR explicitly empowers what we call the lead supervisory authority, or the LSA, to request mutual assistance and conduct joint operations with other concerned authorities. You can think of the lead supervisory authority as the primary regulator in the country where the company has its main European headquarters. But under Article 62, they don't just work in a silo. The law establishes a formal mechanism to invite regulators from other impacted countries to join forces and conduct one unified investigation.
So looking at the breakdown of the actual legal text, Article 62 creates a really clear framework for this participation. Paragraph 1 simply says that authorities must conduct joint operations when appropriate, basically forcing cross-border teamwork. Paragraph 2 is absolutely crucial. If a company's data processing substantially affects citizens in multiple countries, those local regulators have an absolute right to participate. The lead authority simply cannot shut them out. And then paragraph 3 solves the whole jurisdiction puzzle, stating that visiting regulators operate strictly under the host country's laws. You don't just get to bring your home country's rulebook with you when you cross the border.
Now, this introduces some pretty brilliant built-in accountability and fail-safes. Let's look at liability. Say a visiting investigator from Italy accidentally damages an expensive server during a joint raid in Spain. Who pays? Well, Article 62 says the host state, Spain in this case, takes initial liability to immediately compensate the victim. Behind the scenes, Italy will reimburse Spain later. And then we have the ultimate fail-safe in paragraph 7. What happens if the lead authority just ignores a request to join an investigation? Well, if they drag their feet for a month, the concerned authorities can bypass them entirely and adopt urgent provisional measures on their own territory.
Section 2. Operations in practice. Let's take a look at a real-world scenario. Let's walk through a quick case study for our fictitious company, DataStream Inc., which is headquartered in Dublin. Step 1, DataStream suffers a multi-state breach. Step 2, because their citizens are heavily impacted, the French and German regulators invoke their right to request a joint operation. Step 3, to avoid triggering those emergency measures we just talked about, the Irish lead authority officially invites them within the 1-month deadline. And Step 4, French and German investigators physically travel to Dublin. But remember, once they step foot in Dublin, they exercise their investigative powers strictly under Irish national law. The legal handoff here is absolute.
Now, looking at these examples, they highlight a major compliance pitfall. While large tech platforms often face joint operations to ensure consistent cross-border enforcement, a massive failure occurs when a business refuses to hand over documents to a visiting regulator. They might think, hey, you're from France, you have no jurisdiction here in Germany. Actually, that is a huge mistake. Under Article 62, the host German authority has legally conferred powers onto that French investigator, so defying them is literally defying your own host regulator. And just as a side note, a local shop is rarely going to trigger this, unless their processing substantially affects users in other countries.
If you're looking at this from the regulator's point of view, it's really vital to understand their mindset here. As seen in CJEU case law, regulators are legally bound by a duty of sincere cooperation. Basically, they don't keep secrets from one another. They actively share intelligence to build an airtight case against non-compliant organizations. So if your organization faces a joint operation, you must respect the lead authority as your primary point of contact, while understanding that they are acting on behalf of a unified European task force.
Section 3. Knowledge check and wrap-up. Let's test your understanding.
Okay, first question. During a joint operation at a processor's office in Spain, an investigator visiting from the Italian Supervisory Authority accidentally damages expensive server equipment. Under Article 62, who is initially responsible for making good on this damage? Is it A, the Italian Supervisory Authority,
B, the processor, as a cost of doing business. C, the member state of the host supervisory authority, meaning Spain. Or D, the European Data Protection Board.
The correct answer is C. The host country takes immediate legal and financial responsibility. The business whose server was smashed doesn't have to go out and hire an international lawyer to sue Italy. Spain makes them whole immediately, and then the regulators settle the reimbursement between their member states later.
Next up, a tech company has its main establishment in Germany, but substantially affects data subjects in Poland. The Polish Supervisory Authority requests to participate in a joint operation. What happens if the German lead supervisory authority ignores this request for over a month? Does Poland A, lose its right to investigate, B, adopt a provisional measure on its own territory, C, get the EDPB to immediately fine the German authority, or D, force the tech company to relocate to Poland?
The correct answer is B. This is a perfect example of how the GDPR prevents a lead authority from stalling a critical cross-border investigation. If Germany ignores Poland for a month, Poland doesn't just give up. They are legally presumed to have an urgent need to act, and they can adopt provisional measures right there on Polish territory to protect their citizens.
Question 3. Which set of laws governs the investigative powers exercised by visiting French supervisory staff conducting a joint operation on the premises of a controller located in Ireland? A. French national law. B. Irish national law under the guidance of Irish staff. C. A specialized EDPB international code. Or D. The laws of the controller's choosing.
And the correct answer is B. You always follow the law of the land you're standing on. The French staff must operate under Irish national law and under the direct guidance of the Irish host staff. Okay, let's move to our final question, which tests when exactly an authority can invite themselves to the party.
Under Article 62, Paragraph 2, under which condition does a supervisory authority have an absolute right to participate in a joint operation? A, whenever they are curious about a company's practices. B, when the controller has establishments in their member state or their data subjects are substantially affected. C, only when the European Commission explicitly orders them to join. Or D, when the company requests their presence.
The correct answer is B. Curiosity definitely isn't enough, and they certainly don't need a golden ticket from the European Commission. If a company operates an establishment in their country or heavily affects their citizens, that local regulator has an ironclad right to join the operation. All right, let's wrap up with our key takeaways.
So, to summarize the most critical lessons here, Article 62 ensures no single regulator can monopolize or neglect an investigation that impacts citizens across the EU. It legally mandates teamwork. It requires lead authorities to invite concerned peers to the table. It sets very clear jurisdictional boundaries where visiting regulators have to use host country laws. And most importantly, it prevents gridlock with those strict one-month deadlines and initial liability rules for host states. If you enjoy these GDPR explainers and would like to support the channel, please consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale that education globally. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam or certification prep resources, you can definitely explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available right here on YouTube, while privacyuni.com is designed for learners who prefer a much more structured learning experience.
Quick disclaimer, this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. But before you go, consider this. As massive AI systems begin processing data that simultaneously affects all 27 member states, will the joint operations outlined in Article 62 be agile enough to keep up, or will the whole system buckle under the weight of total European collaboration? It's something to think about. Thanks so much for joining me on this explainer, and keep training your privacy skills.
Welcome to Privacy Trainer. Today, we're unpacking what I like to call the GDPR's anti-chaos engine. That's right, we are diving deep into Article 63, and we're going to explore exactly what happens when cross-border privacy rules collide. Seriously, if you've ever wondered how the European Union manages to keep 27 completely different national regulators from just constantly contradicting each other, well, you are definitely in the right place. In this explainer, we're going to break down the massive business risk that Article 63 was specifically designed to solve. Okay, let's take a super quick look at our roadmap to see how this consistency mechanism directly impacts your cross-border compliance. We'll start with why consistency matters, move into decoding Article 63, look at some real-world examples, dig into regulators and case law, test your knowledge, and finally wrap up with takeaways and next steps. Let's jump in. Section 1. Why consistency matters, the chaos problem. We absolutely have to start with the massive business risk that Article 63 was built to solve, because frankly, without understanding the actual problem, the legal text just looks like a bunch of bureaucratic red tape. So I want you to picture a scenario. Imagine the absolute regulatory nightmare for a global tech company if every single European country enforced the exact same privacy law in completely contradictory ways. Say you're rolling out a brand new AI feature, right? The Irish regulator looks at it and says, yep, it's perfectly compliant, but then the French regulator says it violates core principles and slaps you with a massive fine. And then the Spanish regulator steps in and demands you delete all the data entirely. If every local authority had the final say over cross-border processing, doing business in Europe would be literally impossible. It would just be pure chaos. Section 2. Decoding Article 63, the solution. To fix that nightmare scenario, Article 63 establishes what's called the consistency mechanism. Now, in plain English, this is basically the ultimate referee system for European data protection regulators. It's a mandatory dispute resolution framework that literally forces supervisory authorities to cooperate. The goal is to ensure a completely uniform, harmonized application of the law across the entire EU. And what's super interesting is that this is actually a surprisingly rare mechanism in international law, actually forcing sovereign nations to legally agree on how they enforce regulations. Let's look at the actual text for a second. Article 63 says, in order to contribute to the consistent application of this regulation throughout the Union, the supervisory authorities shall cooperate with each other. So the absolute most crucial point of this legal text is that mandate for cooperation. It effectively strips local regulators of their ability to just go rogue and invent their own totally separate interpretations for cross-border businesses. In practice, this means authorities have to share information, provide mutual assistance, and actually submit their draft decisions to their peers for review before they can finalize anything.
Now, looking at the recitals, we can see exactly how this operates under the hood. Recital 119 ensures that even if a member state has a bunch of regional authorities, they still have to have a single point of contact for this mechanism. Recital 135 is absolutely key here. It clarifies that this mechanism is specifically triggered by substantial cross-border processing. And Recital 136, that one gives the European Data Protection Board, the EDPB, the real teeth. It gives them the power to make legally binding decisions to resolve disputes. So the EDPB is not just a suggestion board, they are a binding authority. Section 3. Real-world examples. The mechanism in action. You might be wondering, okay, does this actually apply to my organization? Let's break it down with a couple of real-world scenarios. If you are a small local shop in Berlin processing data only for customers in Germany, well, this article is rarely going to apply to you. Your local German supervisory authority generally has the final say. But if you are a multinational cloud provider, or maybe a big e-commerce brand that substantially affects individuals all across the EU, that is cross-border processing. And in that case, Article 63 is your biggest safety net against chaotic enforcement. You know, a really common compliance failure here is forum shopping, where a company tries to set up a fake headquarters in a country with a regulator they think is more lenient. But because of Article 63, the other 26 authorities will absolutely challenge that through the consistency mechanism and completely unravel that whole strategy. This brilliantly illustrates the actual real-world flow of how this works. Let's say your main establishment is in Ireland. Step 1, the Irish regulator, acting as your lead supervisory authority, drafts a decision about your data processing. Step 2, they share that draft with the other concerned authorities. Now let's say the French and Spanish regulators look at it and raise what the GDPR calls a relevant and reasoned objection within 4 weeks. Step 3, if the Irish regulator disagrees with France and Spain, they can't just ignore them. No way. The dispute is automatically escalated to the EDPB, triggering the Article 63 consistency mechanism to resolve the whole thing. Section 4, regulators and case law. Regulators and courts take this mechanism incredibly seriously, and to be honest, a lot of organizations really misunderstand its power. A super common compliance mistake is assuming your local regulator is kind of like the final boss. But as the Court of Justice of the European Union ruled in the landmark Facebook Ireland case, that's case C645/19, regulators must reach a consensus that is binding EU-wide. The court explicitly stated that the whole purpose of Article 63 is to reach a single decision that binds all establishments of a controller in the EU. This was also confirmed in the Google case C507/17, and then reinforced recently in case C97/23P, which affirmed the legally binding nature of EDPB dispute resolution decisions. Basically, the courts have made it crystal clear. You cannot bypass the consistency mechanism. Section 5. Test your knowledge. Certification prep. All right, let's test your practical understanding with 4 certification-style questions based on what we just talked about. This is super helpful if you're prepping for a privacy certification, or really if you just want to lock in this knowledge. Question 1. A cloud provider faces a draft decision from the Irish Supervisory Authority. The French authority raises a reasoned objection which Ireland rejects. What happens next? Is it A, France issues its own fine, B, it's sent to the consistency mechanism, C, the company chooses their preferred regulator, or D, the CJEU takes over? Think back to that exact step-by-step dispute process we just walked through. And the correct answer is B. If a lead supervisory authority rejects a relevant and reasoned objection, they cannot just ignore it or override the other country. The Article 63 consistency mechanism is automatically triggered, and the matter gets escalated straight to the EDPB for a binding decision. Okay, question 2. Let's see if you recall the specific voting mechanics we mentioned in the recitals. According to Recital 136, what voting threshold is required for the EDPB to issue a legally binding decision during a dispute? A, unanimous consent, B, simple majority, C, 2/3 majority, or D, approval by the Commission. The answer is C. The EDPB issues legally binding decisions by a 2/3 majority of its members. This is designed to ensure that a significant supermajority actually agrees on the harmonized interpretation, which prevents any single country from hijacking the process, but still demands a really broad consensus. Question 3 is going to test your knowledge of the regulatory perspective on when this mechanism is actually put to use. Based on the EDPB handbook, when is the consistency mechanism used? Is it A, only in court lawsuits, B, for EDPB opinions on things like SSCs and for binding dispute resolutions, C, for local data breaches, or D, when a data subject complains directly? Answer B is the one we're looking for. The mechanism is heavily utilized in 2 main scenarios. It's preventative, through EDPB opinions on things like standard contractual clauses or DPIA lists, and it's reactive, through binding dispute resolutions in one-stop-shop enforcement cases. All right, final question. Let's look at how the highest court interpreted the core purpose of this article. In CJEU case C645/19 involving Facebook Ireland, what was identified as the ultimate goal of the Article 63 consistency mechanism? A, creating multiple fines, B, letting local authorities override the EDPB, C, reaching a consensus and a single binding decision, or D, bypassing the GDPR entirely? The correct answer is C. It is all about avoiding fragmentation. The Court of Justice ruled that authorities must cooperate to reach a consensus, resulting in one unified regulatory voice and a single decision that is absolutely binding on all of a company's establishments across the EU. Section 6. Takeaways and next steps. Summary. Let's wrap this up with the absolute most important lessons you should take back to your organization and apply to your compliance strategies. To summarize, first, Article 63 is quite literally the glue holding the GDPR together. It actively prevents fragmented enforcement across 27 different countries. Second, it strips away isolated enforcement by mandating really rigorous cooperation between regulators. Third, when those regulators inevitably disagree, the EDPB acts as the ultimate referee with binding authority. And fourth, for cross-border processing, this entire engine is specifically designed to result in a single EU-wide binding decision, meaning cross-border businesses get to deal with a unified European legal front, providing some much-needed regulatory certainty. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com.
Privacy Trainer focuses on making knowledge freely available on YouTube, while PrivacyUni.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I want to leave you with this final thought today. As brand new technologies like AI really push the boundaries of cross-border data flows, do you think the Article 63 consistency mechanism will be fast enough to keep up, or will the speed of innovation force the EDPB to evolve its dispute resolution process? Thanks so much for joining me, and keep learning. Imagine, just for a second, the sheer chaos of 27 different European regulators trying to apply the exact same data protection law, but in 27 completely different ways. I mean, a ruling in Germany could totally contradict a ruling in France, which then contradicts a ruling in Spain. It would be an absolute regulatory nightmare, right? Well, today, in this explainer, we are focusing on the exact mechanism that's designed to prevent that nightmare from becoming a reality. We're talking about GDPR Article 64. We're going to break down exactly how the European Data Protection Board, the EDPB, steps in as the ultimate referee to maintain harmony across the entire continent. Okay, let's dive right into this. Here is our roadmap for today. We'll start with the foundational need for consistency, then we'll unpack the specific triggers of Article 64. After that, we'll look at some real-world applications and common mistakes, and then we'll finish up with a rapid-fire knowledge check and your key takeaways. Section 1. The need for consistency. Bringing order out of chaos. So, to really understand Article 64, we first have to look at Recital 10 of the GDPR. The law explicitly states that we need a consistent and homogeneous application of the rules throughout the European Union. Why? Well, to protect fundamental rights and to remove obstacles to data flows. In practice, this means we absolutely must have a referee to prevent a totally fragmented digital market. Without it, the whole single market concept literally just falls apart. And this brilliantly illustrates how the GDPR was specifically designed to solve bureaucratic chaos. You see, Article 63 introduces what's called the consistency mechanism, which establishes a formalized process of cooperation between supervisory authorities. Think of Article 63 as setting the stage. It builds the arena where the regulators have to play together. Article 64, on the other hand, is the actual rulebook for what happens when they finally step onto the field. Section 2. Unpacking Article 64. Let's get into the mechanics and the triggers. Let's translate the dense legal text of Article 64, Paragraph 1 into plain English. Essentially, when a national regulator, a competent supervisory authority, wants to approve major compliance items, they cannot act alone. If they want to adopt a list of high-risk operations requiring a data protection impact assessment, or approve global binding corporate rules for international data transfers, determine standard contractual clauses, or approve codes of conduct, they have to communicate their draft decision to the EDPB for formal opinion. They are legally required to ask the referee first. Now, what's really fascinating here is the stark contrast between Article 64 and Article 65. Under Article 64, the EDPB issues an opinion. It's highly cooperative and advisory. It standardly takes about 8 weeks and requires just a simple majority vote. But if regulators clash, or if an Article 64 opinion is straight up ignored, the whole thing escalates to Article 65. This results in a forceful, binding decision which heavily accelerates the timeline down to just 1 month and requires a 2/3 majority. So think of it this way. Article 64 is the carrot, and Article 65 is the stick. Section 3, real-world application. Let's ground this in some practical scenarios. How does this actually impact the market you work in every day? Well, if you are a global tech company trying to get Biden corporate rules approved for international transfers, you don't just have to win over your lead supervisory authority. Your rules are going straight to the EDPB for an Article 64 opinion. Or if you're a small business, you still benefit from this because those standard contractual clauses you rely on every single day are harmonized across the EU thanks to this exact mechanism. And in the event of a compliance failure where a national authority tries to go rogue, the mechanism automatically escalates to protect the consistency of the law. Let's look at a quick mini case study to really cement this. Imagine a global tech firm wants to roll out a massive new internal data sharing tool. To do this legally across borders, they need their binding corporate rules approved. The business challenge here is huge. How does this tech company get an approval that is legally valid in every single member state without having to apply 27 different times? Here is the step-by-step structural flow under Article 64. First, the tech firm submits their BCRs to their lead supervisory authority, let's say the Irish or the French regulator. Second, that lead authority drafts a decision to approve them, but they have to stop right there. They must submit that draft to the EDPB. Third, the EDPB reviews it and issues an Article 64 opinion, usually within 8 weeks. And finally, assuming the EDPB actually agrees, the lead authority adopts the final harmonized decision. The referee makes sure absolutely everyone is on the same page before the final whistle is blown. Section 4. Enforcement and common mistakes. Let's talk about public consequences. Probably the most common misconception in privacy compliance is that the one-stop-shop mechanism gives a single lead supervisory authority absolute unchecked power. That is simply false. The actual reality is that national regulators are always checked by the EDPB on matters of general application or cross-border processing. They are deeply, deeply bound by obligations of mutual assistance and cooperation. From an enforcement perspective, the courts take this incredibly seriously. Just look at the Court of Justice of the European Union in case C645/19, which involved Facebook Ireland. The court strongly reaffirmed that Article 61 mutual assistance and Article 63 consistency mechanisms aren't just polite suggestions. They are strict legal obligations. If a regulator attempts to circumvent Article 64, it immediately triggers an Article 65 binding dispute resolution, which effectively pulls the decision right out of their hands entirely. Section 5. Knowledge check. Let's move to a quick review and see how this all builds together. I'm going to give you 4 rapid-fire scenarios to test your understanding. Question 1. A lead supervisory authority drafts a decision to approve new binding corporate rules. What must they do next under Article 64? Is it A, publish it immediately, B, communicate the draft to the EDPB for an opinion, C, ask the European Commission for permission, or D, implement it only in their own member state? Take a second to lock in your answer. Great job if you guessed B. That is exactly correct. Under Article 64(1)(f), before a competent supervisory authority can approve binding corporate rules, they are explicitly required to communicate the draft to the EDPB for an opinion. This ensures consistency across the entire EU. Question 2. Let's look at procedural timelines.
How long does the EDPB standardly have to issue an opinion under Article 64 after a matter is formally submitted? A, 14 days, B, 1 month, C, 8 weeks, or D, 6 months?
The answer is C, 8 weeks. Remember that comparison we discussed earlier? Article 64.3 states the opinion shall be adopted within 8 weeks by a simple majority of the board members. Now, this can be extended by 6 weeks for highly complex matters, but 8 weeks is absolutely your standard baseline.
Question 3. According to Article 64.2, who actually holds the power to request the EDPB to examine a matter of general application, or one producing effects in more than one member state? A, only a data subject. B, any supervisory authority, the EDPB chair, or the commission. C, only the lead supervisory authority. Or D, the European Court of Justice. The correct answer is B. Article 64.2 empowers any supervisory authority, the chair of the EDPB, or the European Commission to request this examination. This specific rule ensures a really robust system of checks and balances across the entire European Union, preventing any single regulator from dominating the landscape. Final question. What happens if a competent supervisory authority outright ignores or fails to request an EDPB opinion when legally required? Is it A, nothing, they are completely independent, B, they are fined by the EU, C, it triggers a binding decision under Article 65, or D, the GDPR no longer applies to their territory? The answer is C. It triggers a binding decision. Article 64 has real teeth, precisely because Article 65 acts as the ultimate enforcer. Under Article 65, 1C, if a supervisory authority does not request the required opinion or doesn't follow it, the matter gets communicated to the board, which will then step in and adopt a binding decision. So the crucial point is this. Article 64 is the absolute engine of GDPR harmonization. It prevents regulatory chaos across 27 member states by positioning the EDPB as the vital referee. Whether it's BCR approvals, DPIA lists, or standard clauses, national regulators must seek an EDPB opinion. And if they ignore it, they face the binding force of Article 65. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I'll leave you with this final provocative thought. If regulators are constantly refereeing each other, how can your organization stay one step ahead of the whistle? Thanks for learning with me today, and I'll see you in the next one. Welcome back to Privacy Trainer. In this explainer, we're mastering the GDPR, one article at a time. And today, well, we're unpacking an absolute heavyweight of the regulation, Article 65. This is essentially the ultimate dispute resolution mechanism. Think of it as the rulebook for what happens when the regulators themselves just can't agree. Let's just dive right into it by picturing a very real-world problem. Imagine a massive cross-border tech company, okay? They've suffered a data breach. The lead supervisory authority, let's say they're in Ireland, drafts a decision proposing what they think is a modest fine. But then, a concerned supervisory authority over in France looks at that draft and says, no way, absolutely not. That fine needs to be literally 10 times higher. So who breaks the tie? If we didn't have a mechanism to handle this, the GDPR would just completely fracture into this messy web of conflicting national opinions. And that right there is exactly the problem Article 65 is here to solve. So here's our roadmap for today's explainer. 1. When regulators disagree. 2. Breaking down Article 65. 3. Article 65 in practice. 4. A step-by-step dispute. 5. Our certification knowledge check. And finally, 6. Takeaways and next steps. Let's get to it. Starting us off, Section 1. When regulators disagree. You know, to really get Article 65, you first have to understand the massive pain point of regulatory inconsistency. Under the GDPR's one-stop shop system, a company typically deals with just one lead supervisory authority. But obviously data flows constantly across borders. So when national enforcers inevitably clash over a penalty, the European Data Protection Board, the EDPB, steps onto the field. They act as the supreme referee. From a big picture regulatory perspective, Article 65 is literally there to prevent legal fragmentation. It's what ensures that a data subject sitting in Berlin gets the exact same level of privacy enforcement as someone down in Madrid. Moving right along to Section 2, breaking down Article 65. Let's get into the mechanics. Okay, let's translate the actual legal text of Article 65, specifically paragraph 1A, into plain English. It's kind of like a four-step dance. Step 1, the lead supervisory authority, the LSA, drafts a decision. Step 2, a concerned supervisory authority reviews it and raises what the law calls a relevant and reasoned objection. Step 3, this is the actual trigger. The LSA looks at that objection and rejects it. Boom, stalemate. When that happens, we hit Step 4. The matter is completely forced out of their hands and pushed up to the EDPB, which then steps in to adopt a legally binding decision. So how exactly does the EDPB make that decision? Well, it all comes down to some really strict voting thresholds. Recital 136 is our interpretive guide here, and it explains that the EDPB actually needs a strict 2/3 majority of its members to adopt this initial binding decision. 2/3, why so high? Because the law is literally designed to force overwhelming consensus among the countries. Now, if they're completely deadlocked after a time extension, they can eventually pass it with a simple majority. And in the rare case of an absolute tie, the chair steps in and casts the deciding vote. Now for Section 3, Article 65 in practice. Let's look at the real-world impact. Let's talk about how this actually impacts real organizations on the ground. Think about a multinational tech giant that's processing data across all sorts of European borders. They carry a very high risk of ending up in an Article 65 dispute purely because their compliance posture affects millions of people across dozens of jurisdictions. But flip that around. If you're running a standalone bakery in Vienna with just a single establishment, you are completely unaffected by this article. It's not even on your radar. The consistency mechanism is strictly triggered by those messy cross-border complexities. Now here is a massive compliance failure that we actually see happen in practice. Sometimes organizations try to hold back key evidence, thinking, oh, I'll just present this later if things go south.
Big mistake. EDPB Guidelines 03/2021 make it explicitly clear, once a matter is referred up to the EDPB, the file is totally locked. You absolutely cannot sneak in new elements of fact or drop in new evidence during the drafting stage to try and bolster your position. Your regulatory file literally has to be 100% complete from the very beginning. Which brings us to Section 4, a step-by-step dispute. Let's map out the timeline. Let's track the actual life cycle of one of these cross-border privacy disputes. And remember, the clock is always ticking. Once consulted, a concerned authority has just 4 weeks, that's it, to express a relevant and reasoned objection. If the dispute escalates to the EDPB, the board has exactly 1 month to adopt its binding decision. Now, they can extend that by another month if it's a super complex case, but that's the limit. After the EDPB notifies the authorities, the lead supervisory authority has exactly 1 month to adopt its final national decision. And I have to highlight a critical legal precedent here, case C97/23P. This case confirmed that the EDPB's decision has external legal effects, meaning it is fully legally binding on all parties. It's not just some friendly internal suggestion among regulators. All right, let's test what we've learned in Section 5, Certification Knowledge Check. Question 1, when exactly does the EDPB adopt a binding decision under Article 65(1)(a)? Is it A, when a data subject appeals, B, when an LSA rejects a CSA's objection, C, when the commission asks, or D, on all fines? Take a quick second to lock in your answer. And the correct answer is B. Article 65 is purely an escalation mechanism. It only gets triggered after the Article 60 cooperation process essentially breaks down. Specifically, that's when the lead supervisory authority refuses to follow or just outright rejects a relevant and reasoned objection from a concerned supervisory authority. Let's try question 2. What majority vote does the EDPB need to adopt a binding decision initially? A, simple majority, B, unanimous, C, 2/3 majority, or D, the chair decides. Lock it in. The answer is C. A strict 2/3 majority of EDPB members is required to adopt that initial binding decision. Remember, a simple majority is only ever used as a fallback option if they totally fail to reach that 2/3 consensus after an extension period. Moving right along to question 3, which focuses on those strict timeline constraints we just talked about. After the EDPB notifies its decision, how long does the lead supervisory authority have to adopt its final decision? A, 14 days, B, 1 month, C, 2 months, or D, no deadline? Think about that ticking clock. The correct answer is B. According to Article 65, Paragraph 6, the LSA has to formalize the EDPB's binding ruling into their final national decision without undue delay and at the absolute latest within 1 month. So the EDPB makes the ruling, but it's the LSA that actually hands the final paperwork to the company. All right, our final question, and this one addresses a pretty major misconception out there. Question 4. Can the EDPB use Article 65 to resolve disputes over procedural requirements? A, yes. B, no, it resolves the merits of the case. C, only for joint operations. Or D, only if the LSA agrees. The crucial point here is B. The EDPB explicitly notes in their guidelines that this mechanism evaluates substantive privacy violations. We're talking about the actual merits of the case, like whether consent was truly valid or if an infringement actually occurred. It is not designed to resolve procedural squabbles or administrative delays between local regulators. Finally, Section 6. Takeaways and next steps. Let's wrap this up. Let's bring all of this together. Here's what you really need to walk away with today. First, the EDPB ensures consistency across the European Union. They are the ultimate tiebreaker. Second, their decisions are legally binding on the authorities and have real external legal effects on the organizations involved. Third, there are strict, fast-moving deadlines once this dispute is triggered. And finally, if you're an organization under investigation, your regulatory file must be totally complete early on because you absolutely cannot introduce new evidence once the EDPB takes over. At the end of the day, cross-border compliance hinges entirely on these unified decisions. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thank you so much for joining me today, and I will see you in the next explainer. Urgent tone. Imagine a popular software update rolls out across Europe tonight, quietly activating the microphones on millions of smartphones without user permission. People are being recorded in their homes in real time. Regulators need to stop it, but the GDPR's standard one-stop shop mechanism requires a process. If the company is headquartered in Ireland, the Irish lead authority must coordinate the investigation, gathering input from local authorities across the continent. It is a thorough legal process, but building consensus across borders takes months, sometimes years. In a true emergency where data is actively being compromised, that standard bureaucratic timeline fails. Millions of people would suffer irreversible privacy violations while the paperwork clears. To solve this, the GDPR includes a built-in emergency brake, Article 66, the urgency procedure. This specific mechanism allows a local data protection authority to bypass the lead authority and take immediate, unilateral action in their own country. The legislative intent is clear. Recitals 136 and 143 of the regulation outline that protecting fundamental human rights takes priority over standard regulatory cooperation. When rights are under imminent threat, the polite exchange of memos has to stop. Article 66 operates as a targeted safety net, reserved for extreme, highly destructive situations where standard cross-border rules would be too slow to prevent harm. Article 66, Paragraph 1 dictates, under exceptional circumstances, a local authority can adopt a provisional measure valid for 3 months. Under Paragraph 2, they must request an urgent binding decision from the EDPB. Paragraph 3 allows any authority to request intervention if lead authorities fail. Step 4 imposes a brutally tight deadline. Once the matter reaches the EDPB, the board has exactly 2 weeks to issue a binding decision.
This four-step progression transitions a localized 3-month freeze into a permanent pan-European legal resolution in a matter of weeks. Regulators treat Article 66 as a nuclear option. Invoking it requires strict, documented proof of a severe risk to individuals. We can see the baseline rules they are bypassing right here in Articles 61 and 63, which govern mutual assistance and consistency. Rulings confirm that local authorities must attempt this standard cooperation first. The urgency procedure is a strict derogation from these norms. The consequences of this mechanism are intense for regulators too. As shown in paragraph 81 of the General Court ruling, an urgent binding decision under Article 66 can force a lead authority to drop other tasks, imposing a mandatory order of priority. If a local authority uses this power over a minor compliance issue, the courts will swiftly strike down their provisional measures. To see the threshold in practice, let's look at valid scenario. If a social media company activates a feature that permanently records device microphones, the immediate threat to human privacy justifies a localized ban on the spot. Another valid scenario. A local analytics firm suffers a breach and is actively exposing patient medical records in real time, yet the lead authority isn't responding. The local regulator steps in immediately to stop the bleeding. Compare that to an invalid scenario. If a local authority tries to use Article 66 to ban a company over poorly designed, annoying cookie banners, the measure will fail. Bad cookie banners violate the GDPR, but they do not pose an imminent, irreversible threat. The legal threshold for Article 66 is defined by the immediacy and severity of the threat to human rights, rather than the mere presence of a regulatory violation. Many corporations operate under the assumption that having a designated lead supervisory authority grants them absolute immunity from local regulators in other countries. Let's apply this to a case study we'll call BioTracker. BioTracker is headquartered in France, and their lead authority is the French CNIL. They roll out an illegal facial recognition software targeting children across Italy and Spain. Facing an active threat to children, the Italian Data Protection Authority skips the CNIL and triggers Article 66. They issue an immediate 90-day operational ban, forcing BioTracker to completely halt processing in Italy. Within 2 weeks, the issue escalates to the EDPB. The board issues an urgent binding decision ordering the French lead authority to take EU-wide enforcement action based on Italy's initial findings. Assuming a lead authority provides total protection can lead directly to a rapid, pan-European shutdown of an entire operation. Let's test what we've covered. Question 1. What is the maximum duration of a local provisional measure under Article 66? The answer is 3 months. Question 2. Which scenario justifies Article 66? The answer is severe, immediate threats, like tracking vulnerable individuals, not standard compliance issues. Question 3. What must the local authority do immediately after adopting the measure? They must communicate it without delay to the EDPB, the Commission, and other concerned authorities. Question 4. What is the timeframe for the EDPB to adopt its decision? Exactly 2 weeks. Article 66 serves as an emergency brake, requiring a high threshold of immediate risk to human rights. It begins as a localized, temporary measure under 2-week EDPB oversight, proving that lead authorities offer no absolute immunity in a crisis. If you found this breakdown valuable, support the channel by becoming a Privacy Trainer YouTube member. For structured learning paths, deep dive workshops, and certification prep, head over to privacyuni.com. And remember, this video is strictly for educational purposes and does not constitute legal advice. Thanks for watching.
Let's dive right into this explainer on GDPR Article 67. Think of this as the hidden digital plumbing that powers the entire GDPR enforcement machine. I'm your host, and today we're going to uncover exactly how European privacy regulators actually talk to each other to enforce the law. It's way more interesting than it sounds, I promise. So to really get why this article matters, just imagine a massive data breach, right? One hitting citizens in 27 different European countries. How in the world do 27 different regulators quickly and securely share case files to stop it? Well, without a standardized way to communicate, the whole cross-border consistency mechanism would literally fall apart. And that is exactly the problem Article 67 is here to solve.
Here's our quick roadmap for today. We'll start with the overview and legal text, move into the real-world impact, do a quick knowledge check, and wrap up with some key takeaways.
All right, Section 1. Let's start with a foundational overview of the legal text. So Article 67 is officially titled Exchange of Information. Basically, it's the specific provision that empowers the European Commission to create standardized digital formats. It's essentially the official technical blueprints for secure communication between supervisory authorities and the European Data Protection Board. You can think of this as a mandated secure network. It makes absolutely sure that when, say, a French and a German regulator need to collaborate on a case, they're speaking the exact same digital language.
Okay, so here is how this actually plays out in practice. Step 1. The Commission adopts what are called implementing acts. Step 2. This leads to the creation of standardized electronic formats, and this specifically ties right into the consistency mechanism we see over in Article 64. Then, Step 3, regulators can exchange information frictionlessly. The really crucial point here is that this isn't just regulators sending a few emails back and forth. No, it is a legally binding procedure to establish secure, unified systems for sharing some highly sensitive investigative data. If you want to understand the why behind all this, you just have to look at the GDPR's recitals. Recital 5 points out the massive increase in cross-border data flows. Meanwhile, Recital 82 demands effective and consistent monitoring. Put simply, data moves fast, so regulators need rapid, equivalent investigative tools just to stand a chance of keeping up.
Moving on to Section 2, let's look at the real-world impact and how this affects enforcement. Now you might be sitting there thinking, I'm on the business side, why do I even care how regulators talk to each other? Well, let's look at some practical scenarios. If you're a tech company, this means you could face rapid, coordinated joint operations from multiple regulators all at the exact same time. For a small business, your local supervisory authority can get immediate investigative help from a lead authority. And if you have a compliance failure, because regulators are perfectly synced up digitally through Article 67, a failure in one country immediately becomes visible to all of them. This drastically speeds up enforcement timelines against your organization. And let me tell you, the courts take this incredibly seriously. If you look at cases like C-507-17, the Court of Justice strictly enforces this duty for authorities to cooperate. Article 67 is literally the mechanism that makes that fast exchange of information possible.
So a really huge misconception is just ignoring this article because you think, oh, it only targets regulators. But as a privacy professional, you have to maintain pristine, easily shareable evidence because investigators are going to distribute it EU-wide in a matter of seconds. People often think cross-border cases are going to take years to organize, but the harsh reality of enforcement is that the EDPB uses these standardized formats to issue rapid binding decisions.
Let's walk through a quick timeline to put this into perspective. Say on day 1, there's a major tech breach affecting multiple countries. By day 3, the lead supervisory authority is notified and opens a case. Day 5, they're already using Article 67 formats to instantly and securely share evidence with concerned authorities. And by day 14, a coordinated multi-country enforcement action begins. Your biggest business challenge here is trying to manage a unified defense when the regulators across the table are already perfectly synced up. All right, Section 3. Let's do a quick knowledge check to test your practical understanding.
Here is our first scenario. Take a look at the screen. A multinational company is under investigation by the EDPB. Under Article 67, who actually has the specific authority to adopt implementing acts to specify the electronic exchange arrangements between the regulators? Is it A, the lead supervisory authority, B, the EDPB, C, the European Commission, or D, the data controller? Lock in your answer.
And the correct answer is C, the European Commission. So while the EDPB absolutely uses this system all the time to communicate, it's actually the European Commission that holds the legal power to define and mandate these standardized electronic formats.
Moving on to scenario 2. A privacy lawyer tries to argue that local regulators cannot share unredacted case files with a lead authority, and they blame it on format incompatibilities. Based on GDPR Article 67 and related case law, is this a valid defense? Read through those options and think about the fundamental goal of the consistency mechanism here. The answer is B. No, it is not a valid defense. Regulators just can't hide behind technical incompatibilities. Article 67 exists quite literally to eliminate those exact barriers and enforce the mutual assistance that the courts require.
Okay, scenario 3. According to the specific text of Article 67, the standardized format for the exchange of information is particularly linked to which other GDPR article? This one really tests your knowledge about the different pieces of the GDPR interlock with one another.
The correct answer is C, Article 64, which covers the consistency mechanism. Article 67 specifically calls out the standardized format referred to in Article 64, which just goes to show that the secure data exchange really is the backbone of consistent EU-wide enforcement.
All right, final question. Scenario 4. A compliance officer is assessing risk. Why should they care about Article 67 at all, considering it technically just regulates supervisory authorities? Put yourself in the shoes of a business leader evaluating this kind of regulatory risk.
The answer is B. You have to care, because it drastically accelerates the speed and coordination of cross-border regulatory investigations against your company. You must understand that because of this hidden network, you're never just dealing with one isolated regulator anymore. You're up against a unified, high-speed coalition.
Okay, Section 4. Let's wrap things up with some key takeaways and resources.
So here is what you need to remember. Article 67 is absolutely the digital plumbing of the GDPR. The EU Commission creates these standardized formats through implementing acts, and it directly supports the consistency and cooperation mechanisms in Articles 64 and 60. Case law demands this frictionless sharing of information, so organizations have to be prepared for rapid multinational enforcement. If you only take away one single thing today, let it be this. Article 67 ensures regulators are always connected and coordinating, so your compliance program has to be ready to respond just as fast.
If you're enjoying these GDPR explainers and want to support the channel, definitely consider becoming a member of Privacy Trainer. Those memberships are what help us keep creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality knowledge accessible to everyone. Now, if you are looking for a more structured learning experience, like guided paths, workshops, or certification prep, you should also explore privacyuni.com. Privacy Trainer is all about making knowledge freely available right here, while Privacy Uni is designed for folks who really want that structured deep dive training.
Just a quick reminder, this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. Thanks so much for joining me on this explainer. I'm going to leave you with one final thought. Is your organization's breach response plan fast enough to outpace regulators who can literally share evidence at the speed of light? See you next time.
Welcome to Privacy Trainer. Today we're diving into GDPR Article 68. This is the critical provision that establishes the European Data Protection Board, or the EDPB. Now you might be wondering, why should you care about this specific article? Well, without it, the GDPR would literally fracture into 27 conflicting national laws. It would make EU-wide compliance practically impossible. So let's explore how the EDPB serves as the ultimate architect of privacy consistency across Europe. Okay, here's our roadmap for this explainer. We'll start with the consistency problem, look inside Article 68, see the EDPB in practice, and discuss resolving cross-border disputes. Then we'll wrap up with a privacy professional knowledge check, followed by our key takeaways and next steps.
Section 1. The consistency problem. To really appreciate Article 68, you kind of got to imagine the alternative. What actually happens if 27 different countries enforce privacy differently? Just imagine the absolute chaos for businesses if a single data protection law was interpreted in 27 completely different ways across the European Union. A marketing campaign might be perfectly legal in France, but boom, it gets you heavily fined in Germany. It would be a complete compliance nightmare, basically destroying the digital single market that the EU aimed to create in the first place. And honestly, the GDPR's Recital 139 explicitly warns against this, noting that inconsistent enforcement creates major legal uncertainty and totally unequal protection for citizens.
So, to prevent that total fragmentation, the GDPR created the EDPB. You can think of it as the central nervous system or maybe the air traffic control tower for European privacy rights. Its primary mission is consistency. It's there to ensure that whether your data is being processed in Dublin, Paris, or Warsaw, your fundamental rights are protected to the exact same standard, acting as a fiercely independent body.
Moving on to Section 2. Inside Article 68.
So what does the text actually say? Article 68 states that the EDPB is an EU body with legal personality. That means it can take legal action and operate with true authoritative independence. It's represented by a chair, and most importantly, it's composed of the heads of each national supervisory authority right alongside the European Data Protection Supervisor, or EDPS. Oh, and here's a fun little fact for you. While the European Commission can participate in EDPB meetings to stay aligned, they are strictly denied voting rights. This is totally intentional and fiercely protects the board's independence.
And this structure directly supports its powerful mandate. As highlighted in Case Law C-97/23P, the EDPB doesn't just sit around offering friendly suggestions. No, it steps in with binding authority. It's tasked to monitor and ensure the GDPR is applied correctly and uniformly by absolutely every local regulator across the board.
Let's dive into Section 3, the EDPB in practice. Let's start by looking at a multinational tech company. For these guys, the EDPB is an absolute lifesaver. Say they're rolling out a brand new app across the entire EU. If local authorities clash over an investigation into how that app collects data, the EDPB steps in to provide one definitive, binding ruling. This one-stop-shop consistency means the company doesn't have to face 27 conflicting regulatory judgments for just one single product. That saves them millions in distinct regional compliance costs and legal fees. But it's not just for the tech giants. A small business also relies heavily on the EDPB's practical guidelines. For instance, if a local shop wants to install security cameras, or maybe a startup is building a connected mobility app, they can just look at the EDPB's specific guidelines on video devices or connected vehicles. These documents are fantastic because they help businesses understand really complex rules and apply data protection by design, all without needing to hire an army of specialized privacy lawyers. Now, this brings us to a really common yet massive compliance failure, which is treating privacy as a purely local issue. If you base your operations strictly on a local regulator's outdated guidance while completely ignoring the EDPB, you are setting a massive trap for yourself. True compliance success means you have to track the EDPB's overarching guidelines. Why? Because they literally have the power to overrule local interpretations during an investigation.
Section 4. Resolving cross-border disputes.
Okay, let's play out a scenario. Imagine a cross-border data breach occurs at a major retailer. The lead supervisory authority in Ireland proposes a €10 million fine. However, the concerned authorities in Germany and France object, arguing the fine should be much, much higher. So now they're completely deadlocked. Well, here's exactly where the EDPB exercises its supreme authority under Article 65 of the GDPR. It takes those conflicting views, examines the merits, and then issues a final binding decision that all national regulators are legally required to follow. Deadlock broken, just like that.
Section 5. Privacy Professional Knowledge Check. All right, time to test what we've learned. Question 1. According to Article 68, who makes up the core composition of the EDPB? Is it A, only the European Commission and the EDPS? B, independent privacy lawyers from each member state? C, the head of one supervisory authority of each member state and the EDPS? Or D, the IT directors of the top 50 European companies? Take a second to lock in your answer.
And the correct answer is C. Article 68, paragraph 3 brings together the top regulator from every single member state plus the European Data Protection Supervisor. It essentially requires the top regulator from every member state to be there to ensure that no single country dominates the conversation. It creates a truly pan-European voice on privacy matters. Moving on to question 2. Based on the EDPB's rules of procedure, what role does the European Commission play during EDPB meetings? Is it A, they hold veto power over all decisions? B, they have the right to participate but do not have voting rights? C, they act as the chair of the board? Or D, they're not allowed to attend? Go ahead and make your choice.
The answer is B. While the Commission definitely has the right to participate in the EDB's activities and meetings, which, is great for overall alignment, the EDB remains fiercely independent by explicitly withholding voting rights from them.
Here's question 3. A multinational company is under investigation, and two national regulators completely disagree on the outcome. How does the EDPB intervene? A, by rewriting the company's privacy policy. B, by issuing a legally binding decision under Article 65. C, by dissolving the national regulators. Or D, by referring the case to the U.S. Supreme Court. What do you think?
The correct answer is B. This is actually the EDPB's most powerful tool. Under Article 65, it steps in as the ultimate arbiter to resolve deadlocks and ensure consistent enforcement across the entire continent. And finally, question 4. How does Article 68 define the legal standing of the EDPB? Is it A, an informal advisory group, B, a private corporation, C, a temporary task force, or D, a body of the union with legal personality? This one is absolutely crucial for understanding its authority. If you guessed D, you nailed it. Article 68 explicitly grants the EDPB legal personality, which cements its permanent, authoritative, and independent status in EU law. It is definitely not just some informal advisory group, it is a foundational pillar of the EU. Section 6. Key takeaways and next steps. To quickly summarize, Article 68 prevents fragmented enforcement by uniting national regulators into one body, providing the ultimate binding interpretation of the GDPR. If you enjoy these explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. With all that in mind, I want to leave you with this final thought to consider. If the EDPB dictates the ultimate reality of GDPR enforcement, how confident are you that your organization is actually tracking their guidance rather than just relying on local, outdated advice? Thanks for joining, and I'll see you in the next explainer.
Welcome back to Privacy Trainer. We talk a lot about the GDPR here, but today we're doing something a little different. Have you ever wondered if your organization is, secretly violating the GDPR without even realizing it? It happens way more often than you'd think. In this explainer, we're decoding the GDPR by looking at myth versus reality in the courts. We're going to uncover how European courts actually rule on some of the most common corporate assumptions out there. And stick around, because what you think is totally compliant right now might actually be a massive legal blind spot.
All right, let's just dive right in by tackling a super common corporate myth. I mean, you've definitely seen this 1,000 times, right? You go to a website and boom, there's a pre-selected checkbox just waiting for you, assuming you want to opt into their cookies or their weekly newsletter. The business assumption here is that this constitutes valid user consent because, hey, the user didn't uncheck the box. But let's see how that actually holds up in reality.
So, while businesses often assume a pre-ticked box is perfectly fine, the harsh reality from the Court of Justice of the European Union, the CJEU, says the exact opposite. They completely shattered this assumption. The court made it absolutely clear that relying on a user to deselect a pre-ticked box, yeah, that means the consent is entirely invalid. No way around it. A really fascinating example of this is the famous Planet 49 case. The court explicitly ruled here that silence, inactivity, or a pre-ticked box just cannot be interpreted as valid consent. The user actually has to do something proactive. So hoping your users just kind of don't notice a checkbox, that is definitely no longer a viable legal strategy.
And the crucial point is right here in the actual definition from Article 411 of the GDPR. Active consent demands a freely given, specific, informed, and unambiguous indication of wishes by a, and here's the key part, clear affirmative action. A clear affirmative action means the user literally has to click, type, or explicitly say yes. It leaves absolutely zero room for ambiguity.
Moving on, let's look at another major gotcha when it comes to data sharing. When you hand over personal data, who exactly counts as a recipient under the law? This actually gets pretty tricky, especially when you're dealing with public authorities. Like, we have to ask, is literally any government body that receives data automatically classified as a recipient? Because getting this classification wrong has massive ripple effects on all your compliance documentation.
Well, take a look at this quote directly from Article 4.9 of the GDPR. It says, quote, public authorities which may receive personal data in the framework of a particular inquiry in accordance with union or member state law shall not be regarded as recipients. So this explicitly carves out an exception. If law enforcement is knocking on your door for a specific targeted legal inquiry, they are not technically a recipient that you need to track in the exact same way you would, say, a commercial third-party vendor.
But here is the reality check, brilliantly laid out by KC 200/23. While a specific law enforcement inquiry doesn't make an authority a recipient, an authority that maintains a commercial register was surprisingly deemed to be one. You might be thinking, wait, why? Well, because they merely received documents that companies were compelled to disclose for registration purposes. They weren't conducting a particular inquiry into any wrongdoing, they were literally just running a registry. This case really highlights how the specific legal context of a disclosure completely changes how you classify the entity receiving the data. Just because an entity is a public authority doesn't automatically exempt them. It's a massive, massive nuance for compliance officers to catch, because if you get this wrong, your records of processing activities and your privacy notices might be completely inaccurate. Okay, let's shift gears and transition over to the rules of further processing under Article 6.4. Here's a question I hear all the time. Hey, can we reuse this data for a totally new purpose if we just pseudonymize it first? Like, does a technical trick like masking the data suddenly give a company a free pass to reuse it however they want? It's definitely a tempting thought for data-hungry organizations.
Well, the short answer is no. It's absolutely not a free pass. The European Data Protection Board, the EDPB, who, by the way, operate completely independently under Article 69 of the GDPR to give us these guidelines, they require a very specific sequential logic to assess if a new processing purpose is actually compatible with the original one. First, you must have met the requirements for original lawfulness. Second, you have to assess the link between the original purpose and the new intended purpose. And third, you must apply appropriate safeguards. You simply can't just skip straight to step 3 and call it a day.
The EDPB actually provides a highly specific example regarding this exact process. Imagine a scenario where a web shop wants to share traffic and content data with the cybersecurity incident response team to analyze a potential security threat. Now, the initial data was collected just for running the web shop, right? So can they legally share it for cybersecurity analysis? The key lies entirely in how they handle that data before it ever leaves their hands. To bridge the gap between just routing web traffic and actually conducting a security analysis, they applied a crucial safeguard, pseudonymization. By filtering and mathematically transforming IP addresses and login credentials before sharing them with a security team, the company drastically reduced the risk to the individual users. And it's this specific reduction in risk that effectively makes the further processing legally compatible under the GDPR's legitimate interest balancing test. Let's shift gears for a moment to another area where legitimate interests are heavily used, and that's video surveillance. The burning question here is, can a business legally hold on to security camera footage indefinitely? Just in case something happens. I mean, it certainly feels safer to keep it, but the law sees it very, very differently.
Let's look at how this builds upon the EDPB guidelines on video devices. We have a great everyday example right here. Imagine a convenience store that's having some trouble with vandalism. So they set up video surveillance outside their entrance, basing it on their legitimate interest to protect their property. Makes total sense, right?
But here are the strict rules they actually have to follow. First, they must limit the stored data. If a few days pass and no vandalism occurs, the purpose for keeping that specific footage literally expires. The legitimate interest to store it no longer overrides the privacy rights of the people just walking by on the street. Therefore, the data must be erased. And here is a truly fascinating detail from those guidelines. If you irreversibly blur the footage so that there is absolutely no retroactive ability to recover the personal data or faces, that legally counts as erasure under the GDPR. Pretty cool, right?
So whether we're talking about cookies, commercial registries, cybersecurity, or convenience store cameras, there's one golden thread tying all these court rulings and guidelines together. The general principles apply everywhere. Even if a member state creates specific national adaptations for things like public health or archiving under Chapter 9 of the GDPR, the European courts have repeatedly ruled that the core fundamental principles of lawfulness, fairness, and transparency found in Articles 5 and 6 are absolutely non-negotiable. You can never bypass those foundations.
So as we wrap up this explainer, I want to leave you with a provocative question to take back to your own teams. Are you truly balancing interests and following the letter of the law, or are you just making comfortable corporate assumptions? From pre-ticked boxes to infinite video storage, assuming you are compliant is the fastest way to find yourself on the wrong side of a CGU ruling. Now before we go, let's do a quick rapid-fire knowledge check to see what you've learned today. Question 1. Is a pre-ticked box considered valid consent for cookies? A. Yes if the user doesn't uncheck it. B. Yes if the privacy policy is linked. C. No because it lacks a clear affirmative action. D. No unless it's a B2B website. The answer is C. As we saw in the Planet 49 case, you need a proactive action. Question 2. Is a public authority always exempt from being a recipient under Article 4.9? A. Yes, always. B. No, only when conducting a particular inquiry. C. No, they are always recipients. D. Yes, but only for tax purposes. The answer is B. Case C-200/23 showed us that running a commercial registry doesn't count as a particular inquiry. Question 3. Does pseudonymization automatically allow you to reuse data for any new purpose? A. Yes, it's a free pass. B. Yes, if the data is encrypted. C. No, it's just one safeguard in the compatibility assessment. D. No, pseudonymization is illegal. The answer is C. It reduces risk, but you still have to assess purpose compatibility. Question 4. What is one way to legally erase security camera footage? A. Moving it to a hidden folder. B. Irreversibly blurring the faces so data cannot be recovered. C. Turning off the monitor. D. Password protecting the file. The answer is B. The EDPB guidelines confirm that irreversible blurring counts as erasure. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks for joining me on Privacy Trainer, and keep learning.
Let's just jump right into this explainer of GDPR Article 70. Today, we're going to uncover exactly how the European Data Protection Board, or the EDPB, basically orchestrates privacy across all of Europe. Look, if you work in privacy, compliance, or you're running a business that operates in the EU, understanding the specific article is absolutely essential. It is literally the engine that keeps European data protection from just falling apart into dozens of totally different, conflicting national interpretations. Seriously, imagine the absolute chaos if 27 different countries looked at the exact same privacy rule and interpreted it in 27 completely different ways. What kind of nightmare does that create for businesses? Well, if you're a tech company trying to roll out a new feature, or even just a small business handling cross-border sales, you could be perfectly compliant in France, but suddenly staring down a massive fine in Germany for the exact same processing activity. Without a central referee to step in, the whole idea of a unified European market completely breaks down. So here is our roadmap for the explainer. First, we'll break down the harmonization problem. Then we'll dive into the EDPB's tasks and case law. After that, we'll walk through a realistic mini case study, and finally, wrap things up with a quick knowledge check. All right, starting right off with Section 1, the harmonization problem. Think of the EDPB as the ultimate conductor of the GDPR orchestra. Now, while Article 68 formally established them as an independent EU body with its own legal personality, it's actually Article 70 that hands them their sheet music. Their entire primary mandate, written right there into the law, is to ensure the consistent application of the GDPR throughout the Union. Before the EDPB stepped up, navigating data protection was honestly like walking through a minefield. You had incredibly unpredictable local rules, which led to unequal rights for citizens and almost guaranteed compliance failures for organizations. The harmonized approach driven by Article 70 fixes that. It gives us consistent enforcement, unified guidelines, and, most importantly, legal certainty. Because whether you're a scrappy local startup or a massive global tech giant, you really need to know that the rules of the game are exactly the same across the board. Moving right along to Section 2, EDPB Tasks and Case Law. So, the EDPB officially replaced the old Article 29 Working Party, which operated under the previous Data Protection Directive. But unlike that old Working Party, which honestly mostly just issued non-binding opinions, the EDPB got a massive upgrade. Now they monitor compliance, they actively advise the European Commission on things like adequacy decisions, and they play a massive, pivotal role in the one-stop-shop mechanism for cross-border processing. The really crucial takeaway here is that they are legally mandated to execute a few core tasks. First up, they issue the essential guidelines, recommendations, and best practices that compliance professionals rely on every single day. We're talking everything from handling data breach notifications to calculating administrative fines. Second, they advise the EU Commission on any matters that need further clarification. And third, maybe the most powerful tool they have, they resolve disputes between national supervisory authorities through binding decisions under Article 65. And if you're wondering if they actually use that power, the courts say yes. In the landmark Schrems II case, that's case C31/18, the Court of Justice of the European Union made it crystal clear that the EDPB has real teeth. The court highlighted that the EDPB can adopt a binding decision if a national supervisory authority tries to go rogue and ignores an EDPB opinion on things like cross-border data transfers. So they aren't just making polite suggestions, they are actively enforcing a single unified European standard. Let's make this concrete. Section 3, a mini case study. Okay, picture this. A major tech firm operating all over Europe suffers a massive data breach. Step 1, the breach happens. Step 2, the lead supervisory authority, let's say they're based in Ireland, investigates and drafts up a proposed decision on how to penalize the company. But then, Step 3, other local regulators, maybe in France and Germany, raise a relevant and reasoned objection because they think the penalty is way too lenient. Suddenly, you've got a total deadlock. That brings us to Step 4. The EDPB steps in under the consistency mechanism. They issue a binding decision that decisively resolves the dispute. This ensures the tech firm is judged by one consistent European standard instead of being caught in a tug-of-war between arguing regulators. All right, let's see how much of that stuck. Section 4, knowledge check and takeaways. Question 1. What is the primary purpose of the EDPB under Article 70? Is it A, write national laws, B, ensure consistent GDPR application, C, arrest violators, or D, issue individual fines directly? Take a second and lock in your answer.
If you guessed B, you nailed it. The EDPB's entire existence, right there in Article 70, Paragraph 1.a, is built around keeping the GDPR harmonized and ensuring its consistent application across the Union. They definitely don't write national laws, and they aren't a police force running around arresting violators. Moving on to question 2. According to Recital 136 and Article 65, what legal mechanism does the EDPB use when there is a cross-border regulatory dispute, like when local authorities object to a lead regulator's draft decision? The correct answer here is B, binding decisions. As confirmed in case C645/19, binding decisions force regulators to fall in line with a unified interpretation. This goes way beyond just sending out suggestion letters. It ensures the consistency mechanism actually works when push comes to shove. Question 3 gets a bit into the weeds of recent Court of Justice rulings. Does the EDPB determine the exact financial amount of a fine when they are resolving a dispute? The answer is B again. Case C97/23P explicitly confirms this. While the EDPB can decide that a violation absolutely exists, and they can even instruct that a fine must be imposed to ensure deterrence, the actual math, the precise financial amount of the fine, that remains the job of the National Supervisory Authority handling the case. And our final question, number 4. A little bit of privacy history for you. Which former group did the EDPB officially replace when the GDPR came into effect? That would be A. The GDPR took the old Article 29 Working Party and upgraded it into a formal EU body with independent legal personality and actual binding powers. Okay, let's wrap this up with our key takeaways for today. Article 70 basically establishes the EDPB as the engine preventing a fragmented digital Europe. They are the consistency conductor. They issue the practical, day-to-day guidelines businesses desperately need. They conclusively resolve cross-border regulatory disputes through binding decisions. And they advise the EU Commission on the overarching protection of personal data. Simply put, they are the glue holding the GDPR together. Hey, if you're getting value out of these GDPR explainers and you want to support the channel, definitely consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone, and we use AI to help scale this education globally. And if you're looking for more structured training, stuff like guided learning paths, workshops, practice questions, and full-on certification prep, you should really check out PrivacyUni.com. Privacy Trainer focuses on making all this knowledge freely available right here, while Privacy Uni is designed for folks who want a more structured, step-by-step learning experience. Just a quick disclaimer before we go. This content is provided for educational purposes only. It does not constitute legal advice. And hey, the content might include mistakes. But here's something to think about. As we've seen, the EDPB clearly holds immense power to unify privacy law right now. But as crazy new technologies like AI push cross-border data flows to the absolute limit, will Article 70 actually be strong enough to keep 27 nations marching to the exact same beat? Keep asking questions and I'll catch you in the next explainer. Welcome to this Privacy Trainer Explainer. Today, we're uncovering how GDPR Article 71 acts as the vital pulse check for European data protection. You know, I'm genuinely so excited to guide you through this one, because while some of the other GDPR articles get all the flashy headlines, Article 71, well, it's the quiet engine that keeps the entire framework alive and actually relevant. So, let's start with a really crucial question. What happens if regulators make these incredibly strict rules, but nobody actually tracks their real-world impact or enforcement? I mean, think about it. You can have the absolute best privacy laws in the world on paper, but if there's no structured way to measure whether companies are complying, or if the rules are actually protecting people, the law just becomes a static, useless textbook. And that is exactly the problem Article 71 solves. All right, looking at our agenda today, we're going to clear up a massive industry confusion, look at some real-world case law, and then test your skills with a certification-style knowledge check. Let's get to it. Section 1, the heartbeat of GDPR. Let's clear up arguably the biggest misconception in the privacy profession right off the bat. Article 71 is entirely about the European Data Protection Board's annual reports. Literally, if you ask a privacy pro what 71 means in the GDPR, half of them are going to instantly say, oh, automated decision-making and profiling. But actually, scratch that, they're confusing the recital with the article. Recital 71 is what provides the guidance on automated profiling. You know, things like e-recruiting and credit applications, which connects back to Article 22. Keeping these two totally distinct is an absolute must for any compliance professional. The GDPR was specifically designed with a built-in mechanism to constantly evaluate its own effectiveness across the union. The lawmakers knew, they absolutely knew, that technology would evolve way faster than legislation ever could. They needed a reliable feedback loop. And the crucial point is right here in the legal mandate. The European Data Protection Board is legally required to compile and publish a comprehensive public ledger every single year. Notice how the law explicitly states that the board shall draw up an annual report regarding the protection of natural persons. It's not a maybe, it's not optional. It is a mandatory audit of the state of data protection. So let's translate that into plain English. Basically, this means the EDPB must publicly report on the practical application of their guidelines, their best practices, and their binding decisions, and then send it directly to the EU Parliament, the Council, and the Commission. This ensures total transparency. It's like telling the highest legislative bodies in the EU, hey, here's what we guided companies to do, and here's how it's actually playing out there in the real world. Moving right along to Section 2, Scenarios and Enforcement. Let's look at a timeline that brilliantly illustrates how case law actually evolves. For instance, we have major Court of Justice rulings, like C319/20, which confirmed that consumer protection associations can bring representative actions against platforms like Meta, independently of specific data subjects. Big deal, right? Then we have C807/21, which clarified the conditions for imposing administrative fines on legal persons, specifically noting the requirements around intentional or negligent infringements. These are exactly the types of massive landscape-shifting developments that the Article 71 report synthesizes for compliance teams, so you can clearly see the big picture of enforcement. Let's walk through a mini case study, just to make this super practical. Imagine a scaling tech firm facing cross-border compliance challenges. Okay, that's their business challenge. The privacy issue? Well, they aren't exactly sure how strict the supervisory authorities will be regarding cross-border data processing consent. So for their regulatory analysis, instead of just guessing, their privacy team uses the insights from the latest Article 71 report to analyze recent binding decisions made by the EDPB. This lets them accurately adjust their risk models based on actual, recent regulatory behavior, rather than just relying on outdated assumptions. It's a real game changer. You know, a super common compliance failure is treating the GDPR as a static textbook instead of tracking the EDPB's annual updates. Regulators actually use these updates to evaluate whether a business is genuinely adapting to new privacy threats. So if your organization is still relying on a compliance playbook from 2018, there's no way around it. You are entirely missing the living, breathing application of the law that the EDPB explicitly publishes every single year under Article 71.
All right, Section 3, Privacy Knowledge Check. Let's see what you've learned.
Question 1. Under Article 71, what specific elements must the EDPB's annual report review? Is it A, national budgets, B, practical application of guidelines and binding decisions, C, individual consumer complaints, or D, new legislation drafts? Think about this scenario carefully and recall the core mandate we just discussed. What is the explicit requirement found in the text of Article 71, Paragraph 2? Go ahead and lock in your answer.
And the correct answer is B. Article 71 specifically requires the board to review how their guidelines, recommendations, and Article 65 binding decisions are actually working in the real world. It's not about tracking individual complaints or national budgets. It's really a macro-level review of the board's own regulatory mechanisms.
Moving to question 2. A compliance officer is assessing an automated credit scoring tool. Which GDPR provision should they consult? A, Article 71, B, Recital 71, C, Article 11, or D, Recital 173. Now, this is a classic trap on privacy exams that tests if you truly understand the structure of the GDPR. Remember that massive industry confusion we covered earlier? Think carefully.
The answer is B, Recital 71. This perfectly proves why you must never confuse the EDPB reporting mandate of Article 71 with the automated profiling rules found in the recitals. If you're dealing with an automated credit scoring tool, you definitely need Recital 71 and Article 22, not the EDPB annual reporting mandate.
All right, question 3. To which official bodies must the EDPB transmit its public annual report? A, only the European Commission, B, member state courts, C, EU Parliament, Council, and Commission, or D, local supervisory authorities. Try to think back to the exact entities listed in the legal text we reviewed earlier. Who exactly needs to see this pulse check to ensure the law is functioning across the Union? And the correct answer is C, the European Parliament to the Council and the Commission. This three-pronged reporting structure basically guarantees that data protection remains a top-tier priority across all branches of European Union governance.
Last question, number 4. How should a business leader practically use the Article 71 report? A, as legal advice, B, to anticipate regulatory enforcement trends, C, to override national laws, or D, to report data breaches. Consider the strategic value of this document for a company's ongoing compliance program. How does a smart leader leverage this public ledger? The answer is B, to anticipate regulatory enforcement trends. Smart organizations use this annual ledger to proactively align your practices with what regulators are actively focusing on right now. It definitely doesn't override national law, and it certainly isn't a mechanism to report a data breach. Rather, it's your ultimate crystal ball for enforcement trends.
Finally, Section 4, Takeaways and Next Steps. So, what does this all mean for you? Your key takeaways here are that Article 71 acts as the GDPR's pulse check. It mandates total transparency from the EDPB, and honestly, it proves that compliance is a living, breathing journey, rather than just a one-time destination. By studying the practical applications and binding decisions summarized in these reports, you can completely shift your privacy program from being reactive to proactive. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and certification preparation resources, you can absolutely explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available, while privacyuni.com is really designed for learners who prefer a more structured learning experience. Disclaimer time. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I want to leave you with one final thought today. Is your organization's privacy program evolving as fast as the EDPB's annual reports? Think about it. Thank you so much for joining me, and I will see you in the next explainer.
Okay, welcome back to Privacy Trainer, where we break down the GDPR one article at a time. Today's explainer is a really big one. We're zooming in on the broader ecosystem driven by Article 72, which officially establishes the European Data Protection Board, or the EDPB. But why should you care about a regulatory board? Well, because without it, the GDPR is just a static piece of paper. It's the EDPB that turns these rules into a living, breathing ecosystem. If your organization misunderstands how this ecosystem works, it's literally like trying to play a high-stakes game without knowing who the referee is or how they interpret the rules. And trust me, the penalties for getting it wrong are massive. Let's dive in.
Right out of the gate, we have to ground ourselves in the GDPR's foundational premise. Recital 1 makes it crystal clear. The protection of personal data is a fundamental right designed to serve mankind. It's not just legal red tape, it exists to protect us. But, and this is a big but, it's not an absolute right. It constantly has to be balanced against other rights and the realities of running a business. This constant balancing act is exactly why lawmakers establish bodies like the EDPB in Article 72 to help us figure out what that balance actually looks like in practice.
To make sense of all this, we're going to break it down into 6 quick parts. We'll look at the goal of harmonization, define a couple of crucial terms like processing and controllers, explore the EDPB's practical guidance, see how they regulate emerging tech, talk about the CJEU as the ultimate referee, and wrap up with accountability and enforcement.
Section 1. The goal of harmonization.
So, before this massive regulation was published in the official journal, Europe was a total mess of fragmented, competing national privacy laws. It was a nightmare for businesses trying to scale, and super inconsistent for citizens. The whole point here was to tear down those obstacles to data flows and replace them with a consistent, high, and homogeneous level of protection across all member states. Basically, one rulebook for everyone.
Section 2. Defining processing and controllers.
Before we get into the complex disputes, we need to nail down 2 definitions from Article 4 that trigger literally everything else. First up, processing. I cannot stress this enough. Processing is incredibly broad. Are you merely storing an IP address on a server? You're processing. Did you shred a physical document? You're processing. The courts, like in case C-349/21, have repeatedly shut down companies trying to claim their specific data handling somehow doesn't count. If you touch the data, you're processing it.
And right next to that is the controller. This is the person or company that actually decides why and how the data is processed. Why is this so crucial? Because the controller is the one left holding the bag. They hold the ultimate responsibility and liability. When there's a data breach, regulators look directly at the controller when they start handing out those massive administrative fines.
Section 3. The EDPB's practical guidance.
Okay, so what happens when those broad legal definitions crash into complex real-world situations? This is where Article 72 really comes to life, by establishing the EDPB. Think of the EDPB as the interpreter. They issue the practical, everyday guidelines you need to do your job. On the flip side, you have the CJEU, the Court of Justice of the European Union. They act as the referee. They handle the heavy judicial reviews and have the absolute final say on what the law means.
The EDPB is incredibly busy. They tackle those highly specific friction points where modern tech is moving way faster than the law. We're talking guidelines on virtual voice assistants, connected vehicles, the intricacies of the right to be forgotten, and how to actually implement data protection by design. They do the heavy lifting to ensure the GDPR is applied consistently no matter what crazy new tech comes out.
Section 4. Regulating emerging technologies. Let's look at a practical compliance failure that we see all the time. Consent. For years, companies relied on implied consent. You know those pre-ticked checkboxes where you had to actively opt out? Well, the CJEU in case C673/17 completely destroyed that assumption. Pre-ticked boxes are legally invalid, period. The GDPR demands explicit consent, a clear affirmative action. You literally cannot assume a user agrees just because they didn't uncheck a box. Now, let's take a tech company example where things get even trickier. Connected vehicles. The EDPB pointed out that getting valid, informed consent in a smart car is wildly difficult. Imagine someone renting a car or just sitting in the passenger seat. They are often totally unaware that the car is vacuuming up their data in the background. If they don't know what's happening, they can't legally consent to it. This is a massive challenge for auto manufacturers.
So how do you actually fix that? The EDPB doesn't just complain, they offer solutions. For example, they heavily promote pseudonymization. This is a technical safeguard where you strip out or isolate the identifying details from the core dataset. It's an absolutely brilliant way for organizations to meet the strict data minimization rules while still getting to use the data for analytics or research.
Section 5. The CJEU as ultimate referee.
When the EDPB's guidelines aren't enough and massive legal disputes bubble up, the CJEU steps onto the field. Their job is to ensure our fundamental rights are protected consistently across the entire EU. They are the ones doing the ultimate balancing act, weighing legitimate business interests against an individual's right to privacy, and making sure local regulators actually have the teeth to enforce the rules everywhere.
Section 6. Accountability and enforcement. This brings us to a mini case study on how the system self-corrects. Let's say a business challenge arises involving a cross-border privacy issue. Step 1, a local dispute kicks off. Step 2, the lead supervisory authority drafts a decision. But wait, Step 3, a regulator in another country raises a reasoned objection. They totally disagree. So who breaks the tie? Step 4, the EDPB steps in and adopts a final, binding decision. The system escalates to ensure consistency.
And here is the actual legal text of Article 65 proving exactly that. It formally cements the EDPB's power to ensure correct application of the law. When local authorities just can't agree, the GDPR doesn't allow the system to fracture into regional rules. It forces a centralized resolution.
And trust me, you do not want to be caught ignoring those binding decisions. Regulators are laser focused on this. Article 83 is the heavy hitter here. It outlines the framework for severe administrative fines. Whether your infringement was intentional or just negligent, this is the article that gives regulators the power to hit your company's bottom line hard.
But compliance isn't just about dodging fines. It's about proactive accountability. Under Article 32, the burden of proof is entirely on the controller. Let's clear up a common misconception right now. If you have a data breach, you cannot just tell the regulator, well, we didn't have the budget for better security. As the CJEU ruled in case C340/21, that excuse does not fly. You must actively maintain evidence proving your technical measures were appropriate.
Which brings us to the final question on screen. How is your organization actively monitoring the continuous output of the EDPB and CJEU? It's a constantly evolving ecosystem. Speaking of questions, before we wrap this explainer, let's do a rapid-fire scenario-based knowledge check to see what's stuck. 4 quick questions. Ready? Question 1. Your company sets up a pre-ticked checkbox for marketing emails. Is this valid? A, yes if they can opt out later. B, no, consent requires clear affirmative action. C, yes for small businesses. D, yes if clearly visible. The answer is B. It's legally invalid. Question 2. You rent a connected car that collects your location data without you knowing. Why is this a GDPR issue? A, cars can't collect data. B, implied consent is sufficient. C, valid consent is impossible if users are unaware. D, the car dealership is exempt. The answer is C. You can't consent if you're unaware. Question 3. A data breach occurs and the CEO says, we couldn't afford better firewalls? Under Article 32, is this a valid defense? A, yes, budgets matter. B, no, the controller bears the burden of proving adequate measures. C, yes if it's a first offense. D, only if the EDPB approves. The answer is B. The controller always bears the burden of proof. Question 4. 2 European regulators completely disagree on a cross-border privacy case. How is it resolved? A, they flip a coin. B, the company decides. C, the EDPB adopts a final binding decision under Article 65. D, the CJEU finds both. The answer is C. The EDPB steps in to ensure harmony. Okay, here are your key takeaways for today. First, the GDPR is a living ecosystem, not a static document. Second, the EDPB, born from Article 72, gives us the practical map, while the CJEU sets the final legal boundaries. And finally, the burden of proving compliance always falls on you, the controller. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer.
Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam or certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks for joining me, and I'll see you in the next explainer.
Welcome, everyone, to The Explainer. I am absolutely thrilled to have you here today because we're tackling one of the most critical, yet honestly most frequently misunderstood areas of privacy law. Today, we're demystifying the complex relationship between controller liability and administrative fines under the GDPR. If you've ever wondered how regulators jump from finding a seemingly small compliance gap to issuing a multi-million euro penalty, well, you are exactly in the right place. Okay, let's dive into this. What actually triggers a GDPR administrative fine? It's a pretty simple question, but it has a really layered answer. You know, a lot of organizations operate under this terrifying misconception that any tiny mistake automatically results in a maximum penalty. And then on the flip side, some think they can just hide behind their third-party software vendors. Misunderstanding how these enforcement actions are actually triggered can lead to some severe financial and operational consequences. So today, we're going to clear all that up using the actual guidelines in case law. Here's a quick look at our roadmap for today's explainer. First, we'll cover the cost of noncompliance. Then, we'll define controller liability, followed by lessons from the courts, and how administrative fines are actually calculated. After that, we'll do a practical knowledge check and wrap it all up with our key takeaways.
Section 1. The cost of noncompliance.
To really understand the penalties, we first need to understand the regulatory framework. We're talking specifically about Article 83 of the GDPR, which establishes the general conditions for imposing administrative fines. Now, under Article 83, the framework doesn't just throw out random, arbitrary numbers. It exists to ensure that fines are effective, proportionate, and dissuasive. Regulators are constantly having to balance the severity of a data protection failure against the practical realities of business operations. It basically gives supervisory authorities the teeth they need to enforce compliance, ensuring that ignoring the law is absolutely never cheaper than just following it in the first place.
Section 2. Defining controller liability and Recital 74.
Before a regulator can even calculate a fine, they have to figure out who to hand the bill to, right? That brings us to the vital importance of the accountability principle. Let's put this in plain English. Controller responsibility is the obligation to implement appropriate measures and, crucially, to be able to demonstrate that compliance. The controller is the entity that determines the why and the how of data processing. And here is the real kicker. You, as the controller, are ultimately on the hook for how that data is processed, even if you're using third-party cloud vendors or external marketing agencies. You literally cannot outsource your accountability.
Now, what's really interesting about this slide is how Recital 74 frames this exact obligation. It says the controller must implement appropriate and effective measures. This isn't just about, writing up a privacy policy, sticking it in a binder, and letting it gather dust on a shelf somewhere. This legal language translates to active, provable compliance. Regulators want to see that your measures actually work in the real world to protect people's data.
Section 3. Lessons from the courts. So we know the rules as they're written on paper, but how are they actually applied when push comes to shove? Well, two landmark cases, C-683/21 and C-807/21, completely clarified how these fines are applied. The courts determined that GDPR fines are not a strict liability trap. An administrative fine can only be imposed when an infringement is committed wrongfully, meaning it was done either intentionally or negligently. Think about it this way. If a company does absolutely everything right, implements state-of-the-art security, and still suffers a completely unforeseeable zero-day cyber attack, they aren't automatically slapped with a fine just because a breach happened. There has to be negligence or intent.
Let's move to and see how this builds. Section 4. Calculating administrative fines.
Once a regulator determines that you've been negligent, how do they actually come up with the euro amount? The European Data Protection Board, or the EDPB, has very specific guidelines for this. Regulators follow a highly logical step-by-step process. Step 1 is assessing the nature, scope, and intent of the infringement. Basically, how bad was it? Step 2 involves checking for multiple infringements. Did you break one rule, or did you break 5? And finally, Step 3 evaluates aggravating or mitigating factors. For example, did you actively cooperate with them? Do you adhere to an approved code of conduct? Or on the flip side, did you ignore previous orders from the regulator? All of this shifts the final fine up or down. And this brilliantly illustrates exactly how Step 2 works in practice, based directly on EDPB Example 3. Imagine an inspector visits a company. They find the company failed to provide privacy info to HR, they failed to secure their website, and they failed to report a vendor breach. These aren't just one big mistake rolled into one. They are a plurality of action. Because these are completely distinct failures, the regulator doesn't just issue one single capped penalty. No, they issue separate cumulative individual fines for every single specific failure.
Regulatory and enforcement perspective. When an investigation actually starts, what are the common mistakes organizations make? And what exactly are regulators looking for when they knock on your door? Listen, you do not want to be an outlier here. One of the most catastrophic compliance failures an organization can make is ignoring a prior corrective measure or an order from a data protection authority. If a regulator told you to fix something last year and they come back this year to find you just completely ignored them, under Article 83, that acts as a massive aggravating factor and those fines will absolutely skyrocket.
Mini case study. Let's ground all this theory in a realistic business scenario and look at how controller liability applies across borders. Here's our scenario. A Chinese e-commerce site actively targets customers in the European Union. They suffer a massive data breach because of terribly outdated security. Hoping no one notices, they completely fail to notify the regulators or the users. So, what happens here? Well, first, because they target EU customers, they are fully subject to the GDPR. Second, as the controller, they are liable for that poor security. And finally, because they failed to secure the data and failed to notify the authorities, we have a plurality of action. They are looking at severe, cumulative fines for negligent infringement. So the crucial point is, Section 5, Practical Knowledge Check. Knowing the text of the law is great, but it isn't enough. You really have to know how to apply it. Let's test your skills. Here is your scenario.
During a single audit, a data protection authority discovers a company failed to secure its website and failed to provide privacy notices to its employees. How are the fines applied? Is it A, one fine capped at the maximum, B, a warning only as it's the first audit, C, individual fines for each separate infringement, or D, fines are waived if a code of conduct is signed? Take a second to think about the legal principles we just discussed. If you guessed C, you're absolutely correct. Individual fines for each separate infringement. As per the EDPB guidelines, this is a classic plurality of action. Failing to secure a website and failing to give HR notices are not linked as a single processing operation. They are totally distinct actions, breaching different articles of the law, which means distinct cumulative fines.
Section 6. Key takeaways. We've covered an immense amount of ground today, from Recital 74 all the way to CJEU case law. Let's pull it all together to ensure you walk away with some truly actionable knowledge. Remember these 4 pillars. First, based on CJEU case law, regulators can't fine you just for bad luck. Fines require intentional or negligent infringement. Second, as a controller, you can't just be compliant in theory, you must actively prove it with effective measures. Third, distinct violations lead to separate stacking fines under the plurality of action rule. And lastly, never ever ignore a past DPA order unless you want to see your penalties multiplied. Which leaves us with one final provocative question for you to chew on. Are your organization's compliance measures truly effective, or are they just waiting to be tested by a regulator? If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thank you so much for joining me on this deep dive into controller liability and administrative fines. Stay curious, stay compliant, and I will see you in the next explainer. Have you ever wondered who actually pays the price when data processing goes horribly wrong? You know, when a massive breach hits the news or data is misused, somebody has to answer for it. Today, we're unpacking the heavy burden of accountability under the GDPR, specifically zeroing in on Recital 74. It is literally the beating heart of data protection liability. And honestly, understanding this is absolutely crucial, whether you're a privacy pro, a business leader, or even if you're just starting your compliance journey. Welcome back to the explainer. Here's a super quick roadmap of our accountability journey for today. 1. The controller's burden. 2. Decoding Recital 74. 3. Real-world scenarios. 4. Enforcement and case study. 5. A knowledge check. And finally, 6. Takeaways and next steps. It's a packed agenda, so let's jump right in. Section 1. The controller's burden. Let's start by defining exactly who is carrying the weight of GDPR compliance on their shoulders. So who bears the ultimate liability when data processing operations fail to protect individuals? This brings up a massive business problem because organizations so often misunderstand where the legal liability actually lands when a breach or privacy violation happens. It's incredibly common to see companies pointing fingers, right? They'll blame their software vendors, the IT department, or external partners, but the law is actually crystal clear about where the buck stops. And that brings us to the controller, defined right here in Article 4, Paragraph 7. In plain English, the controller is the ultimate decision maker. If your organization decides why personal data is being collected and how it's going to be processed, guess what? You're the controller. And because you hold that decision-making power, you hold the accountability. You can absolutely outsource the processing work, but you definitely cannot outsource the liability. Section 2, Decoding Recital 74. Now we're going to look at the practical obligations and the foundational text that guides all of this responsibility. What's really fascinating here is how this specific legal text lays the practical foundation for liability in European law. This is the official text of Recital 74, which gets frequently cited in major court of justice of the European Union rulings, like the famous Deutsche Wohnen case, that's C-807/21. Recital 74 essentially states that the responsibility and liability of the controller needs to be clearly established. It obliges the controller to implement appropriate and effective measures, and crucially, to actually be able to demonstrate that compliance. So let's translate that dense legal jargon into 3 highly practical steps. Step 1, you have got to implement effective security and privacy measures. Step 2, those measures must account for the nature, scope, and context of the processing, plus the actual risk to individuals. Basically, your security has to match your risk. And step 3, you must actively demonstrate compliance. It's not enough to just follow the rules in secret. You have to have the hard evidence to prove you're following them. Section 3, real-world scenarios. Let's take all this theory and see what it actually looks like out there in practice. Let's contrast 2 completely different approaches. Over on one side, we have a proactive tech company. They process thousands of user profiles, so naturally they implement risk-based security measures, robust encryption, and automated access logging. They're perfectly aligned with Recital 74. But on the other side, a classic compliance failure. An organization collecting highly sensitive data but totally ignoring the context. They use weak, shared passwords and keep absolutely zero documentation. When a breach inevitably happens, they have no evidence of protective measures, and that leads to severe penalties. Now, don't panic if you aren't a massive tech giant. Take a small business scenario, like a local bakery that just keeps a mailing list. The GDPR does not demand the impossible. It just demands measures that are appropriate to your specific context. So a local shop needs strong passwords, maybe multi-factor authentication, and basic access logs. They do not need million-dollar enterprise security software. It is all about scaling the level of protection to the actual risk involved. Section 4, Enforcement and Case Study. If you're the controller, how do regulators actually evaluate your compliance when they come knocking? Let's dive in.
Looking impartially at recent court rulings tells us exactly what regulators are hunting for. Take the Punky's S case, C579/21, where an employee queried their own data in the company system. The court ruled that employee log data, which shows exactly who accessed data and when, is vital. It proves whether data was processed lawfully under the controller's direct instructions. Meanwhile, over in the Deutsche Vennen case, C807/21, we see that massive administrative fines can be levied directly against the corporate entity itself for failing to implement structural compliance policies. And this brilliantly illustrates how enforcement can actually overlap between entirely different types of regulators. Just look at this timeline. You begin processing data. Then an investigation kicks off. Interestingly, as we saw in the Meta case, C252/21, even national competition authorities can investigate GDPR compliance if they're trying to establish an abuse of a dominant market position. Sure, they have to sincerely cooperate with the lead data protection authorities, but it goes to show that privacy noncompliance can trigger antitrust issues, which can ultimately lead to those massive administrative fines we saw in C807/21. The enforcement net is way wider than most people think.
Section 5, Knowledge Check. All right, it is time to test your skills with a few scenario-based, certification-style questions to make sure we've locked down these core concepts. Treat this like a real exam.
Question 1. Regulators knock on your door and request proof that your processing operations are lawful. Under Recital 74, who is primarily responsible for providing this demonstration? Is it A, the processor, B, the data subject, C, the controller, or D, the data protection officer? Take a second to think it over. And the answer is C, the controller. You see, while a data protection officer advises and a processor acts on behalf of someone else, Recital 74 places the burden of implementing and demonstrating compliance squarely on the controller. They are the ultimate decision maker. Moving on to question 2. An HR platform uses basic, easily guessable passwords to secure highly sensitive employee health data. What Recital 74 requirement did they primarily fail? A, accounting for nature and risk, B, territorial scope, C, data portability, or D, joint controllership. Lock in your answer. The answer is A, accounting for nature and risk. Remember, appropriate measures are always relative. Health data carries a huge risk to individuals' rights and freedoms. So, basic passwords, they simply do not cut it. Question 3. According to case C57/21, that's the Panky Cess case, what specific evidence must a controller be able to provide to demonstrate that processing was genuinely carried out under its authority? A, source code, B, employee log data, C, marketing budget, or D, server locations. What do you think? The answer is B, employee log data. Logs are basically the digital footprint of processing. They allow both the controller and the data subject to verify exactly who accessed the data, proving that actions were taken lawfully and strictly under the controller's instructions. And our final question, question 4. Based on the Meta case, C252/21, if a national competition authority finds a GDPR breach to establish market abuse, does that competition authority replace the GDPR supervisory authority? A, yes, B, no, they must cooperate, C, only for tech companies, or D, yes, if fines exceed 20 million euros. Think about it. The correct answer is B. No, they must cooperate. The court ruled that while a competition authority can absolutely examine GDPR compliance to establish market abuse, they are bound by a duty of sincere cooperation. They have to work hand in hand with the lead data protection supervisory authority to ensure everything stays consistent. Section 6, takeaways and next steps. Excellent job on the knowledge check, guys. Let's go ahead and wrap up with our essential lessons extracted from Recital 74 and those major court cases. So here are your key takeaways. First, if you determine the purpose and means of processing, you hold ultimate accountability. Second, your security measures absolutely must scale to the actual risk. Third, you must actively demonstrate compliance by maintaining concrete evidence, like access logs. And finally, remember that enforcement spans multiple regulatory bodies. If you enjoyed these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I'll leave you with this one thought. If regulators knocked on your door today, would your documentation actually prove your compliance or just highlight your vulnerabilities? See you at the next explainer.
Welcome back to Privacy Trainer. If you've ever felt completely bogged down by dense data protection jargon, well, you are definitely in the right place. Today, we're demystifying privacy risk and accountability. And you might be wondering, why should we care about this? Well, what happens if you get this wrong? It's simple: real-world harm for your users and massive, massive fines for your organization. So let's translate all that legal theory into clear, actionable steps you can actually use. Okay, let's dive right into this. Misunderstanding GDPR risk isn't just some minor paperwork error. Notice how Recital 75 explicitly points out that processing personal data doesn't just happen in a vacuum. It carries real risks of varying likelihood and severity that can potentially cause physical, material, or non-material damage to actual people. This right here, this is the foundational problem these laws are trying to solve. So here's our quick agenda for today's explainer. We'll cover the accountability framework, defining privacy risks, some compliance examples, an enforcement case study, a privacy knowledge check, and finally, key takeaways. Let's kick things off with Section 1, the accountability framework. The core rule of accountability is actually pretty straightforward. If you collect the data, you own the risk. Recital 74 clearly states that the controller absolutely must implement measures that take the specific risks to natural persons into account. You know, it's not enough to just draft a shiny privacy policy, post it on your website, and call it a day. No way. You've got to implement appropriate technical measures, and crucially, you must be able to demonstrate that those measures actually work in practice. Moving on to Section 2, defining privacy risks.
But what exactly do lawmakers mean when they throw around the phrase risk to rights and freedoms? Well, Recital 75 translates that abstract concept into practical reality. Lawmakers are highly concerned about data processing that leads to things like discrimination, identity theft, financial loss, or damage to someone's reputation. And they are equally worried about the unauthorized reversal of pseudonymization. Basically meaning if you strip names from a dataset but leave enough breadcrumbs to identify someone later on, that risk is still very much alive.
Which brings us to Section 3, Real-World Compliance Examples. Let's look at how all these rules apply in the real world. This breakdown brilliantly illustrates the difference between treating privacy as a total afterthought versus building it in by design. On the left side, reactive compliance is your classic failure scenario. It's like a small business that only decides to encrypt their data after a breach has already happened. At that point, it's just too late. On the right side, Article 25 requires data protection by design. This is like a smart tech company building data minimization into their architecture from day one. Retrofitting privacy? It simply doesn't work. Let's get into Section 4, Enforcement and a mini case study. All right, I want you to put yourself in the shoes of a regulator for a second. Imagine your organization faces this exact scenario. Step 1, the challenge. You're launching a brand new AI tool. Step 2, the privacy issue. The tool sucks up excessive user data by default just to train its models. Step 3, the regulatory analysis. Regulators are going to look straight at Article 25 and Recital 75. They'll ask, did you assess the risk beforehand? Did you ensure only strictly necessary data was processed by default? Because if you didn't, you were staring down a massive compliance failure. During an investigation, regulators heavily weigh the technical measures you already had in place. Under Article 83, administrative fines are calculated based on the nature, gravity, and duration of the infringement. Was it intentional, or were you just negligent? Crucially, regulators actively look at what actions you took to mitigate the damage for the user, and how robust your baseline security controls were. Good faith efforts to fix things can drastically reduce your liability. Section 5, Privacy Knowledge Check. It's time to see what we've learned with 4 certification-style questions. Question 1 tests the foundational obligations of the controller. According to Recital 74, a controller's appropriate and effective measures must take what into account? Is it A, only the cost of implementation, B, the nature, scope, context, purposes, and risk to rights and freedoms, C, the size of the company's legal team, or D, the marketing objectives of the processor? Think about it for a second. And the correct answer is B. Accountability requires a truly holistic assessment of the processing context and risks. You absolutely cannot look at cost or marketing goals in total isolation. You have to evaluate the nature, scope, context, and purposes, right alongside the genuine risk to the fundamental rights of the people whose data you hold. All right, let's move to question 2, which is all about identifying specific risk scenarios. Under Recital 75, which scenario explicitly represents a risk to rights and freedoms? A, processing publicly available corporate contact data. B, anonymized statistical counting. C, evaluating personal aspects to create personal profiles. Or D, deleting user accounts upon request. The answer here is C. Lawmakers specifically highlighted profiling as a significant potential harm to individuals. When you analyze someone's health, their economic situation, reliability, or even their location to build a profile, the severity of potential harm, like discrimination or loss of confidentiality, absolutely skyrockets. Let's tackle question 3, looking at the enforcement side of things. When calculating administrative fines, what is considered a mitigating factor under Article 83? A, the intentional character of the infringement. B, actions taken by the controller to mitigate the damage suffered by data subjects. C, the high profitability of the processing. Or D, hiding the breach from the supervisory authority. If you guessed B, you are spot on. Regulators actively look at how quickly and effectively you responded to protect users after an incident. An intentional breach, or worse, trying to hide a breach, are massive aggravating factors. But proactive damage control, that demonstrates the accountability framework in real action. Finally, question 4 covers some vital case law regarding compliance documentation. Based on CJEU case C60/22, does the mere absence of a record of processing activities automatically give a data subject the right to erasure? Is it N, yes, all documentation failures are unlawful processing, B, no, unless it also infringes the core principle of accountability, C, yes, but only for special categories of data, or D, no, Article 30 is voluntary? And the answer is B. The CJEU ruled that a missing record alone doesn't violate fundamental rights unless the overall accountability framework completely fails. This is a super important distinction. Administrative errors are obviously bad, but the courts are ultimately looking at whether you failed the broader principle of protecting the data subject's rights. Let's wrap things up with Section 6, Key Takeaways and Support. Let's lock in the most important lessons you should be applying in your daily practice. To summarize, risk isn't abstract. It is all about real harm. Proving your accountability through proactive design is hands down your best defense. Remember, accountability is a continuous life cycle. It's not a one-and-done checklist. The risks outlined in Recital 75, things like identity theft and discrimination, are what you are actively defending against. Article 25 makes data protection by design mandatory, and when things inevitably go wrong, regulators will heavily weigh your proactive mitigation efforts. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and certification prep resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Before we sign off, ask yourself, if a regulator walked into your office today, could you truly prove your technical measures match your data risks, or are you just relying on a paper policy? A quick disclaimer. This content is provided for educational purposes only and does not constitute legal advice. Keep learning, keep protecting data, and we will see you in the next explainer.
Welcome to Privacy Trainer. I am absolutely thrilled to have you here today. We're diving into something that literally affects almost every single organization operating in the digital space. You know, with how fast tech is developing, data collection is seamless. Honestly, it's almost too seamless. Because of that, it is incredibly easy to accidentally violate GDPR rules without even realizing it. So today, we're going to decode some of those dense Court of Justice of the European Union rulings and turn them into actionable, practical insights for you.
So let me start by asking you a really simple question. Does a pre-ticked box count as user consent? If you're a privacy professional, a business leader, or really anyone dealing with digital marketing, you absolutely need to know the definitive legal answer to this. Lock in your guess right now in your head, because the courts have a very strong opinion on it. And getting it wrong, well, that could literally cost your organization millions.
Okay, here's our agenda for today's explainer. 1. Defining personal data context. 2. The high bar for consent. 3. Accountability and lawful processing. 4. Fines and enforcement powers. 5. A quick certification knowledge check. And 6. Key takeaways and support.
Section 1. Defining personal data context. Right. Before we can actually protect data or establish a lawful basis for processing it, we have to understand exactly what the courts consider personal data today. And spoiler alert, it's way broader than you might think. Let's take the Breyer case, C582/14. The Court of Justice ruled that even dynamic IP addresses stored by an online media provider are in fact personal data. Why? Well, because the provider had the legal means to identify the user by combining that IP address with other info held by the internet service provider. It's like a giant puzzle. You can't just wave back-end identifiers away and say, oh, it's just anonymous system data. It doesn't work like that. And this brilliantly illustrates why definitions matter so much. Recital 6 of the GDPR specifically warns us that rapid tech developments, think connected vehicles, smart cities, mobile apps, have increased the scale of data collection exponentially. We're talking massive amounts of data. And that unprecedented scale is exactly why our definition of personal data has to be incredibly comprehensive.
Section 2. The high bar for consent.
Now, this right here is the core conflict for a lot of businesses. How would we actually get a valid legal basis to process all this data? Let's look at Article 4, Paragraph 11. For consent to be valid, it has to be a freely given, specific, informed, and unambiguous indication of what the user wants. In plain English, that means an active, explicit, affirmative action. On the flip side, silence, inactivity, or pre-ticked boxes, those are completely invalid. The law expressly precludes passive consent. It literally requires the user to do something.
Let's make this concrete with a real-world example. Enter the Planet 49 case, C67317. So this company was running an online promotional lottery, right? And they used a pre-ticked checkbox for users to consent to cookie storage. The CJEU was incredibly clear here. They hit the nail on the head and ruled that a pre-ticked checkbox is absolutely not valid consent. You need active consent. You cannot just presume a user wants something simply because they didn't untick a box that you conveniently ticked for them in the first place. And it goes even deeper. Take a look at the Orange Romania case, C61/19. Here, a mobile telecom provider collected copies of customers' ID documents, claiming, hey, they consented. But here's the catch. The consent was basically buried in standard contract terms, with boxes already checked by the sales agent. The court hammered home that this completely violates the freely given and informed requirements. You absolutely cannot bury consent to copy ID documents inside standard paperwork and just call it a day. No way.
Section 3, Accountability and Lawful Processing. Okay, we're shifting gears a bit to the broader concept of accountability. Because under the GDPR, compliance isn't just about what you do, it's heavily about what you can formally prove you do. Let's look at the nuance in case C60/22. This is regarding Article 26 on joint controllers and Article 30 on records of processing activities. The ruling clarified that yes, failing to maintain these records is a violation of your accountability obligations, but interestingly, it doesn't automatically mean the underlying data processing itself is unlawful under Article 6. So an administrative failure doesn't necessarily invalidate your legal basis, but it absolutely exposes you to penalties.
So the crucial takeaway here is that the accountability principle, which is Article 5.2, demands you proactively structure your data governance. It's really a 3-step process. Step 1, establish your lawful basis under Article 6. That could be consent, contract performance, legitimate interest, whatever fits. Step 2, maintain your Article 30 records to document exactly what you're doing. And Step 3, if you're working with partners, conclude your joint controller arrangements under Article 26. You literally have to build this architecture before you even start processing data.
Section 4, Fines and Enforcement Powers. So what happens if you get this wrong? Well, the stakes are absolutely massive. Under Article 83, the maximum administrative fine for violating these core principles, like consent or lawful processing conditions, can reach up to 20 million euros, or up to 4% of a company's total worldwide annual turnover from the preceding financial year, whichever is higher. And yes, to put that into perspective, they mean the entire company's global turnover, not just the one little subsidiary that made the mistake. This is a structural, whole business risk. Now, you might be wondering, how do regulators actually arrive at those massive numbers? Well, the European Data Protection Board, or EDPB, gives them strict guidelines. Regulators look at the gravity of the infringement, any previous violations, and your degree of cooperation with them. They also look at the specific categories of personal data affected. And this is super important. Human error, or simply failing to read and follow your own internal policies, can be heavily penalized as negligence. You can't just throw your hands up and claim ignorance.
Section 5, Certification Knowledge Check. All right, it's time to see how well you've absorbed these cases. Treat this like a real professional privacy certification exam. Here's your scenario. A tech company runs an online lottery. To enter, users must leave a pre-ticked box checked that allows tracking cookies. Is this valid consent? A, yes, if it's clearly visible. B, no, it requires active behavior. C, yes, if it's a free lottery. D, only if the data is pseudonymized. Take a second. Lock in your answer based on the case law we just went through. And the correct answer is B. No, it requires active behavior. As we saw in the Planet 49 case, the CJEU specifically ruled out silence, pre-ticked boxes, or any form of inactivity. Valid consent literally requires a clear, active, affirmative action. Huge congrats if you got that one right. Section 6, Key Takeaways and Support. Okay, we've covered a ton of dense legal ground today. So let's distill the whole shebang into 4 critical takeaways for you. Number 1, IP addresses, even the dynamic ones on the back end, are personal data, thanks to the Breyer ruling. 2, Consent demands active, unticked boxes. No passive agreements allowed. 3. True accountability means you have to maintain formal records of processing and joint controller agreements. And 4. Failing to follow your own internal policies? Regulators will view that as negligence when they're calculating your fines. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale this education globally. Also, if you're looking for more structured privacy, security, or AI training, which includes guided learning paths, workshops, practice questions, and certification exam prep resources, you can definitely explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available right here, while privacyuni.com is really designed for learners who prefer a more structured, comprehensive learning experience. And of course, a quick disclaimer, this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes, so always consult your own legal counsel for specific guidance. I want to leave you with this final, somewhat provocative thought. Are your digital consent forms silently violating the law right now? Seriously, take a hard look at your organization's cookie banners and contract checkboxes today. Thanks so much for joining me on this explainer, and I'll see you in the next one. Have you ever felt that complete sense of powerlessness when a company just totally mishandles your personal data? You know the feeling. You send an email asking them to delete your account or stop tracking you, and you get absolutely nothing back but radio silence. In the digital age, it really can feel like a David versus Goliath battle. But what if I told you that under the GDPR, David doesn't just have a slingshot, he actually has a direct line to a massive regulatory army? In this explainer, we are breaking down Article 77 of the GDPR to make privacy law practical and accessible. And honestly, this article is the ultimate shield and megaphone for individuals. It solves that frustrating problem of corporate unresponsiveness by giving everyday people a direct, free, and incredibly powerful line straight to the regulators. If organizations misunderstand the sheer force of this article, they aren't just risking a little bad PR, they're risking intense, full-blown regulatory scrutiny. Okay, let's look at our roadmap for this explainer really quickly. We'll start with an overview of the article, dive into its practical application, look at things from the regulator's perspective, run through a mini case study, and wrap it all up with a quick knowledge check. All right, Section 1, the article overview. Let's figure out exactly what this piece of the GDPR actually is. So Chapter 8 of the GDPR is really all about remedies, liability, and penalties. And Article 77 is basically your gateway into all of that. Let's look at the actual legal text. It states, without prejudice to any other administrative or judicial remedy, every data subject shall have the right to lodge a complaint with a supervisory authority. Okay, let me translate that legal speak into plain English for you. It simply means that if you believe a company is mishandling your data, you have the absolute right to complain directly to a data protection authority or DPA. You do not need to hire an expensive lawyer. You don't need to drag anyone into court. You just need to reach out to the regulator. Lawmakers intentionally designed it this way to make sure privacy rights aren't just some theoretical concept for the wealthy, but a practical, accessible tool for literally everyone. Now, here's where it gets really interesting. Recital 142 expands this power significantly. Because, let's be real, not everyone has the time or the legal expertise to file a formal regulatory complaint. Recital 142 recognizes that, so it allows privacy advocacy groups, specifically mandated not-for-profit bodies active in data protection, to step in and file these complaints on your behalf. Think about organizations like NOIB in Europe. If you mandate them to do so, they can legally champion your cause for you. It's a total game changer that completely levels the playing field against massive multinational corporations. So how does this actually play out? It's basically a simple 4-step life cycle showing how a complaint travels from your desk to the regulator. Step 1, you file the complaint in your own home country, specifically the member state of your habitual residence, your place of work, or where the alleged infringement actually happened. Step 2, the supervisory authority receives your complaint and investigates. Step 3, under Article 77, Paragraph 2, they are legally required to keep you informed on the progress and the outcome. And finally, Step 4, if they fail to update you within 3 months, or if you completely disagree with their legally binding decision, Article 78 steps in and gives you the right to an effective judicial remedy against the regulator itself. The whole system is designed to keep absolutely everyone accountable. Moving right along to Section 2, Practical Application. Let's look at how this plays out in the real world. This article applies universally, literally across the board. Take a massive tech company, for example. Let's say a data broker completely ignores a user's deletion request under Article 17. The user doesn't just have to give up. They can fire off an Article 77 complaint and immediately trigger a DPA investigation. Or consider a small business, like a local shop that keeps spamming a customer's email without their consent. That customer can complain to their local DPA, and that shop might get hit with a reprimand or a fine. Finally, look at a major compliance failure. A company tries to sweep a data breach right under the rug. Well, an employee or any data subject affected can act as a whistleblower, file a complaint, and the DPA is going to be knocking on that company's door very soon. And the consequences, they will be severe. But of course, organizations still stumble here. In fact, there are a few really common critical mistakes. First, companies often assume individuals have to go through expensive court battles to get any kind of resolution. As we've just seen, they definitely don't. Second, companies ignore user complaints because they arrogantly assume DPAs are just too understaffed to bother investigating. Let me tell you, that is a wildly dangerous gamble. And third, and this is a very common compliance failure, they just outright forget to explicitly list the right to complain to a supervisory authority in their privacy policies. Articles 13 and 14 of the GDPR strictly require you to tell users about their Article 77 rights at the exact moment you collect their data. Make no mistake, if it's missing from your privacy notice, you are already in violation. Okay, Section 3, the regulator perspective and case law. Let's see how DPAs handle these things. Now, regulators, they can't simply ignore the complaints they receive. This was heavily reinforced by the Court of Justice of the European Union in case C311/18. You'll often hear this referred to in the context of the Schrems litigation. The court made it crystal clear. DPAs are legally obligated to investigate the subject matter of a complaint with all due diligence. They can't just arbitrarily toss a complaint in the bin because they're busy. They have a strict duty to act, to examine the nature of the complaint, and to maintain documented evidence of their process. This means businesses should absolutely expect that when a user complains, the regulator will be following up. And this brings us to a massive, really recent ruling that absolutely every privacy professional needs to know about. CJEU case C414/24.
This clarifies the relationship between Article 77, complaining to a DPA, and Article 79, which is suing a company directly in civil court. The court ruled that these are parallel concurrent rights. What does that mean for you? It means a regulator cannot reject your complaint just because you happen to also be suing the company in court for the exact same issue. Both paths can run at the exact same time. So for an organization, you cannot use a pending lawsuit as an excuse to get a DPA to just drop their regulatory investigation.
Let's put this all together in Section 4 with a mini case study to really ground these concepts. All right, walk with me through this scenario step by step. Imagine a user finds out a company has been secretly sharing their highly sensitive health data with third-party marketers. Naturally, the user is furious. So in step 2, they hire a lawyer and sue the company in civil court under Article 79. But they don't stop there. They also file a regulatory complaint with their local DPA under Article 77. Now in step 3, the DPA is overwhelmed with work and tries to pause or reject the complaint, saying, hey, a judge is already looking at this, we'll wait. But as we see in step 4, based on that recent case law we just covered, the DPA is forced to proceed anyway. The business challenge here is immense. The organization must now defend itself on 2 fronts simultaneously, fighting a civil lawsuit in court while also responding to a formal regulatory investigation that could easily lead to massive administrative fines.
All right, time for a quick GDPR knowledge check to test your practical understanding. Question 1. Read the scenario carefully. A user sues a controller and simultaneously files a DPA complaint about the exact same issue. Under recent CJU case law, what must the DPA do? Is it A, reject the complaint, B, proceed with the complaint, C, find the user, or D, transfer it to the court? Think about those parallel paths we just talked about. Did you pick B? If so, you hit the nail on the head. Because, as we learned from case C414/24, these remedies are entirely independent and concurrent. The supervisory authority cannot just abdicate its responsibility to investigate simply because a judge is also looking at a civil claim for the same infringement. Here's question 2. This one tests your knowledge on the jurisdictional flexibility that Article 77 grants to individuals. Where does Article 77 explicitly state a data subject can lodge their complaint? A, only where the controller is headquartered, B, only in Brussels, C, habitual residence, place of work, or place of infringement, or D, any global privacy office? The correct answer here is C. And honestly, this is a huge part of the whole empowerment narrative behind the GDPR. Individuals can file in their own home country, which makes the process highly accessible. They don't have to book a flight to Ireland or Luxembourg just because some tech giant is headquartered there. They complain right to their local data protection authority in their own language. Moving on to question 3. Let's see if you remember that specific standard of accountability imposed on regulators by the CJEU. What is a supervisory authority's legal obligation when receiving an Article 77 complaint? Per case C311/18. A, forward it to the controller, B, handle it with all due diligence, C, publish it online, or D, charge a filing fee. And the answer is B. This really highlights that regulators are strictly bound to investigate complaints appropriately. They must handle each and every one with all due diligence. They can't arbitrarily dismiss them, which means organizations absolutely cannot rely on DPAs being too busy to investigate user complaints. All right, final question. Think about who else can wield the power of Article 77 on an individual's behalf. According to Recital 142, who can lodge a complaint on behalf of a data subject? A, only a certified lawyer. B, a mandated not-for-profit body in the field of data protection. C, any family member. Or D, a competing business. The correct answer is B. It's such a powerful mechanism, showing how privacy advocacy groups can champion the rights of everyday individuals who might otherwise feel totally intimidated by the legal and regulatory process. It basically turns individual complaints into collective, highly organized regulatory action. So, to wrap this all up, Article 77 is literally the ultimate tool of empowerment for data subjects. It creates a strict loop of accountability that neither companies nor regulators can ignore. Our key takeaways are, first, individuals have a free, completely unrestricted right to complain directly to a DPA in their home country. Second, mandated nonprofits can do this on their behalf. Third, DPAs are legally required by the highest courts to act on these complaints with all due diligence. And finally, complaining to a DPA under Article 77 is concurrent with suing a company in court under Article 79. Both can happen at the exact same time. Hey, if you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale that education. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam prep resources, you can explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is really designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Now, before we go, I want to leave you with a final, slightly provocative thought to take back to your teams. How well is your organization actually prepared to respond if an empowered, frustrated user exercises both their Article 77 and Article 79 rights simultaneously tomorrow morning? Could your compliance team handle a lawsuit and a DPA investigation at the exact same time? Thanks for joining me on this explainer, and I'll catch you in the next one. Hey everyone, let's kick off this explainer with a pretty massive question about the balance of power in data protection. We spend a ton of time talking about how organizations have to comply with the GDPR and how supervisory authorities, our privacy regulators, enforce all those rules. But seriously, who watches the watchdogs? What happens if a regulator abuses its immense power, completely misinterprets the law, or just straight up ignores your totally valid privacy complaint? Well, that is exactly the problem that GDPR Article 78 is designed to solve. It is essentially the ultimate democratic safeguard built right into European data protection law. Here's our roadmap for today. We're going to hit the watchdogs, decode the legal text, check out recitals and case law, walk through scenarios and mistakes, dive into a case study, and wrap it all up with a knowledge check. Let's get to it. Section 1, the watchdogs. This is all about oversight for the overseers.
So, we're starting our journey by looking at why regulators themselves actually need oversight. Supervisory authorities possess a massive amount of power. But what on earth happens when they just get it wrong? Picture this. Your personal data gets breached in a huge way, but the regulator just formally dismisses your complaint without even doing a proper investigation. Or on the flip side, imagine you're a business leader and the regulator slaps you with a gigantic fine based on a completely flawed understanding of the technology you're using. You absolutely need a way to fight back, right? And that's exactly where Article 78 swoops in. The crucial point here is that Article 78 provides an effective judicial remedy against the watchdogs themselves. It guarantees your right under European law to literally take a data protection authority into a national court. It completely levels the playing field, making sure that these powerful regulators are actually held accountable to the very same laws they enforce.
Moving on to Section 2, decoding the legal text. Let's look at the actual mechanics of Article 78.
Okay, so looking at the way paragraphs 1 and 2 are laid out in the text, it's actually pretty brilliant. Paragraph 1 explicitly grants you, whether you're a natural person or a legal entity, the right to an effective judicial remedy against any legally binding decision from a regulator. But paragraph 2, that's the real kicker for individuals. It says that if you file a complaint and the regulator basically ghosts you, if they don't handle it or fail to inform you of any progress within 3 months, you can take them to court. They literally cannot just leave you on read. Now hold on, because you really need to nail this definition down. The whole right to appeal completely hinges on whether the regulator's action is actually a legally binding decision. So what does that mean? It means the decision produces real legal effects concerning you. As the sources outline, we're talking about the exercise of investigative powers, corrective powers like massive fines or authorizations, or formally throwing out your complaint. So here's the crucial split you've got to remember. On one side, you've got binding decisions, fines, bans, dismissed complaints. You can totally appeal these under Article 78. But on the other side, non-binding measures. Think general guidance, friendly advice, or an official opinion issued by the regulator. You cannot use Article 78 to sue a regulator just because you happen to disagree with their general advice. It absolutely has to be a legally binding action directed right at you.
All right, Section 3, recitals and case law. Let's do a little reality check. To really see how this plays out in practice, we've got to look at recitals 141 and 143, alongside how the European courts actually interpret them. These recitals basically translate all that dense legal jargon into the real world. For instance, recital 143 makes it super clear that you bring these proceedings to the courts in the member state where the authority is set up. It also double downs on the fact that you can't appeal non-binding measures. But honestly, the most important takeaway here is that national courts have to exercise what's called full jurisdiction. And this quote from the recent Court of Justice of the European Union, case C-2622, nails exactly what full jurisdiction actually means. It means the courts don't just do a quick vibe check to see if the regulator stamped the right administrative forms. They don't just rubber stamp the decision. No, they roll up their sleeves and fully review all the facts in the law. If a regulator's decision is challenged, the national court digs right into the actual evidence to figure out if the regulator made the right call. Let's jump into Section 4, scenarios and mistakes. This is how Article 78 applies out in the wild. Okay, so where do organizations and individuals usually mess this up? Here are the most common slip-ups. First off, trying to appeal general advice. Like we said, save your legal budget. You can only appeal binding decisions. Second mistake, waiting forever for a regulator to update you on a complaint. Remember, Article 78, Paragraph 2 is your best friend here. If 3 months go by with crickets, you can sue. And the third big mistake is just assuming the regulator has the absolute final say. Spoiler alert, they don't. The courts do. Let's put this into practice with a few scenarios. Say you're a big tech company. For you, this might look like appealing an unfair ban on data transfers because the regulator completely botched the technical assessment. Or maybe you're a small business and you're fighting back because a regulator prematurely tossed out a complaint you made against a massive vendor. And as for the regulators themselves, a huge compliance failure on their end is simply ignoring that 3-month statutory response window. Doing that basically rolls out the red carpet for an immediate judicial review. Section 5, case study and enforcement. Let's break this down step by step. All right, let's walk through a realistic mini case study to see how a dispute unfolds from start to finish. Imagine a user hits a company with a really complex data access request, and the business just flat out refuses. So the user files a complaint with the supervisory authority. But the regulator, maybe they're super swamped, they just dismiss this totally valid complaint without even really looking at the facts. So does the user have any options? Absolutely. The user immediately files an appeal against the regulator under Article 78 in their national court, which forces a full judicial review of that dismissed complaint. Now look at this from an enforcement angle. Just knowing that their decisions can be dragged into court forces regulators to be incredibly strict about following procedures. For your organization, this means keeping meticulous, rock-solid records is literally your best defense. When a regulator's decision gets escalated to a national court, that court is going to heavily scrutinize the evidence. So if your internal policies and security measures, like all those Article 32 requirements, are well documented, you're handing the court the exact facts they need during that full jurisdiction review. Almost at the finish line, Section 6, knowledge check and takeaways. Let's test what we've learned. Okay, let's see how you do with a classic certification-style question. Read the scenario carefully. A regulator issues an official opinion advising against your company's brand new AI processing, but they don't actually impose a formal ban or fine. Can you appeal this opinion under Article 78? Is it A, yes immediately, B, yes if it impacts revenue, C, no, it is not a legally binding decision, or D, only after 3 months? Lock in your answer. And the correct answer is C. Remember our golden rule? Because the regulator only issued an opinion and didn't drop a formal ban or corrective measure on you, it is simply not a legally binding decision. So Article 78 does not apply here. You can't sue a regulator just because they gave you some advice you weren't a fan of. So to wrap this all up, here are the big takeaways you need to remember. First, Article 78 provides essential democratic oversight over the privacy watchdogs. Second, these appeals apply strictly to legally binding decisions, not just general opinions. Third, it protects individuals by allowing them to sue if a regulator ignores their complaint for 3 months. And finally, national courts have full jurisdiction. They look at both the facts and the law, ensuring regulators absolutely do not have unchecked power. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone.
Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available right here, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Always consult a legal professional for your specific compliance needs. But hey, keep learning, stay curious, and ask yourself, in a world increasingly driven by data, are we doing enough to ensure the overseers themselves are held accountable? Thanks for joining me, and I'll catch you in the next explainer. Welcome to today's explainer. Today we're tackling a piece of the GDPR that completely flips the script on the balance of power. We are digging into Article 79, which covers the right to an effective judicial remedy. This is essentially the mechanism that empowers everyday people to take direct civil legal action against organizations. It is a really big deal, so let's dive right in. So picture this scenario for a second. Your personal data gets swept up in a massive breach, or maybe you find out some company is unlawfully tracking you online. You do exactly what you're supposed to do, right? You file a complaint with your local data protection authority. But what happens when that regulator is just incredibly backlogged? Do you just sit around waiting for months or maybe even years while your privacy rights are actively being violated? Well, the answer is a resounding no. Enter Article 79. I actually like to think of this as the individual's direct action superpower, because it allows data subjects to completely bypass those frustrating regulatory bottlenecks and drag a controller or processor straight into court. For privacy pros and business leaders, misunderstanding how this works is a huge risk. It can honestly lead to a total nightmare of unexpected cross-border litigation. To make sure your organization doesn't get caught off guard, here's our quick roadmap for today. First, we'll decode the text of Article 79 itself. Then we'll compare the regulatory route versus the court routes. We will explore the home court advantage, look at the dual track threat using some recent case law, walk through a realistic case study, and then wrap it all up with your key takeaways. Section 1. Decoding Article 79. Let's look at how this builds the legal foundation for the right to sue. The precise wording of Article 79, paragraph 1 is super important to get right. It states, without prejudice to any available administrative or non-judicial remedy, including the right to lodge a complaint with a supervisory authority, each data subject shall have the right to an effective judicial remedy where he or she considers that his or her rights under this regulation have been infringed as a result of the processing of his or her personal data in non-compliance with this regulation. Okay, let's translate that dense legal jargon into plain English, because it's actually pretty straightforward. An effective judicial remedy simply means an individual has the undeniable legal right to directly sue your organization in civil court for a GDPR violation. Lawmakers included this because they wanted to ensure our fundamental rights weren't just theoretical. If someone's data is misused, they don't have to wait for a regulator's permission to seek justice. They literally hold the keys to the courthouse themselves. Section 2. Regulator versus the court. How exactly does this civil court action compare to the standard process of just filing a privacy complaint? The absolutely crucial thing to understand here is that Article 77 and Article 79 represent two entirely different battlegrounds. Under Article 77, an individual files a complaint with the Data Protection Authority. That is an administrative process. The DPA investigates, and maybe it eventually leads to regulatory fines, but those fines go to the government, not the individual. Under Article 79, though, the individual is filing a direct civil lawsuit. This judicial remedy usually goes hand in hand with Article 82, where the individual is going after direct financial compensation for damages they personally suffered. Moving on to Section 3, the home court advantage. If you're running a business, you might be thinking, okay, sure, but if they want to sue us, they have to come to the country where our headquarters are located, right? Well, not exactly. Let's talk about jurisdiction. To really grasp why, we need to look at Recital 145, which helps interpret the article. It explicitly says that the plaintiff should have the choice to bring the action before the courts of the member states where the controller or processor has an establishment or where the data subject resides. Lawmakers were very intentional here. They handed the jurisdictional power directly to the consumer. Article 79, paragraph 2 specifically ensures data subjects can sue in their own home country. And why does this matter so much? Because if you force a normal citizen to travel, hire foreign lawyers, and try to navigate a totally foreign legal system, you essentially kill their right to a remedy. It's just too expensive and complicated. But for businesses, this means if you offer services across the EU, you have to be ready to defend a civil lawsuit in the local courts of literally any member state where your users happen to live. Section 4, the dual track threat and case law. This is where we run into probably the most dangerous misconception organizations have about this entire process. A major question businesses always ask is, hey, if an individual files a complaint with a regulator, doesn't that pause their ability to sue us in court? For the answer to that, we have to look at recent case law, specifically CJEU case C414/24. The courts have been dealing heavily with this exact clash of parallel remedies. Let's break down these rulings because it's pretty fascinating. In cases C132/21 and C414/14, the CJEU confirmed that the remedies under Article 77 and Article 79 can be exercised concurrently and independently, meaning an individual doesn't have to choose one or the other. They can attack you on both fronts simultaneously. On top of that, cases like C340/21 and C741/21 clarify that while a mere technical infringement of the GDPR isn't enough to get compensation, non-material damages definitely are. That includes things like a well-founded fear that data might be misused after a breach. That fear alone can give rise to a valid claim. Section 5, mini case study and practical application. Let's take these dense legal concepts and plug them into a highly realistic everyday business scenario. Imagine a medium-sized enterprise. We'll call them Techco, suffers a data breach. A user in Spain finds out their data was exposed. Step 1, the user is rightfully angry. Step 2, they file an Article 77 complaint with the Spanish DPA, which kicks off a long regulatory investigation. But they don't stop there. Step 3, exercising their Article 79 rights, they simultaneously file a civil lawsuit in their local Spanish court, claiming non-material damages for the fear of identity theft under Article 82. So now, Step 4, Techco, which might be headquartered all the way over in Germany, has to spend massive amounts of money and resources fighting two completely separate parallel legal battles over the exact same incident. Section 6, common mistakes and enforcement.
After seeing that scenario, it's pretty easy to see where companies tend to trip up. The biggest mistake we see is organizations assuming that dealing with a regulatory investigation somehow gives them a magic shield against civil litigation. It absolutely doesn't. Another massive failure is just not budgeting for cross-border legal defense. If you're a startup based in France with users in Poland, Italy, and Greece, you could face local lawsuits in all 3 of those jurisdictions. Finally, a lot of companies ignore the risk of non-material damages. They think, well, no actual financial fraud happened, so we're completely safe. But as the courts have ruled, just the psychological distress or the fear of data misuse can be more than enough for a plaintiff to demand compensation.
All right, let's do a quick knowledge check to test your understanding. This is very similar to what you might see on a professional privacy certification exam. Here is the scenario. A user residing in France suffers a data breach from a controller headquartered in Germany. Under Article 79, where can the user file their civil lawsuit? Is it A, only Germany, B, only France, C, either France or Germany, or D, the CJEU directly? Take a second to lock in your answer based on what we just covered about the home court advantage.
And the correct answer is C, either France or Germany. Remember Recital 145 and Article 79, Paragraph 2? The data subject has an immense amount of flexibility here. They can choose to sue in the member state where the controller is established or where they themselves habitually reside. Key takeaways. We have covered a lot of really important ground today. Let's consolidate this into the most critical points you should bring back to your executive and compliance teams. Number 1, Article 79 is that direct action superpower. It allows individuals to launch civil lawsuits, completely bypassing regulatory backlogs. Number 2, plaintiffs enjoy a powerful home court advantage, meaning they have the right to sue you in their local jurisdiction. Number 3, the CJEU explicitly confirmed that concurrent actions are completely legal. A user can trigger a regulatory investigation and sue you in civil court at the exact same time. And finally, this type of litigation is almost always tied to Article 82, meaning they're actively pursuing financial compensation for material or even non-material damages. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. I want to leave you with one final provocative thought today. Is your organization genuinely prepared to defend a privacy lawsuit in the local courts of every single country where your customers live? It's definitely a daunting question, but understanding Article 79 is the crucial first step toward getting ready. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks so much for joining me today, and I'll see you in the next explainer.
Hey everyone, and welcome to today's explainer. Today, we're diving into a genuinely fascinating and honestly kind of underestimated piece of the GDPR, Article 80. We're going to see exactly how everyday people can use proxy organizations to essentially fight their privacy battles against absolutely colossal data controllers. It's David versus Goliath, but with data.
Okay, let's dive right into this. Here's our roadmap. We'll kick off by understanding Article 80 itself, jump into some recitals and real-world examples, and then look at actual enforcement and case law. After that, we've got a practical compliance case study, a quick certification knowledge check, and we'll wrap up with the big takeaways.
So Part 1, understanding Article 80. I like to call this the hero's proxy.
Let's start by looking at the fundamental problem this article actually solves. What happens when an everyday person realizes their data is being misused, but they entirely lack the resources to fight back? I mean, think about it. The average person rarely has the time, the deep pockets, or the super specialized legal expertise required to take on a massive tech giant, right? It is a massive power imbalance. And, well, that is exactly why Article 80 was written into the GDPR. It acts as a mechanism to totally level the playing field.
All right, here is how it breaks down in plain English. Article 80 is essentially split into 2 very distinct powers. First, Article 80, Paragraph 1, requires a direct mandate. This just means an individual explicitly asks a properly constituted nonprofit organization to act on their behalf, to lodge a complaint or seek a remedy for them. But then, look at Article 80, Paragraph 2. This is the real heavy hitter. It allows these organizations to take independent action without a specific mandate from a user, provided that the national law of that member state allows it, meaning an NGO can step right in to protect collective consumer rights entirely on its own initiative. Pretty powerful stuff.
Moving right along to Part 2, recitals and real-world examples.
Now, what's really interesting here is the actual legislative intent behind this. Recital 142 of the GDPR explicitly clarifies that member states have the option to empower consumer rights groups to act independently. Lawmakers knew that waiting for individual victims to just, realize they've been wronged and then go through the hassle of filing paperwork, it was just too slow and way too burdensome. So this recital proves the GDPR was intentionally designed to allow watchdogs to proactively patrol the digital landscape. Let's look at 3 concrete scenarios to show how this actually plays out. First up, the big tech scenario. Imagine a digital rights NGO notices a global social network using highly deceptive cookie banners. Under Article 80, Paragraph 2, they don't even have to wait for users to complain. They can just independently sue the company. Second, the small business scenario. A local nonprofit uses Article 80, Paragraph 1 after a senior citizen specifically mandates them to help file a complaint against a local clinic that mishandled their health data. And finally, a real cautionary tale. A company gets an inquiry from a recognized NGO. They completely dismiss it because it didn't come from a specific user. And boom, they end up facing massive fines from the Data Protection Authority because that NGO actually had full independent legal standing to escalate the issue.
Those examples lead us directly into the biggest traps organizations fall into. The most common mistake? Assuming that only individual data subjects can lodge complaints. Absolutely do not ignore inquiries from established consumer rights NGOs. Doing so is a massive organizational risk. But there is a flip side to this. A huge misconception is that NGOs can seek financial compensation on their own. As we'll see in a minute, they absolutely cannot do that without a direct user mandate.
Which brings us to Part 3, enforcement and case law.
If there is one landmark case you absolutely need to remember for Article 80, it is the Court of Justice of the European Union, case C319/20. This involved Meta Platforms Ireland and a German Federal Union of Consumer Organizations. The court ruled definitively here that consumer protection associations have serious teeth. They confirmed that under Article 80, Paragraph 2, an NGO can bring representative proceedings without needing a specific mandate, without needing to identify a specific individual who was harmed, and without even needing to prove a specific concrete infringement of rights. Literally, just the allegation of unlawful processing that could infringe rights is enough for them to act. A real game changer.
Let's move on to Part 4, a privacy compliance case study.
Okay, picture this scenario. Step 1, an edtech company rolls out this highly invasive AI tracking tool to monitor students during online exams. Step 2, a prominent digital rights NGO reviews the software and considers that the fundamental privacy rights of the students are being infringed by this processing. Step 3, because the member state law permits it, the NGO does not sit around waiting for a single student to complain. They step right in and file an independent complaint with the Supervisory Authority under Article 82. So now, this edtech company is facing a major regulatory investigation initiated entirely by a proxy.
All right, on to Part 5, the certification knowledge check. Let's see how this builds and test your skills with 4 scenario-based questions. Here's our first scenario. An individual is totally overwhelmed by a data breach. Who can they mandate to represent them under Article 80, Paragraph 1? Is it A, a for-profit law firm? B, any unregistered group of friends? C, a properly constituted not-for-profit active in data protection? Or D, only a government agency?
And the correct answer is C. Article 80 specifically requires that the representative body must be a not-for-profit, it must be properly constituted according to member state law, it has to have statutory objectives in the public interest, and it must be active in the field of data protection. So a standard for-profit law firm doesn't fit this very specific proxy definition under Article 80. Moving to question 2. A privacy NGO notices an app is illegally scraping data, but no users have complained. Can the NGO act? A, no, they always need a mandate. B, yes, if member state law permits independent action under 82. C, yes, but only to issue fines directly. Or D, no, only the DPA can initiate an investigation. The answer here is B. The absolutely crucial point to remember is that Article 80, Paragraph 2 is what we call an opening clause. It explicitly gives member states the option to allow independent NGO action without a direct user mandate. If the national law allows it, the NGO can absolutely jump in and act independently.
Let's check question 3. Based on the CJEU case C319/20, the meta case we discussed just a few minutes ago, does an NGO need to identify a specific individual whose rights were violated to sue? A, yes, they need at least one name. B, yes, they need a class action list. C, no, they just need to consider rights infringed by the processing. Or D, only if they are claiming financial damages.
The answer is C. The Court of Justice of the European Union made this crystal clear. NGOs do not need to carry out a prior individual identification of a specific person. They simply need to consider that the rights of a data subject have been infringed as a result of the data processing. It's a huge shift in power. Finally, question 4. An NGO wants to claim €500 for every user affected by a breach independently of any user mandates. Can they? A, yes, under Article 82. B, yes, if the breach is severe. C, no, compensation claims always require a direct mandate. Or D, no, NGOs cannot ever deal with compensation.
And the answer is C. This brilliantly illustrates the boundary of NGO power. While NGOs can absolutely lodge complaints and seek injunctions independently, the GDPR explicitly prevents them from claiming financial compensation on a data subject's behalf without a direct, explicit mandate from that individual. Okay, Part 6, takeaways and next steps. So what's the big picture here? First, Article 80 allows qualified nonprofits to act as true privacy proxies for everyday people. Second, remember the core distinction. 81 requires a mandate, while 82 empowers independent action if national law allows it. Third, NGOs cannot claim financial compensation independently. That always requires a mandate. And finally, as proven by case C319/20, NGOs are a major proactive enforcement threat that organizations really have to take seriously. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thank you so much for joining this explainer. As data processing becomes more and more complex, the power of privacy NGOs acting as proxies is literally only going to grow. So, are your compliance practices ready for them? See you next time.
Hey everyone, welcome back to another Privacy Trainer Explainer. Today we're diving into a piece of the GDPR that's honestly a bit of a hidden gem, Article 81. We're going to look at exactly how the GDPR takes what could easily turn into total cross-border judicial chaos and transforms it into organized, predictable order. Now, you may be wondering, why on earth should I care about some procedural rule? Well, it's pretty simple. If you misunderstand this one, your organization could literally end up fighting and paying for the exact same legal battle in multiple countries at the exact same time. And nobody wants that. So, to really grasp why this matters, I want you to imagine a massive data breach hits your company. It's bad enough, right? But then, almost overnight, this single event sparks simultaneous lawsuits in France, Germany, and Spain. It is an absolute nightmare scenario for any legal team. So, what prevents a chaotic clash of conflicting judicial judgments? And, maybe more importantly for the budget, what stops you from hemorrhaging wasted legal fees to defend the exact same processing activity across multiple European jurisdictions? Well, that is exactly the problem Article 81 was built to solve. All right, let's just jump right in. We're going to start with an overview and the mechanics, run through some practical scenarios, look at enforcement and pitfalls, dive into a quick case study, and then finish up with a knowledge check. Section 1, Overview and Mechanics. Let's take a look at how these core rules actually operate under the hood. Think about a world without this rule. Organizations would be facing the absolute nightmare of forum shopping, where plaintiffs deliberately hunt down the most favorable courts. You'd get conflicting rulings, like a judge in Madrid telling you to do one thing, while a judge in Warsaw orders the complete opposite. But with Article 81 in place, courts are literally forced by the GDPR to talk to each other and pause overlapping cases. It creates a unified, predictable legal order across the entire European Union. What's really fascinating here is how the legal text maps out into this incredibly simple three-step mechanical process. This was actually confirmed in case C132/21. Basically, if a second court in a member state gets a case that involves the same subject matter in the exact same controller or processor that is already pending in another member state, it absolutely shall contact that first court to confirm the proceedings exist. That communication is completely mandatory. Then, once it's confirmed, that second court may suspend its own trial. Now, while Article 81 handles all those procedural mechanics, Recital 141 steps back and reminds us why this actually matters for everyday people. It states that every data subject should have the right to an effective judicial remedy. Lawmakers essentially included Article 81 to make sure that providing this remedy doesn't just bog down the entire European judicial system in redundant parallel trials that waste everyone's time and money. Moving on to Section 2, Practical Scenarios. Let's see how this actually plays out in the real world. Let's look at a few quick examples here. Say you're a massive tech company dealing with a continent-wide issue. Article 81 ensures you're fighting a single, coordinated lawsuit for that processing activity, instead of 27 separate lawsuits for a single breach. For a small business, honestly, this is a financial lifesaver. It means you aren't paying double legal fees if a disgruntled client decides to sue you in 2 different countries at the same time. But look at the compliance failure side of things. If your defense team just forgets to inform the second court that a case is already pending somewhere else, well, the court won't know to suspend it, and that leads directly to a massive pile of wasted defense costs. All right, Section 3, Enforcement and Pitfalls. Where do organizations usually trip up? So a super common compliance failure is defense teams completely misunderstanding the triggers for this article. The cases have to concern the same subject matter and the same controller or processor. If that second lawsuit is about a totally different data processing activity, Article 81 isn't going to help you. Another huge pitfall is failing to proactively notify the courts. Sure, the law says the courts must communicate with each other, but in reality, it's really up to your legal team to actively present evidence to that second court showing an identical case is already pending elsewhere in the EU. If you don't raise your hand and point it out, you are going to waste resources fighting duplicate battles. Let's head into Section 4, our case study, and put all of this into practice. Imagine this timeline playing out. On day 1, a user sues your company in Paris over a specific algorithmic profiling mechanism. Then, on day 15, an identical lawsuit about the exact same profiling mechanism is filed by a totally different user in Berlin. Luckily, your legal team is on it and immediately notifies the Berlin judge. By day 30, following Article 81, Paragraph 1, the Berlin court officially contacts the Paris court to confirm the case actually exists. Then, by day 45, using Article 81, Paragraph 2, the Berlin court suspends its proceedings. They're deferring to the court first seized, which just means the court that got the case first, over in Paris. Just like that, you've saved your company thousands of euros in redundant litigation. Okay, time for Section 5, the knowledge check. Let's test your applied reasoning with some certification-style questions. Question 1. Take a look at this scenario. If Court B receives a case matching a pending case in Court A, what is the very first mandatory action Court B must take under Article 8.1? Is it A, dismiss the case, B, suspend proceedings, C, contact Court A, or D, find the controller? Take a second and lock in your answer. And the correct answer is C. Article 81, Paragraph 1, explicitly states that the court shall contact the other court to confirm the proceedings exist before making any suspension decisions. It is a strictly mandatory communication step. Moving on to question 2. Once Court B confirms the case is actively pending in Court A, is suspension completely mandatory? A, yes, it's mandatory. B, no, it may suspend. C, only if requested. Or D, only for processors. This one really highlights the flexibility built into the law. The correct answer is B. Article 81, Paragraph 2, specifically uses the word may. The second court may suspend its proceedings, meaning it retains its judicial discretion based on the specific circumstances of its local case. All right, question 3. For Article 81 to even trigger, the case must concern the same subject matter, and what else? A, same data subject, B, same supervisory authority, C, same controller or processor, or D, same member state. The answer here is C. It has to involve processing by the same controller or processor. This is to guarantee we aren't duplicating trials for the exact same entity defending the exact same business practice. Finally, question 4. What is the core structural problem that this specific article is actually designed to prevent? A, high administrative fines. B, cross-border data transfers. C, conflicting judgments from different courts. Or D, lawful basis errors. The correct answer is C. It serves as our judicial traffic controller, essentially preventing parallel proceedings that could lead to conflicting judgments and absolute chaos across member states. To wrap things up today, let's review your key takeaways. Article 81 is basically your procedural safeguard against having to defend the same processing activity in multiple European courts at the exact same time. Remember the mechanics here. The second court absolutely must contact the first court to confirm, and then it may suspend its proceedings. But keep in mind, it only applies if you're dealing with the exact same subject matter and the exact same controller or processor. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Now, I want to leave you with a final thought to ponder today. Is your legal team actively prepared to spot a parallel cross-border lawsuit before it completely doubles your legal fees? Stay vigilant, keep learning, and I'll catch you in the next explainer.
All right, let's dive right into this explainer on GDPR Article 82. Welcome back to Privacy Trainer, the series where we take every single article of the GDPR and break it down one by one. Today, we're tackling a big one. What exactly happens when data privacy goes wrong and an organization is suddenly staring down claims for financial compensation? Whether you're a privacy pro, a business leader trying to protect your company, or a student just starting out, understanding who pays and why is absolutely essential. So here's our game plan for today's explainer. First, the hook. Then we'll unpack the article itself, look at the 3 conditions for a claim, explore defenses and liability, run through a mini case study, and wrap it all up with key takeaways. Section 1, the hook, the cost of getting it wrong. Let's look at why a simple misunderstanding about liability can actually lead to a massive financial headache. This right here, this is the million-dollar question that keeps business leaders, lawyers, and privacy pros awake at night. Think about it. If your organization makes a tiny mistake, sending an email to the wrong person, or maybe keeping data a day past its retention schedule, are you automatically writing a check to the user? We're going to answer exactly that today. Moving into Section 2, unpacking Article 82, legal text and recitals. To really find the answer, we have to cut through the noise and go straight to the blueprint of the law itself. Okay, look at this. The really interesting part here is that little phrase, non-material damage. Material damage, that's easy, right? It's actual financial loss. But Recital 85 of the GDPR tells us that non-material damage includes intangible harms. We're talking about a loss of control over personal data, discrimination, or even just distress. The lawmakers wrote it this way to make sure individuals are fully protected, not just when their bank accounts get drained, but when their fundamental privacy rights are compromised. All right, Section 3, anatomy of a claim, 3 key conditions. So wait, does that mean every single little slip-up causes non-material damage? Well, the European Court of Justice actually gave us some brilliant clarity on this. In case C-321, they established a crucial point. A mere infringement is not enough on its own. You absolutely must have all 3 of these cumulative conditions to trigger compensation. You need an infringement, actual damage, and a direct causal link between those 2 things. It's exactly like a 3-legged stool. If just one piece is missing, the whole claim completely falls apart. And this really illustrates how the courts are viewing harm these days. There is absolutely no de minimis, no minimum threshold for how bad the damage has to be. In fact, case C-456/22 showed us that even a brief loss of control over data can count. But, and this is a big but, the user still has to prove they actually suffered some form of real impact, like, say, a genuine fear of identity theft following a hack, which we saw in case C-340/21. Also, it's super important to remember that Article 82 is strictly about compensating the victim to make them whole. It's not a punishment for the company. Regulatory fines under Article 83 handle the punishment side of things. Let's move to Section 4, defenses, liability, and mistakes. So, where do organizations usually drop the ball when the pressure is on? It all comes down to the burden of proof. Case C-667/21 established what's called a fault-based liability regime. What this means, in plain English, is that the burden of proof rests heavily on the controller. The controller is presumed to have participated in the processing that caused the mess, so they have to actively demonstrate their innocence. They have to prove they are not in any way responsible. Seriously, it's not the user's job to prove the company was negligent, it's the company's job to prove they weren't. So how does this actually work in those messy, complex vendor ecosystems? Well, if multiple companies are joint controllers, a data subject doesn't have to sue all of them. They can sue literally any single joint controller for the entire amount of the damage. And honestly, this rule is there to make sure victims get fully compensated quickly, without having to fight a massive court battle against 5 different tech vendors at the same time. The company that pays out can just claim back a share of the cost from its partners later. Processors, on the flip side, are only liable if they ignore the controller's instructions or if they break processor-specific rules. Okay, Section 5, quiz, mini case study. Let's put everything you've learned to the test with some practical certification-style questions. Question 1. Imagine a tech firm's database gets hacked by a third party and a user claims non-material damage because they're terrified their data will be misused. Is the firm automatically exempt here? A, yes, because a third party committed the hack. B, no, they must prove they were in no way responsible. C, yes, fear is not considered damage. Or D, no, but they only pay for material financial loss. Take a second to think about who holds the burden of proof here. And the correct answer is B. The controller can only escape liability if they can prove their security measures were state-of-the-art, and they were in absolutely no way responsible for the vulnerability. Just pointing the finger at the hacker? Yeah, that's not a valid defense under case C-340/21. This is exactly why keeping bulletproof security documentation is so critical. Let's try question 2. A small business forgets to reply to a data access request. This causes a GDPR infringement, but absolutely no actual harm is done to the user. Does the user get compensation? A, yes, infringement automatically equals damage. B, yes, to punish the small business. C, no, mere infringement without actual damage is not enough. Or D, no, small businesses are strictly exempt from Article 82. The answer is C. Think back to that 3-legged stool we talked about earlier, an infringement, actual damage, and a causal link. Case C-300/21 makes it crystal clear. Without actual proven damage, even if it's just non-material distress, the chain is broken. No damage means no right to financial compensation. Moving on to question 3. 2 companies act as joint controllers for a campaign that unlawfully processes data and causes distress. Who does the data subject sue for compensation? A, both companies demanding exactly 50% from each. B, the processor they used. C, either one of the joint controllers for the entire damage amount. Or D, the National Supervisory Authority. Put yourself in the shoes of that frustrated consumer for a second. The answer is C. Article 82, paragraph 4 is heavily weighted in favor of making things easy for the data subject. The consumer can sue just one of the joint controllers for the whole entire amount. The company that gets sued and pays out can just quietly sort out the reimbursement from their partner behind closed doors after the fact. All right, final question, question 4. A processor strictly follows a controller's lawful instructions, but the processing ultimately infringes the GDPR and causes damage. Who is liable? A, the processor. B, the controller. C, both equally. Or D, neither. If the processor just did exactly what they were told, who takes the fall?
The answer here is B. According to Article 82, Paragraph 2, because the processor simply did exactly what they were legally instructed to do by their client, the controller bears the full responsibility for the fallout. The processor is only liable if they go rogue and ignore instructions or break specific processor rules. Section 6. Key takeaways. Summary. Let's wrap this up and cement the most vital points into your memory. If you take away anything at all from today's explainer, let it be this. While you aren't automatically liable for a simple administrative mistake, proving you aren't at fault when real damage does occur is entirely on your shoulders. Remember those three elements: infringement, damage, and a causal rank. Remember that fear of misuse counts as damage. And remember that any joint controller can be sued for the full amount. You absolutely must maintain excellent records, document your security measures, and keep those vendor agreements airtight. If you've been enjoying these GDPRI explainers and want to help support the channel, consider becoming a member of Privacy Trainer. Memberships are what help us keep creating free privacy, security, AI, and compliance education for learners all over the world. Our mission is to make high-quality privacy knowledge accessible to absolutely everyone and use AI to scale that education globally. Your membership really makes this all possible. And finally, if you're looking for more structured privacy, security, or AI training, stuff like guided learning pads, workshops, practice questions, and certification prep, you can explore privacyuni.com. Privacy Trainer is all about making knowledge freely available right here, while privacyuni.com is really designed for learners who prefer a more structured, step-by-step experience. Disclaimer, this content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. As you look at your own organization's vendor contracts and security logs today, ask yourself, if a breach happens tomorrow, could you truly prove you were in no way responsible? Think about it. I'll see you in the next explainer. Welcome to Privacy Trainer. This is the series where we break down the general data protection regulation one single article at a time. And today we are focusing on the big one, the one that literally keeps executives up at night and makes splashy headlines all around the world. We're decoding GDPR Article 83, the article that governs administrative fines. Now, there's a whole lot of fear-mongering out there, kind of painting the GDPR as this massive, unpredictable fine-generating machine. But the truth is actually much more structured than that. In this explainer, we're going to translate the dense legal text into plain English, explore exactly how regulators calculate these penalties using European Data Protection Board guidelines, and we'll even look at recent case law to see how this all works in practice. So let's dive right in. Article 83 grabs all the headlines with these absolutely astronomical maximum penalties, 20 million euros or 4% of a company's total worldwide annual turnover, whichever is higher. But it's absolutely crucial to understand exactly what triggers these massive numbers. The GDPR explicitly states that fines must be effective, proportionate, and dissuasive in every individual case. This means these eye-watering numbers are the ceiling, not the floor. Lawmakers included this specific provision to ensure that fines couldn't just be brushed off as a mere cost of doing business by massive multinational corporations, The fine has to actually sting enough to encourage real compliance, but at the same time it has to be strictly proportional to the actual harm and the specific conduct of the organization. The GDPR doesn't just slap the same penalty on every single mistake. It uses a really specific tiered approach for maximum fines. Everyday operational and administrative failures, those fall into Tier 1. So think of things like failing to put the right contract in place with your data processor under Article 28, or maybe having poor security measures under Article 32. Those max out at 10 million euros or 2% of global turnover. However, if you commit severe breaches of core principles, like processing data without a lawful basis, completely ignoring the conditions for consent, or violating data subject rights, that's when you trigger the higher Tier 2. Those are the ones that reach up to that famous 20 million euro or 4% mark. It basically all comes down to the fundamental nature of the obligation you breached. Section 1. How regulators calculate fines. Let's see how the math actually works. So how do regulators actually arrive at these specific numbers? It's definitely not just a random guess or a spin of a roulette wheel. The European Data Protection Board, or the EDPB, uses a very clear 5-step framework. First, they identify the specific processing operations and check if multiple articles were breached. Second, they find a starting point amount based on the classification of the infringement, so whether it's Tier 1 or Tier 2, and the seriousness of the violation. Third, and this is critical for you, they evaluate aggravating and mitigating factors under Article 83 with 2. That means looking at your past behavior, whether you fully cooperated or if you actually took action to mitigate the damage. Fourth, they check this calculation against the legal maximums. And finally, step 5, they apply a proportionality test to make absolutely sure the final number is fair. So you see, fines are carefully calculated based on specific circumstances, not just a simple mathematical formula. Now, a really critical concept here is the undertaking. When the GDPR says 4% of the total worldwide annual turnover of the preceding financial year, whose turnover are we actually talking about? Well, Recital 150 points us straight to EU competition law, specifically Articles 101 and 102 of the Treaty on the Functioning of the European Union. This means the turnover used for that maximum limit isn't just your local subsidiary's revenue, it's the entire global economic undertaking. So if a tiny subsidiary in France commits a breach, but they're fully controlled by a massive parent corporation in the US, regulators can and will look at the worldwide revenue of the entire corporate family to calculate that maximum cap. It's a huge deal. Here's a massive point from recent case law, specifically from the Court of Justice of the European Union in cases like C807/21 Deutsche Wohnen. There is absolutely no strict liability under the GDPR. Organizations often have this major fear that if a breach happens, a fine is completely automatic, regardless of what they did to try and prevent it. But the court clarified that regulators actually must prove intentional or negligent wrongful conduct to impose a fine. So if you did absolutely everything right, you implemented state-of-the-art security, you trained your staff perfectly, and some unforeseeable zero-day exploit still occurred, you might not be fined because the negligence standard just wasn't met. Culpable conduct is a strict condition. Section 2, Article 83 in practice. Abstract legal concepts are great, but let's apply these rules to practical, real-world scenarios, because that's where the real learning happens. Imagine a massive tech company that gets caught aggressively harvesting user data without proper consent under Article 6. Because consent is a core principle, boom, they are immediately in Tier 2, facing up to 4% of their global turnover. Now contrast that with a small business that suffers a localized data breach because they just failed to encrypt an employee laptop, breaching Article 32. That's a Tier 1 operational failure, which is capped at 2%. But beware, if that same small business then intentionally ignores a direct order from the supervisory authority to fix the problem, that non-compliance jumps right back up to Tier 2. The fine tier depends entirely on the specific obligation that was breached. Let's run a quick mini case study to really cement this. Picture an e-commerce platform that suffers a breach because a hacker exploits an outdated, unpatched server. Regulators step in. First, they ask, was this negligent? Well, failing to patch known server vulnerabilities is definitely negligent, so yes, that meets the strict condition for a fine. Next, they look at the starting point. This is an Article 32 security failure, so we're in Tier 1. Then they looked at those Article 83(2) factors we talked about. Did the company have a prior history of breaches? If yes, the fine goes up. Did they immediately notify users, offer free credit monitoring, and patch the server within hours? If yes, those are mitigating actions, and the final fine proportionally scales down. Your exact reaction to an incident directly impacts your wallet. Section 3, Common Compliance Failures. We need to highlight the most frequent pitfalls organizations face regarding their Article 83 exposure, because misunderstanding this can lead to terrible business decisions. First, as we covered, organizations wrongly assume fines are automatic. They simply aren't. Fault is strictly required. Second, executives often miscalculate their risk by only looking at a local branch's revenue, completely forgetting the global undertaking rule. Third, they fail to properly document their mitigation efforts during a crisis. Think about it. If you don't document how incredibly hard you work to stop a breach, the regulator can't use it to lower your fine. And finally, the myth of infinite stacking. Some people fear that if one event breaches 5 different GDPR articles, the fines stack on top of each other infinitely. Not true. Article 83(3) prevents this, capping the total amount at the limit for the single gravest infringement.
Section 4, Test your privacy knowledge. Let's see how much you've picked up. Okay, it's time to put your practical understanding to the test with 4 certification-style questions. Let's start with the tiers. Read the scenario and lock in your answer. What is the maximum fine for violating the core principles of processing, like those found in Article 5? Is it A, 10 million or 2%, B, 20 million or 4%, C, 5 million or 1%, or D, 50 million? Take a second to think about it. And the correct answer is B. As we discussed earlier, core principles, along with data subject rights and cross-border transfer rules, are considered the absolute most fundamental parts of the GDPR. Because of that, they are explicitly subject to the higher Tier 2 maximums under Article 83(5). All right, moving on to case law. Think back to the requirement for wrongful conduct. According to the Court of Justice in the Deutsche Wohnen case, can an organization be fined purely on a strict liability basis, without any fault at all? If you guessed C, you nailed it. The Court of Justice clearly established that a culpable, wrongful infringement is a strict condition for a fine. There absolutely must be an element of intentional or negligent conduct by the controller or processor to trigger Article 83. Question 3 tests your grasp of the economic scope outlined in Recital 150. When regulators calculate that 2% or 4% cap, what financial metric are they actually looking at? The answer is C again. Regulators look at the total worldwide annual turnover of the entire economic unit or the undertaking, which draws directly from EU competition law. They are absolutely not just looking at the local office or merely your profit margin. Finally, let's consider a highly realistic scenario. Let's say a single linked processing failure occurs, but it technically breaches 3 different GDPR articles simultaneously. How is the maximum fine set? And the answer is B. Article 83(3) explicitly prevents the infinite stacking of penalties. If linked operations infringe several provisions, the total amount of the administrative fine shall not exceed the amount specified for the gravest infringement. Essentially, you get penalized for the worst part of the interconnected failure. You don't get punished 3 times over. Section 5, Takeaways and Next Steps. Brilliant work on those questions. Let's wrap up this explainer with the most crucial lessons to remember about Article 83, so you can take these directly into your professional practice. First, remember that fines use tiered maximums based on the nature of the infringement. Second, the maximum cap targets the global economic undertaking, meaning the exposure is often way larger than localized businesses realize. Third, fines require fault, either negligence or intent. Strict liability does not apply. Fourth, your mitigating actions during and after an incident are actively used to lower your penalties, so write everything down. And finally, linked breaches are capped to the highest tier, which prevents infinite penalty stacking. Understanding these points completely changes how you assess organizational risk.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Furthermore, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience.
Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Always consult with a qualified professional. Now, we've seen just how steep Article 83 penalties can be from regulators, but what happens when data subjects want to sue for compensation directly? Join me in the next explainer as we tackle Article 82 and ask yourself, is your organization more at risk from regulators or from your own users? See you there.
Okay, let's dive into this explainer and uncover a really powerful yet surprisingly overlooked enforcement tool hidden right inside the GDPR. I'm talking about Article 84. You see, when most business leaders think about GDPR penalties, their minds instantly go to those massive headline-grabbing administrative fines. But what if I told you there's actually an entirely different layer of severe consequences that most organizations completely miss until it's way too late?
So I want you to think of GDPR penalties kind of like a giant iceberg. Pretty much everyone sees those massive administrative fines above the surface. You know, the ones capped at 20 million euros or 4% of global turnover. But today, we're going to put on our scuba gear and explore the really severe sanctions lurking just beneath the waterline. What happens when a violation is so bad it warrants more than a standard fine? Or what if it happens in a country where regulators literally can't legally issue one? Well, that is the exact problem Article 84 solves.
All right, here's our quick roadmap for today's explainer. We'll start with the hidden GDPR penalties, move into recitals and real-world examples, cover common mistakes and enforcement, do a step-by-step case study, run through a quick privacy trainer knowledge check, and finally, wrap up with our key takeaways.
Okay, let's jump right into Section 1, the hidden GDPR penalties. Now, recent European case law, specifically if you look at cases C300/21 and C182/22, really drew a hard line between two very different types of enforcement. On the left side here, Article 82 is basically a shield. It's compensatory. It exists purely to make a victim whole after they've suffered actual damage. But over on the right, that gavel, that represents Articles 83 and 84. These are strictly punitive. Their entire purpose is to punish the offender and scare off future violations. And the kicker, they don't require a victim to prove individual damage to take a serious bite out of an organization. So what is the golden rule here? Well, Article 84 says that member states actually have the power to create other penalties for infringements, as long as they meet three absolutely crucial criteria. They have to be effective, proportionate, and dissuasive. You might be wondering, why did lawmakers even include this? It's because a one-size-fits-all fine just doesn't work for every unique legal system across Europe. This rule gives countries the flexibility to craft their own localized punishments.
Moving right along to Section 2, recitals and real-world examples.
This part is actually fascinating. Recital 151 and Case C383/23 reveals some wild exceptions to the standard GDPR model. Normally, a supervisory authority just issues an administrative fine. But take a look at Denmark and Estonia. Their national legal systems literally do not allow for standard administrative fines. No way around it. So how on earth do they enforce the GDPR? They route these penalties straight through national criminal courts in misdemeanor procedures. It's just a brilliant example of the GDPR adapting to national constitutions without losing any of its teeth.
Let's make this a bit more practical with three quick scenarios. First, imagine a massive tech company intentionally misusing sensitive data. Under Article 84, a state could hit them with severe criminal sanctions, not just to cut a fine. Second, a local small business might face a specific national penalty that isn't even covered by standard GDPR fine tiers. And third, actually this one is a real shocker from Recital 149, a compliance failure could result in the actual deprivation of profits. That's right, member states can legally confiscate every single cent you made through a GDPR violation. It is a massive, massive risk that completely flies under the radar.
All right, on to Section 3, common mistakes and enforcement. One of the most fatal compliance mistakes we see is treating the GDPR as this single uniform fine system, completely ignoring the fact that local regulators might actually pursue criminal charges. A lot of business leaders just assume standard administrative fines are the only risk out there. But to be fair, regulators have strict boundaries too. As Recital 149 points out, they have to respect the ne bis in idem principle. In plain English, no double jeopardy. A regulator cannot hit an organization with an administrative fine and a criminal penalty for the exact same offense. Let's move to Section 4, a step-by-step case study. Okay, let's walk through a realistic scenario to see how this plays out. Step 1, the challenge. A company suffers a pretty severe data breach, but instead of just a standard fine, the local regulator goes after them with national criminal charges and tries to confiscate their profits. So, Step 2, the core issue here. Does the GDPR even allow criminal penalties instead of administrative fines? Honestly, a lot of professionals mistakenly say no. But Step 3, the analysis. Yes, it absolutely does. Article 84 and Recital 149 explicitly allow member states to enforce proportionate criminal penalties. And this right here proves exactly why you have to understand the specific criminal laws in the member states where you operate, not just the GDPR itself. All right, Section 5. Time for our privacy trainer knowledge check. Let's see how much of this is sticking.
Here's question 1. According to Case C300/21, what is the primary purpose of Articles 83 and 84? Is it A, compensatory, B, punitive, C, administrative, or D, advisory? Go ahead and lock in your answer. If you chose B, you nailed it. The courts clearly differentiate between Article 82, which is there to compensate victims, and Articles 83 and 84, which are strictly punitive to punish bad behavior and discourage unlawful conduct.
Moving to question 2. Under Article 84, what three criteria must member state penalties meet? A, fast, cheap, easy. B, public, strict, severe. C, effective, proportionate, dissuasive. Or D, local, uniform, regulated. The correct answer is C. This is the absolute golden rule, acting as the ultimate safeguard to make sure local penalties remain fair, but still highly impactful across all the different member states.
Okay, question 3. Based on Recital 151 and Case C383/23, how does Denmark handle GDPR fines? A, through the EDPB. B, they do not issue fines. C, through civil lawsuits. Or D, through national courts as criminal penalties.
And the answer is D. Because their specific national system doesn't accommodate standard administrative fines, Denmark processes these through their national courts as criminal penalties. It's a perfect example of the GDPR adapting to local constitutions. Last one, question 4. Recital 149 states that criminal penalties must not breach ne bis in idem. What does this legal concept actually mean in plain English? A, right to a lawyer. B, no double jeopardy. C, innocent until proven guilty. Or D, right to appeal. If you said B, you've got it. No double jeopardy. Basically, regulators cannot stack an administrative fine and a criminal penalty on top of each other for the exact same offense. You can't be punished twice for a single infringement. Finally, Section 6, key takeaways and next steps.
All right, so what is the real bottom line here? Well, first, Article 84 regulates other penalties that go way beyond standard fines. Second, it allows member states to impose really severe criminal sanctions and even confiscate illicit profits. Third, it accommodates unique legal systems like we saw with Denmark and Estonia. And lastly, all penalties must always remain effective, proportionate, and dissuasive. Ultimately, Article 84 is kind of the GDPR's hidden arsenal. It's a strict reminder that local criminal courts are watching your compliance just as closely as the European data authorities.
Before we wrap up, I want to leave you with a question to really think about. If your organization suffered a massive breach tomorrow, are you only prepared to handle an administrative fine, or are you actually ready to defend against local criminal charges and profit confiscation? If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Now, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks so much for learning with us, and I'll see you in the next explainer.
Welcome to Privacy Trainer. Today, we're going to unpack a truly fascinating yet incredibly delicate balance within European law. We're talking about the deep tension between protecting personal data on one hand and preserving our fundamental right to free speech on the other. In this explainer, we are diving deep into Article 85 of the General Data Protection Regulation, which honestly performs one of the greatest legal balancing acts in modern history. So let's kick things off by addressing a massive anxiety that popped up right when the GDPR was first introduced. A lot of people were asking, wait, does strict data protection completely kill free speech? Think about it. If I have a right to be forgotten or erase my data, couldn't I just use the GDPR to silence journalists who write negative things about me? Or what if corrupt politicians use privacy laws to hide whistleblowers' leaks? If organizations misunderstand this dynamic, the consequences are literally severe. We'd be looking at widespread censorship, all completely hidden under the guise of privacy compliance. To figure out exactly how the GDPR solves this massive problem, we have to look over at the European Charter of Fundamental Rights. I want you to picture a giant set of balancing scales. Now, on one side of those scales, we have Article 8 of the Charter, which guarantees everyone the right to the protection of their personal data. But then, on the exact opposite side, we have Article 11, which guarantees freedom of expression and information. Now, these are both heavyweight fundamental rights, and in the real world, they crash right into each other all the time. That is exactly why Article 85 of the GDPR exists. It's there specifically to reconcile these two competing rights, making sure that neither one completely destroys the other. Here's our roadmap for this explainer. 1. Privacy versus free speech. 2. Unpacking Article 85. 3. Real-world scenarios. 4. Regulatory focus and mistakes. 5. The Privacy Trainer knowledge check. And finally, 6. Takeaways and wrap-up. All right, let's jump straight into Section 1, unpacking Article 85 and looking at the legal resolution. So let's look at the core text of Article 85, and we'll translate this into plain English. The GDPR actually places a very strict duty on national governments, the member states themselves. It mandates that they must pass local laws carving out specific exemptions to the GDPR. In other words, the GDPR is basically saying, hey, countries of the EU, you absolutely must create exceptions to these privacy rules because we need journalism, art, and academic expression to still thrive. Now, this is where it gets really interesting. Lawmakers actually helped us interpret this rule through Recital 153 of the GDPR. They realized pretty quickly that free speech isn't just about traditional printed newspapers anymore, so they explicitly state that the concept of journalism must be interpreted very broadly to properly protect democracy. This exemption doesn't just stop at the news. It also covers academic research, artistic creations, and literary expression. The whole point is making sure that filmmakers, authors, and researchers aren't suddenly paralyzed by endless privacy requests. But of course, there are limits to this. If we look at the famous Sata Media case, known as Case C73/07, the European Court of Justice clarified that these exemptions only apply if the processing is carried out solely for journalistic purposes or artistic expression. You can't just slap the word journalism on a massive corporate database to dodge the GDPR. The exemption has to be strictly necessary to reconcile the right to privacy with the rules governing freedom of expression. Moving right along to Section 2, real-world scenarios and our mini case study. Okay, let's take all of this legal theory and drop it into the real world. I love this example because it brilliantly illustrates the exact step-by-step balancing test a tech company has to perform. Picture this. An individual demands that a major search engine remove links to old, highly embarrassing news articles about them. The data subject cites their right to privacy and their right to erasure. Now, the search engine can't just blindly hit delete on those links. They have to pause, take a step back, and conduct a thorough GDPR analysis. They literally have to weigh the individual's privacy against the general public's right to access that information. And this isn't just a hypothetical. This exact scenario played out in the landmark Google Spain case, C131/12. The court totally acknowledged the right to be forgotten, but they heavily stressed that it is not absolute. If the information relates purely to someone's private life and there's zero public interest, privacy wins the day. But if that person is a prominent public figure, or maybe the information involves a serious financial crime, well, the general public's preponderant interest in having access to that information completely overrides the individual's privacy right. In those cases, the scales tip heavily toward free expression. Now, regulators absolutely will aggressively target organizations that get this wrong. One of the most common compliance failures we see is applying a blanket excuse, basically an organization claiming their entire platform is just journalism. To avoid getting hit with fines for this, you absolutely must conduct and clearly document case-by-case balancing tests. Another massive mistake is trying to use free speech to hide malicious corporate gossip. You have to ensure the disclosure actually serves a genuine public interest. Finally, never, ever ignore local laws. Because Article 85 tells member states to write their own specific exemptions, the exact rules you follow in France might actually differ slightly from the rules over in Germany. All right, Section 3. It's time for the Privacy Trainer knowledge check. Let's see how you do with these scenarios.
Question 1. A blogger publishes a heavily researched expose on local government corruption, which includes the names of specific officials. One of those officials demands data erasure under the GDPR. How should the blogger proceed? Is it A, comply and erase the names immediately, B, transfer the data to a server outside the EU, C, refuse, citing the Article 85 journalistic exemption, or D, request consent from the official to publish? Think about how we balance the official's privacy against the public's right to know. And the correct answer is C. The crucial point here is that exposing local government corruption is a matter of clear, undeniable public interest. This falls squarely under that broadly interpreted journalistic exemption we talked about from Recital 153. The public's right to information vastly outweighs the corrupt official's right to privacy. Let's move to question 2. According to the CJEU in the Google Spain case, which factor most heavily weighs in favor of the public's right to information over an individual's right to be forgotten? A, the data subject is a prominent public figure. B, the search engine's economic interests. C, the amount of time the data has been online. Or D, the server's physical location. Think back to our search engine dilemma and what tilts the scales. The correct answer here is A. When you are dealing with a prominent public figure, the public's legitimate interest in having access to information about them generally justifies the interference with their data protection rights. And just as a quick aside, the search engine's economic interests are never, ever enough to override fundamental privacy rights. Okay, question 3. This one's a bit wild. A vengeful ex-employee posts a list of their former coworkers' personal phone numbers online, claiming the whole thing is an artistic expression. Will Article 85 protect them? A, yes, because all internet posts are protected speech. B, yes, if they declare it as art on their website. C, no, because it does not genuinely reconcile rights or serve public information. Or D, no, because employees cannot be data controllers. Does simply stamping the word art on a vindictive data breach automatically grant an Article 85 exemption? If you guessed C, you hit the nail on the head. Regulators look straight through fake exemptions. As the SATA Media case highlighted for us earlier, the processing must genuinely be intended for academic, artistic, or literary expression, and it must be absolutely necessary to balance those rights. A malicious data dump serves zero public interest, and it's definitely not going to be protected. Last one, question 4. How is Article 85 actually implemented across the European Union? A, through a single identical set of rules dictated by the EDPB. B, member states must pass their own national laws to provide specific derogations. C, it is strictly enforced through the ePrivacy Directive. Or D, organizations self-certify their own exemptions. This is a super critical compliance detail that we covered earlier. And the answer is B. Remember, Article 85 is not a direct rule. It's an instruction. It actively requires individual member states to create local laws reconciling these rights, which means your exemptions will vary slightly depending on exactly which country's jurisdiction you fall under. Which brings us nicely to Section 4, takeaways and wrap-up. You've done a fantastic job navigating a really complex legal intersection today. So let's quickly summarize our key takeaways. First, privacy and free speech are not mutually exclusive. They have to be carefully balanced. Second, Article 85 dictates that member states themselves create the legal exemptions to achieve this balance. Third, keep in mind that terms like journalism, art, and academic expression are interpreted very broadly to protect our democratic rights. Fourth, the right to be forgotten is never absolute. Public figures and the public interest can absolutely override it. And finally, from a practical compliance perspective, you must conduct and carefully document these balancing tests on a case-by-case basis. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I'll leave you with a final thought to chew on today. The GDPR really isn't about hiding information at all. It's about protecting people. So when you face your next complex privacy challenge, how will you ensure you keep the scales perfectly balanced? Thanks so much for learning with me today, and I'll see you in the next explainer.
All right, let's just dive right into this explainer by asking a pretty critical question. What happens when a citizen's fundamental right to access public records collides head-on with a private individual's right to data protection? It's honestly one of the trickiest tightropes to walk in modern compliance. Welcome to Privacy Trainer. Today we're unpacking Article 86 of the General Data Protection Regulation, which tackles exactly this tension. If you've ever wondered how public authorities can legally release documents without completely shattering data privacy laws, well, you are in the right place. To really get a grip on how the GDPR handles this delicate balance, we're going to hit 4 main areas today. We'll start with the transparency versus privacy conflict, then move into Article 86 and some real-world scenarios, followed by enforcement and a case study, and finally, wrap it all up with a quick knowledge check.
Section 1. The transparency versus privacy conflict. Let's start with the core problem that Article 86 was literally built to solve. On one side, we've got public access. Freedom of information, keeping governments and public bodies accountable to the people. But on the exact opposite side, we have data protection, our fundamental right to privacy and the security of our personal information. And here's the kicker. If an organization gets this balancing act wrong, they are either illegally hiding public records or they're unlawfully exposing sensitive personal data. Either way, it's a massive compliance failure waiting to happen.
Now, the exact phrasing of Article 86 is actually really interesting. It says personal data in official documents may be disclosed in order to reconcile public access with the right to the protection of personal data. Notice how it doesn't just hand out a blanket GDPR exemption just because something is a public record? No way. Instead, it demands a reconciliation. It's basically telling organizations, hey, you need to build a bridge here, not just pick one side over the other.
This whole idea is backed up by Recital 154 of the GDPR. Translated into plain English, this just means that just because a document is public, the personal data inside it doesn't suddenly lose its GDPR protection. Sure, public access is absolutely a valid public interest, but national or union laws have to explicitly reconcile that access, the underlying data privacy rights, they stay completely intact throughout the entire process.
All right, moving on to Section 2, Article 86 and real-world scenarios. Let's see what this actually looks like for different types of organizations on a day-to-day basis. Okay, let's run through a few quick scenarios. First up, imagine a tech vendor lands a massive government contract. A citizen files a Freedom of Information request to see that contract. Well, the government can't just hand over the entire unredacted file, right? They have to reconcile the request by blacking out the names of the vendor's everyday employees, leaving only the necessary corporate data. Or think about a small business on a public licensing registry. The registry might need to publish the owner's name to maintain public trust, but they definitely shouldn't be blasting out their home address or personal phone number if it isn't strictly necessary. And the ultimate compliance failure here is just blindly releasing unredacted files. Whether you're a public authority or a private body doing a public task, somebody always has to evaluate what data is strictly necessary to share.
So how do we avoid messing this up? Well, the biggest trap is just assuming freedom of information always overrides privacy without actually doing a proper balancing test. You absolutely cannot forget to consult specific member state laws, because Article 86 leans heavily on national law to dictate how that reconciliation even happens. And if you blindly release highly sensitive data or completely ignore the proportionality principle, meaning releasing way more data than you actually need to satisfy the public interest, you are going to land in some incredibly hot water with regulators.
Which brings us to Section 3, Enforcement and Case Study. Because let's face it, when things go wrong and a complaint gets filed, the authorities are definitely going to come knocking.
When regulators launch an investigation, they are not just looking at your final yes or no decision on releasing a document. They want to see your homework. If they're checking your legal basis for disclosure, you better have the specific union or member state law documented. For the necessity assessment, they're going to want solid proof that less intrusive methods, like redaction, just wouldn't work. And for proportionality, they expect to see a clearly documented balancing of those competing rights.
A fantastic example of this tension is the landmark Client Earth versus EFSA case. The Court of Justice of the European Union had to step in and decide if releasing the names of external experts on a draft pesticide report violated the privacy. The public obviously wanted transparency on who was shaping food safety policies, but the agency wanted to protect their experts. Ultimately, the court ruled that even expert identities require careful reconciliation. You can't just redact names by default without first assessing if the public actually has a legitimate need to know.
Let's break this down even further with a quick mini case study based on 2 recent rulings. Imagine someone requests public documents that happen to contain criminal convictions. Well, Case C 740/22 makes it clear that criminal records are highly sensitive, so the severe interference with privacy generally wins out over public access. You just can't hand that stuff over. But what if the law requires you to consult the data subject before releasing a document? Case C 710/23 steps in here and notes that while consultation is a great safeguard, it's not an absolute must if it's practically impossible to track the person down. An absolute requirement there would disproportionately restrict public access. So again, it's all about that careful step-by-step reconciliation.
All right, Section 4, Knowledge Check and Takeaways. Let's put everything we just talked about to the test with a few certification-style questions.
Here's our first scenario. A public authority receives a Freedom of Information Act request for official documents that contain personal data. According to Article 86, what is their primary obligation? Think back to the exact wording and core purpose we discussed earlier.
Is it A, deny the request immediately? B, release all data unconditionally? C, reconcile public access with data protection under applicable law? Or D, forward the request to the EDPB? The correct answer is C. Article 86 doesn't say you have to automatically release or automatically deny. The whole point is to legally reconcile both rights under member state or union law.
Moving on to question 2. Under CJEU precedent, specifically case C 740/22, if a requested public document contains highly sensitive personal data, like criminal convictions, which right generally prevails? Think about the severity of the privacy interference here.
Is it A, the public's right to access always wins? B, privacy and data protection rights prevail? C, the requester's commercial interest decides? Or D, the data subject must hold a public office to be protected? The answer here is B. The court ruled that because criminal records are so incredibly sensitive, privacy rights absolutely prevail over the general public interest in access. Okay, question 3. According to case C 710/23, must a public authority always inform and consult a data subject before disclosing a public document containing their personal data? Consider the practical limits of administration on this one.
The options are A, yes, without exception, B, no, an absolute obligation could disproportionately restrict public access if consultation is impossible, C, only if the data subject is a minor, or D, only if the data is processed automatically. And the correct answer is B. The court realized that forcing an absolute requirement to consult could basically destroy the right of public access if you simply can't find or reach the individual.
And our last question. Based on Recital 154, how does the EU directive on the reuse of public sector information interact with the GDPR? Try to remember how we defined Recital 154 earlier. Is it A, it overrides the GDPR completely? B, it only applies to private bodies? C, it leaves the level of data protection intact and does not alter GDPR rights? Or D, it exempts public authorities from Article 86? The correct answer is C. The directive for reusing public information explicitly leaves GDPR protections completely intact. Public access does not mean a free-for-all on personal data.
So let's wrap this up with a few key takeaways you can actually use. First, Article 86 is a bridge between transparency and privacy. It is absolutely not a blanket exemption. Second, national or union law has to dictate how you perform your balancing test. Remember that highly sensitive data will almost always tip the scales toward privacy. Also, always document your reconciliation and proportionality assessments so you have the proof regulators want. And finally, while consulting the data subject is a best practice, it's not an absolute barrier to access if it's practically impossible.
If you're enjoying these GDPR explainers and want to support the channel, consider becoming a member of Privacy Trainer. Memberships really help us keep creating free privacy, security, AI, and compliance education for learners everywhere. Our whole mission is to make high-quality privacy knowledge totally accessible and use AI to scale that education worldwide. And hey, if you are looking for more structured training like guided learning paths, workshops, and certification prep, definitely check out privacyuni.com. Privacy Trainer is all about making knowledge freely available here, while Privacy Uni is designed for folks who want that structured, step-by-step learning experience.
Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. And that leaves us with one final thought to ponder. As governments and public bodies rapidly digitize more of their historical records, how is your organization going to accurately weigh the scales of public transparency and individual privacy? Thanks for hanging out with me for this explainer, and I will see you in the next one.
All right, let's dive right into this explainer on why Article 87 is notoriously known as the GDPR's biggest complication to European harmony. Look, if you're working in privacy, compliance, or security, you already know the whole point of the GDPR was to create one single unified set of rules for all of Europe. But what happens when we're dealing with a piece of data that is just so sensitive, individual countries absolutely refuse to hand over control? Well, that's the national identification number. In the wrong hands, this thing is a master key. It unlocks tax records, healthcare data, financial history, the whole shebang. So today we're going to explore exactly what goes wrong if your organization misunderstands these totally unique rules and why ignoring them could literally derail your entire privacy program. Here's a quick look at our agenda for today. First, the Article 87 challenge. Second, text and interpretation. Third, real-world application. Fourth, enforcement and cases. Fifth, a knowledge check. And finally, takeaways and next steps. Let's jump right now. Section 1. The Article 87 challenge. Harmonized law versus local exceptions. So, to start us off, let's ask a really fundamental question. If the GDPR is this beautifully harmonized European law, are the rules for national IDs the exact same everywhere? The short answer is absolutely not. No way. You see, a national ID, whether that's a US Social Security number, a UK national insurance number, or say a French NSE number, is a universal identifier. Actually, think of it more like the ultimate thread that can track a person's entire life across completely different databases. From birth certificates to bank accounts, it connects everything. To prevent this massive dystopian Big Brother scenario, where corporate databases know literally everything about a citizen, the GDPR intentionally takes a step back here. It allows for local legal fragmentation. Sure, it's a massive compliance headache for businesses trying to centralize their data, but it is a fundamental privacy necessity for citizens. Moving on to Section 2, text and interpretation, decoding the legal framework. Okay, what's really fascinating about the official text on the screen is that very first sentence. It says, member states may further determine the specific conditions for the processing of a national identification number or any other identifier of general application. Guys, this is a massive carve-out. The GDPR is basically looking right at you and saying, don't just look at me, you have to go check the local laws of the specific country you're operating in. And this directly ties into Recital 10 of the GDPR, which explicitly gives member states a margin of maneuver to specify their own rules. The lawmakers knew a one-size-fits-all approach just wouldn't work for something as culturally and legally sensitive as a national ID. Because this number is treated as a master key, standard GDPR legal bases just aren't enough on their own. The article throws down a strict mandate in its second sentence, stating it shall be used only under appropriate safeguards for the rights and freedoms of the data subject. Meaning you can't just rely on legitimate interest or even explicit consent if a local member state has decided to completely ban or restrict collecting that ID. You also have to factor in the spirit of Recital 39 and Recital 51. Those recitals emphasize that specific, robust safeguards must be in place for highly sensitive data points. So, simply put, local law dictates if you can process the ID, and Article 87 dictates how securely you absolutely must do it. Which brings us to Section 3, real-world application, putting Article 87 into practice. Let's pull this out of the legal text and into the boardroom. Imagine a tech company rolling out an age verification feature across Europe. They literally have to sit down with legal counsel and map out 27 completely different legal landscapes before they launch. Because, what's perfectly legal in Sweden might result in a massive fine in Germany. On the flip side, a small business employer might only be allowed to use a national tax ID specifically for payroll purposes, and purely because a local employment law strictly mandates it. And what about a major compliance failure? Picture a big retail store capturing national IDs to use as a unique customer loyalty number and storing it in plain text. Yeah, that is a direct, flagrant violation of both purpose limitation and the mandatory safeguards required by Article 87. So what are the common mistakes you need to avoid? Well, a really massive misconception is assuming that if a user just gives you consent, you can do whatever you want with their ID. This completely ignores the fact that local laws might strictly forbid that processing altogether. You cannot contract your way around statutory national bans. Plus, you can't use a national ID as a lazy way to index your customer database. If you fail to implement robust technical measures, we're talking heavy encryption or strict pseudonymization, you are failing the explicit text of the law. Treating these master keys like basic contact information is pretty much a guaranteed path to a devastating data breach and some hefty fines.
Let's look at Section 4, Enforcement and Case Study, how regulators evaluate compliance. When a data protection authority comes knocking, they don't just want to see a nice policy on paper. They want to see the technical reality of your safeguards. This fintech case study brilliantly illustrates the right way to handle things. Say your app has to verify user identities for anti-money laundering purposes, right? But Germany's rules for storing these IDs differ wildly from Italy's. So what does the team do? They map out the specific legal basis permitted per country. And crucially, aligning with European Data Protection Board guidelines, they implement strong pseudonymization. They don't just dump the IDs into a massive data lake. No, they separate the ID from the rest of the user profile, replace it with a randomized token, and heavily encrypt the actual ID on a completely separate, ultra-secure server. This ensures the master keys stay safe even if the general user database ever gets breached. All right, Section 5, Knowledge Check. Test your understanding. Time to see how well we can apply these rules in practice. Question 1. An organization wants to use a national ID as a general account number because the user provided consent. Is this compliant under Article 87? A. Consent overrides Article 87. B. No. Local laws and mandatory safeguards still apply. C. Yes, if it is a small business. Or D. No. IDs can never be processed. Take a second to think about the relationship between user consent and specific member state rules.
The correct answer here is B. Consent does not bypass specific member state conditions. The law absolutely forces you to respect local restrictions, regardless of whether the individual gave consent. You simply cannot contract your way out of a national restriction on ID processing. Plus, using an ID as a general account number, that clearly lacks the appropriate safeguards we just talked about.
Moving on to question 2. What is the primary function of Article 87 within the GDPR framework? A. To create an EU-wide digital ID. B, to ban the collection of national identifiers. C, to allow local member states to set specific conditions with required safeguards. Or D, to harmonize all ID processing under a single rule. Think back to what the lawmakers specifically conceded here. And the answer is C. This right here is the absolute essence of the article. It's a deliberate, calculated choice by lawmakers to leave this highly sensitive issue partially up to national governments. It gives them that margin of maneuver and is, frankly, the exact opposite of absolute harmonization. All right, question 3. Which of the following best represents an appropriate safeguard when processing an ID number? A, storing it in plain text in a global database. B, publishing it in an internal company newsletter. C, applying strict pseudonymization and access controls. Or D, sharing it freely among third-party marketers. Based on regulator guidelines, what's our technical gold standard? The answer for sure is C. Regulators fully expect to see concrete security measures, and strict pseudonymization is absolutely the gold standard for protecting these master keys. If you're storing an ID in plain text, you are essentially leaving the bank vault wide open for attackers to steal the most sensitive data point a citizen possesses. And our final question. Question 4. A hospital suffers a data breach exposing patient national IDs because the database was unencrypted. What specific part of Article 87 did they violate? A, the first sentence on member state conditions. B, the requirement to use appropriate safeguards. C, the right to data portability. Or D, the freedom of expression. Look really closely at the explicit wording of the article we've been breaking down. The answer is B. Failing to protect that data is a direct, clear-cut violation of the explicit safeguard requirement written directly into the article. I mean, just look at massive enforcement actions, like the Bulgarian National Revenue Agency breach, which resulted in a 2.6 million euro fine under a CDP penalty decision. Failing to secure sensitive databases against breaches leads to intense regulatory scrutiny and just devastating financial penalties. Finally, Section 6, takeaways and next steps. Summary and resources. Let's quickly wrap up this explainer with the most critical lessons you need to remember. Your main takeaway is that when it comes to national IDs, absolute harmonization takes a total backseat to local laws and rigorous data security. You must map the local laws for every single country you operate in. You must treat the ID as the highly sensitive master key that it is, no lazy data practices allowed. And you must implement appropriate technical safeguards like encryption and pseudonymization. It's a hard legal requirement, not just an optional IT suggestion. Hey, if you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale that education globally. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam and certification prep resources, you can absolutely explore privacyunit.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyunit.com is really designed for learners who prefer a more structured, step-by-step learning experience. I'll leave you with this final thought. If your organization operates across borders, do you truly know where all your ID data lives and exactly which local laws govern it? Take the time to audit your systems, verify your technical safeguards, and ensure you aren't treating a master key like just another random piece of data. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks so much for joining me on this explainer, and keep learning.
All right, let's jump right into this explainer on GDPR Article 88. Have you ever wondered how your employer can legally track your work, process your payroll, or, read your emails without crossing a massive legal line? Well, you are definitely in the right place. Today, we're unpacking exactly what happens when the incredibly strict privacy rules of the GDPR collide with the everyday realities of the modern workplace. As you'll see, employee data requires a completely different rulebook.
So here's our roadmap for today. We're going to start with the Employment Data Challenge, decode Article 88 itself, look at some real-world scenarios, discuss enforcement and common mistakes, walk through a mini case study, and then wrap it all up with a quick quiz and our key takeaways.
Section 1. Let's start with a fundamental truth about the modern workplace, and really, the whole reason Article 88 even exists. Okay, think about this for a second. Can an employee ever truly consent to having their data processed when their paycheck is on the line? The crucial point here is the inherent power and economic imbalance between an employer and an employee. I mean, saying no to your boss isn't exactly a free choice when your livelihood, your next promotion, or just your daily work environment is hanging in the balance, right? Because of this, regulators and the European Data Protection Board, the EDPB, view traditional consent in the workplace with a lot of suspicion. Imagine handing a new hire a contract on day one that basically says, sign here to consent to all data processing. That consent, it's almost certainly invalid because it wasn't freely given. And this creates a massive challenge. If employers can't rely on consent, how on earth do they legally process the data they actually need to run their business?
Moving on to Section 2, decoding Article 88. Because of this massive power imbalance we just talked about, the GDPR includes a specific opening clause to address it. So Article 88 essentially functions as a highly specialized toolkit. It allows member states, or collective agreements like the ones made with the Works Council, to create specific customized rules just for the workplace. It's basically the GDPR saying, look, we know employment is a unique situation, so individual countries and unions can lay down more specific rules for things like hiring, firing, payroll, and workplace monitoring. But, and this is a really massive but, these customized rules absolutely cannot override a worker's fundamental rights. They're specifically meant to add protection, not strip it away.
Now, what's really fascinating here is that these national rules aren't just a blank check for employers. Article 88, paragraph 2, right alongside recital 155, draws a very hard line. Any specific national law or works agreement must include strict, actively applied safeguards. They have to specifically protect human dignity, ensure total transparency, and be incredibly careful when it comes to things like workplace monitoring systems or transferring employee data around a corporate group. If a national law just copies and pastes the baseline GDPR text without adding these highly specific employment safeguards, well, it completely fails the Article 88 test.
Section 3. Let's look at some real-world scenarios to see how this actually plays out in practice across different types of organizations.
Okay, let's break down 3 quick scenarios. First, imagine a tech firm that wants to introduce productivity tracking. Because they can't just ask their employees to consent, they sit down with a works council and negotiate a strict collective agreement. This agreement protects worker dignity while still allowing for reasonable tracking. That right there, that's Article 88 in action.
Scenario 2, a small business processing payroll data. Now, they don't need a works agreement for this because they're processing the data under a strict legal obligation to pay taxes and wages. Simple enough. But then there's scenario 3, a major compliance failure. Imagine a company secretly monitoring employee emails just to catch them scrolling social media on company time. Because it's done in secret, it completely fails the transparency and human dignity safeguards, and that is going to lead to some massive fines. Section 4, enforcement and mistakes. So what actually happens when employers get this wrong? Regulators are paying very close attention. One of the most massive mistakes an employer can make is assuming that their internal company policy reduces an employee's privacy to zero. We've actually seen this play out in major human rights cases, like Burbalusca v. Romania at the European Court of Human Rights. In that specific case, an employee was fired for using the work internet to send personal messages, but the courts firmly established that even if an employer has strict policies in place, an employee's right to a private life in the workplace simply cannot be reduced to absolute zero. Employers constantly make the mistake of over-relying on coerced consent, or they install aggressive camera systems and completely forget that the general GDPR principles like data minimization still absolutely apply. Now, this quote from the Court of Justice of the European Union, the CJU, is a massive warning for both businesses and lawmakers. In case C-3421, the CJU ruled that if a national employment law lacks those specific tailored safeguards for human dignity and transparency that Article 88 requires, regulators will just completely disregard that national law. Literally, they will throw it out and apply the strict baseline GDPR rules instead. You absolutely cannot use a weak national law as a shield to process employee data. Section 5. Let's put you in the driver's seat with a realistic mini case study to bring all of this together. Okay, imagine your company wants to replace old-school punch cards with facial recognition time tracking. Step by step, we can see that implementing this requires some intense scrutiny. You're processing highly sensitive biometric data under a massive power imbalance. Now you might be thinking, hey, we got the Works Council to sign a collective agreement, so we're good to go, right? Actually, wrong. Under the recent CGU case CC65/23, even if a Works Council agrees to it, the processing must still be strictly necessary under the core GDPR principles of Article 5. A collective agreement doesn't give you a free pass to just ignore data minimization. If a standard plastic keycard works just as well as facial recognition, you probably can't legally justify using facial recognition. It's really that simple.
Section 6. Time for our quiz and key takeaways. Let's test your understanding with a few certification-style scenario questions.
Question 1. If your employer wants to monitor your emails and asks for written consent right there in your employment contract, is that consent valid under the GDPR? Think back to that power dynamic we established at the very beginning. If you're handed a contract on your first day, how free are you, really, to cross out a clause about email monitoring?
And the correct answer is B. Because the employee's livelihood is on the line, their consent cannot be considered freely given. Employers generally have to find another legal basis, like legitimate interest, and balance it very carefully against the employee's rights, or they have to rely on a specific law or works agreement.
Next up, question 2. What happens if a national law that's meant to protect employees actually falls short of Article 88's strict human dignity requirements? Does that weak law still stand, or do the courts intervene?
The answer is C. Regulators and courts will completely bypass that weak national law and hold the employer directly to the stringent standards of the general GDPR. A weak law offers absolutely no protection for the employer's processing activities.
Question 3. Does signing a collective agreement act as a get-out-of-jail-free card that lets a company just bypass general GDPR principles? Think back to our facial recognition case study we just talked about. The answer is B. A collective agreement is definitely a valid tool under Article 88 to set specific rules, but it's not an exemption from the law itself. Core principles like data minimization, fairness, and strict necessity always apply no matter what the union signs.
Final question. When you use a company laptop, do you surrender all your privacy rights simply because the boss owns the hardware?
The answer is C. An employer cannot secretly monitor staff, and, as established in key human rights case law, an internal company policy cannot reduce a worker's privacy to absolute zero. There is always a baseline expectation of privacy, even when you're on the clock.
So to wrap everything up today, remember that the power imbalance is the absolute key to understanding Article 88. Employers have to rely on specific safeguards and legal necessities, not coerced consent. And while Article 88 does allow for custom workplace rules, those rules must actively protect human dignity, and the core GDPR principles of data minimization and transparency will always rule the day. Which leaves us with a pretty big question for the future. As AI and automated workplace surveillance tools become cheaper and vastly more advanced, will Article 88 be enough to protect our minds at work, or just our emails?
Leaving that question hanging for just a moment, if you enjoy these GDPR explainers and would like to support the channel, please consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to absolutely everyone and use AI to scale education globally. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and exam prep resources, you can explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available here, while privacyuni.com is designed for learners who prefer a more structured, comprehensive learning experience. Finally, a quick disclaimer. This content is provided for educational purposes only and does not constitute legal advice. Content might include mistakes. Thanks so much for joining me, and I'll see you in the next one.
Welcome to this Privacy Trainer Explainer. Today, we're tackling something absolutely crucial, the bridge between human progress and fundamental privacy rights. We're talking about GDPR Article 89. This is literally the part of the law that answers a massive question. How exactly can we innovate, conduct research, and archive history without completely trampling on the personal data of everyday people? It's a fascinating balance, so let's just dive right in. You know, this is the ultimate innovator's dilemma in the privacy world. Because on one hand, society absolutely needs data. We need it to cure diseases, to build incredible AI models, and, to preserve our shared history. But on the other hand, individuals have a fundamental right to keep their personal lives private. Right? So Article 89 solves this exact dilemma by giving us a specific legal framework. But, and I really have to warn you here, misunderstanding this delicate balance can lead to some truly catastrophic compliance failures. Regulators are paying very, very close attention to organizations that try to use the word research as a convenient excuse to just hoard data.
So here's our roadmap for today. We're going to unpack Article 89, run through the required safeguards and recitals, check out some real-world applications, dive into a practical step-by-step case study, and wrap it all up with a quick knowledge check to make sure you've got this locked down.
Okay, to really understand Article 89, you first need to see exactly where it fits into the broader GDPR framework. Normally, under standard processing rules, you collect data for one very specific purpose, and you can only keep it for as long as necessary for that initial purpose. That is the bedrock of GDPR, purpose limitation and storage limitation. But Article 89 steps in and creates some pretty powerful exemptions. If you're processing data for archiving in the public interest, or for scientific, historical, or statistical purposes, the law basically says, hey, we'll allow you to repurpose this data and we'll even allow you to keep it longer. But, and this is a massive but, you only get to do this if you play by a very strict set of rules.
Now, what's really interesting here is recent case law. Specifically, case C484-24 directly ties Article 89 to this ability to store data longer. The courts have made it crystal clear. Yes, you absolutely can get an exemption from standard storage limitations for your research, but that extended storage is legally chained to your implementation of appropriate technical and organizational safeguards. Basically, if you drop those safeguards, you instantly lose the exemption, and you're suddenly unlawfully hoarding data.
When you look at the fine print of Article 89, it talks a lot about derogations, which is really just a fancy legal word for exceptions to the rules. Lawmakers actually allow member states to pass laws that restrict certain data subject rights, like the right to access, rectify, or object to processing. And why is that? Well, think about it. If 1 million people suddenly asked a university to delete their data from a massive, decade-long cancer study, it would completely ruin the research. However, the catch is, you can only ignore these rights if honoring them would seriously impair or render your research completely impossible. If we look at Recital 156, it unpacks the true intent of the lawmakers beautifully. It essentially tells us, look, you are absolutely encouraged to conduct your research, but you must aggressively minimize the data you expose. You have to put a protective shield between the data subjects' identities and the researchers who are actually analyzing the trends. So the primary goal here is to ensure the principle of data minimization is always respected, even when you're doing really expansive research. And this brings us to the absolute primary safeguard demanded by Article 89, Paragraph 1, pseudonymization. It's pretty straightforward. If you don't actually need real names to do your statistical analysis, you must mask them. You separate the identifying details from the research data, and you lock the key away securely. If you can achieve your research goal without knowing that John Doe is the subject, the law explicitly requires you to do it that way. Let's look at how this actually plays out in the real world. Say you have an AI developer doing broad scientific research using heavily pseudonymized data. That is a great valid use of the exemption. So is a local historian archiving town records in the public interest. But look at that final scenario on the table. A retail store indefinitely hoarding customer marketing data, and they're trying to just call it statistical research purely to avoid deleting it. That is a blatant compliance failure, and I guarantee you it is exactly the kind of thing regulators love to punish.
So avoiding these common misunderstandings is absolutely critical. The biggest myth out there by far is that research is some sort of magic password that lets a business analyze whatever they want forever. Spoiler alert, it doesn't. Internal business analytics just to sell more shoes is absolutely not scientific research. Other major mistakes we see all the time include failing to actually implement pseudonymization, keeping data forever without any specific research area defined, and assuming you automatically get to ignore user rights. Remember, those derogations require actual member state or union law to back them up. From an enforcement perspective, regulators are looking heavily at this timeline of case law. Cases like C3421 and C23122 confirmed that yes, you can repurpose data for science. But then case C48424 clamped down hard. It clarified that storage limitations are strictly tied to those safeguards we talked about. What this means for you practically is that if a regulator ever knocks on your door and you claim an Article 89 exemption, you better have documented rock-solid proof of your technical and organizational measures. Without that documentation, you literally have no defense. Let's put this into practice and walk step by step through a realistic scenario. Imagine a health app that tracks daily steps. The business wants to pivot, and they want to use this massive data set for a legitimate new medical study on cardiovascular health. The privacy issue? Well, the users originally consented to step tracking, not medical research. So step 1 is confirming the new project actually qualifies as scientific research. Step 2, they apply Article 51B, which gives them a presumption of compatibility, meaning the law says this new research purpose isn't inherently incompatible with the old tracking purpose. And finally, step 3, they must implement strict pseudonymization under Article 89(1) before the researchers ever even touch the data. Do that and boom, pivot complete, fully compliant.
All right, it's time for our certification-style knowledge check. Let's test your practical understanding of purpose compatibility. A tech company collects data for customer service, but now wants to use it for an academic AI research project. Under GDPR, is this allowed? Take a few seconds to look at the options. Is it A, no purpose limitation forbids new use? B, yes, but only with new consent? C, yes, further processing for scientific research is not considered incompatible? Or D, yes, because tech companies are exempt? If you guessed C, you nailed it. Article 51B creates a specific presumption of compatibility for scientific research. As long as the Article 89 safeguards are met, using that data for a new scientific research purpose is generally considered totally compatible with the original collection purpose. Let's move to the next question. Let's test your understanding of data minimization when identities are no longer needed. To rely on Article 89 exemptions, what must an organization do if the research purpose can be fulfilled without identifying data subjects? Is the answer A, pseudonymize the data, B, anonymize the data, C, encrypt the database, or D, delete the data immediately? The correct answer here is B. Now, while pseudonymization is a really great tool, Article 89(1) strictly dictates that if the research can be fulfilled using data that does not permit identification at all, meaning anonymized data, it shall be fulfilled in that exact manner. Anonymization is always the gold standard if the scope of the research allows for it. Okay, question 3. This one deals with how to handle a mixed data set, which is a very common pitfall for large organizations like hospitals and universities. If they have a data set with both administrative HR data and scientific research data, can they apply Article 89 derogations to the whole thing? Take a quick look at the options on your screen.
The correct answer is D. You definitely can't just blanket your entire organization in a research exemption. Article 89.4 clearly mandates that if processing serves multiple purposes, the derogations are strictly isolated and they only apply to the specific data processing being done for the research portion. No free rides for the HR data. Final question. Do you get a free pass on privacy rights just because your organization is doing research? Look closely at the choices here. A, yes, automatically. B, no, it requires union or member state law. C, yes, if under 250 employees. Or D, no, rights can never be derogated. And the answer is B. This is a huge trap for compliance professionals. You cannot just ignore data subject rights on your own authority. You must rely on specific union or member state laws that activate these Article 89 derogations. So always check your local jurisdiction. To wrap things up today, let's hit our rapid-fire key takeaways for Article 89. I highly recommend memorizing these if you want to keep your compliance programs totally secure. Number 1, research is a privileged purpose, absolutely, but it is not a free pass to ignore privacy. 2, purpose compatibility allows you to legally repurpose data for science. 3, you do get extended storage limits, but only if you have strict safeguards in place. 4, pseudonymization and anonymization are your best friends here. And 5, derogations from user rights always require backing from member state or union law. I'll leave you with this provocative thought to audit your own systems. Ask yourself, are your current data analytics truly research in the eyes of the law, or just a convenient excuse to hoard data? Be honest with yourself before a regulator ends up making the decision for you. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer: this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks for joining me on this explainer, and keep safeguarding that data.
Hey everyone, and welcome to Privacy Trainer. Today, we're unpacking the grand compromise of GDPR Article 90, and we're going to explore exactly how the law protects some of society's absolute oldest trusts.
Here is our quick roadmap for today. First, a hook and overview, then recitals and examples. After that, enforcement and a case study. We'll follow that up with a knowledge check and wrap things up with takeaways and our outro.
All right, part 1, hook and overview, the ultimate balancing act.
So picture this scenario for a second. What actually happens when a GDPR investigator knocks on a clinic's door and demands to see a doctor's patient files? It's a question that highlights a massive real-world problem. You see, data protection authorities have sweeping powers to investigate organizations, right? But doctors, lawyers, and bankers are legally bound to never reveal client data. So, who wins?
This right here is literally an unstoppable force meeting an immovable object. On the left side, you've got Article 58 of the GDPR. This is what gives regulators their investigative teeth, meaning sweeping access to premises and data. But on the right side, you have national professional secrecy laws demanding absolute confidentiality for specific professions. Article 90 exists for one very specific reason: to resolve this exact tension between a regulator's right to audit and a professional's duty to maintain absolute confidentiality.
Now, to really grasp this article, we have to understand that professional secrecy isn't just a nice-to-have preference. It is a strict legal duty. In many jurisdictions, it's the ethical foundation for medicine, law, and banking. And honestly, it's protected as a fundamental form of the right to respect for private life. If a lawyer or a doctor violates this trust, they don't just get a slap on the wrist. We're talking potential criminal charges.
Okay, let's break down the actual legal parameters and see how this builds. Article 90 empowers member states to create their own specific rules, which can limit a data protection authority's access to premises and data. But there are major guardrails here. It applies only to professions actively bound by secrecy, the limitation has to be necessary and proportionate, and crucially, it only protects data received during that specific secret activity. So in plain English, Article 90 empowers individual countries to write specific exceptions that shield secret keepers from standard GDPR investigations, provided that shield is proportionate and strictly limited to protected client data.
Moving right along to Section 2, recitals and examples, bringing the law to life.
Notice the specific wording of Recital 164 here. I really want you to focus on the word reconcile. It brilliantly illustrates that privacy rights and professional secrecy are not enemies. The goal isn't for one to crush the other. The goal is to carefully reconcile them so they can coexist without undermining each other. Let's look at how this plays out in different industries, because it gets interesting. Say you have a tech company processing data for a health app strictly under a doctor's orders. Those specific records might be shielded from routine DPA access. Or consider a small local law firm being audited. Their highly sensitive client files are absolutely protected, but their basic administrative payroll data, yeah, that must be turned over to the regulator. And what about a classic compliance failure? Imagine a bank executing a blanket refusal, just denying a DPA access to their entire building. They're going to get fined heavily because secrecy only covers banking data, not employee HR files or cafeteria records. So these examples show us that Article 90 is a precise scalpel. It is not a broad shield. It protects specific confidential data while leaving general business operations completely open to regulatory scrutiny.
Section 3, Enforcement and Case Study, Regulatory Realities.
You have to know that regulators are highly trained to spot abuse of this rule. The most common compliance failure we see is an organization just assuming their entire business is immune to GDPR audits. They completely misunderstand the scope of protected data, or they fail to actually document the national legal basis that grants them the secrecy in the first place. Regulators will penalize you if you cannot precisely prove which specific files are shielded by national law. For instance, if you look at the recent C313/23 case regarding banking secrecy limits, it becomes obvious that you have to categorize your data meticulously. You can't just guess.
Let's walk through a mini case study.
We'll call it the lawyer's dilemma. So a DPA audits a law firm and demands access to all their servers. The issue, of course, is that these servers hold highly confidential client litigation files. The correct step-by-step analysis asks, does national law actually provide an Article 90 exemption? In this case, yes. Therefore, the resolution is that the firm hands over HR and marketing data to the regulators, but they lawfully shield the client files. Walking through this, we see that the correct analysis requires you to segregate your data in advance. You have to be ready to comply with an audit of regular business files while legally blocking access to privileged communications, echoing precedents just like the Brito Farino case regarding professional confidentiality.
All right, Section 4. Time for a quick knowledge check to test your understanding. Question 1. A DTA attempts to audit a medical clinic's patient records. Under Article 90, what must the member state's national law balance? Is it A, corporate profits and privacy? B, DPA investigative powers and professional secrecy? C, data security and implementation costs? Or D, data subject consent and legitimate interest? Think back to those two conflicting forces we discussed at the very beginning of this explainer. If you guessed B, you hit the nail on the head. Article 90 is explicitly designed to reconcile the investigative powers of the supervisory authority with the sacred obligation of professional secrecy.
Let's try question 2. A bank refuses to give a DPA access to its employee payroll records, citing Article 90 banking secrecy. Is this compliant? A, yes, banks are entirely exempt. B, no, secrecy only covers data received in the covered banking activity. C, yes, if the payroll includes executive salaries. Or D, no, Article 90 does not apply to banks at all. Consider the exact scope of what the law actually protects here.
The answer is B. Article 90 only protects personal data obtained specifically during the activity covered by the secrecy obligation. This means standard administrative data, like payroll, is absolutely not exempt from DPA audits. Simply put, you can't hide your HR files behind a banking shield.
Question 3. Which specific GDPR provisions does Article 90 allow member states to modify regarding supervisory authorities? A, the power to issue administrative fines. B, investigative powers of access to data and premises. C, the ability to approve binding corporate rules. Or D, the power to order data erasure. Recall the specific powers we contrasted with national secrecy laws earlier on.
The correct answer is B. Article 90 explicitly references points E and F of Article 58(1), which govern the DPA's investigative powers to access premises and data processing equipment.
And our final question, question 4. In the context of a DPI investigation into a law firm, if national law lacks specific rules safeguarding professional secrecy under Article 90, what happens? A, standard GDPR investigative powers apply. B, the DPA is automatically blocked by the EU Charter. C, the law firm decides what to disclose. Or D, the investigation is transferred to the police. Remember that Article 90 says member states may adopt specific rules, implying an action is actually required by the country.
The answer is A. Article 90 is an enabling provision. This means if a member state hasn't proactively adopted specific shielding rules in their own laws, the standard GDPR investigative powers remain in full effect, and the regulator's door to your data is wide open.
Which brings us to Section 5, takeaways and our outro.
So what's the most critical thing to remember from all this? Article 90 empowers member states to write specific exemptions, but it protects specific confidential data, not entire businesses. The exemption always has to be necessary and proportionate. Ultimately, Article 90 proves that the GDPR really is flexible enough to enforce modern data rights without destroying the ancient foundational trust between doctors, lawyers, bankers, and their clients.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyunit.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyunit.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I want to leave you with this final thought today. As data becomes increasingly weaponized, is professional secrecy our last true bastion of absolute privacy, or merely a loophole just waiting to be exploited? Thanks for joining us, and I'll see you next time.
All right, welcome back to Privacy Trainer. Today we are tackling a really fascinating and honestly often misunderstood part of the law. Let's dive right into this explainer and demystify Article 91. This is the section that deals with the very unique intersection of data privacy and religious organizations. Now, you might assume that the GDPR just applies a blanket rule to absolutely everyone across the board, right? Well, not quite. Churches and religious associations actually have a distinct historical and constitutional standing in Europe. So Article 91 is basically the law's way of bridging the gap between that deep-rooted autonomy and our modern privacy rights.
Here is a quick look at our agenda for today's explainer. We'll start with a broad overview, then we'll unpack the legal text itself, dive into some real-world applications and enforcement, break down a really important landmark case study, and then finally wrap things up with a knowledge check.
Okay, moving into Section 1, Overview and Hook, why Article 91 actually matters. So, if you're a privacy professional, legal counsel, or maybe you work within a nonprofit or religious sector, getting Article 9 wrong is a literal recipe for disaster. Why is that? Well, because data that reveals religious beliefs isn't just your standard run-of-the-mill personal data. Under Article 9 of the GDPR, it's actually classified as a special category of data, meaning it is highly sensitive. So mishandling this doesn't just mean a tiny slap on the wrist, it can lead to massive penalties and severely damage the trust of some very vulnerable community members. But that brings up a fair question. Why do churches even get their own specific GDPR article in the first place? It's a balancing act. The GDPR has to weigh the fundamental right to data privacy against the fundamental right to freedom of religion, plus the historical autonomy of churches. For decades, a lot of European churches already had their own internal data protection rules. So Article 9.1 was written to answer a super practical question. Do these churches have to throw out their historical rules completely, or can they keep them? Let's move to Section 2, unpacking the legal text and recitals. Let's see what the law actually says here, paragraph by paragraph. So before we even get to the main text, we absolutely have to look at Recital 165. This is crucial because it confirms that the EU respects the historical autonomy of religious communities. It's essentially merging ancient tradition with modern digital regulation. The GDPR explicitly states it is not going to trample over Article 17 of the Treaty on the Functioning of the European Union, which is what guarantees the organizational autonomy of churches. This really sets the stage for paragraph 1 of Article 91, which basically says that if a church or religious association had comprehensive data protection rules already in place when the GDPR entered into force, they can just keep applying them. But, as we're going to see in a second, respect for autonomy does not mean a free pass on privacy. And that brings us to the difference between standard oversight and Article 91 oversight. So, paragraph 1 says, sure, keep your legacy rules. But paragraph 2 drops the hammer. It says those rules must be brought entirely into line with the GDPR. They have to meet that strict, modern protective baseline. And it doesn't stop there. Article 91 explicitly states that a church cannot just police itself. They must be subject to an independent supervisory authority. Now, it can be a specific authority created just for the church, but it absolutely must be genuinely 100% independent. No external influence and no taking instructions from the church leadership itself.
Okay, Section 3, Real-World Application. Let's look at a few practical scenarios to see how this plays out.
Think about a standard tech company building a religious app or just a small local business. They're just going to use standard GDPR compliance frameworks, plain and simple. But where we see massive compliance failures is when a church relies on, say, pre-2018 internal rules without actually updating them to meet those strict independent oversight requirements. Imagine a large religious association saying, hey, we've got our own privacy rulebook from 2010, so we don't really need to worry about the GDPR. That is a huge direct violation. Their legacy rules might be missing mandatory data breach notification protocols, or they might not even give data subjects the right to erasure. Under Article 91, keeping your own rules is completely conditional upon bringing them up to the exact same protective baseline as the rest of the GDPR.
Moving into Section 4, Enforcement and Common Mistakes.
Regulators are definitely actively watching this space. When data protection authorities go in to audit religious organizations, they know exactly what kinds of excuses to look for. One massive mistake is just assuming that organizational autonomy automatically equals a privacy exemption. It absolutely doesn't. Regulators are going to look for documented, hard proof of an independent supervisory authority, not just the head pastor signing off on a policy document. Another really common misconception is thinking that internal church discipline or administration somehow operates totally outside the bounds of EU law. The reality is, the GDPR absolutely applies here. And if a religious community does set up its own supervisory authority, regulators will heavily scrutinize just how independent it really is. Like, does the investigator actually have the power to penalize the church leadership? If the answer is no, then it's not truly independent, and it completely fails the Article 91 test.
Let's look at Section 5, a mini case study on CJEU case C-2517. This is the famous Jehovah's Witnesses case. If you want to understand how the highest court in the EU views religious data processing, this is the one case you really must know. So, here's the scenario. Members of the Jehovah's Witnesses community were collecting personal data during their door-to-door preaching. They were actually taking notes on who they visited, what their religious beliefs were, and noting down who didn't want to be visited again. The court took a hard look at this door-to-door preaching activity and had to answer two massive questions. First, is this just a personal household activity? And second, who is actually responsible for this data? The court ultimately determined that because the community itself organizes and encourages this activity, they have de facto control. So they are joint controllers of that sensitive data, right alongside the individual preachers. Now, the GDPR does contain an exemption for purely personal or household activities. And the church argued, well, preaching is just a personal manifestation of faith. But the court ruled that because preaching is directed outwards to a potentially unlimited number of people, strangers at their homes, the GDPR's household exemption absolutely does not apply here, period. Furthermore, the court said that even though the central church didn't have direct access to those specific handwritten notebooks held by the preachers, the mere fact that the church organized the territories, coordinated the preaching, and encouraged it, well, that meant they exerted de facto control. And that makes them a joint controller, making them fully liable under the law.
All right, Section 6. It is time for a privacy trainer knowledge check. Let's test your practical understanding.
Question 1. Does the GDPR household exemption apply to members logging names during organized door-to-door preaching? Is it A, yes always, B, only if written, C, no it spreads outwards, or D, yes for religious groups? Think back to our case study here. Is collecting data on strangers really a purely private affair? Take a second to lock in your answer.
Okay, the correct answer is C. The court made it incredibly clear that bringing the message out into the public sphere to people entirely outside the faith completely nullifies that purely personal exemption.
Question 2. Can a religious community be a joint controller without direct access to the data? A, no access is required. B, yes via de facto control. C, only with written orders. Or D, never. Think about what actually constitutes control over data processing activities. Take a guess.
And the answer is B, yes, via de facto control. This really highlights that organizational influence alone is enough to trigger joint controllership. The CJU ruled that you do not need a formal written contract or direct database access. Just orchestrating and benefiting from the activity creates that joint liability.
Question 3. Under Article 91, churches can keep their own data protection rules if they A, are a recognized religion, B, register with the state, C, align with GDPR and have independent oversight, or D, keep data on paper. What were those strict conditions we talked about in the actual text of Article 91? Give it some thought.
The correct answer is C. You can absolutely keep your legacy rules, but they have to meet modern GDPR standards and, critically, they must be subject to an independent supervisory authority.
Last one, question 4. According to Recital 165, the GDPR respects the existing status of churches under what legal framework? Is it A, the Geneva Convention, B, Article 17 TFU, C, local city bylaws, or D, the Digital Services Act? This goes all the way back to the foundation of why Article 91 was even written. Lock it in.
The answer is B, Article 17 of the Treaty on the Functioning of the European Union. That's the bedrock text that balances our fundamental EU privacy rights with constitutional religious autonomy.
Let's wrap things up with some essential takeaways. First, Article 91 is a very delicate balancing act between religion and privacy. Second, always remember that religious data is highly sensitive under Article 9, which means the stakes are incredibly high. Third, legacy rules are perfectly fine, but they absolutely need strict GDPR alignment. Fourth, independent supervision is non-negotiable. You literally cannot mark your own homework. And finally, as that CJEU case showed us, religious autonomy doesn't just give you a free pass to bypass the GDPR when you're dealing with the public. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks so much for joining me on this explainer. I'm going to leave you with this one final thought. Is your organization's oversight truly independent, or is it just a rubber stamp? See you in the next one. Welcome to another Privacy Trainer explainer. Today, we're taking a look at a highly administrative but absolutely crucial part of the GDPR, Article 92. Now, at first glance, I know it looks like just a bunch of bureaucratic boilerplate, but it's actually the hidden engine room that keeps our privacy regulations fully up to date with modern technology. Honestly, without it, the GDPR would probably already be obsolete. So, let's dive right in. Here's our quick agenda for this explainer. We'll start with the GDPR engine room, decode Article 92, look at its real-world application, jump into some enforcement and a case study, run through a rapid-fire knowledge check, and finally wrap up with your key takeaways and next steps.
All right, Section 1, the GDPR engine room, adapting to tech changes. Let's get to it.
So I want you to think about this for a second. How exactly does the GDPR adapt to rapid technological changes? Because rewriting a massive piece of European legislation through the standard process is incredibly slow. We're talking years. Yet things like AI, cloud computing, and advanced tracking, they literally evolve daily. So how do you keep a law from becoming completely useless the moment it's printed? Well, that is exactly where Article 92 steps in. Article 92 gives the European Commission the power to issue what are called delegated acts. You can really just think of a delegated act as a regulatory software patch. It's a brilliant mechanism that allows the Commission to push out real-time updates and highly technical standards without having to open up and mess with the foundational text of the GDPR itself. It's a real game changer. Moving right along to Section 2, decoding Article 92, mechanics of delegation.
Let's look at how this builds step by step in the background. First, power is granted. The GDPR leans on Article 290 of the TFEU, which is the broad treaty governing how the EU functions, and this allows lawmakers to delegate power for non-essential elements. Second, that power is exercised. The Commission gets to work setting precise technical requirements, like those needed for data protection certifications. And third, legislative review. The European Parliament and Council provide strict oversight, meaning they can actually revoke this delegated power at any time if they feel there's an overstep.
If we look closely at Recital 166, it reveals exactly why lawmakers included this in the first place. It explicitly states that delegated acts should be adopted specifically for things like certification mechanisms and standardized icons. So, you know when the EU decides to roll out a universally recognized privacy seal. They don't have to rewrite the whole GDPR to do it. They just use Article 92 to push out the new technical specs.
Okay, Section 3, real-world application, impacts on business.
This delegation of power creates two very different realities depending on your size. Imagine a massive tech company. They absolutely must proactively track these legislative patches. If the Commission issues a new delegated act that changes certification criteria, that giant company has to go in and re-architect their global systems. But a small business, they have a much simpler path. They basically just need to make sure they're buying software from vendors who actively maintain those officially updated, Commission-approved certifications.
Now, if you misunderstand this dynamic, you're going to fall into some pretty common compliance traps. The biggest one, treating the GDPR like it's some frozen static document. If you falsely believe your initial 2018 compliance effort acts as a permanent shield, you are going to completely miss the crucial updates pushed out through these delegated acts. Please never assume Article 92 is just internal bureaucracy for the regulators. It directly shapes the exact technical standards your business is going to be measured against.
Let's look at Section 4, Enforcement and Case Study, Meeting Today's Standard.
Let's walk through a realistic scenario. Imagine you're launching a brand new health tech cloud service. Your main business challenge is proving absolute data security to your hospital clients. So the GDPR question becomes, which Article 42 certification standard actually applies to you right now? Well, when regulators investigate your security claims, much like we've seen in broader enforcement cases, where DPAs scrutinize outdated security frameworks under decisions like case number 2021-03 or similar precedent, they won't just look at the high-level GDPR text. No way. They are going to evaluate your evidence against the precise current technical standards the Commission most recently enacted via an Article 92 delegated act. Basically, you have to meet the standard of today, not yesterday.
All right, Section 5, time to test your knowledge with some certification prep.
Here's our first scenario. Your organization is applying for an Article 42 data protection certification. Under Article 92, who has the power to adopt the specific delegated acts that define these certification requirements? Is it A, the local DPA, B, the European Commission, C, the data controller, or D, the EDPB? Take a second and lock in your answer.
And the correct answer is B. Article 92 explicitly grants this really unique legislative updating power specifically to the European Commission, allowing them to define all those granular technical requirements for the certifications.
Moving on to the next question. This one tests your understanding of the limits placed on this immense power. The Commission issues a new delegated act. A compliance officer argues this act is invalid because it changes fundamental data subject rights. Is the officer correct? A, yes, delegated acts can never be issued under GDPR. B, yes, delegated acts cannot alter the essential elements or fundamental rights of the law. C, no, the Commission can rewrite any part. Or D, no, they only apply to criminal investigations. What do you think?
The answer here is B. This is a crucial distinction. While the Commission can issue technical updates, like our software patch analogy, they absolutely cannot rewrite the core fundamental rights guaranteed by the GDPR itself. The essence of the law always remains fully protected.
Okay, question 3. Let's look at real-world risks.
A technology vendor ignores a recent delegated act detailing new criteria for a data protection seal, assuming the original 2016 GDPR text is all that matters. What is the primary compliance risk here? A. Their existing seal becomes invalid. B. Forced relocation outside the EU. C. A direct fine from the European Parliament. Or D. No risk, it's totally optional.
Yup, the answer is A. Treating the GDPR as static is a massive, massive failure, because Article 92 is constantly working in the background to modernize requirements. Ignoring those updates means your hard-won certifications can quickly just become invalid.
For our final question, let's connect the core article back to its most important explanatory recital. You are interpreting Article 92 and look to the recitals. According to Recital 166, which specific area is highlighted as requiring delegated acts? A. Calculation of fines. B. Requirements for certification mechanisms and standardized icons. C. Format of consent checkboxes. Or D. Appointment criteria for an LSA.
And the correct answer is B. As we touched on earlier, Recital 166 explicitly connects the European Commission's delegated powers directly to the creation of robust, standardized certification mechanisms and those easily recognizable privacy icons.
All right, Section 6, takeaways and next steps. Applying compliance.
Let's summarize all this into a few actionable points. First and foremost, you've got to view GDPR compliance as an active, ongoing process. Article 92 is the vital update mechanism that empowers the European Commission to issue delegated acts. And because these acts dictate the reality of technical standards and certifications, your compliance teams absolutely must continuously monitor these EU-level updates. Simply reading the original text printed years ago just isn't going to cut it anymore.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. Also, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I'll leave you with this one final thought. When was the last time your organization actually checked if its vendor certifications meet the most recent delegated act, rather than just relying on the baseline standards from 2018? Something to think about. Thanks for tuning in, and I'll see you in the next explainer.
Welcome back to Privacy Trainer. Today, we're doing something a little different. We're heading straight into the engine room of the GDPR to unpack Article 93. Now, if you're a privacy professional, a lawyer, or a business leader, you might be tempted to just kind of gloss over those administrative articles at the back of the regulation. But trust me, you absolutely shouldn't skip this one. Article 93 is essentially the hidden mechanism that keeps global data flowing. Why should you care? Well, because if you don't understand how the rules of the game are actually made and updated, you're always going to be reacting to compliance changes instead of anticipating them. If organizations misunderstand this, they might mistake who actually holds the power to approve their compliance tools, and that leads to wasted time and totally misdirected lobbying efforts. All right, let's take a quick look at our roadmap for this explainer. We'll start with a welcome to the engine room, then we'll decode the procedure, look at some real-world practice, tackle a knowledge check, and finish up with your key takeaways and next steps. Okay, let's jump into Section 1, Welcome to the Engine Room. To really get why this highly administrative article matters to you, we first need to look at the massive problem it solves for international privacy and the broader EU framework. When international data transfers hit a sudden crisis, or when new standard contractual clauses need to be published, you might be wondering who exactly holds the power to adopt those new rules or, hit the emergency stop button. Now, the GDPR is a massive piece of legislation, right, passed by the European Parliament and the Council, but the day-to-day implementation of those rules, things like declaring a specific country adequate for data transfers, well, that falls to the European Commission. But here's the catch. Member states didn't just want to hand the Commission a blank check to make all these decisions without any oversight. They desperately needed a system of checks and balances. And that brings us to Article 93. It is quite literally the ultimate system of checks and balances. It translates all that dry legal text into a living, breathing framework. In plain English, Article 93 dictates that when the Commission wants to implement a new operational rule under the GDPR, they can't just act like a dictator. They have to be assisted and overseen by a dedicated committee made up of representatives from the member states. This guarantees that the operational reality of the GDPR reflects a true consensus across Europe, not just the will of the Commission sitting in Brussels. Moving right along to Section 2, Decoding the Committee Procedure. Let's actually look at the text of Article 93 and see how this bureaucratic engine is built step by step. Step 1. Article 93, paragraph 1 explicitly states that the Commission is assisted by a committee within the meaning of Regulation 182/2011. Now, this is a very famous piece of EU law governing something called comitology. That's just a fancy word for the overarching rules on how committees oversee the Commission across all EU sectors, not just privacy. Step 2. Article 93.2 points to the examination procedure. This is the standard, careful process where the committee formally reviews and votes on routine acts from the Commission. And finally, Step 3. We have to look at Recital 106. This recital explains that the Commission must constantly monitor its decisions, like those adequacy decisions, and report any findings right back to this very committee. So it creates this continuous loop of oversight. What's really fascinating here is that the GDPR actually has two distinct speeds. Lawmakers totally understood that privacy isn't always a slow, steady process. On one side, we have the standard examination procedure from 93.2. We use this when we have time to build consensus, like drafting new standard contractual clauses. But on the flip side, Article 93.3 introduces the urgency procedure. If a massive privacy threat pops up and there are duly justified imperative grounds of urgency, the Commission can adopt immediately applicable implementing acts. It's basically the GDPR's emergency brake. It lets Europe instantly suspend data flows to a rogue nation if they have to, completely bypassing those slow bureaucratic waiting periods. All right, Section 3, Article 93, in practice. So we know the rules, but how does all this comitology stuff actually impact tech giants and small businesses day to day? Let's take this out of the textbook and into the real world. Whether you're a scrappy startup or a massive multinational, Article 93 is the gateway for your compliance tools.
For instance, tech companies rely on adequacy decisions to freely transfer data all over the globe. As we saw in the famous case C311/18, the Schrems II ruling, when adequacy gets challenged, it throws the entire industry into absolute chaos. Reestablishing those rules, that happens through the Article 93 procedure. For small businesses, when an industry wants an approved code of conduct to make compliance cheaper and easier, the Commission uses this exact examination procedure to give it validity across the EU. Now, here is a super common mistake, confusing the Article 93 Committee with the European Data Protection Board, or EDPB. You have to understand the difference here. The EDPB is made up of independent privacy regulators giving expert opinions. The Article 93 Committee is made up of political representatives of the member states, giving the final administrative green light. They are two entirely separate bodies.
Let's walk through a real-world scenario so you can really picture this. Imagine your business heavily relies on an adequacy decision for a specific third country, but suddenly, that country passes a highly invasive surveillance law overnight, completely violating the fundamental rights of EU citizens. The Commission doesn't have months to debate this. Bam, they trigger the Article 93, Paragraph 3 urgency procedure. An immediately applicable implementing act is passed to suspend that adequacy decision. As a business, you don't get some nice, long transition period. Your legal basis for data transfer vanishes instantly, and you've got to immediately pivot to alternative safeguards, like SCCs or binding corporate rules. This shows exactly why understanding Article 93's emergency powers isn't just academic theory, it's absolutely vital for your daily risk management.
Let's move into Section 4, the knowledge check. It's time to test what we've covered with 4 professional-grade, scenario-based certification questions. These are designed to test your practical understanding, not just rote memorization. Read through this first one carefully, and think back to the administrative engine we defined earlier. Question 1. Under Article 93, which EU regulation dictates the rules for the committee that assists the Commission? Is it A, Regulation EC 1499/2001, B, Regulation EU 182/2011, C, Regulation EC 45/2001, or D, Regulation EU 883/2013? Take a second to decide. If you went with B, you nailed it. Regulation EU 182/2011 sets out the rules and general principles for how member states control the Commission's exercise of implementing powers. It is literally the backbone of the entire Article 93 process. Moving on to question 2. Consider the 2 speeds of the GDPR we talked about. When an imperative ground of urgency arises, and the Commission needs an immediately applicable act, which specific procedure is used? A, Article 93.1, B, Article 93.2, C, Article 93.3, or D, Article 93.4. And the correct answer is C. This perfectly illustrates how the law has that built-in emergency brake for critical privacy threats. While 93.2 is the standard procedure, 93.3 is specifically reserved for urgency. All right, question 3. This one is all about the system of checks and balances. When the Commission periodically reviews how well an adequacy decision is working, to whom must they report their findings? Is it A, only the EDPB, B, the Committee, the European Parliament, and the Council, C, the Court of Justice, or D, local data protection officers?
The answer here is B. As outlined in Recital 106, the Commission does not act in a vacuum. To ensure total transparency and robust oversight, they absolutely have to keep the Parliament, the Council, and the Article 93 Committee fully informed of their evaluations.
Last one, question 4. Let's test how you apply this to a real-world business challenge. Imagine you're a compliance officer waiting for the new SECs to drop. What is the specific role of the Article 93 Committee in this process? Do they A, issue the final judicial ruling, B, replace the EDPB, C, assist the Commission in the examination procedure for the implementing act, or D, issue administrative fines? If you chose C, fantastic job. You've perfectly grasped the operational reality here. This committee is an essential operational checkpoint. They do not issue fines. That's what supervisory authorities do. They don't make judicial rulings. That's for the courts. Their job is simply to assist the Commission in examining and approving those implementing acts. And finally, Section 5, takeaways and next steps. Let's distill all of this down into the most essential takeaways you need to remember for your day-to-day compliance work. Ultimately, while it might read like some dry bureaucracy at first glance, Article 93 is the beating heart of how the GDPR adapts to a rapidly changing global digital economy. It's the engine that generates your operational rules. It keeps the Commission in check through member state oversight. It allows for both careful deliberation and rapid emergency action. And perhaps most importantly for your organization, it is the absolute gatekeeper for crucial compliance tools like adequacy decisions, SCCs, and codes of conduct that you rely on every single day. If you're enjoying these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships really help us continue creating free privacy, security, AI, and compliance education for learners all around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education globally. Also, if you're looking to dive deeper with more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, and certification prep, you can explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available here, while privacyuni.com is designed for learners who prefer a much more structured learning experience. Before we go, a quick reminder. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Thanks so much for exploring the engine room with me today, and I'll see you in the next explainer. Welcome to Privacy Trainer. In this explainer, we're focusing on a part of the GDPR that is honestly incredibly easy to overlook. We're talking about Article 94. Now, at first glance, this looks like a purely administrative housekeeping provision. I mean, it's just 2 short paragraphs about repealing an old law. But definitely don't let its brevity fool you. This seemingly administrative article actually controls the legal fate of literally decades of legacy data. It's essentially the invisible engine that upgrades older legal frameworks across the entire European Union right into the modern era.
Okay, let's dive into this. Imagine the absolute chaos that would happen without a bridge between the old 1995 Data Protection Directive and the modern GDPR. Think about it. You've got thousands of databases, millions of user consents, and hundreds of national laws that were entirely built around a legal text that suddenly, on a very specific day in 2018, just ceased to exist. Without a transition plan, organizations would be totally in the dark, wondering if they had to delete absolutely everything and start from scratch. National governments would be scrambling to rewrite their legal codes, while Article 94 exists specifically to solve this massive problem. To really understand how it works, we need to look at the timeline. The European privacy landscape is basically divided into two distinct eras. You have the original era, which began way back in October 1995 with the enactment of Directive 95/46/EC. Now, this was the law of the land when the internet was still in its infancy. Then you have the modern era. May 25, 2018 is the absolute hard cutoff. That's the day GDPR enforcement officially began. Article 94 is the exact mechanism that sits right on that date, officially acting as the legal bridge transitioning the entire European privacy framework from the past right into the present. So let's look at the actual text of Article 94, Section 1. It states plainly, Directive 95/46/EC is repealed with effect from 25 May 2018. In plain English, lawmakers included this to ensure there was absolutely no confusion about which law ruled the land. The old directive is dead. You simply cannot rely on its interpretations, its looser definitions, or its outdated mechanisms after this date. If you're processing the personal data of individuals in the EU today, the GDPR is your master framework, period. And this brilliantly illustrates the second part of the article. Section 2 says, references to the repealed directive shall be construed as references to this regulation. Now, I like to call this the universal translator concept. Think about the hundreds of other laws, like the ePrivacy Directive or various national member state laws, that pointed directly to the 1995 directive for their definitions. Instead of forcing European lawmakers to manually hunt down and rewrite every single one of those interconnected laws, Article 94 acts as a universal translator. It automatically upgrades all those old references to GDPR standards. Plus, it explicitly transitions the old Working Party 29, which was the group of regulators under the 1995 law, into the modern European Data Protection Board, or EDPB. Now, to really apply Article 94 practically, you have to read it alongside Recital 171. This recital deals with the big question, what happens to all the data you collected before May 2018? It states that processing already underway must be brought into conformity with the GDPR. But crucially, it says you don't need to get consent from a user again if the manner in which the original consent was given is already in line with the much stricter conditions of the GDPR. So it essentially grandfathered in old, valid consent. But, and this is a big but, only if it could pass the modern test of being freely given, specific, informed, and an unambiguous affirmative action. Let's look at how this impacts everyday business across three real-world scenarios. First, take a massive tech company operating in Europe. Because of Article 94, the older ePrivacy Directive, which governs cookies, now relies on the GDPR's definition of consent. So that tech company literally had to completely overhaul its cookie banners to meet modern standards. Second scenario, a small business. Say they have a physical paper mailing list from a store event back in 2015. Well, they have to evaluate those physical signatures to see if they genuinely meet the GDPR's high bar for consent today. And third, a classic compliance failure, a company just assuming that an old opt-out checkbox from 2014 is still perfectly valid today. As you'll see in a minute, that is a highly dangerous assumption. Which brings us to some of the most common mistakes organizations make regarding this transition. The absolute biggest misunderstanding is assuming all legacy consent is just automatically grandfathered in. It's really not. Passively assuming your old data is safe is a massive compliance risk. Another huge mistake is ignoring how older sector-specific laws, like national telecommunications laws, now rely on GDPR definitions because of that universal translator effect we talked about. And finally, failing to document your analysis. If you decided to keep a pre-2018 database, you need documented proof showing exactly how that old data collection meets modern, strict standards. And let me tell you, during investigations, regulators take a very strict view on this. They focus heavily on Article 94 when scrutinizing legacy data or cookie banners. A landmark example is case C673/17, widely known as the Planet 49 case. In this ruling, the European Court of Justice used Article 94 to definitively tie the older ePrivacy Directive directly to the GDPR's strict definition of consent. The court made it crystal clear, because of Article 94, there's no way you can use outdated interpretations of consent when dealing with modern cookie placements. The standard has been upgraded across the board. Let's put you in the hot seat for a second with a mini case study. Step 1, your business challenge. Let's say your marketing team wants to launch a massive campaign using a legacy database compiled back in 2015. Step 2, the privacy issue. You dig into the old records and you find that the original consent was gathered using pre-ticked opt-out boxes. Basically, the user had to actively uncheck a box to not be added to the list. Step 3, the GDPR question. Does Article 94, combined with Recital 171, actually allow your organization to keep using this data today? So the crucial point here is the analysis of that consent mechanism. Under the old 1995 rules, some jurisdictions might have tolerated an opt-out approach. But the GDPR, it requires an unambiguous affirmative action. A pre-ticked box is literally the exact opposite of that. Therefore, that legacy consent totally fails the test laid out in Recital 17.1. The conclusion? That 2015 database cannot be used under its original premise. The organization has two choices. They must either run a repermissioning campaign, asking users to actively opt in using modern standards, or they have to delete the data entirely. Okay, time for a quick certification-style knowledge check to test our practical understanding. Question 1. A company collected consent in 2014 using a pre-ticked box. Under Article 94 and Recital 171, is this consent still valid today? Is it A, yes, it's grandfathered in, B, no, pre-ticked boxes do not meet GDPR standards, C, yes, if they later emailed the user, or D, only for non-sensitive data? Take a second and think about that Planet 49 case we just talked about. The correct answer is B, no. As we just discussed, the European Court of Justice in the Planet 49 case explicitly confirmed that pre-ticked boxes simply do not constitute valid consent under the GDPR. Because the original method doesn't meet the new, stricter standards, it completely fails the grandfathering test in Recital 171. The transition is strict, folks, and old habits do not survive it. Moving right along to question 2, a national member state law from 2010 directly references the old Directive 95/46/EC.
Does that national law need to be completely rewritten to apply to the GDPR? A, yes, immediately. B, no, Article 94 acts as a universal translator. C, yes, within a 2-year grace period. Or D, only if it involves criminal justice data. And the answer is B, no. This perfectly tests our grasp of that universal translator concept. Article 94, paragraph 2 clearly dictates that references to the repealed directive shall be construed as references to the GDPR. This elegant little legal mechanism saved European lawmakers an absolutely immeasurable amount of time, preventing them from having to systematically hunt down and rewrite thousands of interconnected laws across the entire continent. Okay, question 3, which brings in real-world regulatory application from our sources. The ePrivacy Directive relies on the definition of consent from the old 1995 directive. According to EDPB Guidelines 2020-05, how is this handled post-2018? A, it continues to use the old 1995 definition. B, the ePrivacy Directive is repealed. C, it relies on the GDPR's definition via Article 94. Or D, consent is no longer required for cookies. Yep, the correct answer is C. It relies on the GDPR's definition. The EDPB guidelines specifically state that because of Article 94, the conditions for obtaining valid consent under ePrivacy are automatically upgraded to match the GDPR. Now, it is worth noting that Article 95 of the GDPR ensures no additional obligations are created beyond the objective of the ePrivacy Directive itself, but the foundational standard of what actually constitutes consent is absolutely and universally upgraded. All right, our final question, question 4, focusing on the administrative shift. Under Article 94, what happens to the working party on the protection of individuals established by the old 1995 directive? A, it is permanently disbanded. B, it translates into the European Data Protection Board, or EDPB. C, it merges directly with the European Commission. Or D, it remains unchanged. And the answer is B. It translates right into the European Data Protection Board. Article 94 explicitly states that references to the old Working Party 29 should now be read as references to the EDPB, ensuring a completely smooth transition of regulatory guidance and authority. Great job if you got all of those right. That wraps up our knowledge check. So let's wrap this all up and summarize the core lessons here. First, the 1995 directive is officially dead. You absolutely cannot rely on it for processing data today. Second, Article 94 is incredibly powerful because it acts as a legal universal translator, updating older frameworks automatically. Third, any legacy consent you currently hold is only valid if it meets the strict affirmative standards of the GDPR. Fourth, cross-referenced laws, most notably the ePrivacy Directive concerning cookies, automatically inherited these upgraded definitions. And finally, the administrative body known as the Working Party smoothly transitioned into today's EDPB.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. I want to leave you with one final thought today. When dealing with data, the past is honestly never truly in the past. If you don't fully understand the legal bridge of Article 94, how can you be sure the foundation of your legacy data isn't secretly crumbling right beneath you? Keep exploring, keep learning, and I'll see you in the next explainer.
Let's dive right into this. Today, we're exploring one of the most misunderstood, yet literally game-changing components of European data protection. We're talking about GDPR Article 95. Now, you might be asking yourself, why should I care about this specific article? Well, imagine you're launching a massive new marketing campaign, or maybe you're just setting up tracking cookies on your company's website. Without Article 95, you'd probably be terrified of getting penalized twice by two completely different legal frameworks for the exact same action. Nobody wants that, right? So Article 95 steps in as the ultimate traffic cop. It prevents these catastrophic collisions between the incredibly broad GDPR and the highly specific ePrivacy Directive. So let's figure out exactly how this works in this explainer. Here is our roadmap for today. We'll quickly cover the privacy law overlap, decode Article 95, look at some real-world scenarios, dive into enforcement and a case study, do a quick knowledge check, and finish up with key takeaways.
Okay, Section 1, the privacy law overlap.
To really appreciate the solution here, we first have to understand the panic. What actually happens when the GDPR and ePrivacy laws collide? Well, if an organization is launching a tech product, dropping cookies on a user's device, or sending out automated marketing emails, they usually hit a wall and wonder, wait a minute, am I governed by the GDPR here, or the ePrivacy Directive, or is it both? Am I going to face double the administrative burden and double the fines? It's a very real fear, and honestly, it can totally paralyze a business.
To resolve this anxiety, we have to contrast the scopes of these two legal heavyweights. The GDPR is incredibly broad. It is the overarching, all-encompassing framework for pretty much any processing of personal data. The ePrivacy Directive, on the other hand, specifically Directive 2002/58/EC, is highly specific. It laser targets the telecommunications sector, digital marketing, and terminal equipment, like your smartphone or your laptop. Article 95 exists for one simple reason, to make absolutely sure these two laws play nicely together.
Moving right along to Section 2, decoding Article 95.
Let's look at the actual wording here, but we'll keep it super practical. The text states that this regulation shall not impose additional obligations on natural or legal persons in relation to matters for which they are subject to specific obligations with the same objective set out in Directive 2002/58/EC. Now, the absolutely crucial phrase here is shall not impose additional obligations. Think of this as your regulatory shield. It guarantees you aren't doing double the paperwork for the exact same objective.
And this brings us to a really foundational legal concept. Don't worry, you don't need to speak fluent Latin to get this. It's called lex specialis. Simply put, it means a specific rule overrides a general rule. So when a highly specific rule exists in the ePrivacy Directive, like exactly when you need to ask a user before placing a tracker on their phone, the broader GDPR doesn't just stack additional competing obligations on top of that specific action. Essentially, ePrivacy takes the driver's seat for that specific rule.
But, and this is a big but,
Here is where we apply the rule of once. As European Data Protection Board guidelines have clarified, just because ePrivacy takes the wheel for the rule itself, that doesn't mean the GDPR is completely thrown out the window. The ePrivacy Directive actually relies on the GDPR's definition of consent. So while ePrivacy tells you when you need to get permission, the GDPR's high standard is what dictates how that permission must be freely given, specific, and informed. You avoid all those redundant administrative steps, but you absolutely maintain the high privacy standard.
All right, Section 3, Real-World Scenarios. Legal theory is great, but let's see how this actually plays out in practical, everyday business situations. Look at the first scenario here, a tech company using cookies. ePrivacy Article 5.3 sets the rule that you need consent to place the cookie. But the GDPR sets the standard for what that consent actually looks like. The outcome? No double penalty for the exact same tracking mechanism. Or take a small business sending direct marketing emails. ePrivacy Article 13.1 governs that specific communication method. You don't have to go digging for a separate GDPR rule to authorize sending the email because ePrivacy already handles it. It's a pretty brilliant balance.
However, we need to talk about a massive compliance failure we see all the time. A really common mistake is organizations assuming the GDPR is completely irrelevant just because the ePrivacy Directive applies. They think, oh, ePrivacy covers our marketing email, so we can completely forget about the GDPR. Yeah, no, that is completely wrong. Remember our traffic cop analogy? The cop tells you which lane to be in, but you still have to follow the general rules of the road. Things like data minimization, individual rights, and as we just mentioned, the definition of valid consent.
Next up, Section 4, Enforcement and Case Study. So how do regulators and courts actually evaluate this delicate balance during a high-stakes investigation? Well, we don't have to guess, because the Court of Justice of the European Union has explicitly weighed in. European courts have repeatedly reinforced Article 95. For example, in case C-102/20, which dealt with inbox advertising, the court looked very closely at how the ePrivacy Directive specifically protects users from intrusion. And more recently, in case C-654/23, the court confirmed that regulators issuing administrative penalties must carefully analyze whether a specific fine falls under national ePrivacy laws or the broader GDPR. They literally cannot just throw the book at you twice for the exact same violation.
Let's walk through a realistic mini case study so you can see this in action. Step 1, identify your business challenge. Let's say you're launching an automated email marketing campaign. Step 2, spot the privacy issue. You need legal permission to send these messages to people's inboxes, right? Step 3, apply the Article 95 analysis. So you apply ePrivacy Directive Article 13 to find the specific rule for direct marketing, but you use GDPR Article 4 to define what makes that consent legally valid. Boom. You see Article 95 acting perfectly as the operational traffic cop, directing which law handles which part of the process.
Which brings us to Section 5, time for a knowledge check.
Let's test your practical understanding with a scenario-based certification question. Here is the scenario. A company relies on user consent to deploy tracking cookies on terminal equipment under the principle of Article 95. Which framework specifically dictates the initial rule requiring this consent? I want you to think carefully about which law targets the specific technology versus which law provides the general framework.
Is it A, GDPR Article 6 on lawfulness of processing? Is it B, the ePrivacy Directive Article 5.3 regarding confidentiality of communications? C, GDPR Article 9 for special categories of data? Or D, neither. Consent is not required for tracking cookies. Take a second and choose the option that best reflects that lex specialis principle we discussed just a few minutes ago.
If you guessed B, you hit the nail on the head. The ePrivacy Directive Article 5.3 establishes the specific rule for terminal equipment access. This directly prevents the GDPR from imposing an overlapping, redundant obligation just to place the cookie. Remember, while ePrivacy sets the specific requirement to ask for permission, the GDPR is what dictates how clear and freely given that permission must be.
Okay, let's move to Section 6, takeaways and wrap up.
Let's lock in the absolute most critical lessons from our deep dive today. First, Article 95 is the GDPR's built-in mechanism to prevent regulatory overlap. Second, specific rules, like those for direct marketing or cookies, fall squarely under ePrivacy, and that overrides general GDPR obligations for that specific task. Third, no additional obligations absolutely does not mean the GDPR is ignored. The high GDPR standards for things like consent still serve as your foundation. And finally, regulators are bound by law to respect these boundaries when issuing administrative fines. Honestly, keeping these takeaways in mind should fundamentally shift how you approach compliance, and it's going to save your organization from a lot of unnecessary anxiety and double work.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone.
If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore PrivacyUni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while PrivacyUni.com is designed for learners who prefer a more structured learning experience.
Before we go, a quick reminder. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. And finally, I'll leave you with this provocative thought. As technology rapidly evolves with things like AI and spatial computing, how do you think this delicate traffic cop balance between general data protection and specific communication privacy is going to hold up in the future? Thank you so much for joining me to explore Article 95, and I will see you in the next explainer.
Welcome back, focused learners, to Privacy Trainer. I'm your host, and I am absolutely thrilled to have you with us today. You know, our mission here is to make the world's privacy laws accessible, understandable, and, dare I say, actually fascinating by breaking them down using our custom AI-generated visuals. Today, we're diving straight into an explainer entirely focused on GDPR Article 96. Now, it's a pretty short provision, but one that quietly sustains massive international data flows. It's basically the ultimate legacy bridge, and really understanding it is absolutely crucial for anyone dealing with cross-border data transfers.
Here is our game plan for today's explainer. We'll start with the pre-GDPR time capsule, then we'll decode Article 96, explore some real-world applications, review a regulatory case study, jump into a professional knowledge check, and finally wrap up with our key takeaways. All right, let's kick things off with Section 1, the pre-GDPR time capsule. I want you to picture a scenario for a second. It's May 25th, 2018. The GDPR officially becomes enforceable. What if, at the exact stroke of midnight, the GDPR instantly shattered every single pre-existing international treaty that involved data sharing? We're talking about mutual legal assistance treaties, tax sharing agreements, and international law enforcement pacts that member states had relied on for decades. It would have been absolute global gridlock. I mean, total chaos, right? Well, the drafters of the GDPR knew they couldn't just break international law overnight. And that is the exact problem Article 96 solves. It prevents this gridlock by acting as a protective time capsule. Moving right along to Section 2, decoding Article 96. So the text here essentially establishes what lawyers call a grandfather clause. It states that international agreements involving data transfers concluded by member states prior to May 24, 2016, and which complied with prior union law, remain in force until amended, replaced, or revoked. Basically, if a country signed a valid treaty under the old rules, it actually survives the GDPR. But, and this is a massive but, only under some incredibly strict, really fragile conditions. It's all about the timeline here, which completely dictates whether an agreement is saved or scrapped. Looking at how this played out, you've got the old 1995 directive. Then, right there in the middle is our magic cutoff date, May 24th, 2016. That was the date the GDPR officially entered into force, even though it wasn't actually enforced until 2 years later on May 25th, 2018. So, if a member state concluded a treaty before that May 24, 2016 cutoff, Article 96 acts as a bridge, safely carrying that old treaty right into the modern enforcement era. Okay, let's see what this looks like in practice. Section 3, real-world applications. Let's say you're a tech company transferring data to a foreign government, and you rely on a member state's mutual legal assistance treaty signed back in 2012. That's a totally valid use case because it's a state-level agreement. But what if you're a small business? You might assume your private business-to-business vendor contract from 2015 is grandfathered in. Well, that is a massive misconception. Article 96 applies to member state agreements, not private corporate contracts. And finally, let's look at a common compliance failure. Say two countries decide to update or amend their grandfathered 2014 treaty today. Bam, the time capsule breaks. The moment it's amended, it instantly loses that Article 96 protection and has to become fully GDPR compliant. Next up, Section 4, regulators and case study. Let's walk through a real-world scenario. Imagine a European public hospital is sharing sensitive patient data with an overseas research institute. Their primary business challenge is maintaining this vital medical research. The privacy issue, of course, is that this involves cross-border transfers of highly sensitive health data. So the big GDPR question is, can they use a bilateral treaty signed by their national government back in 2010 as the legal basis for the transfer? Regulators who are highly sensitive to international transfers, especially after strict rulings like Schrems I, KC 362/14, they're going to do a strict step-by-step analysis here. They will ask, was it concluded by a member state? Yes. Was it before May 24, 2016? Yes. Has it been amended since? No. And finally, did it comply with the old 1995 directive back when it was actually signed? If the answer to all of these is a solid yes, the hospital can lawfully proceed. All right, time to test what we've covered. Section 5, professional knowledge check. Here is our first scenario. A member state signed a data sharing treaty with a third country on June 1, 2016. Does Article 96 protect this agreement? Think back to the timeline we just discussed. Is it A, B, C, or D? And the answer is C. No, it completely misses the cutoff. Remember, the hard deadline is May 24, 2016. Even though the GDPR wasn't enforced until 2018, literally anything signed after May 24, 2016 does not get grandfathered in, and it has to fully comply with the standard GDPR Chapter V transfer rules. Let's try another one. Imagine a public health authority relies on a 2014 treaty to share data overseas, but the treaty was officially amended in 2020. What is the GDPR status of this agreement today? If you guessed B, you hit the nail on the head. It loses Article 96 protection. The grandfather clause is incredibly fragile, guys. The text clearly states agreements remain in force only until amended, replaced, or revoked. Simply touching or updating that old treaty immediately shatters the time capsule, triggering modern compliance requirements. Moving to Scenario 3. What if a 2010 international agreement violated the old Directive 95/46/EC at the time it was signed? How does Article 96 treat it today? The correct answer is C. It does not qualify. Article 96 is definitely not a get-out-of-jail-free card for historically bad agreements. For the legacy bridge to work at all, the treaty must have been lawful under the old rules. If it violated EU law back then, it certainly isn't protected now. All right, final scenario. During an investigation, a tech company claims Article 96 protects their private vendor contract from 2015. Is this correct? The answer is C. Now, it only covers member state agreements. Private companies absolutely cannot use Article 96 to shield their old corporate contracts from modern data transfer mechanisms. They are going to need standard contractual clauses or another valid mechanism under Chapter 5, for sure. Let's wrap things up. Section 6, takeaways and final thoughts. Here are your key takeaways. 1. Article 96 is a very strict grandfather clause designed to prevent international legal chaos. 2. The absolutely vital cutoff date is May 24, 2016. 3. It only ever applies to member state international agreements, never private B2B contracts. 4. The agreement must have been lawful under pre-GDPR union law. And 5. It is highly fragile. The protection completely vanishes the very moment the agreement is amended, replaced, or revoked. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone.
And hey, if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyunit.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyunit.com is designed for learners who prefer a more structured learning experience. Finally, disclaimer. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Before we sign off, I want to leave you with one final provocative thought. Next time you hear about a massive cross-border data exchange between governments, ask yourself, are they actually relying on the modern GDPR, or are they secretly writing the legacy bridge of an invisible treaty from 2012? Honestly, the answer might surprise you. Thank you so much for learning with us today. Stay focused, and I'll catch you in the next explainer. Right, let's jump straight into this explainer and take a look at the actual engine of evolution inside the GDPR. You know, when we think of the General Data Protection Regulation, it's super easy to picture this massive, unchangeable block of legal text just gathering dust on a shelf somewhere. But what if I told you the GDPR actually has a built-in mechanism to upgrade itself? Seriously. Today, we're unpacking Article 97. This is literally the exact article that stops the law from becoming a relic of the past. If you've ever found yourself wondering how privacy law actually survives in a world that pumps out new, data-hungry tech every single week, well, you are absolutely in the right place. So it turns out lawmakers anticipated a massive challenge way before this law even went live. They asked, is the GDPR already outdated in the age of artificial intelligence, machine learning, and these massive global data brokers? A lot of people tend to think of laws as static, rigid rules that eventually just snap when technology outpaces them. But the architects of the GDPR, they knew the digital landscape is constantly shifting underneath our feet. They absolutely needed a built-in way to guarantee the law would stay relevant, effective, and protective. And that brings us right to the core of our topic today. Article 97 is officially titled Commission Reports, but in plain English, you can really just think of it as the GDPR's built-in software update mechanism to prevent obsolescence. Instead of a static textbook, imagine the GDPR as an operating system. And Article 97, it forces regular diagnostics and patches. It legally mandates the European Commission to take a step back, evaluate how the law is actually functioning in the real world, and then report those findings straight to the European Parliament and the Council. To see how this evolution builds over time, we just need to look at the timeline. The law mandates a comprehensive evaluation every 4 years to ensure it keeps pace with reality. The very first report was mandated from May 25, 2020, which was exactly 2 years after the GDPR became fully enforceable. From there, it shifted into a strict quadrennial cycle, 2024, 2028, and so on. Now, this isn't just some casual, hey, how are things going check-in. No, it's a formalized, highly predictable timeline that organizations can literally put on their calendars to anticipate shifts in the regulatory weather. So, a crucial point here is that Article 97 zeroes in on two massive pain points for global businesses. The Commission doesn't just evaluate the entire law at random. Actually, Article 97 explicitly directs them to focus heavily on two very specific areas. First up, Chapter V, which governs international transfers of personal data to third countries or international organizations. And second, Chapter 7, dealing with cooperation and consistency among supervisory authorities. Why these two? Well, these are the exact areas that most directly impact global trade and the harmonized enforcement of the law across borders. This brilliantly illustrates that the law is fully prepared to literally rewrite itself in response to new tech. Article 97, paragraph 5, gives the Commission the power to submit appropriate proposals to amend the regulation. Just listen to that phrasing. In the light of the state of progress in the information society, lawmakers didn't pretend to have a crystal ball for what the internet would look like in 20 years. Instead, they explicitly tie the evolution of the law directly to the advancement of information technology. To really grasp this, we have to unpack the lawmaker intent, and that points us straight back to Recital 10 of the GDPR. The lawmakers knew that without a mandatory review mechanism, the rapid evolution of digital data flows would literally leave the law in the dust. They wanted to ensure a consistently high level of protection for individuals while simultaneously removing arbitrary obstacles to cross-border data flows within the internal market. Think of Article 97 as the balancing scale they use to make sure neither privacy nor commerce is fundamentally broken by technological shifts. Let's ground this in some real-world business impacts, shall we? Say you're a global tech startup relying on adequacy decisions to transfer data internationally. Well, the Commission's quadrennial report directly dictates the stability of your compliance roadmap. Or maybe you're a small business operating across 3 European countries. In that case, the report's focus on regulatory cooperation completely determines whether you're going to have to deal with conflicting rules from different authorities. A major compliance failure here is simply getting caught off guard just because you weren't paying attention to the systemic shifts signaled by these Article 97 reviews. A massive misconception I see all the time is building a compliance program once and never looking back, totally ignoring the upgrades triggered by Article 97. The common mistake is treating privacy compliance like a static checklist. You tick the boxes in 2018 and consider the job done. The best practice, however, is treating the GDPR as a living, breathing, evolving framework. Smart privacy professionals use the Article 97 reports as strategic intelligence to see exactly where enforcement trends and legal requirements are heading next. From an enforcement perspective, regulators in the Commission look at the big picture, meaning the flow of data across borders to evaluate if the current rules are actually working. Under Article 97, the Commission is authorized to request information directly from member states and supervisory authorities. This means the evaluations aren't just happening in some isolated ivory tower. They are based on the on-the-ground reality of investigations, fines, and the daily struggles of data protection authorities trying to maintain consistency across the entire European Union. Okay, let's walk through a scenario step by step to see how a savvy privacy pro uses Article 97 to predict the future of compliance. Imagine a fast-growing software as a service company that relies heavily on standard contractual clauses to move data globally. They know international transfer rules under Chapter 5 are incredibly volatile, especially following landmark rulings like Schrems 2, that's case C 311/18 for those of you tracking court precedent. Instead of sitting around waiting in fear for a sudden legal change, their privacy team actively monitors the Article 97 evaluation process. By reading the reports, they gain early warning of any proposed amendments to transfer mechanisms, which allows them to adopt their business model long before a crisis hits. So how well can you anticipate these regulatory shifts? Let's test your understanding with a certification-style question. Imagine your company relies heavily on standard contractual clauses. To stay ahead of the curve, when should you expect the next major evaluation report from the Commission? Is it A, annually,
B, when a major data breach occurs, C, every 4 years, or D, only upon request. Take a quick second to lock in your answer. And the correct answer is C, every 4 years. It's a highly predictable cycle, meaning your privacy team can literally put these milestones right on your long-term calendar. Starting in May 2020, Article 97 locked the European Commission into a mandatory continuous 4-year rhythm of evaluating and reporting on the GDPR's real-world performance.
Let's look at another scenario, this time from an auditing perspective. Think back to the specific chapters the law forces the Commission to scrutinize closely. A compliance officer is auditing operations. Based on Article 97, which specific areas are legally mandated focus areas for the Commission's review? A, consent forms and cookies. B, international transfers and authority cooperation. C, DPO appointments and DPIAs. Or D, age of consent and sensitive data. What do you think?
The answer is B, international transfers, which is Chapter V, and authority cooperation, which is Chapter 7. Chapter 5 and Chapter 7 are basically the engine room of international data protection, which is exactly why they are explicitly highlighted in the text of Article 97. These are arguably the absolute most politically complex and commercially sensitive aspects of the law, directly impacting how the European market interacts with the rest of the digital world.
Now, to execute these massive software updates, the Commission needs reliable intelligence. So how do they actually gather it? Let's try this one. The European Commission is drafting its Article 97 report. To accurately reflect enforcement challenges, who does the GDPR explicitly authorize them to request information from? A, top 500 tech companies. B, member states and supervisory authorities. C, the Court of Justice. Or D, individual data subjects.
If you selected B, you nailed it. They need the real-world data from the enforcers on the ground to understand what's working and what's breaking. The Commission relies heavily on the feedback and operational metrics provided by member states and their independent supervisory authorities. This ensures the review is grounded in practical enforcement reality and not just theoretical legal debates.
All right, final question. This is the ultimate test of whether the GDPR is truly future-proof against something wild like generative AI. Let's say an explosive new AI technology completely changes how data is processed globally. Under Article 97, what is the built-in mechanism to address this rapid technological shift? A, the Commission bypasses Parliament to ban it. B, supervisory authorities independently rewrite Chapter 2. C, the Commission submits proposals to amend the regulation. Or D, the GDPR becomes void for that technology. The answer is C. The Commission submits appropriate proposals to amend the regulation in light of IT progress. This brilliantly illustrates that the GDPR is designed to adapt, proposing formal amendments rather than just becoming obsolete. Article 97, paragraph 5, specifically empowers the Commission to submit proposals to amend the GDPR to keep up with the state of progress in the information society. It ensures the entire legislative framework can bend and evolve without breaking.
So the crucial takeaway here is that compliance is a moving target, and Article 97 gives you the binoculars to see exactly where it's going. To quickly summarize, Article 97 is the GDPR's built-in upgrade mechanism. It operates on a strict 4-year cycle. It focuses incredibly heavily on the flow of international data and the harmony of regulatory enforcement. And most importantly, it is driven directly by progress in information technology, meaning your privacy program needs to be just as adaptable as the law itself.
We really appreciate your support as we build out this incredible library of free knowledge. If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. For those wanting to take their careers to the next level with guided paths, definitely check out privacyuni.com. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. As always, a quick disclaimer. This content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes, and I'll leave you with this thought to ponder today. Knowing that the GDPR is designed to evaluate itself and evolve every 4 years, how will your organization adapt when the next Article 97 update rolls out? Are you preparing for the GDPR of yesterday or the GDPR of tomorrow? Thanks for joining me on this explainer, and keep learning.
Welcome to Privacy Trainer. Today, we're diving into what is honestly a pretty fascinating and totally unique part of the GDPR, Article 98. Now, normally, when we're talking about the GDPR, we're laser-focused on rules for businesses, controllers, and processors, the usual suspects, right? But Article 98, it's entirely different. It basically acts as the GDPR's built-in cleanup crew. It's an administrative provision designed to bring order to what was, quite frankly, a chaotic European legal landscape. So if you've ever felt completely overwhelmed by conflicting privacy rules, you're going to love this one, because this is the article written specifically to eventually make your life easier. So let's start with a massive, very real problem. What on earth are organizations supposed to do when the GDPR demands one thing, say strict, unambiguous consent, but older European laws like the ePrivacy Directive seem to demand something else entirely? These conflicting signals create incredible friction for privacy professionals, lawyers, and business leaders who really just want to figure out how to comply. Seriously, what happens when 2 different EU privacy laws actually contradict each other? Well, lawmakers absolutely knew this was going to be an issue, and they built a specific mechanism right into the text to fix it. Here is our roadmap for today's explainer. We're going to quickly cover the harmonization problem, decode the actual text of Article 98, look at some real-world scenarios, analyze a mini case study, test your knowledge, and wrap up with some key takeaways. Let's get right into it. Section 1. The harmonization problem. Let's talk about resolving conflicting directives.
Before Article 98 really came into play, the European legal landscape was a total fragmented mess. You had all these various directives, older regulations, localized rules. They overlapped, intersected, and honestly sometimes directly contradicted the fresh, sweeping mandate of the General Data Protection Regulation. So think of the GDPR like a massive universal operating system update for data protection. It's robust, it's modern, it's comprehensive. But you've still got all these legacy apps running on the system, like older directives. Article 98 acts as the protocol that literally forces all those outdated legacy apps to finally upgrade to the new standard. It ensures that the rest of the European Union's legal framework eventually catches up to the GDPR's baseline.
Section 2. Decoding Article 98. Let's translate the actual legal text.
Let's look under the hood to see how lawmakers actually built this harmonization engine. The text states, the Commission shall, if appropriate, submit legislative proposals with a view to amending other Union legal acts on the protection of personal data in order to ensure uniform and consistent protection of natural persons with regard to processing. Okay, in plain English, the European Commission is legally obligated to review existing EU laws and propose amendments. And this is heavily supported by Recital 171, which explicitly calls out the need to repeal or amend earlier privacy directives to avoid inconsistencies. Essentially, it's a direct mandate to clean house so that absolutely everything aligns perfectly with the GDPR.
Now, this timeline perfectly illustrates the Commission's ongoing duty. First up, they have to review those legacy laws, which is a process that takes months. Then, they submit legislative proposals to amend those laws, which, as we know, can take years of political debate. Finally, they have to ensure that Union institutions themselves are aligned, which is an ongoing effort. Article 98 makes a point to highlight that EU bodies and agencies must practice what they preach and process data according to GDPR standards. Now, from a regulatory and enforcement perspective, national data protection authorities aren't enforcing Article 98 against private companies, but they rely entirely on the outcome of this timeline. They desperately need this harmonization to ensure they are applying a single, unified standard during all their investigations.
Section 3. Real-world scenarios and mistakes, from tech giants to your local small business.
So while Article 98 is a direct instruction for the European Commission, its ripple effects dramatically impact everyday businesses. For a massive tech company, the eventual outcome means navigating unified cookie rules once older directives are finally amended. For a small business, it means vastly simplified, single standard consent requirements. Before the GDPR, a lack of harmonization led to highly fragmented rulings all across Europe. We saw this with early interpretations in cases like Google Spain under the older frameworks. To prevent a repeat of that, Article 98 ensures unified rules eventually apply everywhere. However, a common compliance failure we see is organizations completely misunderstanding these overlapping obligations in the interim. And the single biggest mistake? Thinking Article 98 is a direct compliance checklist for your business. It is absolutely not. You cannot be fined under Article 98 itself because it's a rule for the European Commission, not for data controllers.
Section 4. Enforcement and analysis. Let's look at a mini case study. So how exactly do we analyze situations where the laws just haven't fully harmonized yet? Let's imagine an ad tech company rolling out a brand new app. Step 1, the business challenge. They need to design a compliant cookie banner. Step 2, the privacy issue. The GDPR requires strict, explicit opt-in consent, but an older local law based on a legacy directive suggests implied consent might just be okay. So step 3, the analysis. A smart privacy professional knows that under the spirit of the GDPR, and thanks to the eventual harmonization mandated by Article 98, the highest standard of uniform protection is always going to win out. So they design for the strict GDPR standard today, knowing for a fact that Article 98 ensures all other laws will eventually be elevated to match it anyway.
Section 5, knowledge check. Let's get into some certification prep. All right, let's shift gears and test your practical understanding with 4 scenario-based questions designed exactly like professional certification prep. Question 1. Who is the primary entity directed by GDPR Article 98 to ensure harmonization? Is it A, data protection officers, B, the European Data Protection Board, C, the European Commission, or D, individual member states? Take a quick second to consider which body is actually tasked with doing the heavy lifting here. And the correct answer is C, the European Commission. The absolutely crucial takeaway here is that Article 98 is an administrative instruction directed exclusively at the European Commission, compelling them to submit legislative proposals. It is definitely not directed at your company's DPO or at individual member states.
Moving on to question 2. A tech company is confused by differing rules in the GDPR versus an older directive. What is the ultimate goal of Article 98 in this specific scenario? A, to penalize the company. B, to ensure uniform and consistent protection. C, to repeal the GDPR. Or D, to exempt the company from compliance. Think about the fundamental objective lawmakers actually wanted to achieve when they wrote this.
The answer is B, to ensure uniform and consistent protection. Lawmakers really wanted to guarantee that a citizen receives the exact same high-level protection regardless of which specific EU law is being applied to their data. It's all about consistency.
Question 3. Besides amending General Union Acts, Article 98 specifically highlights the rules for data processing by whom? A, small businesses. B, non-EU citizens. C, union institutions, bodies, offices, and agencies. Or D, third country controllers. The second sentence of Article 98 points a very specific finger. Do you remember who it points at?
The answer is C. This brilliantly illustrates that the European Union institutions must practice what they preach. Article 98 makes it totally clear that the rules must be harmonized so that EU bodies, offices, and agencies hold themselves to the exact same rigorous GDPR standards they expect from the private sector. No double standards allowed.
Finally, question 4. Which of the following is a common compliance mistake regarding Article 98? Is it A, believing it impacts EU institutions? B, assuming it acts as a direct compliance checklist for private businesses? C, understanding it forces regulators to harmonize laws? Or D, believing it applies to the Commission? Let's see if you caught the most frequent misunderstanding we talked about earlier.
The correct answer is B. Honestly, you'd be amazed at how many people try to audit their own companies against Article 98. It is a huge, common mistake to assume it acts as a direct compliance checklist for private businesses. Remember, you literally cannot be fined for violating Article 98 because it is a rule for the lawmakers, not a compliance obligation for your business. Section 6, takeaways and support. Let's wrap this up with some final thoughts.
Let's synthesize everything down to your top 5 takeaways. Number 1, Article 98 acts as the EU's harmonization engine. Number 2, it is directed solely at the European Commission, not private companies. Number 3, its ultimate goal is to ensure uniform and consistent protection across all laws. Number 4, it specifically mandates that union institutions align their own processing. And number 5, while you don't directly comply with it, its ongoing work actively reduces legal friction and overlapping rules for your business over time.
Just imagine the power of a legal ecosystem where 100% of the laws sing in perfect harmony with the GDPR. That is the bold, overarching vision of Article 98. It is the invisible engine working tirelessly in the background, constantly updating the European legal framework so that your future compliance efforts are smoother, clearer, and far more predictable. So next time you're frustrated by overlapping laws, just remember, the cleanup crew is on it.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. If you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience. Disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. Keep learning, keep harmonizing your privacy practices, and I'll catch you in the next explainer.
Okay, let's dive right into this explainer and uncover why Article 99 of the General Data Protection Regulation is actually a massive deal. I mean, on the surface, it's just a seemingly simple 2-sentence provision about dates, right? But in reality, it is a profound legal threshold for privacy compliance. Article 99 doesn't just tell us when the GDPR kicks in, it's literally the definitive line in the sand. It determines whether your organization is held to modern, rigorous privacy standards or the outdated rules of the past.
Here is our roadmap for today. We'll start with the hook and overview, move into the regulatory transition, explore some real-world scenarios, break down a compliance case study, run through a privacy knowledge check, and finally, wrap up with your key takeaways and next steps.
Section 1, the hook and overview.
So, you might be wondering, why should a privacy professional actually care about a simple effective date? Well, it's because Article 99 solves a really complex problem called temporal scope, or if you want to use the fancy legal term, ratio temporis. It dictates exactly when the old legacy rules end and strict GDPR enforcement begins. Without this definitive threshold of May 25, 2018, organizations would basically be trapped in regulatory limbo. And if you misunderstand this, you might end up applying repealed, totally outdated laws to modern data requests.
Section 2, the regulatory transition. Let's break down the actual text of Article 99. It's neatly split into 2 distinct parts. Paragraph 1 says that the GDPR enters into force 20 days after its publication in the official journal. But paragraph 2, which is the famous one, states it formally applies from May 25, 2018. Now, lawmakers deliberately built in this 2-year grace period. They knew the transitioning massive, complex IT systems from the old 1995 directive to the GDPR just couldn't happen overnight. Organizations desperately needed this buffer to bring their data processing into conformity. Though, let's be real, a lot of companies treated that grace period like a college term paper and waited until May 24, 2018 to absolutely panic. That is exactly why your inbox was suddenly flooded with all those "we're updating our privacy policy" emails on that specific day. To really grasp this transition, we have to look at Recital 171, which clearly states that the old Directive 95/46/EC should be repealed by this new regulation. Right at the stroke of midnight on May 25, 2018, Article 94 officially repealed that old 1995 directive, while Article 99 simultaneously activated the GDPR. It was a complete regulatory substitution. It locked in a totally new era of privacy in an instant. There was no grandfathering and absolutely no overlap. Section 3, real-world scenarios.
We actually see common compliance failures centered around this specific date all the time. For instance, imagine a tech company gets a data deletion request today for a user profile that was created way back in 2014. They might mistakenly think, well, we collected this under the old directive, so the GDPR doesn't apply to it. That is a massive compliance failure. Or think about a small business that just failed to update its privacy policies during the 2-year grace period because they assumed they were grandfathered in. Let me be clear, there is no grandfathering here. The exact moment that May 2018 threshold was crossed, all ongoing data processing became subject to the GDPR, regardless of when that data was initially collected. From an enforcement perspective, you have to know that regulators will aggressively scrutinize the timeline of your processing activities. If a user complains about how their legacy data is being handled today, a regulator is going to pull out their magnifying glass to see exactly which side of the May 2018 threshold your processing actions fall on. So it is absolutely vital that your organization maintains hard evidence of when data was collected, but even more importantly, how and when it is being actively processed right now. Section 4, compliance case study.
Okay, let's ground this with a real scenario. Imagine a bank processed a client's data back in 2013. Years go by. Then, on May 29, 2018, which is just 4 days after the GDPR application date, that client submits a data subject access request. Now, the bank argues that because the actual data processing happened in 2013, the old directive should govern the request, not the strict new GDPR. So, which law actually wins out here? Well, the Court of Justice of the European Union ruled very clearly on this in case C579/21. They said because the action of the request was submitted after the GDPR became applicable, the GDPR entirely governs that access request. The date of the original processing doesn't shield you at all if the regulatory trigger, the user's request, happens today.
Section 5, privacy knowledge check.
All right, it's time to test your understanding with a few certification-style questions to see if you can apply these temporal scope concepts. Question 1. An ethics commission issues a decision on February 7, 2018. Based on case C-184/20, which law governs this specific decision? Is it A, the GDPR, B, Directive 95/46, C, ePrivacy, or D, none? Think really carefully about the exact date the decision was adopted versus the Article 99 timeline we just talked about. And the correct answer is B, Directive 95/46. Because the decision was definitively adopted in February 2018, it predates the threshold and is entirely governed by the old directive. This proves that May 25th is a hard line in the sand for historical actions that were completely finalized before the deadline.
Let's move on to question 2. A user requests data access on May 29, 2018 for data that was processed back in 2013. Which law applies to the request? A, GDPR, B, Directive 95/46, C, both, or D, neither. This is the exact scenario from our case study earlier. So does the date of the original processing or the date of the request matter more?
The answer is A, the GDPR. Just like we saw in case C579/21, the court ruled that the GDPR applies simply because the action of requesting access happened after the Article 99 application date. That action effectively brings that legacy data right under modern scrutiny. Question 3. This is a kind of tricky scenario. A person failed to lodge a required private interest declaration before May 25, 2018. If they finally lodge it after that date, does the GDPR apply to that action? A, no. B, yes. C, only with consent. Or D, only for large tech. How exactly do ongoing obligations that cross the deadline work under the law?
The correct answer here is B. Yes. Case law makes it crystal clear that if the processing action, like finally publishing or lodging that declaration, happens post-threshold, the GDPR strictly applies ratio temporis. Basically, you can't escape the GDPR just by being late on an obligation that started under the old rules.
Finally, let's test the legislative intent behind the structure of Article 99 itself. Question 4. Why does Article 99 provide a specific date of application that is distinct from its entry into force? Is it A, bureaucracy, B, a 2-year grace period for transition, C, to delay fines indefinitely, or D, for translation purposes?
And the answer is B. The lawmakers intentionally built in this 2-year buffer. It was just a practical necessity so that massive global data systems could actually be updated and brought into full compliance before the strict new rules locked into place.
Section 6. Takeaways and next steps.
Misunderstanding Article 99 can lead to some massive vulnerabilities for your organization. So your key takeaways today are simple but incredibly profound. First, May 25, 2018 is the ultimate legal threshold. There's absolutely no blurring of this line. Second, it's the date of a specific action, like a data subject's request, that dictates which law applies, not necessarily when the data was born. And third, legacy data is absolutely not immune to modern rules. Understanding temporal scope is absolutely vital for handling historical privacy claims accurately.
If you enjoy these GDPR explainers and would like to support the channel, consider becoming a member of Privacy Trainer. Memberships help us continue creating free privacy, security, AI, and compliance education for learners around the world. Our mission is to make high-quality privacy knowledge accessible to everyone and use AI to scale education to everyone. And if you're looking for more structured privacy, security, or AI training, including guided learning paths, workshops, practice questions, exam and certification preparation resources, you can also explore privacyuni.com. Privacy Trainer focuses on making knowledge freely available on YouTube, while privacyuni.com is designed for learners who prefer a more structured learning experience.
Quick reminder, disclaimer, this content is provided for educational purposes only and does not constitute as legal advice. Content might include mistakes. But I want to leave you with a pretty provocative thought to end on today. Considering everything we just uncovered about Article 99, what forgotten legacy data sitting quietly in your own servers right now might suddenly trigger a massive GDPR compliance issue if a user takes action today? Think about it. Thanks so much for joining me on this explainer, and I'll see you in the next one.